House Committee on State Affairs will now come to order. Clerk, call the roll.
Hunter,
Here.
Hernandez, Thompson, Smithy,
Here.
Raymond,
Here.
Guerin,
Here.
Guillen, Anchia,
Here.
Turner,
Here.
Metcalf, Dean, Slauson, Spiller.
Here. Please note for the record, Representative Spiller is here. Vice Chair Hernandez is here. Due to the number of witnesses and a quorum is present, due to the number of witnesses registered to testify today, we will be limiting testimony to 2 minutes per each witness that testifies during the public testimony period. In addition, it may be necessary to limit testimony to no more than 4 hours per bill in order for the committee to ensure consideration of all items posted on today's agenda. Should this be necessary, the chair will alternate witnesses registered for and against the bill. For those unable to testify in the allotted time frame, your registered position will be reflected in the official record. As a reminder, all that plan to testify, please ensure that you're registered through the electronic witness affirmation system that's located on the tablets in the hallway. If you're having trouble registering, please see our Assistant Clerk Isabella Huerta. She will assist you. Please also remember that when you testify in front of our committees, you're testifying under oath and are required to testify fully and truthfully. Registration for witnesses wishing to testify, register a position on the bills posted on today's agenda will be closed at 5 p.m. today, 5 p.m. All witnesses should register by that time through the electronic witness affirmation system. Today's hearing is also being live streamed on the House website, which is www.house.texas.gov/video-audio. Members of the public wishing to submit comments on today's hearing may do so through the public portal till the hearing is adjourned. Pursuant to House Rule 4, Section 20B and the standard electronic public comment process established by the Committee on House Administration, all public comments submitted through the portal will be posted on TLIS, TLO, and the House website if the comment period is closed. Directions of how to submit public comments on the portal can be found on today's hearing notice. One noted, for the record, the chair moves to correct the minutes for the meeting held on April 14th upon final adjournment. Is there objection? The chair hears none. The motion prevails. All right, who is it? Zero. What number? The chair lays out HB 5174 and recognizes Chairman Bonnet to explain his bill. The chair offers a committee substitute to HB 5174.
Thank you, Mr. Chairman and members. House Bill 5174 addresses a very key and strategic aspect of national defense and also our state and national economy, and that is semiconductors. Texas has been a leader since the inception of this industry back in the 1950s. However, there is now intense competition internationally and then also domestically. And there are concerns about the supply chain as it relates to semiconductor. What this legislation does is a couple of things. It first of all, creates a consortium that will bring together stakeholders both from the private sector and higher education, and also I would envision public education as well, to form and maintain a strategic plan for the state as we focus on the critical future of this industry. Secondly, we create a fund that would be used to leverage state dollars in matches either with federal funding or private funding that would allow us to further foster innovation, research, and manufacturing, as well as workforce development in the state. And with that, I'm happy to answer any questions and would like to reserve the right to close.
Any questions, members? We'll give you the right to close. Anybody? Members, we don't show any witness affirmations, registration on this bill. Is there anyone else who wishes to speak on, for, or against the bill? Seeing none, the chair recognizes Chairman Bond to close on his bill.
Thank you, Mr. Chairman. I close.
Any questions? Thank you, members. Thank you, Chairman Bond. The chair moves to withdraw the committee substitute to HB 5174 and leave the bill pending at this time. Is there any objection? Hearing none, HB 5174 is left pending. Chair lays out HB 1899 and recognizes Chairman Meyer to explain his bill.
Thank you, Mr. Chairman, committee. Members, HB 1899 strengthens the state's law regarding abuse of official information. I believe the severity of the penalty should match the magnitude of the crime. Currently, the misuse of official information by a public servant is a third-degree felony. It's also a Class C misdemeanor for a public servant to coerce another into suppressing or failing to report that information to law enforcement. HB 1899 increases the punishment for suppression from a Class C misdemeanor to a third-degree felony and creates a tiered system of punishment that would increase in criminal penalty the more someone illegally gains. Thank you, members. I respectfully reserve my right to close.
Members, any questions? Thank you. We give you the right to close. Members, we don't show any witness affirmations or registrations. Is there anyone else who wishes to speak on, for, or against the bill? Seeing none, chair recognizes Chairman Meyer to close on the bill.
Thank you, Mr. Chairman. I close.
Any questions? Thank you, Chairman. Chair moves to leave HB 1899 pending at this time. Is there any objection? Hearing none, HB 1899 is left pending. Chair lays out HB 3668 and recognizes Representative Holland to explain his bill.
Thank you, Chairman. Members, House Bill 3668 is just an extension of the PUC's authority to hire any consultant, accountant, auditor, engineer, or attorney to represent it in matters in front of the FERC, Federal Energy Regulatory Commission. This is already something that we do at PUC. We're lining it up with the sunset dates in the bill that we just passed today on the floor. I reserve my right to close.
Members, any questions? Thank you. We give you the right to close. We show no witness affirmations or registrations. Is there anybody else who wishes to speak on, for, or against? All right, hold on.
3668? I'm just going to say yes.
No, hold on. Do we show he's there?
Actually, yes.
Okay, thank you. We'll call you up to close. We do have a witness affirmation, members. John Gordon. John, the affirmation registration says, John Gordon, representing yourself, 4HB 3668. Is that correct?
That is correct.
Go right ahead.
And all I want to say is I think that it should be extended.
Any questions, members? Thank you very much. Now, is there anybody else who wishes to speak on, for, or against the bill? Seeing none, chair recognizes Representative Holland to close on the bill.
I close.
Thank you, Representative Holland. Any questions? The chair moves to leave HB 3668 pending at this time. Is there any objection? Hearing none, HB 3668 is left pending. Who's got it? Is it rolling, bro? How many is crowded? Which one? Who? Okay, which one? What is it? All right, the chair lays out HB 4930 and recognizes Dean Craddock to explain his bill. Good work.
Thank you, Mr. Chairman, members. Thank you for taking the time to review this legislation. It's important to all Texans. House Bill 4930 seeks to address the problem of any city adopting a climate charter without a state assessment from a state agency stating the charter is necessary. The legislation still requires a vote on the city charter, like it does today. In addition, any charter approved prior to the enactment of this legislation must be put to a community vote and approved by January 1st of 2025, or the charter is invalidated effective January 1st, 2026. This is the reason for that is the consistency across the state. We see time and time again where cities are taking bold actions which are not in the best interest of their citizens. Here is a prime example. This legislation will protect the citizens of many cities across the state. And there aren't many that have done this, but people are looking at it, and we feel like that we need a vote.
Any questions, members? Thank you, Dean. We'll give you the right to close. First witness, Michael Siegel. Michael, we show you have registered for Ground Game Texas against HB 4930. Is that correct?
Yes, Chair.
Go right ahead.
Thank you, sir. Michael Siegel, General Counsel for Ground Game Texas. We're one of the organizations participating in the El Paso Climate Charter campaign and speaking in opposition to this bill. First of all, as a co-author of the bill, I'm a former city attorney for the city of Austin, co-author of the El Paso Climate Charter, that is. I can say that we intentionally drafted this policy to make sure it's focused on matters within the city's control and not to intrude on any state regulatory authority. So the Climate Charter in El Paso sets goals for the city, things like creating jobs, reducing emissions. But these are goals for the city. They don't regulate private business. They don't regulate private individuals. They do set, big picture goals like, hey, can we get to renewable energy by 2045? This tracks what the electric utility has also put out, El Paso Electric. But these are aspirations. They're not enforceable. The enforceable parts of this policy are to hold hearings for city residents, to provide informational reports on job goals and reducing emissions. And they don't involve what the PUC or the TCEQ or other state agencies do. In one of the author statements for this bill, at least on the Senate side, there was a concern about the 2045 renewable energy goal. But I just want to reemphasize that that's a goal for city expenditures, not to regulate people's homes or people's businesses. There's also a second major problem that this would involve a lot of micromanaging of local actions. The policy says that basically a state agency or the legislature in the substitute bill, I understand, it would have to basically be referred to the state if a local policy concerns the environmental impact of water, energy, or emissions. So that's extremely expansive. If a city fixes its water lines to reduce leakage, does that have to be referred to the legislature? If they deny zoning for a factory in a school zone, if they want to go after this federal funding under the Inflation Reduction Act. For example, Shell Oil is producing, am I out of time, sir?
Thank you, and we'll note you're against HB 4930. Just a second. You're against HB 4930, correct?
Yes, Chair.
Do you have any questions, members? Yes,
I do, Mr.
Representative
Chairman.
Anchia.
Thank you, Mr. Chairman. So what process did the El Paso voters go through to put this on the May 6th ballot?
Thank you, Representative. So this was a citizen-initiated charter amendment. Over 20,000 El Paso voters signed the petition to put this on the ballot.
And the authority already exists in city charter for you to do this, right? To go to initiative and referendum? It's a signature driven process?
Yes, Representative, under the Texas Local Government Code, charter cities like El Paso can do this as long as they don't legislate on issues of state regulatory authority.
And why is it important for El Paso? Can you explain that?
Sure. I want to be clear that this is led by organizers from the El Paso community, especially young people who are concerned about issues like drought. There's extreme water shortages. There have been major flood events. One part of the climate charter would create a disaster response plan. And so basically, they want to make sure their city government is doing everything possible to protect the community and ensure the future for future
I'm
generations.
glad you mentioned drought because we've had a couple of 100-year droughts since I've been in the legislature in my 10 terms. Water availability continues to be a problem. You, in El Paso, you actually legislate at the local level drought mitigation measures, also water conservation measures. Do you not in El Paso?
Exactly. And basically, what the charter amendment would do is regulate some of the activities of the local city water utility. And so it doesn't involve any state authority.
Okay, thank you.
Thanks, sir.
Any other questions, members? Thank you, sir.
Thank you, Chair.
Cyrus Reed. Cyrus, we have you down representing Lone Star Chapter Sierra Club against HB 4930. Is that correct?
That's correct.
Go right ahead.
For the record, Cyrus Reed, Lone Star Chapter of the Sierra Club. Cities in Texas have undertaken a number of efforts to look at both mitigation of climate and extremes climate, and in some cases trying to get a handle on the emissions that cause climate within their city. Some of these cities have done it through resolutions, ordinances like Chairman Anchia, the city of Dallas has done it through a sort of a collaborative process. Other places like El Paso have used citizen charters. We just don't think it's the role of the state to intercede in those cases, especially when, as the previous speaker mentioned, this is really about setting broad city policy goals and not necessarily dictating what individual members within El Paso do. And for that reason, we're opposed. We are also concerned about the first section of the bill, the definition. It's a pretty wide definition. It refers to a climate charter, but it says a charter is anything establishing a comprehensive provision or policy statement that purports to address climate change or the municipality's environmental impact, including water, energy use, and air pollution. We wouldn't want this bill to catch other cities that are doing climate action plans by that definition. If the intent of the bill is only about charter amendments, we think it could be written in a way that's tighter. We're still opposed to the bill, but we are worried about the definition as well. And we're also concerned with the idea that whether it's ultimately the legislature or TCQ, that they have the wherewithal to really assess a climate action plan or a climate charter, given that the state of Texas doesn't have their own climate plan. And really what TCQ does only in terms of climate is grant permits for emissions. They're not really in the business of setting climate policy as cities might do. So for those reasons, we're respectfully opposed to the bill and happy to answer any questions.
Thank you, sir. Note for the record, Representative Dean is present. Representative Turner.
Thank you, Mr. Chairman. So Cyrus, with your comment about the definition section of the bill, and I looked at that too, because it says climate charter means an overarching or comprehensive ordinance, rule, or other policy statement. So in your reading, could that basically capture a resolution or an ordinance, or as well as a charter revision?
I'm not sure it's the intent of Dean Craddock, but I think it could the way it's written. And so if we really wanted to make sure it only applied to charter, I think you would want to refer back to those sections of the local government code that deal specifically with charters. Otherwise, whether it's Arlington, Dallas, Austin, Houston, San Antonio, there have been a number of climate action plans and resiliency plans where a lot of stakeholders have come together, and we don't really want TCQ to be the business of assessing all those, right? So it would be important to tighten up that definition. And again, we're still opposed to the bill no matter what, but if this is the route the legislature chooses to go, we want to make sure that definition is tight.
Okay. And secondly, it calls for approval from the appropriate state agency with proper jurisdiction. Do you know what agency that would be?
I'm assuming it's TCEQ because if you look at the health and safety code, there are some words in there saying TCEQ can address weather impacts, climate impacts, and TCEQ does have delegated authority on air quality permits involving greenhouse gases. So I assume they're the appropriate agency. That being said, they've never taken any action on climate other than those GHGC permits. So back in the day, Susan Combs did some work on, at the comptroller, did a report on climate action, but that's the only other agency I could think of.
Okay, thank you.
And please note, Chairman Metcalf is here. Any other questions, members of this witness? Thank you.
Thank you so much.
Thank you
Appreciate
so
it.
much. Paula Blackman. Paula, we show you're here on behalf of City of Dallas against HB 4930. Is that correct?
That is correct, sir.
Go right ahead.
Good afternoon, Chairman and members of the committee. My name is Paula Blackman, and I'm a City of Dallas council member and the chair of the Environment and Sustainable Committee for the City of Dallas. On behalf of the City of Dallas, I am testifying in opposition to HB 4930. In 2019, the City of Dallas undertook a comprehensive climate action planning process, which we refer to as CCAP. Contrary to popular belief, CCAP is a result of a public-private partnership with over 60 stakeholder groups, including Texoga, Atmos Gas, Encore, the Dallas Regional Chamber, the Federal Reserve Bank, the Real Estate Council, North Texas Council of Governments, TxDOT, TCEQ, Hunt Consolidated, and numerous other social, community, environmental organizations, and they all endorsed this plan. CCAP is a roadmap that outlines the activities that the city will undertake to improve the quality of life for its citizens. Our plan includes adaptation measures, environmental quality enhancements, measures to bring our air and surface water quality into compliance with state and federal criteria that leads to access to additional funding. Environmental changes have cost our cities, businesses, and residents here in Dallas over $380 billion since 1980. We have all heard the word that we must reach net zero by 2050, but this bill would delay and preempt our attempt at the City of Dallas to help the world reach that goal and cost us billions of dollars more in amount of innocent lives cost. Members, I grew up in West Texas, down the street from Mr. Craddock and Snyder. I know what oil and gas is and means to this state. It meant to my family. But this is not a neither or. It is not a neither, but a both. We can be sustainable. We can reach that goal of being a good steward of our environment, but we also can be mindful of the business that we hold in our state.
Thank you. And we're going to note you're against HB 4930.
That is
Representative Anchia.
Hi, Councilwoman. Thanks for being here. It's good to see you. Just want to reiterate, and you tell me if I've got this right, collaborative process, some of the largest and most important employers in the city, the chamber, all participating together, including NGOs and others.
Robust discussion, too.
Robust discussion, right?
Atmos was at the table. Yes.
Oil and gas was at the table, natural gas, pipelines were all at the table. We came up with something that I'm looking at, a letter of support from the Dallas Regional Chamber, from the Texas Real Estate Council, from the AIA, all in support of this. You articulated others in support. Why do we need politicians or bureaucrats from Austin looking over our shoulder and grading our papers?
Well, I hope that we see each other as partners. I don't want this, big brother telling little brother what to do, but more so, how can we work together to have you achieve your goals? We are in severe non-attainment. Dallas is. That is bad when you have an asthmatic son, and I have one. You watch the pollen counts, you watch the red days, and I believe that we should be partners in this, and let's work together to reach our goals and not have a one-size-fits-all. Texas is big. My parents have a different need than I do in Dallas, and I respect that. And I'm hoping that we can come together as partners and find that working relationship as well.
Thanks for being here today and
thank you.
representing our great city.
Thank you.
Any other questions, members? Thank you very much.
Thank you.
Appreciate it.
Appreciate your work you're doing.
Kenneth Flippin. Kenneth Flippin. Kenneth Flippin. We'll note that Kenneth did a registration for the U.S. Green Building Council, Texas chapter and self against HB 4930, but did not testify. Brent Bennett. Brent, we show you've registered for the Texas Public Policy Foundation for HB 4930. Is that correct?
That's correct,
Go
Chairman.
right ahead.
Thank you. Yes, and we have not had a chance to review the committee sub, so I'm just testifying on the filed bill. And mainly our concern with climate charters comes in the area of cities having knock-on effects, particularly in their attempts to reduce emissions. There's a lot of reasons for cities to take actions to mitigate against weather and climate, and we don't oppose that. It's more about what cities have done to reduce emissions. For example, if, say the city of Austin, the city of San Antonio have plans to, have their utilities go to net zero emissions, that has a lot of knock-on effects with the rest of the ERCOT grid, people who consume electricity. So we think it's appropriate that the state has some level of oversight within this and has, there's a process in place to review things like climate charters, climate action plans, and so on. Cities that may, take actions to, for example, in the case of Dallas, they're considering banning gas-powered small engines, right? Lawnmowers and things like that, right? That has effects on the cities around them. So, perhaps the committee sub might be a little more broader that, from what I've heard, the concerns, but those are some of our main concerns, and we think that there needs to be some state oversight of the charters and also the regulations that flow from that to make sure that other cities are not being harmed by the actions that these cities decide to take. Thank you.
There is no substitute. This is just the bill.
Oh, okay. I'm sorry. I thought I heard there was a substitute. Okay.
So your testimony relates to the bill.
To the bill, yes, sir.
Presented. Okay. Thank you, and we'll show that you're for HB 4930. Any questions, members? Thank you very much.
Thank you.
Members, that's all the registrations we have on this bill. Is there anybody else who wishes to speak on for or against the bill? You're going to have to speak to the assistant clerk. Note for the record that Chairman Thompson is present. All right, Rita Beving, we show that you have registered for yourself against HB 4930. Is that correct?
That's correct.
Go right ahead.
Thank you, Chairman Hunter and members. Sorry, I hit the wrong button where it was testify and no testify. As Councilwoman Blackman said from Dallas, in January 2019, the Dallas Council approved the concept of creating a comprehensive climate plan. I was one of the stakeholders on those plans. The Dallas Regional Chamber, the Black Chamber of Commerce, the Dallas Hispanic Chamber of Commerce, Hunt Oil, Encore, AT&T, JP Morgan Chase, the Federal Reserve Bank, architects, developers, the transportation industry, NGOs, medical, and environmental NGOs also participated. The development of the plan had comments made before the plan was made and after the plan was made. Formal community meetings, 200 public events, 1,200 survey responses, 9,400 community suggestions were evaluated, including that of Texoga, the Greater Planning Commission, the ATMOS, and a number of industries. The final draft plan involved more than 35 comments and letters. The plan was approved unanimously in May of 2020. You know, I have concerns about the bill. And Cyrus may have mentioned this, I'm concerned about what the definition of charter is, for this bill. I also have concerns about the TCEQ evaluating these plans. As I understood from talking to someone from TCEQ, they are 400 staffers short and only at around 60% on their staffing. So I don't see where they have the capacity to be able to evaluate these plans.
Thank you. Now, we're going to show that you're against HB 4930.
Correct. Thank you very much.
Representative Dean?
Okay. I'm sorry, Chairman.
No problem.
I'm
Any
waiting
other
for the
questions?
author. Excuse me.
Thank you very much.
Thank you.
Is there anybody else who wants to testify for or against or on? Seeing none, Dean Craddock to close.
Thank you, Mr. Chairman, members. This deal is about pure and simple as this. It stops cities from enacting climate charters which are not deemed necessary by the state of Texas. It allows for an agency, which is TCEQ today, okay, if it continues to exist, with oversight on the charters to assess the need for climate charters in any city or local government. An existing charter, I told you that if you have one, which would be Dallas, I guess has one, is that correct? Sure, yeah. They have to have a vote of the people by 2025, by January 1st. It provides consistency for cities across the state in adopting climate policies, so you don't have a scattering of across the state. And you know, when you talk about TCEQ, we could have a water issue, so it'd be the, say, water board, not TCEQ. The passage of the El Paso, first of all, I didn't bring it up, they did, but the El Paso deal, I've got the studies, the numbers of their studies. In El Paso, they had a complete study done for them. And by the year 2030, the climate charter would result in a loss of 170,000 jobs in El Paso, nearly $8 billion in earnings in the city of El Paso, and just over $28 billion in sales. And by 2045, this is the study, estimates that the charter will cost 198,000 jobs and over $9 billion in earnings, nearly $4 billion in sales. So it's not something, we need to have a statewide type situation on this, not where 10 different cities can have 10 different programs. And that's all this does.
Questions, members? Representative Dean.
Thank you. Thank you, Chairman. Dean, so basically what you're looking at is some way to where, like you said, instead of having a patchwork of different climate charters scattered around the state, we're trying to put in place something whereby the state would actually, or an agency would take a look at a city that's wanting to do said charter. Is that correct?
That's correct.
Okay. I mean, I know there's a lot of bills in the legislature this session regarding, the inability to use natural gas or propane, appliances in homes and things such as that. And so all of those different things, if there is a charter, it would just give some state oversight to say, hey, this is good or it's not good. But if they're able to get the charter, then it has to go before the voters as well.
That's correct, Mr. Dean.
Okay, thank you.
Other questions, members? Representative Anchia.
Dean, you heard all the work we've done in Dallas.
Yeah, I have.
Why do we need anybody from TCEQ saying anything about what we did? And in terms of a patchwork, how do you feel about FERC grading the Railroad Commission's papers just to have consistency throughout the 50 states, making sure everything the Railroad Commission does, we have to run by Washington? This is kind of the same thing.
Well, now, that has nothing to do with the Railroad Commission in Washington. I mean, you're not even talking apples to apples.
Okay.
I'll answer your first question, but the second one it's not relative.
It's the exact same thing, but go ahead.
Okay. So Yeah, I know what you've done in Dallas. Did you have a vote?
We did, of the city council.
No, but did you have a vote of the people? No.
why
And
do
you
we have to
represent
have
a
a vote of the
huge
people?
amount up there, and whatever you do in Dallas, should it not be some type of a standard type being, I think.
The standard is our
okay.
city charter, Dean. That's the standard. That's
I
the governing
think we're
document.
just
And everything was done consistent with the city charter. So why do we need some bureaucrat at TCEQ grading our papers?
I think we need an overall state policy. We just differ in policy.
All right.
Other questions, members? Thank you very
Thank
much.
you very much, Mr.
Dean Craddock, and the chair moves to leave HB 4930 pending at this time. Is there any objection? Hearing none, HB 4930 is left pending. Chair lays out HB 2470 and recognizes Chairman Kemple to explain his bill. And before you start, there is an overflow room now, JHR 130, JHR 130. Go right ahead, Chairman Kemple.
Thank you, Mr. Chairman. 2470 simply prevents employers of first responders from taking adverse employment action against an employee who discloses they are suffering from a mental illness such as PTSD. And Mr. Sanford passed this out last session and just met the demise of so many other House bills. Thank you, Mr. Chairman.
Any questions, members? Thank you. Any witnesses? And we'll let you have the right to close. Chris Jones. Chris Jones. Chris Jones. We will show that Chris registered on behalf of Combined Law Enforcement Associations of Texas, CLEAT, in favor of HB 2470, but did not testify. Charlie Wilkeson. Charlie, we've got you registered on behalf of Combined Law Enforcement Associations of Texas, CLEAT, for HB 2470. Is that correct?
It is.
Go right ahead.
Thank you, Mr. Chairman. Thank you, Chairman Kemple. Appreciate this bill being brought forward, and we're in strong support. I would use an example for PTSD sufferers that comes to mind. These officers can't unsee the things that they witness and the tasks that are called. So I would say at the UT Tower shooting, some of us weren't born, but Houston McCoy was 26 years old, had to borrow the shotgun shells and a shotgun from a hardware store. He went to the top of the tower, was a hero that day. There were a lot of heroes that day. And one officer standing next to him goes on, have a great life, Houston. His sergeant told him to drink a six-pack a day, and that's what he did until the day he passed away. So PTSD is real. We've talked about this bill for many years, and we're in strong support of there not being adverse effect on an officer when they admit that they have problems or issues. Thank you.
Thank you. Any questions, members? Yes, Representative Thompson has a question.
I didn't hardly recognize you with your beard. You look nice. Let me ask you a question. I recognize the fact that officers go through some very traumatic experiences in their course of duty. Do they ever get rotated out to another area or something different where they just don't have to compound those kind of activities in their capacity?
Well, I'm sure that can happen. What we do see and have seen is when an officer admits they have a problem, when they admit that the traumatic event is on that movie that psychiatrists talk about, and they're seeing it over and over, that cities will dismiss them, and they'll be let go and terminated. So this stops the adverse effect of some negative employment issue. So I've not heard of an officer, I guess they could be taken off duty if someone knows something's wrong. Missing work, alcoholism, issues with controlled substance, those are all examples of what happens to officers when they are placed in a traumatic event and don't get help.
And do we have, in the law enforcement, have we built anything in like a sabbatical, where there could be time that they can take off?
Is limited, and generally speaking, if they admit that there's a problem, then there's a fitness for duties that kicks in, and a lot of times they either expend all the time they have personal leave, or they're let go. That's what this bill could help stop.
I mean, I was just interested in exploring whether or not that we ever thought about officers who have experienced these traumatic experiences during the course of their duty, whether or not that we may start thinking about in the future as to how we rotate them out and into other activities and give them a break without taking them out of the employment system.
What we don't want to do is punish them for admitting they have a problem.
No, I'm not saying that I'm going to punish them. I just want to have more opportunities where they can not only seek help, but they can continue to do their duty, but maybe in another capacity of their work. Thank you.
Yes, we're open to any of that.
Thank you.
Any other questions? Thank you very much, Charlie. Please note Chairman Guillen is present. Is there, members, we show no other witness registrations. Is there anybody else who wishes to speak on, for, or against the bill? Chairman Kimball to close.
Thank you, Mr. Chairman. I close.
I'd like to speak in favor of
Well, check with the assistant clerk. Yeah, I said Chair Thompson, yeah.
Chairman, you can give again a couple of bottles.
I apologize, Mr. Chairman. I'm sorry.
All right. We have Joseph McCoy representing yourself for HB 2470. Is that correct?
Correct, sir.
Go right ahead.
Just quick testimony. I was here to testify on others and other bills and heard this one. I'm a licensed psychologist. I practice in the Rio Grande Valley. I work with Border Patrol, veterans, and first responders and law enforcement. And so I'm for anything that helps them get help immediately because there's a lot of us who are able to do things that help get them back in the field quickly. That's all I have to say. Thank you.
Thank you, Joseph. And we're going to show your 4 HB 2470, correct?
Yes, sir.
Any questions? Thank you very much. Now, is there anybody else who wishes to speak on for or against the bill? Chair Kemple to close.
Thank you, Mr. Chairman and members. I close.
Thank you, Chair Kemple. Any questions? Chair moves to leave HB 2470 pending at this time. Is there any objection? Hearing none, HB 2470 is left pending. Chair lays out HB 3289, recognize Representative Anderson to explain his bill. The chair offers committee substitute to HB 3289.
Thank you, Chairman Hunter and members. It's my pleasure to present committee substitute to House Bill 3289. There's been recent concerns. Independent security experts have expressed concerns about intelligence, disinformation, and cybersecurity concerns. And this bill helps codify some of those concerns that both Governor Abbott and the federal government, as well as others, have shown. The substitute House Bill 3289 prohibits the installation or use of a covered application on any device owned or leased by the state agency and requires the removal of covered applications from those devices. There are several exceptions in the legislation for law enforcement that to do their job in law enforcement and public safety. The committee substitute conforms with work that the Department of Information Resources and Department of Public Safety have already done to comply with these directives. Instead of banning TikTok and ByteDance, the bill changes the covered application to prohibited application and changes direct application to application identified by the Department of Information Resources and Department of Public Safety in consultation with the Office of the Governor as a threat to the state-sensitive information and critical infrastructure. The substitute directs DIR and DPS in consultation with the Governor's office to identify social media applications or services that pose a risk to the security of the state agency information or critical infrastructure. The substitute also requires DIR to develop, maintain, and update annually a list of social media services that pose a threat to the state's sensitive information and critical infrastructure, and post that information on the department's website. There's been multiple, the EU, the India, Australia, Canada, Taiwan, many dozen states have all implicated and induced this type of information, and I think it's a timely application for this potential statute, and I believe we do have a resource witness.
Members, any questions for Representative Anderson? Okay, thank you. We'll let you close.
Thank you.
Any witnesses? Okay, now, members, we have no registered, other than the resource witness, affirmations. Does anybody want to hear from the resource? Is there anybody else who wishes to speak on for or against the bill? If not, Chair recognizes Representative Anderson. Close on the bill.
Thank you, Mr. Chairman. Members, I close.
Thank you, Representative Anderson. Chair moves to withdraw the committee substitute to HB 3289. Leave the bill pending at this time. Is there any objection? Hearing none, HB 3289 is left pending. Chair lays out HB 158 and recognizes Representative Noble to explain her bill. Chair offers a committee substitute to HB 158.
Thank you, Mr. Chairman, and members for giving me the opportunity to lay out House Bill 158. I am laying out a committee substitute today. Members, last summer I learned from a teacher in my district that her personal information may have been released by the TEA in response to an open records request. Unfortunately, as a result of her information being made public, she was receiving unwanted text messages and emails on her personal phone and personal email address. Information she was required to provide to our state in order to get her teaching license. When we reached out to TEA, we learned that under the public information law, school districts, as the teacher's employer, are permitted to withhold a teacher's personal information at the request of the teacher. TEA, however, does not have the authority to withhold this information because they are not the teacher's employer. Therefore, this does require a legislative remedy. This bill would clarify that the personal information of an educator held by TEA is confidential and can be withheld from an open records request. Our teachers make sacrifices to educate our students, and we are so grateful for all they do. In order to do their job, they should not have to risk having their personal information being made public by the state of Texas. My bill closes a loophole and protects our teachers' private information. I'm happy to answer any questions and reserve the right to close.
Any questions, members? We'll give you the right to close. We don't show any witness affirmations on this bill. Is there anybody else wish to speak on for or against the bill? If not, Chair recognizes Representative Noble to close on her bill.
I respectfully request passage.
Any questions? Thank you, Representative. The chair moves, withdraw the committee substitute to HB 158 and leave the bill pending at this time. Is there any objection? Hearing none, HB 158 is left pending. Chair lays out HB 4349 and recognizes Representative Noble to explain her bill.
Thank you, Mr. Chairman and committee, for giving me the opportunity to lay out House Bill 4349. The need for intervention by CPS or Adult Protective Service employees can happen any time of the day or night. Therefore, our Department of Family and Protective Services must have intake staff available around the clock. Sadly, these valuable employees are not allowed by law to accrue time off for working state or federal holidays if those work days fall on a weekend. This bill allows statewide intake staff to accrue time off when they work on holidays that fall on weekends, which aligns with other state agency policies such as the Department of Public Safety and the Texas Parks and Wildlife Dispatchers. I'm happy to answer any questions and reserve the right to close.
Members, any questions? Thank you. Have the right to close. Ray Heimel. Ray, we show you registered for Texas Public Employees Association and self for HB 4349. Is that correct?
That's correct, Mr. Chairman. Thank you.
Go right ahead.
Appreciate Representative Noble bringing this issue forward because, like she said, these folks who work for the Department of Protective and Regulatory Services are providing a critical service, just like the folks at the switchboards at the Parks and Wildlife for the DPS. So the Texas Public Employees Association strongly supports this bill and asks your favorable consideration of it.
Thank you, sir. Any questions? Thank you very much. Members, there's no other witness affirmations on this particular bill. Is there anybody else who wishes to speak on for or against the bill? If not, Chair recognizes Representative Noble to close.
Thank you. I respectfully request passage.
Any questions? Thank you very much, Representative. Chair moves to leave HB 4349 pending at this time. Is there any objection? Hearing none, HB 4349 is left pending. Chair lays out HB 1495 and recognizes Chairman Garrett to explain his bill.
Thank you, Chairman and members, for allowing me to lay out House Bill 1495. I'd like to give some background and context to this legislation. Last session, I filed this same bill as HB 1373, which was passed favorably through this committee, and I hope to pass it all the way this session. In recent years, inflation has affected our state's economy tremendously, increasing costs for nearly everyone, including the state. Performing artists like musicians, dancers, and actors have been hit especially hard and are losing their studios, meeting, and performance spaces. Commercial property prices are skyrocketing, as we all know, in many, many communities, and they're simply too expensive for performing artists to afford. This bill seeks to address both of these problems in a two-for-one solution. Lease state property for additional revenue for the state and provide performing artists affordable rental space to keep practicing their art. HB 1495 directs the state to evaluate the feasibility of leasing state property for local and small businesses, or to local and small businesses. Members, I'm happy to answer any questions. Chairman, I respectfully request the right to close.
Thank you. Any questions, members? Thank you. We give you the right to close.
I think as illustrated with...
Well, I got to make sure you don't have any witnesses.
No.
Well, wait a second. So we'll give you the right to close, Chairman. This isn't the resolution.
That's right.
Okay. Is there, we don't show any affirmations. Oh, Representative Raymond, see, has a question.
Oh, of course. Thank you. Richard.
What?
It's been a long day, I'm sorry.
Long? So I'm looking at your fiscal note. Why does it have a $10 million fiscal note on it?
Well, quite frankly...
Oh, wait a minute. I'm looking at the wrong one.
All right. Any other questions, members? All right, we'll give you the right to close. We don't show any witness affirmations. Is there anybody else who would speak on for or against the bill? Seeing none, Chair recognizes Chairman Garrett to close on his bill.
Thank you, Chairman. Thank you, Chairman or Representative Raymond, for your comments. And thank you very much, members.
Call me governor if you want.
Hereby close.
Thank you, Chairman Garrett. The chair moves to leave HB 1495 pending at this time. Is there any objection? Hearing none, HB 1495 is left pending. Chair lays out HB 3130 and recognizes Chairman Garrett to explain his bill. The chair offers a committee substitute to HB 3130. Go right ahead, Chairman.
Thank you, Chairman and members. And without any humor at this point, thank you for allowing me to lay out House Bill 3130. I'd like to give some background and context to this legislation. I filed House Bill 3130 to ensure that survivors of family violence, domestic violence, and sexual assault who hold on occupational license issued by the state agencies have the ability to protect their private information. In fact, this bill is very similar to Representative Noble's bill, with the exception of the following. The state agencies have the authority to sell or provide identifying information for all of their licenses to anyone who requests it. For example, the Executive Council of Physical Therapy and Occupational Therapy examiners sells mailing lists for $165 that includes all of their licenses, full names and address of record. An address of record is a requirement for applying for or renewing a license. The address of record can be the licensee's physical home address, business address, and or mailing address. These lists are typically used by advertising businesses to offer their services to licensees. However, since anyone can purchase these lists, an abuser could buy a list that revealed the address of record of their victim. A staff member of mine who previously worked for a licensing agency I mentioned told me that she spoke with some folks, some survivors directly, and had to tell them that unfortunately her agency did not have the authority or the statutory authority to keep their information private. House Bill 3130 will permit certain state agencies to withhold identifying information of licensees upon request of that licensee if they indicate they are a victim of family violence, domestic violence, or sexual assault. The bill is filed required the individual to be a current or previous client of a family violence shelter, trafficking shelter center, or sexual assault program. The substitute allows anyone to indicate that they are a survivor of these abuses because advocates told us some victims never seek support services, and we did not want to exclude those victims from this safety exception. This legislation is simple, but provides immense protection. Survivors who hold a state occupational license should not have to choose between walking away from their occupation to protect their privacy or exposing their address and possibly themselves to harm. I'm aware that a minimal fiscal cost is attached to this bill. It's a small amount compared to our tremendous budget. I believe that protecting survivors' identities and giving them the peace and mind they so deserve is worth the price tag. Members, I'm happy to answer any questions, including Chairman Raymond's. Chairman, I respectfully request the right to close.
Any questions? Thank you, Chairman. We'll give you the right to close. Joseph McCoy. Joseph, we show you registered for Texas Psychological Association and Self for HB 3130. Is that correct?
Correct, yes.
Go right ahead.
Yes, I'm a licensed psychologist, and as I said before, I practice in the Rio Grande Valley in Representative Guerra's area. I've had many victims of violence who have had issue with this and have many colleagues who have issues with this as part of why they're in the profession, and I think protecting their personal information is very necessary. Thank you.
Thank you. Any questions, members? Thank you very much. And again, we have a resource if anybody would like to call the resource. We show no other witness affirmations. Is there anybody else who wishes to speak on for or against the bill? If not, Chair recognizes Chairman Guerra to close on the bill.
Thank you very much, members and Chairman Raymond. And with that, I close.
Any questions? Thank you, Chairman Guerra. The chair moves to withdraw the committee substitute to HB 3130. Leave the bill pending at this time. Is there any objection? Hearing none, HB 3130 is left pending. Chair lays out HB 3730 and recognizes Representative Wilson. Chair Wilson explains bill. Chair offers committee substitute to HB 3730.
Thank you, Chairman, members. Committee substitute for House Bill 3730 simply adds agency email addresses to the existing centralized Capitol Complex directory. I'm available for questions.
Any questions, members?
Not after that action, please.
That's correct. Well, we'll give you the right to close. We show no witness affirmations, registrations, or anybody else who wishes to speak on for or against the bill. If not, Chair recognizes Chairman Wilson to close on his bill.
Thank you. Your staff is going to love it. I close.
Any questions? Thank you, Chair. The chair moves to withdraw committee substitute HB 3730. Leave the bill pending at this time. Is there any objection? Hearing none, HB 3730 is left pending. Chair lays out HB 3167. Recognizes Chairman Moody explain his bill.
Thank you, Mr. Chairman and members. Appreciate the opportunity to lay out House Bill 3167. We all get Public Information Act requests and have all had some exposure to ways that open records requests can be weaponized by people who have no actual interest in the public information and just want to harass other people. It doesn't happen often, but there are vexatious requesters out there who abuse our system in ways that can grind government operations down to a halt. Of course, it's one of those things where you might know it when you see it, but you have a hard time coming up with a way to capture it that protects the innocent while punishing the guilty. That's something I've been working with stakeholders on, and I'm going to have New language for you, not here today, but very soon. While the filed bill creates a new process for designating and dealing with vexatious requesters, what I expect to bring you in short order is something that uses existing processes to stop certain abusive tactics, like making anonymous requests to evade the hours threshold that government can set, or making numerous broad requests without paying for anything. So I'd encourage you not to worry about the specific language in front of you and just focus on the concept itself. I do have some witnesses here that'll be able to help explain the real world ins and outs of this, so I'll let them explain those issues, but I'm happy to answer any questions. If there aren't any, I would request the opportunity to close at the end of testimony.
Thank you, Chair Moody. Any questions? Thank you. We give the right to close. Ronnie Wall. Ronnie, we show you've registered for Texas Tech University System neutral on 3167. Is that correct?
That's correct.
Go right ahead.
Chairman and committee, just briefly want to touch on mostly the bill that we've been working with the stakeholders on. We expect it to be a replacement bill soon. And what we're doing here is the Public Information Act provides a 36-hour limit per month, or a 15-hour limit per, 15 hours per month or 36 hours per year to view documents and request documents, and we have to provide those if they're asking to view, for the most part, for free. And so they're able to access a lot of documents under this time limit. What we have seen happen is that occasionally we have a requester who submits requests who has already reached their time limit, and then they continue to submit requests either anonymously or under a pseudonym. And so what this would do is it would close that loophole so that once they have reached their time limit, we would be able to ask them for identification, photo identification, to determine whether they are in fact that same requester trying to circumvent that time limit. So it's an attempt to close that loophole and save taxpayer resources.
Thank you, sir. Any questions? Thank you very much.
Thank you.
Jack Finger. Jack, we show that you have registered for yourself against 3167. Is that correct?
That's correct, sir.
Go right ahead.
Well, Mr. Chair and other members of the committee, my name is Jack Finger. I'm from San Antonio. Well, it seems that one person's vexatious, just a minute, I got caught up with something here. One person's vexatious requester could be another legitimate parent trying to get legitimate information from a school district. No, information such as curriculum, books, administration, policies, et cetera, et cetera. I don't think if also the Attorney General could prosecute such a person or hold them accountable, so-called accountable, without even a trial. No, I think this is really a pig in a poke here. A legitimate parent trying to get legitimate information from a government entity should have that right. And if a school district or some government district needs to charge them appropriately, well, fine. But they shouldn't be placing onerous restrictions on them. If the government entity doesn't like it, well, my question is, what are they trying to hide? No, this is not a legitimate request, and it needs to be scotched. Thank you.
Thank you, and we'll show that you are against HB 3167, correct?
Correct.
Any questions? Thank you very much. Paula Hilliard. Paula Hilliard. Paula Hilliard. Will show that Paula registered for Texas Education 911 and self against HB 3167, but did not testify. Kelly Shannon. Kelly, we show you're with the Freedom of Information Foundation of Texas against HB 3167. Is that correct?
Yes, that's
Go
correct.
right ahead.
Hi there. I'm Executive Director of the Freedom of Information Foundation of Texas, and I'm respectfully testifying against House Bill 3167 as filed. We oppose the bill as filed for various reasons, but to sum it up, as it tries to get at vexatious requesters, it can also have the impact of trampling on the rights of legitimate requesters who are well-meaning and just trying to get information. So that said, we are working with Chairman Moody and other stakeholders to try to come up with a new version of the bill that we think will be much more narrowly focused and addressing the very specific issue that it tries to get to. But I would like to point out that we do have existing law already that gets at this problem in large part, and it was put into place in 2007 and then updated in 2017 with lots of us stakeholders being very involved in it. It's a part of the Texas Public Information Act. It is in section 552.275, provides a government that the government has a tool where it can do time limits, as Ronnie Wall mentioned, I believe earlier, and those are monthly and yearly time limits already in the law, and there also are some payment for records provisions that are already in the law. So we realize some governments aren't even aware of this provision or may not be using it to the fullest extent that they could. So if we need to tweak or update or clarify that part of the law, that's probably the direction to go. With all that said, I just have to take the opportunity to point out that this year is the 50th anniversary of our Texas Public Information Act. And it's a very important law. And even though it's been chipped away at through the years, it still is widely regarded as one of the strongest in the country. And that's something for all of us in this room to be very proud of. And we need to uphold the integrity of this very important law. Thank you.
Thank you, Kelly. And we'll show you're against HB 3167. Any questions? Thank you. Members, that shows all the affirmations, registrations we have. Is there anybody else who wishes to speak on, for, or against the bill? We'll allow Chair Moody to close.
Thank you, Mr. Chairman. I do want to thank Kelly at the Freedom of Information Foundation. They've been partners of mine on multiple other pieces of legislation, and they've been willing to sit down and kind of grind through the details of this. Because what she said in her close is correct. We need to be very careful when we tinker with this statute. It's been chipped away at significantly over the years. And so if there's legitimate issues to address, which I think there are, and that's why I said focus on the concept, we have new language coming for you and hope to have that to you shortly. But I'm grateful for everybody who's a stakeholder in the conversation to be willing to have an open, honest dialogue about a very challenging subject matter. I close.
Thank you, Chairman. Any questions? Thank you very much. Chair moves to leave HB 3167 pending at this time. Is there any objection? Hearing none, HB 3167 is left pending. Chair lays out HB 5260 and recognize Representative Baumgartner to explain his bill. Representative, go right ahead.
Go get it. Well, thank you. I appreciate that. Thank you, Mr. Chairman, members of the committee. I'm here to lay out House Bill 5260, which seeks to clean up and harmonize language in the government code regarding the Office of Vehicle and Fleet Management's annual management plan and allow the office more flexibility when developing the plan. The Office of Vehicle and Fleet Management, OVFM, within the Comptroller's Office, develops an annual management plan with recommendations for improving the administration and operation of the state's fleet of vehicles. Last session, the legislature passed House Bill 3388 to exempt state agencies with more than 2,500 vehicles from using the Office of Vehicle and Fleet Management reporting systems, allowing those agencies to maintain their own reporting systems. The agencies with more than 2,500 vehicles are TxDOT, DPS, TP, WD, and TDCJ. Although these four agencies are no longer required to participate in the Office of Vehicle and Fleet Management reporting system, the four agencies are still statutorily required to assist the Office of Vehicle and Fleet Management with the development of the annual fleet management plan. So basically what this bill does, it repeals section 2171.104 subsection B of the government code that requires the four agencies that I mentioned from being required to assist the Office of Fleet Management to develop the annual management plan. And basically it's solves in waste and basically reduces what they do so they can do other meaningful things for the state. So with that, I'll sit here and answer questions. I think I have a resource witness, and I reserve my right to close.
Any questions, members? Thank you, sir. We'll give you the right to close.
Thank you.
Does anybody want to hear from the resource witness? There are no other witness affirmations. Anybody else who wants to speak on for or against the bill? Not, Chair recognizes Representative Baumgartner to close on this bill.
Thank y'all. I close.
Thank you, Representative. The chair moves to leave HB 5260 pending at this time. Is there any objection? Hearing none, HB 5260 is left pending. Chair lays out HB 818, recognizes Representative Wally explain his bill.
Thank you, Chairman Hunter and members. Allow me the opportunity to lay out HB 818. I don't think any of you would want to eat a prepared meal in a bathroom. With that in mind, does it make sense for a mom to pump and handle breast milk in a bathroom? HB 818 prohibits employers from using single-user restrooms as an acceptable place for employees to pump breast milk. In 2015, in the 84th session, we passed a bill allowing public employees to have reasonable accommodations to express breast milk in the workplace. Unfortunately, an amendment was added toward the end of the 84th session, permitting single-user bathrooms to be utilized for expressing breast milk. Keeping moms from having to pump in the bathrooms was one of the original reasons for first filing the bill in the 83rd session. It is important for breastfeeding mothers to be able to express milk in a safe, clean space. Members, after all, if you wouldn't prepare your lunch in a bathroom, then a mother shouldn't have to feed her breast milk that was pumped in a bathroom. Chairman Hunter, this is probably a couple times I've come to this committee. Hopefully, y'all have been very good about getting this bill out. We're obviously always having difficulty with the other chamber, but respectfully would request the right to close and would we gladly answer any questions that the committee members may have.
Thank you. Any questions, members? Thank you, and we'll give you the right to close.
Thank you.
Ray Heimel. Ray, we show you registered for the Texas Public Employees Association and self for HB 818. Is that correct?
That's correct, Mr.
Go right
Chairman.
ahead.
Just a brief statement that TPEA endorses this bill, and thanks, Mr. Wally, for bringing it forward. Remember that your workforce is not highly paid, and so the benefits are very, very valuable to employees. And this would be one benefit that with a workforce that is well over 50% female, and I think you would have to say this is a valuable benefit to your workforce. So and that is about all I need to say on that.
Thank you, sir. Any questions? Thank you very much. Okay. Amanda Ponson. Amanda, we have you registered for Every Texan and Self for HB 818. Is that correct?
That's correct.
Go right ahead.
Good afternoon. My name is Amanda Posson. I am registering in favor on behalf of every Texan. And personally, as a mother, my most important job. And we're very grateful to Representative Wally for being a staunch advocate on this issue. As the representative said, mothers should have a private and clean space to express breast milk other than a bathroom. This is beyond being a benefit. This is an absolute necessity for women in the modern workplace. The National Institute of Health research continues to support that clean private spaces to express breast milk leads to better outcomes for moms and the babies. Additionally, research supports that this makes workplaces stronger as well. The Harvard Business Review commissioned a study showing that if women feel it's an inconvenience to express breast milk at work, they have lower rates of keeping up with breastfeeding, and this has a negative impact on their children. It also has a negative impact on their productivity at work. So businesses and public sector employers benefit from providing safe, clean spaces for women to express milk. Finally, in closing, we all know how rapidly eroding the state workforce is and what a crisis level it is. Every Texan, the state auditor's office, TSEU have continued to provide research showing how crisis level our erosion is, and this is just one absolutely necessary benefit we need to have to retain women in the workforce. That's it. Thank you.
Thank you very much, Amanda. Any questions? Thank you very much. Members, that's the last witness registration. Is there anybody else who wishes to speak on for or against the bill? If not, Chair recognizes Representative Wally to close.
Thank you, Mr. Chairman. I close.
Thank you, Representative. The chair moves to leave HB 818 pending at this time. Is there any objection? Hearing none, HB 818 is left pending. Chair lays out HB 4579. Recognize Representative Wally explain his bill. Chair offers a committee substitute to HB 4579.
Thank you, Mr. Chairman. The committee substitute for this bill is updated to give us a ledge council draft. The changes made were not substantive, but just including new language required by the Comptroller's Office. So this bill and its substitute would allow select state agencies the ability to compensate certain employees twice per month. These agencies include the Texas Department of Transportation, the Texas Department of Human Services, the Texas Workforce Commission, and the Department of Public Safety, and other agencies at the discretion of the controller, or comptroller, apologize. Currently, the state statute limits state employees from being compensated more than once per month. This limitation is a challenge for state agencies trying to fill and retain certain positions, especially when hiring entry-level employees. Statute requires employees in classified positions who are at or above the A12 salary group under Schedule A, which ranges from an annual salary of $27,840 to $43,798, to be compensated once a month, while employees below the A12 salary group may be compensated twice per month. So many prospective state employees entering state agency professions for the first time may be more accustomed to a bi-monthly payment schedule. With workforce shortages across the state, we must do everything we can to stay competitive in the hiring process. House Bill 4579 aims to better attract and accommodate state employees by expanding the salary classifications of employees eligible for compensation twice per month. With that, Mr. Chairman, respectfully reserve.
Thank you, Representative. Any questions for the representative? Now we'll give you the right to close. Ray Heimel. Ray, we show you registered for Texas Public Employees Association self for HB 4579. Is that correct?
That's correct, Mr. Chairman. Thank you. The Texas Public Employees Association strongly supports and appreciates this bill, and reminds you that the state auditor in consecutive years has reported a total turnover in excess of 20%. But for the positions that are envisioned in this bill, that turnover is often well over 30%. So this is just one more means of attracting and retaining your valuable state workforce and bringing folks into the workforce at a time when you've seen such erosion in employees. So we do ask you your favorable consideration of this bill.
Thank you, Ray. Any questions? Thank you very much. Members, we have a resource from TxDOT. Any questions from them? If not, is there anybody else who wishes to speak on for or against the bill? If not, recognized as Representative Wally to close.
Thank you, Mr. Chairman. I close.
Chair moves to withdraw the committee substitute to HB 4579 and leave the bill pending at this time. Is there any objection? Hearing none, HB 4579 is left pending. Chair lays out HB 4012 and recognizes Representative Kitzman to explain his bill.
Good afternoon, and Chairman Hunter and members of the committee. Thank you for allowing me to lay out House Bill 4012. The Comptroller's Office operates the Electronic State Business Daily, or ESBD, for state agencies to advertise pre-solicitation notices, solicitations, and pass notices of awards where public solicitation was not required. This legislation repeals language that references the outdated practice of state agencies waiting for the Comptroller to compile notices and advertisements in order to publish a business daily. The Comptroller's Office has made the process for advertising on the ESBD more efficient by allowing agencies to self-publish, update their advertisements in real time through the solicitation process, extend postings, and publish awards. This bill amends the existing statute to reflect an updated system that allows agencies to manage their notices and advertisements on their own. Additionally, the bill removes the ability for entities to recover cost or charge a fee for providing access to the ESBD to businesses who do not have the technical means to access the system. House Bill 4012 seeks to modernize the language of the government code to reflect these technological improvements that allow agencies to manage their notices and advertisements independently. There's an expert witness from the Comptroller's Office that may answer any questions. I'll answer any questions that you may have. I thank you for allowing me to be here today and would like to have an opportunity to close.
Thank you, Representative. Any questions? Thank you, sir. Any questions from the resource members? There's no other witness affirmations, members. Is there anybody else who wishes to speak on for or against the bill? Not, Chair recognizes Representative Kitzman to close on the bill.
Thank you, Mr. Chairman and members. I ask for your kind consideration of our bill. With that, I close.
Thank you, sir. The chair moves leave HB 4012 pending at this time. Is there any objection? Hearing none, HB 4012 is left pending. Chair lays out HCR 71 and recognizes Representative Gonzalez to explain a resolution.
Thank you, Chairman, members, for giving me the opportunity to lay out House Concurrent Resolution 71. Texas State Representative Irma Rangel was the first Mexican-American woman elected to the Texas legislature. Elected in 1976, Representative Rangel served her South Texas district for 26 years. Representative Rangel dedicated her life to public service and left a lasting legacy of advocacy and leadership. She fought tirelessly for the rights of Texas children, women, and students. Representative Rangel was the primary sponsor of the bill that gave high school students in the top 10% of their graduating class automatic admission to the state's public universities. Additionally, she helped create centers for victims of domestic violence and expanded educational and employment programs for mothers with dependent children. HCR 71 directs the Texas Facilities Commission to name the building being constructed in Phase 2 of the Texas Capitol Complex Master Plan at the northwest corner of Congress and 15th Street, the Irma Rangel Building. Representative Irma Rangel left a legacy that continues to inspire many to this day. The naming of this state building in her honor would be fitting to tribute to a trailblazer who opened avenues of advancement for all Texans. I am honored to have former Texas State Senator Leticia Van de Putte to testify in favor of this resolution. And unless there are questions for me, I reserve the right to close.
Any questions, members? Thank you. We'll give you the right to close. Leticia Van de Putte. Leticia, Representative Senator we show you registered on behalf of yourself for HCR 71, correct? Is that
Yes, sir.
correct? Thank you. Go right ahead.
Yes, sir. Mr. Chairman, members, my name is Leticia Vandepute, and housebroken, and then on to the Texas Senate. But I'm here today as a personal friend to the late, great Irma Rangel. I first met Irma Rangel in the early 1980s. She was already then an amazing woman and a trailblazer for women, for Mexican Americans, but for Tejanos. Her family roots go back 300 years. And I was friends with her sister, Minnie Henderson, who owned a small pharmacy in Kingsville, Texas. In 1982, my dream was to own my own pharmacy. And there weren't many women owners of independent pharmacies back then, and certainly not ones that operated their pharmacies in what we would classify now as medical deserts. Minnie Henderson, Irma's sister, was my pharmacy mentor. I knew very well how to order, the clinical stuff, but how to own a business, when to order things. So Minnie became my friend, and because we came here to lobby on Texas Pharmacy Day, I met wonderful Irma Rangel. From the moment she saw you, you were mijita or baby. And for those of you that served with her, you know her integrity, her word was her bond, and her strive for the education of children was unsurpassed. I was proud then in 1991 to take that first oath of office where her sister Minnie Henderson was here and walked me from my desk over to Irma's desk and said, you know Leticia from San Antonio, okay, here with all of my kids, right? I've done as much with her as I can. She's yours now. Irma became my mentor, and I'm here today because she blazed the trail for so many of us.
Thank you.
Thank you very
We're going
much.
to note, it's good to see you, and we're going to note for the record, you're for HCR 71.
Yes, sir.
She was a very good friend. I served with her, and I'm glad that you're here.
Thank you, Mr. Chairman, and thank you, members, for your time. This would be a great honor for her and her family, but for all of us. Thank you.
It's great seeing you.
Thank you.
Sean Hall, and then it's Lecuona. Now, Sean, we show you, and I'm going to have to spell it, Kriahb, and then SHALOM, and self, against HCR 71. Is that correct?
Yes,
Go right ahead.
I'll pronounce it for you. It's Kriah Shalom. Thank you. Conscious of the rectitude of our intentions, worshiping Almighty, the glory of the true and living God. Chair Hunter, Representative Gonzalez, and the House State Affairs Committee of the 88th Texas Legislature. I stand against HCR 71. This is Texas Constitution and the established. God gave, remembered my covenant. God have remembered my covenant. 200 years ago, on this date, the War of the Revolution began at Lexington and Concord near Boston in Massachusetts. Jesus Christ, the same yesterday and today and forever. Almighty was there keeping covenant with this land, loving all parties. Present then as he is now, worthy to be honored with his name on the building being constructed in Phase 2 of the Texas Capitol Complex Master Plan at the northwest corner of Congress Avenue and 15th Street, along with the 3 other buildings named after the esteemed representative of this legislature, former legislature. It was him, supreme arbiter of the destinies of nations, whose light and blood in California gave peace order, having already established covenant. This is Texas, Constitution, and the established. God have remembered my covenant. He who sits on the throne said, behold, I am making all things new. He said, write, for these words of God are faithful and true. This is a new time, having a working knowledge of the Ark of the Covenant. Don't remember the former things and don't consider the things of old. Publius coming into divine health. No one is good but one, that is God. But even if you want to enter into life, keep the commandments.
Thank you very much. Sean, any questions? Thank you very much. Members, that's all the other affirmations we have. Is there anybody else who wish to speak on for or against the bill? If not, Chair recognizes Representative Gonzalez to close.
Thank you, Chairman, members. HCR 71 honors pioneering lawmaker Irma Rangel, who left an incredible imprint on the state of Texas. She was the first Mexican-American woman elected to the Texas legislature. And now, 20 years later, MALC has 17 Latinas serving in the Texas House, the most ever. I would respectfully ask for your favorable consideration, and if there are no questions, I will close.
Thank you very much. Seeing no questions. Thank you very much. Representative, the chair moves to leave HCR 71 pending at this time. Is there any objection? Hearing in HCR is left pending. Chair lays out HB 2858, recognizes Representative Morales-Shaw to explain her bill.
Thank you, Chairman Hunter, Vice Chairman Hernandez, and committee members for giving me the opportunity to lay out 2858. This is a bill about inclusion for people with disabilities in disaster planning. This bill was brought to me by the Disability Rights Texas because people with disabilities are disproportionately negatively impacted when disasters strike, and they suffer far worse consequences than every other person during a disaster. And also because there's currently no inclusive disaster planning process that has adequate measures to address their needs during and after a disaster. A couple of striking statistics that I came across: 59% of people that are deaf never return to their home after an evacuation. And for people with disabilities, permanent evacuation often leads to unfair institutionalization. So currently, under Article 2 of the ADA, the Americans with Disabilities Act, states and local governments are obligated to comply and ensure meaningful access to emergency and disaster programs. And as of right now, we have failed to meet that obligation. Department, agency, and local disaster plans that you're probably familiar with, they're called Emergency Operation Plans, or EOPs. They define the coordination of emergency resources. And this bill, 2858, helps those boards that plan EOPs to make sure that they provide meaningful access for people with disabilities by planning with them and not just for them. During and after a disaster, critical resources have to be factored in, but also people with disabilities have to be factored in. Besides the basics like food and water, utilities, communications, transportation, and responses to hazardous materials, HB 2858 will ensure continuity of care and sheltering operations, wellness checks integrated into EOPs, accessible delivery and inclusion content of messaging, and integration of preparedness plans by licensed facilities and providers. So I think that pretty much lays out, I've got a lot more details, but I think you get the gist of it. There's no fiscal note, and I'm available for questions if any members have any questions for clarification.
Members, any questions? Now we'll give you the right to close.
Thank you, Chairman.
Stephanie Duke. Stephanie, we show you've registered for Disability Rights Texas for HB 2858. Is that correct?
Yes, sir.
Go right ahead.
Thank you, Chairman. Thank you, members of the committee. My name is Stephanie Duke. I'm an attorney and a disaster resilience coordinator at Disability Rights Texas. And I am here in support of HB 2858, a bill that deals with disaster preparedness. What I can tell you is that from my work in helping disaster survivors is that we will never be able to 100% truly mitigate all the injury and harm after an event, because if we did, it wouldn't meet the definition of a disaster emergency. We get that the lights are going to go out. The power is going to go down. that critical services are going to be disrupted, but what we can do is do a better job in preparing, planning, and educating the community. Vulnerable populations are at risk, substantial risk, and suffer because they are unprepared and cannot prepare like we do. So I'd like to be able to tell my clients that for someone who's integrated in the community and at home on a ventilator, that they're not going to have to sit in the dark for 4 days before somebody may come and check on them. Or if I have a client in a fixed frame wheelchair, they would like to be able to go to an emergency sheltering operation, but because there's not a continuity of care, if they soil themselves, they may have to sit in fecal matter for 4 days. These are scenarios, and it's just, you know, the tip of the iceberg, that we can do a better job in preparing and giving people choices and options and what they need to know and how to prepare for those events. And it's the reality in which we live, whether it's a man-made disaster, a natural disaster, or a public health emergency. We have to do a better job in preparedness. This bill proposes that the Department of State of Health Services, already that provides education for disaster preparedness, is inclusive of the disability-related needs. It asks that Texas Department of Emergency Management, the model guide that they already provide to local jurisdictions, provides best practices and guidance on how to establish that inclusive planning process. And also at the local level, there's an inclusive planning standard.
Thank you, and we're going to note you're for HB 2858, correct?
Yes, sir.
Any questions? Thank you. Brennan Griffin. Brennan, we show you've registered for Texas Appleseed for HB 2858. Is that correct?
That's correct.
Go right ahead.
Thank you, committee and chair. My name is Brennan Griffin. I'm with Texas Appleseed. We are a nonprofit organization dedicated to changing unjust laws and supporting policies that are data-driven, safe, and efficient. We have worked with survivors after Katrina, after Hurricane Ike, after Hurricane Harvey. We've survivors of Winter Storm Uri, and we've just seen so many instances where just better planning on the part of cities, agencies, medical providers could have prevented enormous harm for people with disabilities. And so we just think that this is a very simple fix that will help, that won't cost extra money, that should be fairly easy to do, that could be really impactful in the long term by requiring cities, or not even requiring, but working with cities and municipalities and counties to update their planning procedures and making sure that they're taking advantage of the opportunities to reach out to people with disabilities. It doesn't help someone who is visually impaired to get a text message if they don't have the right accessible device to see a text message about evacuation. If someone has a medical device that requires electricity, they need to know for certain that they are going to have electricity when they're returning home. These are the kinds of things that if the electricity provider knows to plan for in advance, they can actually accomplish. And these plans are already required and already in place in many cases and need to just be updated and improved to include people with disabilities in many more respects. And so I won't belabor the point, but I really think this is a great bill, and we hope that the committee will pass it forward. Thank you.
Thank you, sir. Any questions? Thank you very much. Members, we don't have any other registrations. Is there anybody else who wishes to speak on for or against the bill? If not, you're recognized as Representative Morales-Shaw to close on the bill.
Chairman and committee members, thank you again. If you don't have any other questions, then I just ask for favorable consideration.
Thank you very much. Representative, the chair moves to leave HB 2858 pending at this time. Is there any objection? Hearing none, HB 2858 is left pending. Chair lays out HB 2474 and recognizes Representative Smithy to explain his bill.
Thank you, Mr. Chairman. I'll do this quickly as possible, just kind of explain what the bill is about. First of all, I've been working with many, if not most, of the kind of people interested in this bill and trying to work out some consensus. It's not a bill that I really want to try to pass unless we do reach a consensus. In talking to them this week, in view of our fairly long hearing this week, I think most of them are going to defer testimony and continue working on the bill. But I'll tell you briefly what it does, and there's really no agenda here other than to try to bring some certainty to the law. You know, in Texas, we have very well-defined laws regarding oil and gas rights and also water rights. We know that the mineral interest is severable from the surface interest. In other words, a surface owner who owns the minerals can reserve those rights when he or she transfers the surface. And then the owner of the mineral interest can lease those rights to a lessee, and the lessee obtains what in Texas courts refer to as a determinable fee estate for the life of the lease. Water is treated roughly the same way, groundwater rights. What we don't know and what we've never defined are wind rights, and whether the right to construct wind turbines on the surface of property is a severable estate, or it's just incident to ownership of the surface. And to put it in fairly simple terms, the problem that's created is we're seeing deeds of wind rights and we're seeing leases of wind rights. And so when you're examining a title out in those areas where you have wind production, nobody knows really if there's title or a right to put the wind turbine up, and it's going to become an impediment. So we've done, you know, the wind, we've had serious wind development for 20 years here in Texas. It's been about 15 years since we did the CREZ lines, and that was kind of the wind boom that occurred in Texas. And there's a lot of uncertainty. So far, the courts have not weighed in on the issue, and I suspect they're kind of waiting for the legislature to do something. So we basically have two options here. We can either go declare it to be a severable estate, severable from the surface, or else it can be incident to surface. Whoever owns the surface owns the right to lease for wind. And two things, I mean, one thing I'd like not to do is affect any prior deals. I don't want to try to judge the validity or invalidity of anything that's already been entered into. That's going to be up to the courts. This is just perspective going forward. So I'll be glad to address any questions. I don't know if there are any witnesses on it or not. But.
Any questions, members? Thanks. We'll give you the right to close. John Gordon. John, we have you registered for yourself or HB 2474. Is that correct?
That is correct.
Go right ahead.
Representative Smithy, it is needed, and I recommend that y'all proceed as best you can and get as much agreement and then get it into law quickly.
Yeah. Thank you.
Thank you, John. Any questions? Anybody else? That's all members of the witness registrations we have. Is there anybody else who would speak on for or against the bill? If not, Chair recognizes Representative Smithy to close.
And thank you, Mr. Chair. As I said, I'll continue trying to work together kind of a consensus of the stakeholders, and I won't bring a bill to the chair unless there is a reasonable, substantial consensus on how this should be handled. So with that, I'll close.
Thank you, Representative. The chair moves to leave HB 2474 pending at this time. Is there any objection? Hearing none, HB 2474 is left pending. Chair lays out HB 558 and recognizes Representative Raymond to explain his bill.
Thank you, Mr. Chairman, members. I'm going to be brief on this and just say that members of Veterans of Foreign Wars of Texas is an organization of U.S. war veterans who fought in wars, campaigns, and expeditions on foreign land, waters, or airspace. We have more than 68,000 members in Texas. And I'm going to jump down to what this bill does. It amends the Emergency Management Government Code to provide an exception for 501c19 nonprofit organizations that benefit U.S. veterans that sell alcoholic beverages from being included in executive orders that restrict hours of operations. And so the short version, members, is that during the pandemic, as you all know, the governor did a bunch of things. And one of the things he did is shut down VFWs. And we have so many veterans, and certainly in Laredo, that that really gather at VFWs for their own health. Yeah, they go get a couple of beers, drinks, whatever, but it's really about getting together and trying to give these folks a chance to, you know, not be depressed and other things that come with having been in battle. So this bill, which I really hope we pass, will make sure that in the future we have a pandemic, they're excluded from being shut down by the governor. With that, if one has questions, I'd be glad to answer. I think we may have one witness or two, maybe one.
Representative Slauson.
I appreciate you bringing this bill. This is an issue I've heard about from a number of constituents in my part of the state that's right around Fort Hood. It affected a lot of our veterans there. Do you have a joint author spot?
Absolutely, and it was veterans in Laredo who asked me to do this, and I know that veterans all over the state support it, and we'll hear that in a minute, but absolutely.
Thank you.
Any other questions, members? I'll let you have the right to close. On testimony, Mitch Fuller. Mitch, we have you registered for Veterans of Foreign Wars, Department of Texas and South, 4HB 558. Is that correct?
That's correct, Mr. Chairman.
Go right ahead.
Thank you very much, Mr. Chairman. Thank you very much, Representative Raymond, for introducing this bill. We didn't ask you to do this, but thank you.
Well, some guys back home did.
We did, yeah. So somebody from the VFW did, so we appreciate it. This is the absolute exact bill that was introduced in the 2021 session. It's exactly what Senate Bill 1493 was. That got a hearing, but never got a vote. And it remains a mystery to us to this day why it never got a vote out of Senate Business and Commerce in the last session. We did get a hearing. So on behalf of all of us in the Texas VFW, our 283 posts, our 60,000 members, our 20,000 members of our auxiliary, we thank you for this and we fully support this. We were treated, we were a loser in the winner and loser choice when the pandemic hit. The final straw for us in that whole what's essential, what's non-essential debate that we all remember from the summer of 2020, the final straw for us was when strip clubs are able to open because they converted to a restaurant. So we got caught up in between what's a bar, what's a restaurant. We don't consider our posts who possess a TABC license to be a bar. We frankly, we're absolutely against that. And so the challenge that we had was dealing with the choices that were made. And so we were barred from entering our post, to your point, Representative Raymond. We were barred from entering our post. Those are second homes to our members, and we served our communities for over 100 years throughout. All of you have a VFW post, at least one, in your district, and we consider that all of our posts to be key parts of our community. We were founded over 100 years ago. We have served our community with distinction for over a century. We are proud to be in our communities, and we hope this never happens again. But if it does, we want to be exempt from that because that had a bad impact on our community. So we fully support this. Representative Raymond, thank you so much for all you do, all of you for all you do for Texas veterans and their families. Thank you.
Thank you, Mitch. Thank you very much. Any questions? Thank you, sir.
Thank you very much.
Members, we don't have any other witness registrations. Is there anybody else who wishes to speak on for or against the bill? Not, Chair recognizes Representative Raymond to close.
Thank you, Mr. Chairman. Members, I hope we can vote this out unanimously, send it to local and consent as soon as the chairman says it's time for it to go, which I hope is very soon. I close.
Thank you, Representative Raymond. The chair moves leave HB 558 pending at this time. Is there any objection? Hearing none, HB 558 is left pending. The chair lays out HB 876 and recognizes Representative Raymond to explain his bill.
Thank you, Mr. Chairman. Members, believe it or not, members, just a couple of years ago, we were in the United States imported over 9 million American flags from another country. It starts with the letter C. And so what this bill does, it's a very simple bill. It says when a state agency purchases a U.S. or Texas flag, it must give first preference to purchasing flags that are grown, produced, or manufactured in Texas. Second preference to flags grown, produced, and manufactured in the other 49 states. There are hundreds of small businesses across the country that would benefit from our leadership. The United States Congress is trying to do at the national level what we're proposing to do with this bill. Right now, there are 50, the U.S. flags, U.S. government can only buy flags that have at least 50% American, that are at least 50% American made. Again, this asks that we give a preference to that, to it being made here in Texas first, then the United States, and then China, in that order. Members, any questions?
Any questions, members? If not, we'll give you the right to close. We have no witness affirmations. Is there anybody else wish to speak on for or against the bill? If not, Chair recognizes Representative Raymond to close on the bill.
Thank you, Mr. Chairman, members. It's important. I just mentioned veterans, and they fought for that flag. We ought to make sure that that flag, I'll tell you where it really came home is we have a very, very big event in Laredo every year called the Washington Birthday Celebration. Chairman Anchia has been there, probably others have. And we do, the most significant event we have is we do an abrazo, which is a hug ceremony at the middle of the International Bridge. U.S. officials, Mexican officials, and we exchange flags. And I realized at one point that the flags that we were giving, United States flags that we were giving to Mexican officials were not made in the United States. And that shouldn't be that way. But anyway, with that, I close.
Any questions, members? Thank you very much, Representative Raymond. The chair moves to leave HB 876 pending at this time. Is there any objection? Hearing none, HB 876 is left pending. At this time, the chair lays out HB 4282 and recognizes Representative Raymond to lay out Representative Longoria's bill. The chair offers a committee substitute to HB 4282.
Thank you, Mr. Chairman. Members, I can't give you the real short version because I don't know it, so I'm just going to go with what Chairman Longoria gave me. As mentioned, this is the committee substitute, and the changes are made to mirror the Senate companion, which is currently in the House but has not been referred yet. The committee substitute makes the confidentiality provisions automatic and removes the opt-in provision of the filed bill. It clarifies the bill applies to individuals and not persons, because persons can include business entities, which is not the intent of the bill. It amends a list of confidential information to remove business address, place of work, business phone, and criminal history. Adds a specific exemption for HHSC to allow the agency's databases to continue to function as they do now, and enhances confidentiality protections for mental health providers. Currently, most information about occupational license holders, which is maintained by state licensing authorities, can be publicly disclosed to any person that submits a public information request. This includes personal identifying information that, when disclosed, can place a licensee at risk. This is a safety issue. The general public should not have access to personal identifying information. License holders have reported stalkers using this publicly available information to harass license holders. Additionally, license holders receive an enormous amount of spam that is sent to home addresses and email addresses. To provide protections to licensees, Committee Substitute House Bill 4282 contains a list of personal identifying information that state licensing agencies must keep confidential. These protections would apply to all occupational license holders. Members, that's it.
Members, any questions? We'll give you the right to close. Joseph McCoy. Joseph McCoy. Joseph McCoy. Will show that Joseph McCoy registered on behalf of Texas Psychological Association Cell 4 HB 4282, but did not testify. Members, that's all the registrations we have. Is there anybody else who wishes to speak on for or against the bill? Seeing none, Chair recognizes Representative Raymond to close on the bill.
Thank you, Chairman. Members, just to let you know, the specific information that is exempt would be home license application, home address, home telephone number, email address, social security number, date of birth, driver's license number, state identification number, passport number, emergency contact information, and payment information. With that, I close.
Thank you, Representative. Chair moves to withdraw committee substitute to HB 4282. Leave the bill pending at this time. Is there any objection? Hearing none, HB 4282 is left pending. Chair lays out HB 2927 and recognizes Representative Turner to explain his bill. The chair offers up a committee substitute, HB 2927.
Thank you, Mr. Chairman and members. This bill has to do with clarifying the statute as it relates to quarantine for first responders. During the 87th regular session, COVID-19 brought about new and unprecedented situations involving public safety officers. Accordingly, House Bill 2073 and Senate Bill 22 were passed in the 87th legislature to ensure the public safety officers who contracted COVID-19 or were ordered into quarantine were not penalized and their medical situations were covered through workers' compensation. SB 22 created a presumption that a public safety employee injury or death caused by COVID is work-related, and HB 2073 required paid leave for employers who were required to quarantine due to COVID. However, House Bill 2073 did not include first responders employed by the state of Texas, only those employed by political subdivisions. Because of this, state-employed first responders or public safety employees ended up having to use the time off they had saved up to quarantine after being exposed to or displaying symptoms of COVID. Further, because HB 2073 specified that to be eligible, an employee was required to quarantine because of an exposure to COVID, there was confusion about whether an employee who contracted COVID but was not sure where the exposure happened would be covered. This bill clarifies the rights of public safety employees when it comes to quarantining with communicable diseases. The bill will ensure that public safety employees told by their employer that they cannot work due to a communicable disease cannot be penalized. It defines ordered to quarantine or isolate, that's in quotes, ordered to quarantine or isolate, as any time a person is not permitted to work because they had displayed symptoms of a communicable disease or have been exposed to a communicable disease. House Bill 2927 also ensures that public safety employees will be given the same protections as those who work for political subdivisions. This includes paid time off that does not affect their sick or vacation leave, pension benefits, health benefit plans, and reimbursement for reasonable costs related to the quarantine. The committee substitute adds the definition of order to quarantine or isolate to the local government code. Members, this bill serves as a shield for the rights and safety of those who tirelessly serve and safeguard us. It's imperative that we honor their selfless commitment and compensate them for the immense risks they undertake as they put their lives on the line every day for our communities, and this is a common sense bill that will help clear up some confusion in the statute. And there are some witnesses, and I respectfully request the right to close.
Thank you, Representative. Any questions? We'll give you the right to close.
Thank you, Mr. Chairman.
We'll go to the witnesses. David Batten. David Batten. David, B-A-T-T-O-N. Will show that David registered for Harris County Deputies Organization, FOP 39-4 HB 2927, but did not testify. John Wilkerson. John, we have you registered for the Texas Municipal Police Association 4 HB 2927. Is that correct?
That is correct, Mr.
Go right ahead.
Thank you, Mr. Chairman and committee members. Want to take this opportunity to thank Chairman Turner for his hard work and his staff's hard work on this bill. During the 87th, as Chairman Turner laid out, there was a committee hearing that was held in regards to Senate Bill 22 and 2073, or excuse me, House Bill 2073, and how it was being applied across the state. TMPA, we brought some issues before that committee that we were experiencing with our members. We represent, over 30,000 first responders throughout the state, law enforcement primarily related. And we were seeing the discrepancies on how those two bills were working with each other. Just to give you a couple of quick examples, in some situations, law enforcement officers working during COVID were being told that they could not come to work because they might have been exposed to somebody. And I'll give you a great example of what that looked like. They arrest somebody, they drop them off at the jail, and the person that they dropped off at the jail was showing signs of COVID. And so now somebody that they worked around brought that to supervisor's attention. Supervisor says, yep, go home. Well, the jail may have not have tested that person for COVID because in the early days, the testing was hard to come by. And so now, because it was not positive that they were exposed to COVID, just the symptoms, the agency was saying, well, nope, 2073 says we have to be sure that you were exposed on duty. And since there's no positive test, we can't say that. Another state employee was clearly exposed on duty, was told he had to quarantine, and after he quarantined, they told him you have to use your own sick time. And after he contacted us and we assigned an attorney, the attorneys reached out to the State Office of Risk Management, and SORM told the attorney, sorry, 2073 only applies to political subdivisions, not the state of Texas. So I think that was just an oversight in the passage of the bill. And so after Chairman Turner's office learned of this, Kelly and his office reached out to me promptly. We've been working with them to get this legislation moving forward.
Thank you, sir. And we'll show your 4HB 2927.
Thank you, Mr. Chairman.
Thank you. Ray Heimel. Ray, we show you registered for the Texas Public Employees Association and self 4HB 2927. Is that correct?
That's correct, Mr. Chairman. Thank you. And thank you, Mr. Turner, for bringing this bill forward. It does clarify an area that's been the source of some distress to those who are truly on the front line. And we hope that you will look at this one group of folks who have served you so admirably during this pandemic, and that you will, in fact, give them this additional benefit. And in that, I know you're anxious to hear from some illustrious witnesses behind me. So any questions?
Any questions, members? Thank you very much, sir.
Thank you.
Members, that's all the witness registrations. Is there anybody else who would speak on for or against the bill? If not, Chair recognizes Representative Turner to close on his bill.
Thank you, Mr. Chairman. If there's no questions, I close.
Any questions? Thank you. Representative Turner, Chair moves to withdraw the committee substitute to HB 2927 and leave the bill pending at this time. Is there any objection? Hearing none, HB 2927 is left pending. All right, members, I'm going to lay out a bill, and so I'm turning the proceeding over to our vice chair.
The chair lays out House Bill 2178 and recognizes Chairman Hunter to explain his bill.
Thank you, Madam Chair and members. Members, you know, I work quite a bit with the Freedom of Information Foundation and all the transparency legislation, and this is part of their package. And what this is HB 2178 adds Texas Government Code Section 2051.054 to provide newspapers which publish a public notice will also publish the notice on a statewide website accessible to the public at no cost. And by publishing public notices in the newspaper, the public's better informed about important events, and additionally allows the public to serve as a third-party checking system on government. And members, the bill does not create any criminal offense, increase criminal punishment, change eligibility, any of that. This is more transparency and making sure that transparency and publication is known to the public. So I will close, and we have a couple of witnesses.
Members, are there any questions? Representative Raymond, do you have a question?
Oh, yes.
If there are no questions, we'll proceed to testimony. The chair calls Donis Baggett.
Thank you, Madam Chair.
We have you registered representing the Texas Press Association and yourself, and you are for House Bill 2178. Is that correct?
That is correct. Thank you, Madam Chair. Madam Chair, members, I'm Donis Baggett. I'm Executive Vice President of the Texas Press Association. We have the honor of representing the 400-plus newspapers in the state of Texas, from the largest to the smallest. This bill codifies what most newspapers in Texas are already doing, and that is provide public notices not only in print, as they have done for more than 200 years, but also online and in digital media platforms. In doing so, we are providing state-of-the-art public notice service by the strongest industry standards. And we have found that people are responding very, very positively to it. You'll hear in a moment from our president about a recent market survey that shows just how intensely we penetrate the Texas market with our public notice services. In fact, newspaper readership far exceeds that of any other medium, especially when it comes to information of this sort. Our websites and our digital products are consistently viewed more often than any combination of governmental websites. And our readers tell us in that survey that you're going to hear about that that's the way they like it, because it's independent, and an independent third-party verification is extremely important to them. I would say that this is done at no additional cost to the entity placing the public notice or to the taxpayer who is reading it, because those online notices are provided outside of the paywall at the local newspaper site and at our statewide website. And you can even get push email notification service at no charge as well. We're very proud to offer this service and very proud to continue our legacy of service to the people of Texas. Thank you. Be glad to answer any questions.
Members, any questions? All right, thank you.
Thank you very much.
Chair calls Leonard Woolsey. We have you representing the Texas Press Association and the Galveston County Daily News, and you are for House Bill 2178. Is that correct?
That is correct.
You may proceed.
Thank you, Madam Chairman, and thank you, Chairman Hunter, for introducing this bill. My name is Leonard Woolsey. I'm the publisher of the Galveston County Daily News in Galveston County and also the president of the Texas Press Association. I am here to testify on behalf of HB 2187, which could easily be called the modernization of public notices for Texas. What is proposed is that for Texas newspapers to qualify to publish Texas legal notices, the newspaper must adhere and follow these items for the benefits of all Texans. 1, publish the print public notices in print. Secondly, publish public notices on their website and provide free access to all residents. And thirdly, the newspaper must also send notices to post on the Texas Press Association statewide public notice site. In turn, the Texas Press Association will keep public notices website updated. It will be fully searchable, sortable, with push notifications to any users. For example, should an individual own a concrete company is interested in bidding on concrete far outside their own market, this service would send them automatically bids that are being submitted across the state and give them the opportunity to participate more widely and help hold down costs in local governments. It's essentially a free one-stop service for readers across Texas. The fact is, print and digital now enjoy their largest audiences in history. Coda Ventures just released a survey in the last few weeks about this item. 79% of Texans read public notices in print or digital newspapers. That has to do with tax changes, zoning changes, minutes of local governments. 89% of Texans consider local newspapers and news sites their most trusted source for public notices instead of city, county, or other independent state websites. And finally, 78% of Texas newspapers readers vote in state and national elections. They are engaged. Newspaper.
Thank you.
I'm going to say thank you very much for your time and
Any
consideration.
questions? All right, thank you.
Thank you.
Those are all the witnesses we have registered. Is there anyone else who wishes to speak on, for, or against the bill? If not, the chair recognizes Chairman Hunter to close on his bill.
Close.
Thank you, Chairman Hunter. The chair moves to leave House Bill 2178 pending at this time. Is there any objection? Hearing none, House Bill 2178 is left pending.
Thank you.
Thank you, Madam Vice Chair. Chair lays out HB 713 and recognizes Representative Shaheen to explain his bill.
Thank you, Chair Hunter, Vice Chair Hernandez, and members. House Bill 713 deals with the state's procurement process and deals with the type of purchase called proprietary purchases. A proprietary purchase refers to a product or service that has distinctive features that are only provided by a single vendor. Therefore, these bids are non-competitive and require a written justification. HB 713 seeks to remove a 20-day deadline that currently exists and a comptroller must approve. The 20-day time constraint is often not a realistic deadline, given the uniqueness of these types of purchases and the fact that these solicitations sometimes include more than one proprietary item. So HB 713 would remove the 20-day time constraint for this process and allow the comptroller the discretion to take the appropriate amount of time needed for each request. With that, members, I'm happy to answer any questions and reserve my right to close.
Any questions? Thank you. We'll give you the right to close. Chair calls Bradley Hodges. Bradley Hodges. Bradley Hodges. Show Bradley registered for self for HB 713, but did not testify. That's all the affirmations, registration, members. Is there anybody else who wish to speak on, for, or against the bill? If not, Chair recognizes Representative Shaheen to close.
Thank you, Mr. Chairman. I close.
Any questions? Thank you, Representative Shaheen. The chair moves to leave HB 713 pending at this time. Is there any objection? Hearing none, HB 713 is left pending. Chair lays out HB 2569 and recognizes Representative Shaheen to explain his bill. The chair offers a committee substitute to HB 2569.
Thank you, Mr. Chair, again, and members. HB 2569 seeks to increase transparency for electricity service interruptions requiring power generations to provide a reason for an outage. This committee is very well aware of the sensitivity around our grid. There is heightened sensitivity with respect to the tightening of grid. I don't know about you all, but every time there's a power outage in a neighborhood in my district, I get emails complaining about the grid. So under this bill, a provider of electric generation services must notify ERCOT of an outage and the reason within a reasonable amount of time. The bill applies to all electrical generation services, regardless of the source of generation. I will tell you, members, we are still in the process of working with stakeholders, so that's still in process. We're working with a lot of the folks within the industry. So with that, I'm happy to answer any questions and reserve my right to close.
Anybody have any questions, members? Thank you. We're going to go to the live testimony and give you right to close.
Thank you, sir.
Just as a reminder, everybody here and listening, we are closing the registrations at 5 p.m. Just a reminder, and everybody check your clocks. John Gordon. John, we show you have registered for yourself for HB 2569. Is that correct?
That is correct.
Go right ahead.
John Gordon, professional engineer. I support this bill. We do need to know when electric generating units are going to be offline or what's causing them to go offline. I believe there may be some reporting that's already going on in the ERCOT system. And so whatever the legislation ends up becoming, it should interface with what's already there in terms of the generating units and their letting people know that the units are not going to be available, especially ERCOT, which has to know it.
Any questions for John, members? Thank you, John. Bradley Hodges. Bradley Hodges. Bradley Hodges. We'll show that Bradley registered by having himself for HB 2569 but did not testify. Michelle Richmond. Michelle, we show you've registered for Texas Competitive Power Advocates neutral on HB 2569. Is that correct?
That's correct.
Go right ahead.
Michelle Richmond, Texas Competitive Power Advocates. We are on the bill. We are working with Representative Shaheen on a couple of issues. There is extensive reporting of outages to ERCOT already. The data is made publicly available on ERCOT's website 3 days after the outage. We understand the updates that Representative Shaheen is looking for, but want to make sure that it's done in a way that provides information that's valuable to the public and not superfluous information that would be useless. So we're working with him on it, working on language, and I expect that we will get to a good place on that.
Thank you, Michelle. Any questions? Thank you very much.
Thank you.
Members, that's all our registrations. Is there anybody else who wishes to speak on for or against the bill? If not, Chair recognizes Representative Shaheen to close on the bill.
Thank you, Mr. Chairman. I close.
Thank you, Representative Shaheen. The chair moves to withdraw the committee substitute HB 2569 and leave the bill pending at this time. Is there any objection? Hearing none, HB 2569 is left pending.
Thank you, members.
Chair lays out HB 3096 and recognizes Chairman Guillen to explain his bill.
Thank you, Mr. Chairman. Members, the Texas Energy Reliability Council is required by law to submit a report to the legislature on the reliability and stability of the electricity supply chain in Texas every even-numbered year. This report provides an assessment of the state's current energy situation, identifies potential issues or vulnerabilities, and recommends strategies to maintain a reliable and stable electricity supply for Texas consumers. This report is meant to provide the legislature with insight into what needs to be improved and what is in good standing. However, because the report must be submitted at the beginning of November, TURC would not have ample time to analyze or report on any unforeseen events such as natural disasters or major power outages in Texas that occurred during the month of November. In response to this issue, House Bill 3096 would change the date that TURC is required to submit the report to the legislature to December 1st, which would still provide them with enough time to submit the report to the legislature before the start of the session and account for any unforeseen circumstances that may occur during the month of November. I can help answer any questions if you have any, and we do have a resource witness here as well.
Any questions, members? All right, we'll go to testimony. We'll give you your right to close. John Gordon. John, we show you're representing yourself neutral on HB 3096. Is that correct?
That is correct.
Go right ahead.
Just have one comment, Representative Gillian. The periods of time in electric utility industry where you have issues usually is in the summer period, starting about May and running through August. And then you have the other period, which is roughly mid-November through February. So a November reporting date for the ERCOT would be probably most appropriate because they'd have the previous year's two highly sensitive times where they have to have plenty of power, the winter time and the summertime already complete. There is really not much that goes on in October. So you can move it to November, but it really doesn't gain you much. And I would say that the representatives that got elected in November would be able to start seeing the information a lot earlier if the report comes out on the 1st of November. So they would have a chance to formulate any additional legislation that they may want to have for the next legislative session a little bit quicker. Thank you.
Any questions, members? Thank you. Thank you very much. All right, we do have a resource. Does anybody need the resource? If not, is there anybody else who wishes to speak for, against, or on the bill? Saying not, Chairman Guillen will let you close.
I close.
Thank you, Chair. The chair moves to leave HB 3096 pending at this time. Is there any objection? Hearing none, HB 3096 is left pending. Chair lays out HB 1215 and recognizes Representative Cook to explain his bill. Chair offers a committee substitute to HB 1215.
Thank you, Mr. Chairman, members. This bill is known as the Fair Chance Hiring Act, and it is born out of the Criminal Justice Reform Subcommittee, or Interim Committee, excuse me, that I served on last session or last summer. And it's a great program for workforce problems that we're having throughout Texas. This is a workforce solution that I would offer. And basically what this bill does is it requires public employers, with the exception of schools and law enforcement agencies, which require licenses at the law enforcement agencies. Those two entities are excluded from this bill, but otherwise, all public employers would have to refrain from pulling criminal background checks until such time as until such time as a conditional offer is made. Once a conditional offer is made, thereafter, the public employer would be able to pull any type of criminal justice reform. The bill does not prohibit an employer from notifying an applicant of that certain criminal convictions would disqualify the applicant from consideration, including a question on the initial employment application asking whether an applicant has been convicted of a criminal offense that would disqualify the applicant, nor does it preclude an employer from conducting a background check after the conditional offer is made. I'd be glad to answer any questions that you have. And the last point I would make is if you're left of center, I would say this is a great criminal justice reform bill. And if you're right of the center line, I would tell you that President Trump signed this similar act in December of 2019, and 35 states have followed suit since then. So again, I would offer myself for any questions, Mr. Chairman.
Any questions, members? Thank you. We'll give you your right to close.
Thank you, Mr. Chairman.
Adam Bazaldua. Adam, we show you've registered for the City of Dallas and yourself for HB 1215. Is that correct?
Yes, Mr. Chair.
Go right ahead.
Thank you, Mr. Chair. Good afternoon, Chairman and committee members. My name is Adam Bazaldua, and I serve as District 7 council member for the residents of the City of Dallas. I'm here today and proud to testify in support of HB 1215. Thank you to Representative Cook for bringing this piece of legislation forward. HB 1215 would prevent public employers from obtaining criminal history, record information from job applicants, or from asking job applicants about their criminal history before making an offer of employment. If this bill is enacted, public employers can still notify applicants of convictions that would disqualify them for employment during the application process, and can still ask about the applicant's criminal history related to these specific offenses. Dozens of states already, and over 150 cities and counties have adopted similar policies, including Dallas County. These are commonly referred to as ban-the-box policies. They arose from the belief that employers should consider a job candidate's qualifications first, without the stigma of a conviction or arrest record. Many ban-the-box policies provide applicants a fair chance at employment by removing conviction and arrest history questions from job applications and delaying background checks until later in the hiring process. I want to tell a personal story. Just a few weeks ago, we celebrated my dad's retirement from 44 years with Frito-Lay. Frito-Lay gave him an opportunity after he was incarcerated in the state of Texas. Without the opportunity given to him, I don't know where our family would be or the destiny of his future as well. HB 1215 is an important part of ensuring that individuals with criminal records do not continue to be impacted by the criminal justice system once they are outside of it. Employment discrimination against those with criminal records.
Thank you. And Adam, we're going to note that you're for HB 1215.
Yes, sir. Thank you.
Any questions? Representative Anchia.
Thank you, Mr. Chairman. Just a comment. It's always good to see you, Councilman.
You as well,
for your support of this bill and for always representing the city of Dallas well.
Thank you, Representative.
Thank you very much.
Thank you, Mr. Chair.
David Emmerich. David, we show you've registered for J.P. Morgan Chase and Company 4HB 1215. Is that correct?
That's correct, Mr.
Go right ahead.
Thank you, Mr. Chairman, members of the committee. I'm Dave Emmerich with JP Morgan Chase. I'm the Regional Director of First State Government Relations. I'm here in support of the bill. You may ask why we're supporting this legislation. We are one of the largest employers in Texas, private employers with over 30,000 employees. We have been one of the founding members of the Second Chance Business Coalition, which is a large coalition of over 50 large national companies dealing and working on second chance hiring initiatives across the country. One of the ways that we've gotten to this process is we have banned the box in our applications for hiring. Over 10% of our new hires each year, close to 4,000 employees in the last 2 years, almost another 2,000 this year, are second chance hires. It's an extremely effective program. These people have been great employees. They're great employees. And when Representative Cook asked me to work on this issue with him, I was more than happy to do so, and I'm pleased that he brought this legislation to the table, and I'd be happy to answer any questions you may have.
Any questions, members? Thank you, sir.
Thank you.
Caden Norton. Caden, we show you've registered for Prison Fellowship Ministries 4HB 1215. Is that correct?
Yes, sir.
Go right ahead.
Thank you, Mr. Chairman and members. My name is Caden Norton. I'm here on behalf of Prison Fellowship Ministries, testifying in support of House Bill 1215. I appreciate the opportunity to visit with you, and thank you, Representative Cook, for your continued efforts to provide second chances to Texans. As a brief introduction, Prison Fellowship is the nation's largest Christian nonprofit serving prisoners, former prisoners, and their families, and is a leading advocate for criminal justice reform. Prison Fellowship serves men and women in more than 20 Texas prisons through character education programs like Prison Fellowship Academy. It's true that removing barriers to reentry for Texans with a criminal record reduces recidivism, but it also affirms their God-given dignity and signals that they're worthy of a second chance. Limited access to gainful employment is a significant barrier for people with a criminal record. Men and women are often screened from job interviews solely on the basis of a criminal record, preventing fair consideration of the strengths that that individual can bring to a job. HB 1215 provides an opportunity for people with a criminal record to demonstrate that they have the qualifications necessary for employment before their public sector prospective employer considers their criminal record. A 2017 study found that these types of policies, which are often referred to as fair chance hiring policies, raise the probability of public employment for those with convictions by 30% on average. Over 35 states, including Utah, Nebraska, Ohio, North Dakota, and Oklahoma, have adopted fair chance hiring policies for public sector employees. And as Representative Cook mentioned, President Trump signed fair chance hiring policies into law for public sector federal employment in 2019. Obtaining employment following incarceration significantly reduces the probability of recidivism. By expanding access to work for Texans with a criminal record, HB 1215 can help break cycles of crime and recidivism, thereby strengthening Texas families and Texas economy and making our communities safer. Thank you again for the opportunity to visit with you. I'm happy to answer any questions you may have.
Any questions, members? Thank you very much, sir.
Thank you.
Members, that's the last of our registrations. Is there anybody else who would speak on for or against the bill? Representative Cook to close.
Thank you, Mr. Chairman. Members, as the witnesses testified today, this is a great policy. Not only, like as I said earlier, is it a criminal justice reform piece of legislation, but it's also good common sense, and I believe that it offers a benefit so that the recidivism rate with regard to those that have been formerly incarcerated have a less likely chance of being put back into TDCJ. This is a great opportunity for Texas to continue to lead. I would appreciate your favorable consideration. Thank you for the opportunity to lay out this bill and be glad to answer any questions.
Any questions, members?
Not I close.
Thank you, Representative. The chair moves to withdraw the committee substitute to HB 1215 and leave the bill pending at this time. Is there any objection? Hearing none, HB 1215 is left pending.
Thank you, Chairman.
Chair lays out HB 4499, recognizes Representative Harris to explain her bill.
Thank you, Mr. Chairman and members, for allowing me to lay out House Bill 4499 before you today. House Bill 4499 establishes a small exception for development in a 3x4 block area currently constrained by Capitol View corridors 14 and 15. These CVCs will go away when the upper deck of I-35 goes away, per TxDOT's final plan approved earlier this year. These CVCs include city and nonprofit-owned properties that are now used to support people facing homelessness and related challenges. Today, we have the CEO of Caritas of Austin, who can speak about her experience as a current resident and why she is looking to move. We'll also have a committee set up to tighten up the language. And with that, I'm available to answer any questions and reserve my right to close.
Any questions, members? Thank you. We'll give you the right to close. Linda Durnin. Linda, D-U-R-N-I-N. Linda Durnin. We'll show Linda registered for herself for HB 4499, but didn't testify. Joe Catherine Quinn. Joe, we show you have registered for Caritas of Austin for HB 4499. Is that correct?
That's correct.
Go right ahead.
Thank you, Mr. Chairman and members. My name is Joe Catherine Quinn. I'm the CEO at Caritas of Austin, and I am testifying in favor of HB 4499. Caritas is a nonprofit whose mission is to end homelessness. We build well-being and stability for our clients by ensuring they have safe and permanent home and comprehensive support. Annually, we serve about 600 people, and our proven methods are very effective. 95% of our clients do not return to homelessness. Since our founding in 1964, Caritas has been located in downtown Austin, and since that time, the homeless population has been concentrated downtown. So our location at the corner of 7th and Neches worked well. However, our client population and the solutions to end homelessness cease to be centralized downtown. In fact, the most recent citywide survey showed an 80% decrease in Austin's downtown homeless population. Consequently, Caritas is reevaluating the increased cost and inconvenience of being located downtown. We own our land, and it's located right in the middle of a Capitol View corridor. As someone who's lived and worked in the Austin area for 38 years, I deeply appreciate the purpose and existence of the CVCs and would not have thought about this bill until the I-35 capital project started moving forward. This bill would create an exemption for the blocks around us, meaning a significantly higher valuation for our property. This would be a financial game changer for our organization. Caritas's goal is to double the number of people we serve by 2025, and our property valuation will be the single biggest financial driver to that goal. I appreciate your consideration of this bill.
Thank you. And we're going to note you're for HB 4499. Any questions, member?
Chairman.
Yes. Representative Raymond has a question.
Would you mind if I ask
Sorry
a little
about
bit, just how you doing? As Ms. T said, how you doing? So I appreciate your mission and what you do. You know, one of the things that those of us who've been here at the Capitol a long time, those of us who've only been here 30 years, we love this Capitol, and we want everybody to see it, to be able to see it. And so I remember when I first got here, we were concerned about trying to keep these sort of corridors or ability to see the Capitol from different parts of the city and so forth. But the number of things that have gone up from then to now is just incredible. I think you can see the Capitol from about a block away, and you know, if you're lucky. So I'm guessing that you don't, but I want to ask you, I'm guessing you don't want to block the view of the Capitol anymore. That's not really what you're trying to do, right?
Correct.
You want to be able to provide the services you provide.
Correct.
So if there are other alternatives, you'd be open to that because it's not really your interest in trying to block more views of the Capitol. Would that be fair?
That's fair.
Okay. So maybe some of us could work with you on that somehow, or with the author of the bill, because I just think it is one of the important things, the history we have here. When this Capitol was built, it was the 7th largest building in the world, and it's still one of the most beautiful buildings, in my opinion, in the world. But it's getting to a point where it's hard to see it unless you're about a block away. And so again, I appreciate your mission and what you do, but I also appreciate your willingness to maybe work with us to see if somehow we can help you without blocking it more. That's a question, and you know, the answer was yes, you'll work with us and we can work.
I will work with you. You know, we are looking to maximize the valuation of our property because it will help us further our mission. So.
Right, but you're still, but it's not.
Sure, I'm certainly.
It's not your goal to block the view of the Capitol more, right?
Correct.
Okay, thank you so much.
Any other questions, members? Thank you very much. Members, there are no other registrations. Is there anybody else who wishes to speak on for or against the bill? If not, Chair recognizes Representative Harris to close on her bill.
Thank you, Mr. Chairman and members. And Representative Raymond, I also very much love the view of the Capitol and this building. It's an honor to serve in it. And I want to point out in our committee substitute, we say that this is not going to affect until construction actually begins on the I-35 project. So that does kind of tighten it a little bit. But of course, I want to work with you and the other members to make sure that we have this in a good place. So thank you for your comments. I really appreciate it. And
Representative Raymond.
Thank you, Chairman. Thank you so much, Representative. Yes, I'm sure this Capitol has a special place in your heart because I believe that you're here today in large part because of the experience that you had working in the Capitol, and then you were able to take that to the voters of your district and say, hey, I'm ready to go. I really think I followed your race, and you know, I follow all the races. And I thought, you know what, I think she's got a really good shot because of the experience having worked in this Capitol. So I'm sure it's got a special place in your heart.
And thank you for all of your advice and help this session. I appreciate it.
Thank you.
Representative Dean.
Representative Raymond answered or asked my question, so thank you.
Okay, all right. Thank you, Member.
So, no, Representative Harris.
Yes, sir.
Where is your fiance from?
Corpus Christi, Texas.
Thank you. Any other questions?
Thank you, members. I close.
Thank you, Representative Harris. The chair moves to leave HB 4499 pending at this time. Is there any objection? Hearing none, HB 4499 is left pending. Chair lays out HB 4728 and recognizes Representative Dean to explain his bill.
Thank you, Mr. Chairman. Members, recent growth of large flexible loads is posing a threat to our ERCOT grid. Namely, we're talking about crypto mining operations. These projects take a large amount of load. They're flexible. Unlike traditional industrial clients, these projects can ramp up or down extremely quickly, sometimes turning on or off 100 megawatts almost instantaneously. To put that number in perspective, members, here's some other approximate load sizes. A house is 10 kilowatt. A large grocery store, 2.5 MWs. A small traditional industrial customer, 50 MW. And unlike crypto mining operations, traditional large load customers take a long time to ramp up or ramp down. These large flexible loads have the potential to destabilize the grid either intentionally or unintentionally. Therefore, what this bill is trying to do is give ERCOT an appropriate amount of information about where these large flexible load customers are. Members, I also want you to know I've worked extensively with stakeholders here and with the Senate B and C committee, and we will continue to do so. Thank you, and I would like to answer any questions you might have.
Any questions, members? Thank you very much. We'll give you the right to close. Thank you. Katie Coleman. Katie, we show you've registered for the Texas Association of Manufacturers neutral on HB 4728. Is that correct?
Yes, sir.
Go right ahead.
Thank you. Katie Coleman for the Texas Association of Manufacturers. We are testifying on the bill. We had concerns about the filed version, but as Representative Dean mentioned, we've been working extensively with his office and also with Senator Johnson on his companion to the bill. Our concern is that as filed, while the bill was intended to pick up cryptocurrency, it actually picked up all large loads, including manufacturing facilities. And for obvious reasons, we have concerns about requiring large manufacturers to be registered directly with the ISO and potentially subject to operational control. So I think there's consensus to exclude manufacturing facilities. We're just working through the exact language to capture that. And so we're hopeful that we can get to a place where we support the bill.
Thank you. Any questions?
Mr. Chair.
Representative.
Just to clarify what you said, we have been working together.
Yes.
As of late this afternoon, I believe y'all have been working with my chief of staff as well as others.
Yes.
And we believe we're at where we need to be point, correct?
I think that's right. So we had gotten comfortable with the companion language that Senator Johnson passed, Senate Bill 1929. And then there was further discussion about defining computing facility. That was sort of the remaining issue, and I think we have settled on a definition
I
of
believe
that.
we understand the concern with your, what was it, telemetry or some other, I mean, some
variety of
stuff. We don't want to know your computer stuff. We don't need to know that. But what we want to try to do, and where we need y'all help, is to try to make sure that we don't have this type of operation that can throw an immediate load onto our grid. It's very hard to stabilize the grid at that point. So I appreciate y'all working with us.
Agreed. Thank you.
Any other questions, members? Thank you very much. John Gordon. John, we have you registered for cell 4 HB 4728. Is that correct?
That is correct.
Go right ahead.
John Gordon, registered professional engineer. First recommendation is instead of using the word large, use a specific number. 20 megawatts would be equivalent to what I would consider as 4,000 residential. Okay. 50 megawatts would be 10,000 residential people. So probably somewhere around 100 megawatts would be what might be the best term for a large. But define what large is, because otherwise you may catch people like they said. There is both the problem about starting up and then getting cut off. Like Samsung up there, it'd be disastrous if they get cut off rather than they start it up. So I think it's very important to know the status of very large loads on the ERCOT grid, but you can't get the level down too low or it'll increase cost and get too many people that probably you don't need to get. So that's just my recommendation to you.
Okay. Hold on.
Any questions, members?
Chair.
Yeah, Representative Dean.
Thank you, John. The premise of the bill, though, you're in favor of.
Yes, very much so.
And your recommendation is a more definitive definition, if you will, of
the term large, because
of large. We'll work on that.
Large is what people think.
I think good suggestion. Thanks.
Thank you very much, y'all. Warren Lasher. Warren, we show you've registered for the Texas Oil and Gas Association, neutral on HB 4720. Is that correct?
That is correct.
Go right ahead.
Thank you, Mr. Chairman, committee members. My name is Warren Lasher, President of Lasher Energy Consulting, here today for the Texas Oil and Gas Association to speak on the committee substitute for HB 4728. Texas Oil and Gas Association is a statewide trade association representing every facet of the Texas oil and gas industry. The membership of Texoga produces approximately 90% of the Texas's crude oil and natural gas, operates nearly 90% of the state's refining capacity, and is responsible for the vast majority of the state's pipelines. In fiscal year 2022, the Texas oil and natural gas industry supported 443,000 direct jobs and paid $24.7 billion in state and local taxes and state royalties. Texoga appreciates the extensive work and conversations that we have had with Representative Dean's office, but we are still not comfortable with the language as filed. We wanted to offer a few recommendations. Obviously, working with TAM on the definition of computing load, understand that that is underway. We would like for the process to be completed through a rulemaking to ensure transparency, a rulemaking at the commission to ensure transparency and stakeholder involvement. We would also like, as was previously noted, some sort of a minimum size, potentially even 100 megawatts associated with the bill. But in particular, we would like the specific language associated with telemetry to be removed from the bill. So I just wanted to hit that one home again. But we look forward to continuing to work with your office and other stakeholders on this issue, and I'm open to questions.
I need to get a clarification. So Warren, we have you registered Texas Oil and Gas Association.
That is correct.
But for clarification, should it be Texas Oil and Gas Association and Lasher Energy Consulting?
My company is Lasher Energy Consulting. I'm here today for Texas Oil and Gas Association. I apologize if it's not filed correctly.
Okay, we just want to confirm on the record and the affirmation, you're here registered representing only Texas Oil and Gas Association.
That is
neutral, HB 47.
That is correct. Thank you.
Other questions? Yeah, Representative Dean.
Just for the record, I'm not sure if it was you or your office. We were in communication with Texoga.
Yes.
Late today. I don't know if it was with you, but just for the record, you are aware of those, and we have met or exceeded expectations that y'all might have had.
I haven't seen.
Have you seen it?
I haven't seen a version of the language.
I just want confirmation that you are aware that that meeting took place, so that conversation has taken place.
Yes, yes, and we are very appreciative of your office working with us.
Any other questions? Thank you very much. Those are all the witness affirmations we have. Is there anybody else who wish to speak on for or against the bill? If not, Chair recognizes Representative Dean to close. Thank you, Representative Dean. The chair moves to leave HB 4728 pending at this time. Is there any objection? Hearing none, HB 4720 is left pending. Chair lays out HB 857. I recognize Representative Gervin Hawkins to explain her bill. The chair offers committee substitute HB 857.
Thank you, Mr. Chair and members, for allowing me to lay out this great bill, House Bill 857. Under current law, contractors on public works projects must take out certain surety bonds, including payment bonds and performance bonds, for contracts in excess of certain sums of money in order to mitigate the risk to the state. Current state law requires payment bonds for contracts in excess of $25,000 and performance bonds for contracts in excess of $100,000. Now, as we know, payment bonds ensure that the general contractor pays all of his or her subcontractors for public works construction projects, and performance bonds guarantee a contractor will complete a project according to the terms outlined in the contract by the project owner. As filed, House Bill 857 raises the contract threshold for payment bonds from $25,000 to $100,000 for non-municipal government entities. Now, I do have two committee substitutes for this bill. The first committee substitute for House Bill 857 would raise contract thresholds for payment bonds for non-municipal governmental entities from $25,000 to $150,000 contract, and performance bonds from $100,000 to $150,000. The second committee substitute will ensure parity between the updated thresholds for payment and performance bonds. The second committee substitute will require payment and performance bonds contracts for an excess of $150,000, regardless of the government entity being a municipality or not. The current bonding thresholds were first established in the early 90s and have not been revised since. Public work projects have continued to increase in size and complexity since the thresholds were first established, and these thresholds have not kept up with inflation. Projects under 100,000 usually involve just one trade or just a few trades. Some examples may include an HVAC replacement, roof repair, flooring replacement, lift station repairs, fencing, or well drilling, among others. They are comparative, nominal, and low-risk projects. Furthermore, raising these thresholds will align the state with other public sector entities, especially the federal government. While municipalities in Texas require payment bonds for contracts in excess of $50,000, the federal government requires payment and performance bonds for projects in excess of $150,000. Raising these thresholds will reduce red tape and the administrative burden on contractors and agency staff while lowering project costs, and would increase the state's bidding pools, especially enabling more small and historically underutilized businesses to compete as prime contractors. Newer and smaller contractors often have issues getting bonded, so by increasing these thresholds, these contractors can act as prime contracts for projects under $150,000. Thank you all for hearing this bill. I'm happy to answer any questions, and I reserve my right to close.
So Representative, so we're clear, you may have made some changes, but procedurally, you only have one committee substitute.
Correct, I'm sorry, yes,
So
sir.
just so the record's clear, we're before the one committee substitute. Thank you.
Yeah,
Thank you.
thank you for that.
We'll give you the right to close. Andrea, Lofye. Andrea, Lofye. Andrea, we got you with the Texas Parks and Wildlife, neutral on HB 857, is that correct?
Yes, sir, it is.
All right, go ahead.
Yes, sir. For the record, my name is Andrea Lofye. I'm the Director of Infrastructure for the Parks and Wildlife Department, serving as a resource witness. I believe Representative Gervin Hawkins did an excellent job of laying out the bill and describing the impact of the bill. As she stated, the Texas thresholds for requiring performance and payment bonds have not been addressed since the 90s, specifically 1993. By contrast, the federal thresholds have been adjusted with the Consumer Price Index, and they were last raised to $150,000 in 2010. She also addressed the fact that this is a cost for the contractor. These costs are rolled into the price of the construction project, so the state ultimately pays these costs. And I'm happy to take any questions.
Any questions, members? Thank you very much.
Yes, sir, thank you.
Jennifer Fagan. Jennifer, we have you registered for the Texas Construction Association against HB 857. Is that correct?
Yes, that's
Go right ahead.
Thank you, Mr. Chairman and members. Again, I'm Jennifer Fagan. I'm here on behalf of the Texas Construction Association. TCA represents about 3,000 subcontractors across the state of Texas. We represent the folks who are swinging the hammers. We don't represent the general contractors who are making these contracts. We represent their subcontractors who they subcontract to actually do the work. We are opposed to this bill because it raises the threshold for the payment bonds, and I understand the performance bonds as well in the committee substitute. We're opposing this because on two levels. When a general contractor goes and seeks a performance and a payment bond, there's underwriting done by that surety. They look at the books, they make sure, and they're looking at two things. For the performance bond, they're making sure that that company has the liquidity and they can perform the job that's being covered for that bond amount. They also ensure that those subcontractors can get paid if something goes squirrely on the job. And those subcontractors then rely on those payment bonds in order to then make a claim to be able to pay their employees and pay their suppliers. So it's a very important aspect. Our guys, I know 150,000 sounds nominal, but it's not when you get to these smaller subcontractors. They're the ones who are taking that risk of taking that job and doing the work, putting in the labor and materials, trying to accomplish it. The other issue is, I understand if Parks and Wildlife is having issues with some of their smaller projects, there certainly can be a carve-out for Parks and Wildlife, but to have a blanket exception and raising the bar for all state entities, our members find problematic. So we oppose the bill.
Thank you. Any questions, members? Thank you very much.
Thank you.
John Martinez. John, we have you registered for the Regional Hispanic Contractors Association 4 HB 857. Is that correct?
Yes.
Go right ahead.
Thank you, Mr. Chairman and the members. We support it because we see this as a way of entry. So our niche, we work with the subcontractors. We say swinging the hammer. Some of our members, we're barely trying to buy the hammer to swing, right? So our members are the people who are learning the trade and turning that trade into a business. So any of these barriers to starting that business will limit them to become a business owner. What construction is, it's one of the last industries that people can achieve the American dream by becoming a business owner. And I know when you're talking about a lot of money, a little bit of money, well, that's who you are, right? But when you run into problems in construction, if you don't have $5,000 and it's payroll, it's an issue, right? If you don't have $5, it's an issue if that's where your payroll limit is. We believe that this will help in the entry of new contractors into bidding for these projects. And we're talking about really small projects. Most of this will be eaten up in supplies, not in labor. We think that will speed up construction, will decrease costs, will allow new pools, especially right now when there's so much construction work going on. And we need these new workers, and especially when we're talking about Black and brown. This really is a small business issue, but when we talk about Black and brown businesses, when we know that it's 7 times harder for Black businesses, even in their credit and their finances, the same as a white business owner to get financing. And it's 4 to 5 times harder for a brown business owner to get financing. And let me tell you, we think construction is about building. Construction is all about money. If you don't have money, you can't build it. Thank you.
Thank you. And again, you're for HB 857.
4.
Thank you, members. Members, we don't have any other affirmations or anybody else who wish to speak on, for, or against the bill. If not, Chair recognizes Representative Gervin Hawkins to close.
Members, again, thank you for this opportunity to present this bill. You know, we're talking about the last threshold in the 90s. We have to come into the 21st century at least. That's number one. And as the gentleman stated, it is important to open up the door for more opportunities. I believe the protection comes during the procurement process. When we think about qualified entities, I think that the check and balances come when a job is procured and they go through that vetting process and one is selected. For a $25,000 contract, then having to pay for a performance and payment bond, that leaves little room for profit. So with that, I'll be happy to answer any questions.
Any questions? Thank you very much. Chair moves to withdraw the committee substitute to HB 857. Leave the bill pending at this time. Is there any objection? Hearing none, HB 857 is left pending.
Thank you. Appreciate it.
Chair lays out HB 1984 and recognizes Representative Vasut to explain his bill.
Thank you, Mr. Chairman, members of the committee, for the opportunity to lay out House Bill 1984. House Bill 1984 amends Section 35004 of the Utilities Code to allow the Public Utilities Commission to establish a reasonable allowance for costs incurred to interconnect generation within the ERCOT transmission system. This cost must include the cost of direct interconnection of the generator to the system, as well as upgrades caused by the interconnection. If these costs exceed the pre-designated allowance, the generation company is responsible for this additional amount. Happy to answer any questions. I believe we got witnesses that would be more of the technical expertise on this bill. Defer to them.
Any questions, members? Thank you. We'll give you the right to close.
Mr. Chairman.
Brent Bennett. Brent Bennett. Brent Bennett. Will show that Brent registered for Texas Public Policy Foundation for HB 1984 but did not testify. Gregory Porter. Gregory Porter. Gregory Porter. Show that Gregory registered for Texas for Liberty itself for HB 1984, but did not testify. Brent Bennett. Brent, we show you've registered for the Texas Public Policy Foundation for HB 1984. Is that correct? Yes. Go right ahead. Turn the mic on right there.
I think I was moving it and I pushed it off. Sorry about that. Yes, Brent Bennett with Texas Public Policy Foundation in support of the bill. This bill, of course, has a very similar intent to Senate Bill 1287, which we've also supported. We supported this concept previously as well, previous session. It's been our concern ever since the CREZ lines were built and the cost of financing that has layered on to the transmission costs for consumers, which now consumers are, if you look at ERCOT's report, consumers are paying more than double for transmission what they were paying about 10 years ago. So that's been, from our perspective as advocating for ratepayers, that's a big concern. And so a lot of the new generation being built in the market, being diffuse wind and solar, has greater interconnection costs than what was conceived of when the ERCOT, when the market was designed. It was thought that, okay, most transmission and distribution would be, relative to connecting new loads and not necessarily connecting that much generation in a given year. And what we've seen now is that, we need to have something to rein in those costs and to ensure better siting decisions. And so we think that, the direction of this bill trying to, and as well as the bill in the Senate, trying to, put some direction and limits around that to ensure better siting and try and put a limit on these rising costs to customers. So thank you very much.
Thank you. Any questions, members? Thank you, Brent. Julia Harvey. Do we need to get that corrected? We need to make sure we're clear in the record. It has an Harvet, so we need to make sure it's Julia Harvey, correct?
Correct, yes.
And
my
you're
apologies.
representing the Texas Electric Cooperatives for HB 1984. Is that correct?
Yes, sir.
Go right ahead.
Great. Thank you, Mr. Chairman, members.
And do we have the okay for the clerk to make any change or correction?
Yes, sir.
Go right ahead.
Thank you. I'm Julia Harvey on behalf of Texas Electric Cooperatives. I'm testifying in support of House Bill 1984. So under the status quo, consumers pay for transmission system upgrades to connect generators no matter what it costs to connect the generator. We support the change in the bill because it shifts some of the burden away from end users onto a generator that's causing the need for the upgrade. We like that the bill's technology neutral, and over time, it should discipline siting decisions because interconnection costs would be part of the economic evaluation of a project. So the bill doesn't restrict or prohibit siting anywhere, but resources would be motivated to locate closer to existing transmission infrastructure because they consider those cost trade-offs. Now, it would increase costs up front to any new generator, but currently those costs aren't a factor at all in the decision-making because they're entirely socialized to consumers. So we support the bill. Thank you, and I'm happy to answer questions.
Any questions, members? Thank you.
Thank you.
Katie Coleman. Katie Coleman. Katie Coleman. Will show she registered for the Texas Association of Manufacturers for HB 1984. Okay, Katie, we have you registered on behalf of Texas Association of Manufacturers for HB 1984. Is that correct?
Yes, sir.
Go right ahead.
Thank you. We support this bill. We have supported a similar version of this bill in a couple prior sessions. Today, consumers pay for all transmission costs, including all generator interconnection costs. We believe that that is a good policy because it is an incentive for generation to be built in ERCOT. However, over the past few years, those interconnection costs have increased substantially, and we are concerned that generators do not have an incentive to site efficiently or site close to load because these interconnection costs are covered completely. So we support allowing the PUC to set a reasonable allowance that still provides the incentive to build here, but is not quite the blank check that we have today. So we do support this bill, and I'm happy to take any questions.
Representative Anchia.
Thank you, Mr. Chairman. Katie, the last speaker representing the co-ops said that this would raise costs to consumers. This is the first time I ever heard you say support a bill that would result in the raising costs to consumers, unless I misunderstood.
So I did not hear that because I was
Okay.
trying to come from the other room, so I can't speak to that. We don't believe it would raise cost to consumers.
So let me just kind of walk through it
Okay.
because your members, they own, and I know this is technology agnostic, but they own renewables and they own sort of thermal generation, right? Your members?
Some of our members have on-site generation that some of it's renewable, some of it's thermal, yes.
Okay, so both.
Yes.
Okay. And if costs go up for generators, that would.
Oh, I see what you're
That gets
saying.
passed through to customers eventually. It'll get socialized, will it not?
Potentially, but I think because it's an allocation up front of interconnection costs, it's a decision that they can make in deciding whether to move forward with the project or whether to choose a different location, or whether they can still come up with pricing in a PPA that is appropriate and they can get a counterparty. So I don't think it necessarily raises consumer costs.
And do you think there are irrational decisions being made currently on siting?
There have been, there are examples where the interconnection costs are quite high for the megawatts that consumers are getting. Not all instances look like that, right? There are a lot of people who are good actors, and that's why we're not suggesting to get rid of consumers paying for these interconnection costs. We just want a reasonable allowance so that those outlier scenarios are reined in.
And with respect to the, to the outliers, do you believe that those outliers or anyone who is sort of baking, their financing together, they're putting their financing together, rational business behavior would be that you would ultimately try to recover those upfront costs, even if they're higher, through your customer base, right? You try to amortize those costs over time. So wouldn't they get socialized in the end?
Not necessarily. I mean, if you're talking about renewable projects specifically, the vast majority of those have an off-taker under a purchase power agreement or multiple off-takers under a purchase power agreement. And so if I were a renewable developer, what I would do is look at, if I site in this location, what are these interconnection costs going to be that I have to bear? And if I think I can still be cost competitive on a PPA bearing some of those costs, I'll move forward. If not, I might choose a different location for the project. I might make a different choice.
But don't you think that the first decision tree that you just described is what rational behavior in the marketplace sort of supports currently?
I'm not sure because today the costs are covered completely. And so there really is no cost incentive for siting discipline on behalf of the developers. So this would, if they exceed the allowance that's set, they would either have to bear those costs and try to pass it through in a PPA or choose not to proceed with the project or choose a different location for the project.
Okay.
Any other questions, members? Thank you.
Thank you.
Michelle Richmond. Michelle, we have you registered for Texas Competitive Power Advocates for HB 1984, is that correct?
Yes, sir.
Go right ahead.
Thank you. Michelle Richmond on behalf of Texas Competitive Power Advocates, and we are in support of House Bill 1984. We too have long advocated for some cost sharing on interconnection costs. They are completely borne by consumers today. They are a significant portion of the regulated side of a consumer's bill for which they cannot compete it away by shopping the market. And there are a number of examples of poor siting decisions that would benefit from this. We have recommended previously and continue to that there be some type of component that looks at the reliability of the resource that's being interconnected in the cost considerations that the commission looks at, as well as to look at some type of capital cost cap to ensure that the estimate for what the interconnection will be when it's approved is not completely blown out of the water by the actual cost when it is completed. And we have seen situations where the estimate for what it was going to cost that's put onto consumers' bills ended up being significantly less than the actual cost when they were put into rates.
Any questions, members? Thank you.
Thank you.
She's for. Mark Stover. Mark, we have you registered on behalf of Apex Clean Energy against HB 1984. Is that correct?
That is correct.
Go right ahead.
Thank you. Good evening, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Mark Stover. I work for Apex Clean Energy. I'm testifying today against HB 1984. Apex is an independent power producer. To date, we've commercialized around 3,000 megawatts of clean power capacity in the state of Texas. That's roughly a $4 billion investment in the state. HB 1984 is based on a narrative that clean power project interconnections are a burden to consumers. You've heard this session and last that clean power developers pay no interconnection costs and that we make poor siting choices. This is simply not true. I want to provide the committee with a few facts and then I'd be happy to answer any questions. First, clean power developers do pay for infrastructure to connect to the power grid, period. Under PURA, utilities pay for work to prepare their system to deliver new power for the benefit of consumers. These expenses are secured by financing from developers like my company and reimbursed after the utility work is done. During that time period, my capital, private capital, is sitting on the sidelines. When the utility work is done to upgrade its system, to prepare its system for new power supply, that cost is then socialized and it is paid for by residential, commercial, and most industrial energy consumers. Third point I'd like to make is that clean power plants are also power consumers. We have a monthly power bill. We need station service to help run our facilities. And we pay a power bill like a residential consumer. And in that power bill, my plants, my company is paying for the socialized costs of transmission and distribution infrastructure. I'd also like to add that despite what you're hearing, it is in our best interest because we do sink a lot of capital into our interconnection process. We seek to build as close to load as possible. We seek to build as close to interconnections, but it's a complex process and always not that simple.
And we have you down again against HB 1984.
That is correct, yes. Thank you.
Representative Anchia.
Yeah, Mark, I'm trying to understand this bill and then, the support of different members. I just thought I heard support of, thermal generators for having more costs built into their site location and interconnection on thermal generation, which was weird. Talk to me about your siting process and just the different factors that go into it. Because Katie talked a little bit about outliers, also said that most of the people in the market make rational decisions. So I assume some of your decisions involve trying to be as close to load as possible, right? Siting near where interconnection opportunities are already, the easiest ones, right? The lowest hanging fruit. What else might go into that decision?
Well, thank you for the question. I appreciate that. It is a complex process. In project development, we do spend a tremendous amount of time and resources trying to find an interconnection point that is beneficial to the project. All resources, whether it's thermal, wind, solar, geothermal, we all follow the resource primarily to maximize the output and the efficiency of our power projects. As I said, we try to get as close to the interconnection point as possible. I can give you a couple of examples. So we built a project about 2 years ago in West Texas where our cost, the cost that we absorbed to interconnect our project to the grid, was $16 million. The work that had been incurred by the utility and socialized was $3 million. When you look at interconnections, there are really two buckets of costs that we're talking about. One that's absorbed by the developer, the other that is absorbed by the utility. And in our case, it's kind of known as the driveway. So if you're the interconnection point, I am building to you in the vast majority of cases. There are times when a TDU, transmission utility, needs to come our way. That is fairly rare, but it does happen. And yes, all forms of generation have some bad examples of high interconnection costs. We've heard a lot about wind and solar interconnection costs. There's a gas plant, it's actually 2 plants, part of a production facility that in 2014 connected to the grid. That project needed a 51-mile line that was constructed by Sherryland Utilities. It was a $104 million investment to connect that project to the grid. That $104 million was completely socialized. So, there's an example of a high-cost thermal plant that connected to the grid. Ironically, that project also connected to a CREZ line. So, we hear a lot about CREZ being just for wind and solar. Well, there's a natural gas plant right there that connected to a CREZ facility. And, again, in many cases, as I said earlier, when the utilities are conducting the work on their system, they are given a lot of runway by the PUC, by ERCOT, to design whatever they think is best in terms of integrating new power into the grid. So the work on their substation, whether it's a new substation or maybe it's an upgrade or there's some other equipment, we leave that decision to them. This bill would put us in a position where, number one, we have an undefined amount of new costs coming our way, and we will put that in our power purchase agreements. We will send that back out to the market right now. And as I think you all know, wind and solar are the only resources in the ERCOT grid that put downward pressure on electricity prices. We've saved consumers roughly $900 million a month last year. We've saved consumers $30 billion since 2010. And if you look at the socialized interconnection costs for wind and solar, very difficult to come up with a number. You could probably work with the PUC and the ERCOT to get that. But at the end of the day, the investment, or I should say the return on investment for socialized costs on wind and solar are high. Lower power bills, you've got avoided emissions, you've got avoided water use, you have local tax revenue, you've got landowner payments. So there's a huge revenue stream that has come out of these socialized investments.
And this is my final question. What's odd to me is that ultimately these costs are going to get baked into your financing, that you're going to finance the project and amortize it. You're going to have an amortization schedule, and you're just going to pass those costs back through in your power purchase agreement, are you not?
That is correct.
Which will increase costs to consumers.
That is correct. I would argue that, the cost will still be there, but it is more efficient and more cost-effective if work on a utility system is conducted by the utility, paid for by the utility, and then spread out to all power consumers on a socialized basis over a longer recovery period. As my private investors, if I have to start paying, and I don't know what it can be. I mean, my company, quite frankly, has really good siting discipline. We don't have a lot of socialized interconnection costs in ERCOT, but under this bill or under 1287, I'm facing an uncertain environment. I could be looking at a couple $100,000 on a project. I could be looking at a few million. Again, if I have those costs, they're going out the door.
Okay, thank you.
Any other, Representative Turner?
Thank you, Mr. Chairman. Yeah, I'm trying to understand this too. So you gave an example of a project where you said your company paid $16 million and then $3 million was absorbed by the utility and therefore socialized. So is that ratio representative of most projects, or is that one more skewed towards your company paying the preponderance of the total cost, or what would be?
Yeah, that's a great question. And I would be hesitant to speak about interconnection costs for other developers. This is a really difficult number to figure out. I've actually spent time doing it. There are two ways. So all generators have to file their interconnection agreements with the Public Utility Commission. Often, though, when those agreements are filed, you're fairly late stage in the project, and so that the estimates from the utilities could be off. I mean, their work could end up being less expensive. It could end up being more expensive. You can then look at the construction reports that are filed by the utilities. It's a really difficult number to figure out. I know that in other markets, other states, they'll have an allowance of, say, $50,000 a megawatt for generators, and then anything above that is absorbed by the generation company. But again, right now, this bill, it's vague enough that we just don't know what the environment will look like going forward. And again, I'd be a little hesitant to try to put a per megawatt number on all socialized interconnections for renewables, thermal, really any resource.
Okay. Is the bill speaks to all forms of generation?
It does. That's correct.
So is the bill, do you feel like the bill is still disproportionately negatively impacting renewables as opposed to thermal generation? And if so, I'm trying to understand why.
Well, I would certainly say that SB 1287, which was sent over, does do that. There is some discriminatory language in that bill. I actually think the bill that was offered today, 1984, is a cleaner approach. We had sat down with the chief of staff or the representative earlier in the week. We've provided some red lines. We do have some ideas on how you could improve the bill, take out some of the uncertainty that I was talking about earlier.
Okay. All right, thanks.
Thank you. Any other questions, members? Thank you, sir.
All right, thank you.
John Gordon. John, we have you registered for self for HB 1984. Is that correct?
That is correct.
Go right ahead.
John Gordon, registered professional engineer electrical. I'm in support of this bill. Prior to 2000, any utility in Texas that had an area, they had to include the transmission cost in with siting generation. And so a Houston Light and Power or a Texas Utilities, they'd site their nuclear plant fairly close by so they wouldn't have to have a lot of transmission, especially the high voltage. At 2000, you cut it off. You had all of the generators separate from transmission. And we had, what we got, 35,000 megawatts of wind power out, including sun power out in West Texas. And yeah, they can hook up for a small amount to the local 138K grid, but that couldn't get the power over to where it's needed in East and Central Texas. So you had Cruz, whatever the name of that huge transmission bill, and that got stuck on all the consumers, and that was all because of a massive amount of wind and solar out in West Texas. And they didn't have to pay for that. That's on all of the customers. So you take a city like Georgetown that buys a wind plant on the west side of Amarillo, and it's got to go 500 miles to their city. They're paying for a little bit of that, but Texans are paying for most of that transmission. Or Georgetown buys solar near Fort Stockton. Texans are paying for that to Georgetown. I site my plant right up here, right next to the substation. There's no transmission lines. Anyway, so this bill puts the owners back on the siting of the plants. And what you just heard, I hope you'll ask questions of me that you just asked of that last gentleman.
Thank you, John. Any other questions, members?
Yeah, how about questions?
No, that's not how it goes, John.
I know.
Thank you very much. Anybody else? Anybody, those are all the registrations. Members, anybody else who wants to speak on for or against this bill? Seeing none, Representative Asut to close.
Thank you, Mr. Chairman. I close.
Thank you, Representative. Any questions? Chair moves leave HB 1984 pending at this time. Is there any objection? Hearing none, HB 1984 is left pending. Chair lays out HB 3440 and recognizes Vice Chair Hernandez to explain the bill on behalf of Chairman Canales.
Thank you, Mr. Chairman and members. House Bill 3440, which aims to increase open government transparency and efficiency by requiring more governmental entities to post their agendas online. Under current law, cities, counties, school districts, and other entities are required to post their meeting notices online if they have an internet website. House Bill 3440 simply requires that these entities also post their agendas. By making agendas available online, local governments can increase transparency and make it easier for the public to stay informed about upcoming meetings and the topics that will be discussed. This bill seeks to help promote trust and accountability between citizens and their local government. Thank you for your time. I reserve the right to.
Any questions? Thank you. We'll let you close. Jack Finger. Jack Finger. Jack Finger. We'll show Jack registered for self for HB 3440, but did not testify. Members, that's all the registrations. Do we have anybody else who wishes to speak on for or against the bill? Vice Chair Hernandez to close.
Thank you, Mr. Chairman. I close.
Thank you very much. The chair moves to leave HB 3440 pending at this time. Is there any objection? Hearing none, HB 3440 is left pending. Chair lays out HB 3941 and recognizes Representative Goodwin to explain her bill. The chair offers a committee substitute to HB 3941.
Thank you, Chairman Hunter and members. The latest winter storm across Texas left more than 400,000 people without power. One cause of outages in central Texas was the accumulation of half an inch of ice on trees. This caused limbs to fall and in some cases entire trees to be uprooted and fall, taking power lines down with them. In response to this recent winter catastrophe, Committee Sub-House Bill 3941 is intended to correct vegetation management issues within municipally owned utilities and electric co-ops. Vegetation management is a crucial aspect of maintaining the safety and reliability of electricity infrastructure in Texas. It plays a significant role in preventing electric outages and wildfires, both of which can have devastating effects on communities and the economy. In recent years, Texas has witnessed an increasing number of wildfires and power outages due to extreme weather events and unmanaged vegetation growth, thus highlighting the urgency of addressing this issue. One of the primary concerns related to vegetation management is its impact on the transmission and distribution of electricity. Unmanaged vegetation can cause power outages by coming into contact with power lines, leading to short circuits or even sparking fires. A third of all regular power outages happen when tree branches fall on power lines. This data highlights the importance of managing vegetation. Wildfires are another significant concern in Texas, and proper vegetation management can mitigate the risk of these destructive events. The Texas A&M Forest Service reported that in 2022, we saw about 12,400 wildfires that burned a little more than 650,000 acres across the state. This is the highest number of reported wildfires that we've had in the state of Texas since 2011. Wildfires can be ignited by power lines coming into contact with dry or overgrown vegetation, resulting in significant property damage, loss of life, and destruction. Vegetation management is essential in preventing these incidents and preserving the safety of Texas communities. To specifically address these concerns, my bill mandates municipally owned utilities to submit annual reports to the PUC on their infrastructure improvement and maintenance efforts, including vegetation management. Electric utilities are already required to submit these reports, and this bill is just holding municipally owned utilities and electric co-ops to the same requirements. This bill requires the utilities to identify areas susceptible to damage during severe weather and harden transmission and distribution facilities in those areas, have and follow a vegetation management plan, and inspect distribution poles. In addition to these requirements, the bill mandates utilities to include a summary of their activities relating to preparing for emergency operations. For utilities and co-ops that do not submit their reports, the PUC will hold them accountable and issue a violation, which would be public. The implementation of this bill will help promote transparency and accountability. As utilities submit their annual reports, regulators and stakeholders will have a clearer understanding of the efforts being made to mitigate the risks associated with unmanaged vegetation. By addressing these concerns, Texas can achieve a safer, more reliable, and resilient electric infrastructure, ultimately protecting communities from the devastating effects of wildfires and power outages. The committee substitute simply adds that electric co-ops are also required to submit vegetation management reports to the PUC, in addition to municipally owned utilities and electric utilities. Thank you. I'm happy to answer any questions.
Any questions, members? Thank you. We'll give you the right to close. Elton Richards. Elton, we show you've registered for Austin Energy 4 HB 3941. Is that correct?
That is correct, Chairman.
Go right ahead.
First of all, good to see you again, Chairman Hunter, Madam Vice Chair, and members. I'm Elton Richards. I'm the Vice President of Field Operations for Austin Energy, and I'm here in support of Bill 3941. So what I'll do first is kind of give a quick history on the vegetation management for Austin Energy itself. In 2019, we implemented a standard that doubled the vegetation distance for the power lines. 2020, we submitted a budget that would double what our current allocation was. That went from 34 to 84 million, or 87 million. In 2021, we initiated a contract with 3 Davy, Wright, and Ashland vegetation management companies to start working those circuits, which are the 15 feet for fast growing and 8 feet for slow growing. Since then, we made a lot of strides. We've got 62 full circuits that have been trimmed to that standard. We have also concentrated on the wildfire circuits and also the underperformance circuits, which are the ones that have the highest amount of outages. One of the issues that we have is, no surprise to anyone, is a labor shortage. So we don't have a budget or a policy issue, we have a labor shortage. So what we've done is we've taken the funds that we haven't utilized and we're submitting a new contract that brings in 4 additional vegetation management companies that potentially didn't have the volume for the large scale, but they'll be able to assist us on the smaller scale to give us that. So we are here in support of it, and at this time I'll take any questions that you have.
Any questions, members? Representative Raymond.
I apologize. Tell me again who you're with?
Austin Energy, sir.
With Austin Energy. Did you, I don't know if you checked on this, but for example, have you all looked at how San Antonio fared and how, you know?
Absolutely, sir. So first, let me explain. I'm retired military, worked in 3 utilities since I've retired.
Man, I can tell.
Don't give the guys behind me any ammo. They use that all the time on me. First of all, there was a great article from a PhD arborist in Fort Worth that explained exactly the difference.
Let me help you out.
I'm sorry, sir.
Just answer his question.
I am.
I'm going to regulate the time. He asked you about San Antonio, so go ahead. And,
did you? So we did. The problem is Austin is very centrally located, very high population, and a high tree population. So one is just the vegetation itself in the consolidated area. The second issue is the 2 most common trees in Austin itself is the live oak and the juniper, which are all green all year round. So the surface area for the ice was almost triple what some of the other trees that did not have any vegetation on it was. So we did look at the other companies, sir.
So San Antonio didn't have as many problems or as you all did?
That is correct. They have half their service territory is rural, where we don't have that. Ours is very concentrated. And then also the issue with the 2 primary preponderant types of vegetation that are in the Austin area versus some of the others.
Well, some of the concern I heard, and you probably heard some of the criticisms, but I don't like to take for granted that the things you sort of hear anecdotally are true, but where there's some areas of Austin where, there wasn't a problem, right? In other areas, there were more problems where the trees had grown more and maybe you should have cut them and you didn't cut them. In part, I guess you're saying you didn't have the workforce to do it. You couldn't find the folks to go hire to do it. So I'll ask you this. In Austin, what areas were affected the most, where branches were breaking because they hadn't been cut?
Sir, I can tell you, and I said this during a press conference, this was a non-discriminatory storm. I've never seen a storm so spread out across the whole service territory. And let me state this, and I said this during a press conference, this wasn't a limb issue with vegetation management. This was an ice and act of God with trees coming down. I had trees coming down that were 30 to 60 feet tall that no amount of vegetation management could have prevented that. So that we had more of those coming down than just the limbs coming down, sir.
And so do you think this could happen all over again?
Oh, absolutely. I've said it before. We could do, if I was today, even before the storm, everything cut to standard, the way that the vegetation is in Austin itself, we had take a 60-foot tree, clear cut 15 either side feet, all the way to the sky. When that amount of ice, which I think one person said added 3,000 to 5,000 pounds on the canopy of that tree, it just pulls it completely over. So it will definitely has the potential to happen again. Can we lessen it? Absolutely, and that's exactly what we're trying to do, is we're trying to see how we can prevent it from being so severe the next time.
Thank you.
Other questions, members? Thank you, sir.
Thank you, Chairman. Thank you.
Julia Harvey. Julia, we have you registered for Texas Electric Cooperatives Against 3941. Is that correct?
That is, yes.
Go right ahead.
Thank you, Mr. Chairman. Members, I'm Julia Harvey on behalf of Texas Electric Cooperatives, testifying in opposition to the committee substitute for House Bill 3941. I understand electric cooperatives were added in the substitute, and so I don't have a lot of information on hand on this issue. We want to follow up with Representative Goodwin and her office with details. I can say that on first impression, I don't think more administrative reporting is really warranted. I know there was a historic ice storm in Central Texas in March that damaged infrastructure, but we don't quite see the need for reporting for all co-ops statewide. We want to engage with Representative Goodwin on the issue. We want to look at it closely. We take it seriously, but based on my understanding of the substitute, this sounds like unnecessary administrative burden that's duplicative of what co-ops are already reporting to their local boards. And so for that reason, we're opposed to the committee substitute. Thank you.
Any questions, members? Thank you.
Thank you.
Thomas Kilgore. Thomas, we have you registered for City of Lakeway and Self for HB 3941. Is that correct?
That is correct, Chair.
Right ahead.
Thank you. I'm Tom Kilgore. I'm the mayor of Lakeway, Texas. I have 2 state representatives, both of who are here today I'm working with. I also have 2 county commissioners. I am a retired military officer, and I spent 20 years in the energy business. I'm here to support this bill. It was not really a regional storm, although it affected the entire region. The area outside of Austin proper, the hill country, the cities of Bee Cave, Lakeway, the Village of the Hills, the small surrounding towns, were horribly impacted by the lack of a vegetation plan by Austin Energy. The fact that they don't have to report that, we don't have to have a chance to look at it, was terrible. We were without power at our hospital for 4.5 days. We were without power at our critical nursing homes for 6 days, all of which was caused by the lack of vegetation trimming in the city of Lakeway and the Village of the Hills, which we are totally surrounding. So this vegetation plan is absolutely essential because we cannot have this mistake happen again. We cannot have this mistake happen again. It happened years ago in Houston, early 2000s, when one of the hurricanes came ashore, and we saw how the PUC regulated Reliant Energy for collecting tree trimming funds, but never actually doing the tree trimming. I lived in Kingwood, Texas at that time. So I'm asking you, please, put these plans in effect. Austin Energy covers roughly 40% of my residences. and about 75% of my commercial infrastructure. And Pedernales Electric Cooperative, which is also affected by this bill, has the other 60% of my residences and about 30% of my commercial. I am deeply invested in making sure the 22,000 residents of Lakeway, Texas do not go through another extended outage. Thank you.
Thank you. Questions, members? Thank you very much.
Thank you.
John Gordon. John, we have you registered for yourself for HB 3941.
Yes, John Gordon, registered professional electrical engineer. A very good bill. I'd like to see if you would add a point C. At the bottom, it says municipal utilities, and now no electric cooperatives, shall make such report available to its electrical customers. Those are the peoples in municipalities and co-ops that actually own the municipality system and the co-op system, and they very seldom get the information. And so I'd like to see that point C added to the language of the bill. I'd also point out, I think I said it a couple of weeks ago, tree trimming is probably the most important thing to keep your electric system running, even under hurricane conditions. And to have 60-foot trees next to a 30-foot electrical line just invites disaster. You've got to do good planning. And that's the whole point of this bill, is what is your plans, how are you doing it, and how are you making sure that you're not going to take down our electric lines? By the way, I do remember a real big ice storm in the late 80s, early 90s in the same area, but it was a little bit west, and it wiped out electric lines. So I support this bill greatly, and I think that the people that own the systems, the municipal systems, should be told by their municipal leaders what they're doing. Same thing for the co-ops. What are you doing to make sure we have power? Thank you very much.
Thank you very much, John. No one else. Members, that's all the witness registration. Is there anybody else who wishes to speak on for or against this bill? If not, Chair recognizes Representative Goodwin to close on her bill.
Thank you, members. I close.
Any questions, members? Thank you, Representative. The chair moves to withdraw the committee substitute to HB 3941 and leave the bill pending at this time. Is there any objection? Hearing none, HB 3941 is left pending. The chair lays out HB 3943, recognizes Representative Goodwin to explain her bill. Chair offers a committee substitute to HB 3943.
Thank you, Chairman. Committee Sub House Bill 3943 was authored in response to the recent winter storm that impacted 400,000 people across Texas. The bill mandates independent third-party auditing of electric co-ops and municipally owned electric utilities following extended power outages. This legislation is a critical step in ensuring the resiliency, reliability, and transparency of our electric power system. The requirement for an audit after a power outage lasting 5 days or more, affecting 10% or more of retail customers, is a reasonable and necessary measure. These audits, conducted by auditors with professional certifications established by the Commission, will help identify vulnerabilities in the power system and promote improvements to prevent future outages. Making the audit reports publicly available ensures that residents and stakeholders have access to essential information about the performance and reliability of their electricity providers. This transparency fosters accountability and empowers consumers to make informed decisions about their energy choices. Additionally, this bill strengthens the relationship between electric utilities and the communities they serve by encouraging proactive measures to improve service reliability. By identifying and addressing weaknesses, electric utilities can better prepare for and respond to potential disruptions, ultimately benefiting customers and enhancing the resilience of the energy infrastructure. The committee substitute makes a few changes to the original bill. The changes are as follows. First, adding safeguards to prevent disclosure of information that would be detrimental to the security of electric companies. 2, clarification that the same 10% of customers must experience the extended outage. 3, clarification that the outage must be caused by failure of equipment to operate by the municipally owned utility or co-op in question. This is needed because outages can occur due to failures of other companies' transmission lines, which feed our system. So overall, Committee Sub House Bill 3943 provides a necessary framework for improving the transparency, reliability, and resiliency of electric utility companies.
Thank you. Members, any questions? All right, well, I will give you the right to close.
Thank you.
Stuart Riley. Stuart, we show you've registered for Austin Energy and you're for HB 3943. Is that correct?
That's correct, Mr.
Go
Chairman.
right ahead.
Thank you, Chairman. Members, I'm Stuart Riley, Interim General Manager of Austin Energy. I appreciate Representative Goodwin working with Austin Energy on this bill. The committee substitute reflects our suggested changes. Currently, Austin Energy conducts an after-action review of each significant event impacting its system. This process is a thorough and honest assessment of what happened and culminates in a public report of specific follow-up actions. Also, after the February ice storm, the city directed an audit of Austin Energy's vegetation management program. This audit is underway. My key staff members and I regularly meet with the city auditor's office, and the findings will be shared and discussed publicly. Generally, Austin Energy's system reliability metrics are better than industry averages. Under normal conditions, our customers experience an average of less than 70 minutes of outage minutes per year, compared to a statewide average of over 370 outage minutes per year. That being said, many electric utilities are experiencing extreme weather, causing extensive damage, leading to longer duration power outages on a more frequent basis. The February ice storm was the largest restoration operation in Austin Energy's 127-year history. My team and I will be visiting peer utilities that experience extreme weather to learn best practices in restoration operations and communications. At Austin Energy, looking at how we can make improvements for our customers is critical. We're currently taking immediate action to enhance our emergency response capabilities, and we're studying longer-term measures to improve the resiliency of our system as we face more extreme weather events. Thank you, Chairman, and I'm available to answer any questions.
Stuart, thank you. Any questions, members? Thank you very much.
Thank you.
Julia Harvey. Now, Julia, we show you've registered for Texas Electric Cooperatives against HB 3943, but it says Julia Harvett. So we have your permission to put Harvey, correct?
Correct, some type
And
of.
everything else is correct.
Yes, sir.
All right, and she has the right to correct it.
Yes.
Go right ahead.
Thank you, Mr. Chairman, members. I'm Julia Harvey on behalf of Texas Electric Cooperatives, testifying respectfully in opposition to the substitute to House Bill 3943. We agree fully with Representative Goodwin's intent, but in our view, an independent audit after a natural disaster isn't necessary for a few reasons. So in review of the recent events that have occurred on electric cooperative systems, the only events that we believe would have triggered a reliability audit under HB 3943 were Hurricane Ike in 2008, Hurricane Harvey in 2017, and Hurricane Laura in 2020. Winter Storm Mara, the ice storm that occurred in March of this year in Central Texas, would not have triggered an audit for any co-op under the bill. Requiring an audit after that kind of natural disaster isn't necessary because we believe there are several independent reviews that already occur after a major weather event. So NERC creates an independent analysis after a major event or a transmission level incident, and then FEMA produces reports after major weather events. Co-ops also conduct their own internal reviews and provide those to their boards. So for co-ops affected by Winter Storm Mara, with that extreme icing, they inspected their system post-event to identify areas where additional maintenance is needed and have devoted resources to improving resiliency there, and there's information online about that. And then finally, for those longer duration events that are described in the bill, those occur for us when the end user can't take power because of damage to their premise. So it's not a problem with the co-op system as much as an inability for the member to be safely restored because of damage on the homeowner side. And so while we, again, agree with the intent of the bill, we don't believe an audit's necessary because those reviews are already happening or the events are outside the control of the co-op. Thank you, and I'm happy to answer questions.
Any questions, members? Thank you very much.
Thank you.
John Gordon. John, we have you registered for yourself for HB 3943. Is that correct?
Yes.
Go right ahead.
John Gordon, registered professional electrical engineer, another well-written bill. I will have to say that I disagree with the numbers in that 5 days and 10% is too large an amount. It should be triggered by a 3-day outage of 3%. And the reason is if you look at like a city of Austin, 10%, you'd have to have probably 50,000 homes or I don't know how many residential out for 5 days. That's a huge amount of time. 3% of the population would, for city of Austin, would be 8 or 10,000 for 3 days. That's a lot of damage to a lot of people or for the businesses. So I would recommend that both that and for the co-ops. By the way, engineering design of the system can limit it. If you're just doing everything radially, then if you chop it off at the start of the radial, everybody is lost. If you do a looped system with segregations, if one part gets knocked out, the rest of the part can be added back again. So this also goes to the engineering design of these systems. And that's why audits need to be done as to whether they're doing a good job of engineering.
Thank you, John. Any questions? Thank you.
No? Okay.
Thomas Kilgore. Tom, we've got you registered for City of Lakeway and Self for HB 3943. Is that correct?
That is correct, Chairman.
Right ahead.
I'm the mayor of Lakeway, as I've said. And by the way, I would like to commend you on the crisp way you run the day. There's an awful lot of wood that you're chopping, and you have to get through an awful lot of statements, as well as the representatives who ask good questions. And then, unlike my council, if one member asks a question, they all have to ask a question. So
you're quite the politician. Go ahead.
So with that being said, I do stand here in favor of the bill. Audits are essential. Austin Electric serves more people than the city of Austin. I'm sorry, we're just a small little town outside here, and along with all the other small little towns. But if they've conducted an after-action review, it's news to the mayor of Lakeway. They have not talked to us. They have not talked to my emergency management coordinator or the director of public works. I don't know how you evaluate and stay internal to a company without an external audit. An external auditor would have gone out to the 50,000 customers outside the city limits and would have said, what did you learn? What did you experience? How can we be better? So that's why the audit, especially for Austin Electric, is important. I would also say, and I've spoken with Representative Goodwin, the co-ops have an independent board that we vote on. And in this case, if the co-ops were to be left off this bill, I would still be in favor of the bill for municipal-owned ones and the co-ops having their own board audit. But that is a slightly different stance than I took on the previous bill, and I wanted to clarify that if that would be okay. And so with that, unless there are questions, that concludes my support for Representative Goodwin's bill. Thank you very much.
Mayor, thank you. Any questions? Thank you, Mayor, for being here.
Thank you very much, Chairman.
Sean Hall Laquana. Sean, I'm going to have to spell it again. So you are registered for KRIAHBSHALOM and Self against 3943. Is that correct?
Yes.
Go right ahead.
All right. Chair Hunter and committee members and sponsor of the bill, I'm against HB 3943. conscious of the rectitude of our intentions, worshiping Almighty, the glory of the true and living God. I stand against HB 3943. Don't blame God. He's the answer. Talk to mental health departments, talk to their law departments, talk to the real estate holders. You'll find out a lot more answers to the questions about what has happened about tree management and growth. No one is good but one, that is God. But if you want to enter into life, keep the commandments. A free, sovereign, and independent republic to secure welfare and happiness, not for equipping boards, rule makers, and or lawmakers, certified or not, public or private, failed. They failed. Even still having revised oath of office in June of 2020, and the Public Accountancy Act, Section 901.257, trying to be above law, and you want to put your trust in accountants? Your mind will meditate on the past terror. Where's the accountant? Where's the tribute collector? Where's the one who spied out our defenses? For the Lord is our judge. The Lord is our lawgiver. The Lord is our king. This is not a joke. He is the answer. Kriyat Shalom means covenant of peace. And he cut a covenant with this land hundreds of years ago. And we are blessed and highly favored that he even continues to keep the covenant in this very hour. Thank you.
Thank you very much. Any questions? Thank you very much. Members, that's the last of our registration. Is there anybody else who wishes to speak on for or against the bill? If not, Chair recognizes Representative Goodwin to close on our bill.
Thank you, Chairman and members. After this recent winter storm, we wanted to make sure we did something to ensure accountability, to have some consequences, but not make it too incredibly punitive on our electric provider. I think these are really solid responses to the storm that will improve our city-owned utility. And I think maybe we can make some improvements. I've heard some things that will potentially help the bills. And with that, I close.
Thank you, members. Any questions? Thank you, Representative. The chair moves to withdraw the committee substitute to HB 3943 and leave the bill pending at this time. Is there any objection? Hearing none, HB 3943 is left pending. Chair lays out HB 4207 and recognizes Representative Trox Claire to explain her bill.
Hi, Chairman and committee members. Thank you so much for taking the time to hear these important bills on Austin Energy and other municipally owned utilities. So 4207, as you just heard during the most recent winter storm, my constituents lost power for up to 11 days, despite the fact that towards the end of that time, we had temperatures up in the mid-50s. While Winter Storm Mara impacted people throughout the state, despite the fact that other areas had more ice accumulation, have utilities that serve more customers and have more tree cover, over 50% of the outages that happened in this state were Austin Energy customers. That's 174,000 people. While this is a symptom of a broader systemic management problem that we will discuss further in the following bill, it is so critical that the most basic services are addressed for operational stability and peace of mind for customers. So what does the bill do? Electric utilities in the competitive market are already required to submit a report to the PUC identifying areas that are susceptible to damage during severe winter weather, including vegetation management and inspecting distribution poles. This bill, simple two-page bill, simply requires MOUs to submit this same information to the PUC. In the case that the commission determines that the plan is insufficient to ensure reliable service, the MOU, the utility would be prohibited from transferring money from the utility into the city of Austin's general fund or the city that it served. Austin Energy transfers about $150 million a year to the city's general fund. And I think customers have a reasonable expectation that when they pay their utility bill, that money goes to providing affordable, reliable electricity, not transferred into other areas with no accountability, especially when they're in situations frequently where they're out of power. However, I am working with the city on a committee substitute that would address two significant concerns that they brought to me and that I'm happy to address. Number one would be allowing the municipally owned utility the opportunity to cure the issue. They submit the vegetation management plan. If the PUC says there is a problem here, they would have the opportunity to cure that issue before any action was taken. And instead of prohibiting the entirety of a transfer from the utility to the city's budget, it would simply hold back the amount of money needed to specifically address vegetation management. So this bill has a little bit more teeth in it to make sure that we're really going to address the problems that were so apparent in this last winter storm. And I look forward to working alongside my former colleagues at the City of Austin to come to a mutual agreement on this bill.
Thank you, members. Any questions? Representative Raymond?
Thank you, Madam Chair. So I think you were sitting here, did you hear the former military guy?
Yes, sir.
Did you hear his testimony?
Yes, sir.
And so had you talked to him before and he seemed to indicate that, I'm not sure you could have stopped what happened. Now, I don't know, you know.
Sure.
It was unprecedented and so forth. But maybe I should ask you, you were on the city council in Austin, right?
Yes, sir.
For how long?
4 years.
And so during those 4 years, did you all ever have, well, you didn't have as big a freeze. I guess the freeze they had recently was bigger than they'd ever had, or certainly?
I mean, certainly the storm was unique, and statistically, while vegetation management would certainly not have prohibited the outages that we saw other utilities who have much better management of their vegetation still have some outages, but much less severe. I mean, when you look at the total of the state, Austin was not the hardest hit. Austin does not have the most dense tree coverage. I mean, you look at East Texas and the Piney Woods and what you have over there. You look at North Texas, and they actually had more icing. Thicker ice on all of their trees. And so when you look at the total data across the state and you see that 50% of the outages were at Austin Energy customers, I think that data clearly shows that there is a significant issue. And it's not surprising. I'm going to take a little bit of liberty. In our next bill, we're going to talk about the fact that the City Council serves as the board of directors for the utility. I think that does cause some unavoidable conflicts of interest when it comes to the management of this utility. And when I was on the council, we certainly had conversations, with neighborhood groups, environmental groups, and others.
If you'll stay on this bill.
Oh, sure. Thank you. So I think the data clearly shows that there are significant issues in Austin Energy and that we should trim our trees.
And looking back, when you were on the council, did you feel like they did a good job then as far as managing vegetation, or?
No, sir.
You don't think they did a good job then?
No, sir.
Is that something that you sort of brought up at times, or what? While you were a council member?
I think that the issue has become more apparent in recent years as we've had multiple storms that have led to this. And I think that due to recent changes that were made, maybe there has been some improvement there. But ultimately, again, this bill is already required by other utilities across the state. We're not asking them to do something that is not already required in the competitive market. It's a pretty simple request to just submit an emergency management plan that would include a vegetation management plan.
With reference to, and you're working on a committee substitute.
Yes, sir.
So I got that, and it sounds like maybe it's getting closer to where you want. But with reference to, I don't want to say penalties. I think what you're saying is if the PUC comes back and says, hey, you need to do more, and I guess you put a value on that, some kind of value on that, that amount of money would be held back so that they could do that job, right?
That's right. That if you're not following through on trimming the trees, and part of the reason is potentially that you don't have the money to do it because you're transferring so much of the utilities revenue to the city's operating fund, you need to make sure that you're taking care of the utilities' basic costs before you're sending that money into other places.
And do you envision that the PUC would put some cost on that, or who would put?
There's no fiscal note, and we met with them yesterday, and there's no fiscal note on this bill, and we did meet with the PUC yesterday and confirmed that. They feel like they have the staff capacity to do that. And again, they're already reviewing these similar plans from other utilities across the state.
And are other utilities doing the same thing? I mean, is it set up to where if the PUC says, hey, we think you need to, do other things, you're not quite there on your vegetation, do those cities have to set aside money specifically for that, or?
Well, those utilities are not owned by a municipality, so they would be accountable to their board of directors and
Right,
their
but
customers. So in this, the difference between, so in this, there is a trigger that would require them to hold back a portion of the
I
transfer.
brought up San Antonio. Do they do that? Does CPS do that in San Antonio, or do you know?
They, as of now, no, because MOUs are not included in this portion of code, but they would be included now.
Would you be open to doing it for others, or just one Austin?
It applies to every MOU.
Okay.
Yes, sir.
All right, thanks.
Other questions, members? Thank you. We'll give you the right to close.
Thank you, sir.
Tom Kilgore. Tom, we've got you registered City of Lakeway and Self, 4HB 4207, is that correct?
That is correct.
Go right ahead.
Thank you, Chairman. So I'm here now supporting my other representative, Representative Troxclair. Austin Energy and their operations desperately need oversight and supervision. It needs to come from a third party. They need to have the same operating standards as publicly traded utilities. The Public Utilities Commission does a great job in determining your emergency management procedures. I know this firsthand, both as a resident and as an energy executive. They have to have better scrutiny of their vegetation management. It needs to be held to account. They need to have the dollars available. I can tell you that they have restarted their tree trimming out in the suburban areas to the extent they have had to hire some new crews. Our city forester had to stop them because they were cutting trees that were protected, and they were cutting trees in violation of the city standard and the utility code. So there's an awful lot of supervision that is desperately needed at Austin Energy in order to protect my residents and to protect those ratepayers who are there, because the work is simply not being done. And again, I will state, the ice storm that occurred downtown was nothing like the ice storm that occurred out in the hill country. We had significantly more damage, and not from large trees. It was the failure to trim trees on local distribution lines that was the responsibility of Austin Energy. And so for that, I would ask that you please move this bill favorably. It's desperately needed. My residents can't go another big ice storm or another big event and have mismanagement lead them to having the hospitals out for 4 days and the elder care facilities out for almost a week. Thank you very much.
Mr. Chairman?
Yeah, Speaker Guerin.
Mayor, did I hear you say that they were trimming some trees that were protected?
Yes, sir.
And so, but did those trees cause some power outages?
No, sir, they were.
Well, I mean, would they have caused had they not been trimmed?
No, they were oaks that are protected that need not to be trimmed until the end of the month of June because of oak
So in other words, you don't want them trimmed until the month of June. They were trimming them prior to that time.
That is correct. They were
trimming trees that could have affected the power line.
Well, they were trying to get back to the standard of 8 and 15 feet, but instead of trimming the junipers and the cedar and all of that, they were going after the oaks and other trees which are currently protected. And even a utility cannot cut a protected tree during the protected season. And so
I find it pretty stupid to protect the trees anytime it's knocking down lines, but that's all it is.
Sorry.
Other questions? Thank you very much.
Thank you very much, Mr. Chairman.
Ed Van EENOO. Ed, we've got you registered for City of Austin against HB 4207. Is that correct?
That's correct.
Go right ahead.
Thank you, Chair Hunter and committee members. My name is Ed Vanino. I am the Chief Financial Officer for the City of Austin. I'm here today on behalf of the city testifying against House Bill 4207 as filed. Under current state law, the authority for a municipality to transfer funds from its electric utility to its general fund appropriately lies with the elected governing body of the municipality. House Bill 4207 would subject that authority to the random and arbitrary approval of a non-elected state commission. This substantial loss in the predictability of general fund revenue would, and in my belief, materially weaken the financial positions of these municipalities, thereby potentially resulting in lower credit ratings and increased borrowing costs for taxpayers. Looking specifically to the city of Austin, the 8% of gross revenues that Austin Energy returns to the city's general fund is currently below the median for municipal-owned utilities in Texas. It is also below the average 9.4% return for investor-owned utilities. The annual return on the community's investment in Austin Energy represents an important, albeit declining, share of the city's general fund revenue, having dropped from 16% of total general fund revenue in 2009 to just 9% today. Over the past 10 years, the city has seen funding from the general fund transfer grow by less than 1% per year on average. Nonetheless, this transfer does add stability and diversity to the city's sources of revenues, which is viewed positively by credit rating agencies and helps the city to maintain a tax rate significantly lower than that of other large Texas cities. I'll just give you some examples. City of Austin, with a municipally owned utility, has a tax rate of 46 cents per $100 of taxable value. Look to San Antonio with their municipally owned utility, CPS, has a tax rate of 54 cents. Looking at three cities without a municipally owned utility, Fort Worth, Dallas, and El Paso, they respectively have tax rates of 71 cents, 75 cents, and 86 cents per $100 of taxable value.
Thank you very much. And we'll note you're against HB 4207.
Thank you.
Any questions? Representative Raymond.
Thank you, Chairman. You're the CFO, is that what you said?
Yes, sir.
So you probably, maybe you don't get into the guts of tree trimming that needs to be done. Is that right?
Only on my property, sir.
Okay. Well, but so you know how important it is.
Yes, sir.
But do you disagree with what Representative Troxclair is trying to do here in terms of making sure that the vegetation that needs to be trimmed is trimmed so that this very important thing called electricity gets to people's homes and so forth, businesses and all that?
Yeah, I don't think the city has an objection to making sure that the trees are trimmed appropriately.
Is it you're just concerned then that with her bill, even though I think she's working with you guys to try to, but are you concerned that a state agency, would come in too heavy and say, well, we think you need to spend, $30 million on this instead of really 15 or whatever it is?
I think my concern specifically as a city CFO is how the bill ties the decision of the commission to the city's general fund transfer for the ability of the city council to make the determination to make a transfer from the city's from the electric utility to the general fund and the impact that would have on our credit rating and our.
But it's only preventing you from transferring whatever you need to make sure that the work is done, right?
I don't believe that's correct. The bill is currently filed.
Well, no, but I thought, well, I'm sorry, you're right. We're testifying on this,
Yeah.
but I guess I thought you were working on it with her.
We are working on it, and I'd be happy to, as we continue to work, just as filed, we're concerned with the bill as filed. And
Okay, so you're hoping that you get to a point where if there's going to be legislation, that it makes it clear that the only thing you'd have to hold back is what is determined as necessary to get this work done, because it's, obviously the money's coming from Austin Electric, from ratepayers paying for that, right? And part of that money is supposed to be used to make sure the vegetation work is done. So I guess I want to make sure I understand. So you're supportive of making sure that all that work gets done the way it's supposed to, right? You don't have any problem with the PUC telling you, reviewing the plan and saying, hey, we think you guys ought to be doing more, or no, you're okay? Do you have a problem with that?
I think, my only problem that I'm testifying to is about tying it to the city's general fund transfer. I think if there was a proposal that simply said, city, you need to remedy the problem, I think that would be something that we'd be supportive of. But, defining what the remedy is.
But how do you, I guess what she's trying to get to, and I agree with, is yeah, they say, city, hey, y'all fix the problem. And they say, okay, we'll do that. And that's that. And we don't know that it really does happen. And what if it doesn't happen? Then you have another issue. So
I don't think the representative would agree to that kind of bill, and that's not what we're talking about.
oh, okay. Well, then I'm getting it wrong about what your position is, but I'm trying to understand your position and,
I think my position, as I'm trying to state it, is if there's a problem with the city's electric utility with Austin Energy's tree trimming, we would look to remedy the problem. Reducing the
I
general
guess my
fund transfer
impression is
doesn't
she's
remedy the problem.
I guess my impression is she's trying to make sure that you do.
And I think we need to work through how we define that.
Okay.
Representative Turner.
Thank you, Mr. Chairman. So I don't have any municipally owned utilities in my district or in my area. So can you tell me how this general fund transfer mechanism works?
Sure. So it's pretty standard for a municipally owned utility to have a transfer from the utility to the city's general revenue budget. The model for doing that varies amongst the different MOUs across the state. In the city of Austin, the formula that is set in place is to take 12% of revenues net of the fuel costs, essentially net of the power supply costs. So take out those and take 12% of the remaining revenue, and that's what the city's general fund transfer comes to. That comes out to be about 8% of total revenue, which is what I testified to earlier.
Okay.
That is set by council resolution. It's not something that we change just for, expediency purposes. If we have a hole in our general fund budget, let's increase the general fund transfer. We've never done that. We have a policy. We stick to it. It's important that we stick to it from the perspective of our rating agencies. And that's something that we've always done.
Okay. So what are when the funds are transferred to the city, what are those funds used for?
They become general revenue, so they're not dedicated to any specific thing in the general fund, but they pay for general fund services, police, fire, emergency medical services, parks, libraries, any municipal service that's in our general fund is supported through all of our general fund revenues, which are largely for the city of Austin: property taxes, sales taxes, the transfer from our two utilities, both Austin Energy and the water utility, and then miscellaneous fees and fines and forfeitures.
Okay. And so, like, cities in my area, I know, receive franchise fees from investor-owned utilities, and property taxes also, that they pay some property taxes. So is it fair to say Austin does not benefit from those revenue streams, or at least not in the same
we don't.
portion?
So there's two rationales, really, I think, behind the concept of a transfer from a municipally owned utility to a city. One is just a return on an investment. If you look at an investor-owned utility, clearly the investors in that utility want to get a return on the investment. And the other perspective to look at is kind of, like you were saying, the franchise fees and the property taxes that an investor-owned utility would be paying to cities in your district. Austin Energy does not pay those to the city of Austin, but they do provide a general fund transfer.
Okay. And you said investors in the utility. So in this case, who are the investors?
City residents. I mean, city of Austin owns the utility, and so I view it as the residents of the city of Austin are the owners, investors in the utility.
Okay.
They're the ones who benefit from the return on investment.
All right, thank you.
Representative Dean.
Thank you. And I may have missed it, but what is the annual revenue of the Austin Electric utility?
If you don't need me to be exact, I'll say it's about 1.8 billion.
The CFO, I'd assume you got a pretty good idea.
I do. It's about 1.8 billion.
What is it?
1.8 billion.
Okay. What is the total budget of the city of Austin?
The city of Austin, total budget, all funds budget is $5 billion.
So roughly 20% of that or more comes from just the electric utility.
Yeah, I think it's about 36%.
36%, okay. And in terms of dollars, what is the annual transfer, again, approximate, from the utility to the general fund?
It's in fiscal year 23, it is $115 million.
Okay, 115 million. Okay. And so again, you know, that general fund, you use that for road maintenance, you use that for pothole fixing, you use that for police, fire, and everything else, right?
Can be used for any of those things.
Okay. So one of the major contributors, or your major contributor, it looks like, as far as outside of, say, property tax and sales tax, the major contributor to the general fund, and again, fees outside of all that, is going to be your electric utility.
It's currently 9% of total general fund revenue.
9%.
Yes,
Okay.
sir.
But from that, a lot of that money that comes out of that utility goes to roads and streets and that type of maybe infrastructure maintenance, correct?
We don't dedicate it to any specific
Well, I know,
service, but it
in
goes to those
theory-
types of things.
in theory, if it goes into the general fund, it generally goes out to all of those type things.
Correct.
Yeah, and I think, in my opinion, what is the attempt here is to try and, you know, come up with a plan that says before that utility money goes out generally, it's to use to upgrade, whether it's through vegetation, some new lines, transmission lines and things, because y'all had problems with that too during this latest. I felt it, okay? And the vegetation. But I think that's some of the intent here is to try to make sure that the city of Austin, and I don't want to use the term wrong, but the city of Austin's not grabbing that money out of that general fund and then distributing it into a lot of things before making sure that that utility is sound from an infrastructure perspective. Does that make sense?
I understand, yes.
Okay. Thank you.
Representative Chia.
Just a couple of questions. I want to understand if the city was or was not being proactive in its vegetation management, because it's my understanding in talking to members of the city council and staff that the city had actually budgeted about, I don't know, between 15 and 20 million more in 19 or 20 for vegetation management. Is that accurate?
I'm sorry, I don't know if that's correct. I know we have an extensive vegetation management program in Austin Energy. What the budget was and versus what it is now, I'm not prepared to respond to that.
Okay. And the sort of a corollary question I had is, are you most concerned about the remedy in Representative Troxclair's bill, the penalty maybe being either proportionate or disproportionate, having a disproportionate impact on the city fund? Is that accurate? And you would prefer, not to put words in your mouth, an administrative penalty instead of proportionate administrative penalty as the remedy?
Yeah, we're still working through the details of that. We're looking forward to continuing to work with Representative Troxclair. I think the idea is to have a remedy in place. And again, simply reducing or eliminating the general fund transfer doesn't necessarily predicate a remedy. So I think we need to talk about what's the issue, what's the appropriate remedy to the issue. You know,
What about an administrative penalty? So I mean, I want to understand where you're headed, right? If you're saying, hey, this is too heavy of a hammer and it's going to impact us, maybe it impacts our bond rating, maybe it impacts, you know, our flow of revenue, then would you be okay with an administrative penalty if you did not adequately maintain your vegetation?
Yeah, we haven't had that discussion yet. Can't say. I'm not willing to say here that we'd be ready to accept.
But you would say there would have to be some remedy if the city failed to maintain its vegetation, would you not?
Thinking that the remedy would be to address the problem. If we had a report that said we've not maintained our vegetation, let's get out there and get done what needs to get done.
Fair enough. I noticed a difference.
To the problem.
Sorry, I noticed a difference in the bills, that one did contain a cure period and one did not. So, and this one does not. Pretty heavy remedy, no cure. But my sense is that a fair outcome on remedy could be you have a cure period so that you can demonstrate through a report, as you said, or otherwise, that you're taking necessary steps. And if you fail to do so, then some sort of administrative penalty.
Those are the types of things we're
Does
discussing.
that sound reasonable? Like a reasonable policy approach?
I think from a big picture, it seems like a reasonable approach, but you know,
That's all I
the
was
devil's always in the details.
That's all I was trying to get to.
Sure thing.
Representative Slauson.
Yes, thank you. So kind of following up on Representative Anchio's questions there. So the changes that Representative Troxclair is talking about, would that move you to neutral, that cure opportunity and limiting that holdback to just the cost to implement that vegetation plan?
Well, we're hoping to continue working with her and get right straight up to being, you know, in support of the bill, being for the bill. But, you know, right now, as filed, we're against it. We're working with the representative, and I'd like to see us get to being in support of the bill.
But would those two things move you to a neutral or to a support?
The cure period and some type of administrative.
Okay, thank you.
Any other questions? Thank you very much.
Thank you.
Adam Kahn. Adam C-A-H-N.
Not here.
Adam Kahn. We'll show that Adam registered for himself for HB 4207, but did not testify. Elton Richards.
Military guy again.
So Elton, we have you registered for Austin Energy against HB 4207. Is that correct?
That is correct,
Go
Chair.
right ahead.
Okay, again, I'm Elton Richards. I'm the Vice President of Electric System Field Operations for Austin Energy, and I'm here against the bill as it is written. I appreciate Representative Troxclair working with us to do the wording, but as it is, it's not a very good bill. Would like to correct a couple of things that were brought up, and thank you.
No.
Yep, sir. Go ahead.
Just talk about this. We're not point counter.
Okay, yes, sir. So as written, it's ambiguous and not well-defined. So Austin Energy has always been transparent and clear. We have no problem reporting to anyone, whether it be homeowners, the city, the state, or the PUC. The reporting is fine. We don't mind the audit. We're going through one right now. But I just feel that the way that it's written, it is ambiguous and not well-defined. And I'll be open to questions.
Any questions, members? Representative Raymond.
Did you say earlier what branch you served in?
Army, sir.
The Army. Thank you.
Thank you.
Representative Dean.
Okay, thank you. Just along the line of some of the other questions, am I wrong in understanding that at some point in time, y'all had a very robust or extensive vegetation program? And then it looks like at some point, then the program was cut entirely. Is that fact?
Not from my knowledge. I've only been there 3.5 years. Okay. I can tell you the knowledge that I do have was, for some reason, in 2006, there was a citywide initiative to reduce the cutting to half of what it was.
Yeah.
That stayed in place until 2019.
Okay.
Now, keep in mind, vegetation management continued during that time frame, but very small funding and very small cutting. And the problem with the tree population that we have in Austin is the reason we came up with this 15 feet, 8 feet, or 10 feet rather, was based upon the tree type on a 5 to 7 year cycle. If you cut that in half, it's impossible to stay up on it. So it got overgrown. So 2019 is when the Austin Energy reinstituted the distance. 2020 was when the budget came through from 34 to 87 million.
Oh, wow. Okay.
But 2021 is, in January 2021 is when the contract was initiated. So that's when I was able to actually bring the crews on. They had a 6-month ramp-up period until July of 2021. That's when we really started going at it. So since that time, it is very robust. I've got more money than I can spend for the people that I can get on system. So the problem is, if we're trying to catch up 16 years behind to get back on, it's going to take me another 4 years to get to a sustainable cycle.
What else besides just I mean, we keep talking about vegetation trimming. I heard Mr. Troxclair talk about my area in East Texas. We've been doing that for years because pine trees snap pretty quick. What else are you doing, you know, from a maintenance or infrastructure perspective? I mean, poles, you know, underground lines. What else do y'all do to try, because it's not just vegetation, right?
That's correct, but it's primarily vegetation getting into a normal system. If it doesn't have anything happen to it, lasts a pretty good time. But the biggest things that you can do to implement would be pole replacement for poles that have some integrity issue. The other issue is what was used about 30 years ago is what's called open number 6. So just think of a copper wire that's probably about a half-inch thick.
Yeah.
And that's predominantly out there because everybody used it. But what happens over age is it degrades, becomes brittle. So what we're trying to do is, one, we have a pole inspection program to change out all of the poles that were identified.
Right.
So that's proactive. The other one is when we go out to do maintenance on a section, if it does have that open number 6 on it, we're changing it out to a covered conductor, which is a lot more durable than open number 6.
Gotcha. Okay, thanks.
Thank you.
Representative Anchia.
Thanks. I want to see if maybe you can help me understand what you might be in favor of.
Okay.
It sounds to me like the penalty feels kind of harsh in this bill. Maybe there's no cure period. Would you be in favor of some sort of cure period, a report that would be required to make sure, you know, to confirm that you're doing what you're doing, and then afterwards, if you fail, right, if it doesn't work, then there'd be an administrative penalty? Does that sound reasonable from a policy perspective?
Theoretically, Representative, but the issue that I've got is what's your baseline? So that would be like you come in and tell me my program's insufficient. How do you define insufficient? So if I have a metric that can be met, that is sustainable, wholeheartedly I'm with you.
I think that's a fair discussion point, right? And what should be the right metric?
Well, see, that's the problem. I think the right metric, if I was king for today, would be have it to the system standard and then a maintenance to maintain that standard. The problem is I'm just trying to get onto the expressway right now with that. And I will say that I'll challenge anyone to talk about density of trees and population on any other utility. There's areas of Texas that are comparable to Austin, but that is the total utility within that area. And if there's people within that area that feel like they're not being taken care of, I apologize, because all I care is you're a customer of Austin. So I don't care if you're on the west side, east side, north side. So I think that's what I would do, is you've got to have a baseline and then show that you're meeting that.
I think that's fair. And what if you helped establish that baseline and then, you know, established a prospective metric about what you could get done? And whether you're hitting that or not.
Absolutely, because one of the things that on any good vegetation is a mid-cycle trim. So what you go through is, let's say if we're on a 6-year cycle, every 3 years we patrol that because something might be encroaching. And so that would be something that would be a measurable, tangible item that you could say, did you do it or did you not do it? And I'll also say, talking about on the budgeting piece, this is the only municipality that I've worked for. Everything else has been IOU. And I can tell you, vegetation management IOU is not looked upon favorably. The reason why it's an O&M, operational maintenance cost, so it's a waste to their opinion.
It's overhead.
Yes, that's correct. It's not a capital investment. So I appreciate the council giving me the budget, the time, and the people to actually take care of it.
Final question, Mr. Chairman.
Yes, sir.
And thanks for your time. You discussed a constraint on your ramp up. And I didn't really understand it. Were you talking about labor costs or labor availability?
Labor availability. Okay. So I give you an example. I'm supposed to have, with what I've got, it's about $17.5 million a year for 60 crews. At best, I've been able to have about 45. With these other 4 companies we're bringing on, I'll actually be able to go over the 60 that I was doing. And we're so close, it's not like we can go out. If I was on a cycle, I go out and I trim like 3 or 4 feet off. Here, it's so far encroached, my crews are trimming 8 to 15 feet off to get out there. So we're getting there. And again, my guys are dedicated. They want to get it done. They care about the customer, and we're doing everything we can to get there.
Appreciate your testimony. Thank you.
Thank you, Representative.
Any other questions, members? Thank you, sir.
Great. Thank you, Chairman.
Cyrus Reed. Cyrus, we have you with Lone Star Chapter Sierra Club against HB 4207. Is that correct?
That is correct.
Go right ahead.
Yeah, Cyrus Reed here for the Lone Star Chapter of the Sierra Club. I wanted to first say, in Austin, where I live, we have a public utility. That public utility has a city council that is the governing body. There is also an electric utility commission that meets monthly. The budgets are all reviewed, and the vegetation management plan, which is the subject of this bill, is something that exists and is available, and all budgeting for the city goes through a budgetary process. Now, I, like many of you who might have been here, was impacted by Winter Storm Mara, as were many people in Central Texas. Some of that is the climate is changing, right? Things are more severe than they were. And we certainly do want improvements in the vegetation management plan in Austin. So we do not object to a reporting requirement to the PUC to make sure they're doing as good a job as they could. And we hope that City Council and Electric Utility Commission, et cetera, will also be reviewing that. But the idea that the state would come in and affect the budget for the city of Austin for all kinds of services because of vegetation management plan might be inadequate. I'm not sure it is. I'm not sure if it is or not, is a real blunt instrument, and we are definitely against that portion of the bill. It seems like the punishment is much greater than any potential crime. And I will say, having been involved in these issues, I give credit to Austin Energy for, after some years of inaction, actually increasing the budget, and sounds like they have some labor issues, but there has been an increase in the actions that have been taken in recent years. So I think they may be on the right path, but certainly we're against the transfer issue. It was a late night on the House floor yesterday, and I didn't have a chance to get to written testimony on this and some of the bills.
Thank you. Any questions, members? Thank you, sir.
Thank you.
Bradley Hodges. Bradley Hodges. Bradley Hodges will show he registered for himself for HB 4207, but did not testify. Craig Nazor. Craig, Nazor. Craig Nazor. Show Craig registered for Lone Star Chapter Sierra Club and self against HB 4207, but did not testify. Taylor Kilroy. Taylor, we have you registered for Texas Public Power Association against HB 4207. Is that correct?
Yes, sir.
Go right ahead.
Chairman, Vice Chair, members, clerics, thank you so much for this opportunity. Taylor Kilroy on behalf of the Texas Public Power Association. We're the trade association for the 72 municipally owned utilities across Texas. And while we talked about Austin Energy a lot today, I really want to emphasize this bill is for all 72 MOUs. And we are concerned about that because each of us would have to report, the PUC would have to make a decision on each of those 72 municipally owned utilities. And as y'all know, the PUC has a lot of decisions coming up. We'll talk about some of that later tonight, judging by the crowd in great detail. And so we are concerned about that because the PUC does have a lot of work coming up. I understand they believe they can accomplish that with existing resources. But man, they've got a lot of work ahead. It's a heavy lift to do this every year, 72 times. Sure, Lubbock might be easy, but if you look at it in the Piney Woods, Timpson, St. Augustine, that's a tough call. You look at it Granbury, that's gonna be a tough call every year. And they're gonna be required to do that every year for every one of the 72 municipally owned utilities spend. And so that's why we oppose. We had a great conversation with Representative yesterday. Really thank her for her time. She did not have to spend as much time with us as she did, but we are appreciative. We are respectfully opposed to the bill. Thank you.
Thank you. Any questions? Thank you very much.
Thank you.
Members, that's the last registration. Is there anybody else wish to speak on for or against this bill? If not, Chair recognizes Representative Troxclair to close on our bill.
Committee, thank you for your patience. You have gotten a little taste of how difficult it is when there is not trust or communication between these parties. This should not have taken up this much time. We had already come to an agreement. The language that I mentioned that would have allowed them the opportunity to cure and reduce the amount significantly to only the amount required to cover the cost of the vegetation management plan was brought to me by the city of Austin. I have agreed to their changes. We didn't have time to get you a committee substitute before the meeting today, but that is why I went out of my way to make sure in my opening that I mentioned that. I thought this testimony would be very quick. I expected the city to come up here and say, we oppose it as is. We're going to support it with these 2 changes that she's outlined and move on. Disappointed that that did not happen. I am sorry that this took up more time than was necessary, but look forward to bringing you the committee sub that has been sent to me by the city of Austin and look forward to unanimous support of this bill.
Any questions, members? Yeah, Representative Dean.
Welcome.
Hey, it's like welcome you guys too to my world with the city of Austin.
Welcome to the big stage, man. Believe me when I see it. So you have agreed to, and they have agreed to, and so y'all gonna work that out in your sub.
Yes, I am concerned now that they told me something different than was just said. So I mean, I don't want to waste any more time with clarifying that.
For the record,
I have agreed to the changes that they brought me.
To the cure and to things that were discussed tonight that are on record.
Yes.
You have agreed to, they agreed to, you've got emails back and forth for their agreement, correct?
Yes, sir.
Okay, thank you. Thank you, that's enough.
Thank you. I close.
Representative, with everybody listening out here, I'll ask that you and your side and the city and their side get together and give me a report by Friday. Thank you, Representative Troxclair. The chair moves to leave HB 4207 pending at this time. Is there any objection? Hearing none, HB 4207 is left pending. Chair lays out HB 4208. Recognizes Representative Troxclair to explain her bill.
Thank you. This is the one that I thought would take up more time, so maybe we'll make up for that time. Thank you, committee. I have a letter here from the mayor of Bee Cave who was not able to make it to the hearing, but can I keep one of those actually? But this bill, I actually think addresses the root of the cause of the issues that the city of Austin's Austin Energy customers experience with the utility. As a quick background, you guys know that 85% of the state is currently in a deregulated market following the passage of landmark legislation that allowed customers in the majority of the state to choose their energy provider. Austin Energy and other MOUs were exempted from these laws. But unlike any other MOU of its size, the City Council serves as the board of directors for Austin Energy. Unfortunately for customers, City Council members understandably do not have the experience, expertise, or frankly, the time to serve in this demanding capacity. And this causes high rates, poor customer service, and frequent outages. And again, they are a true outlier in a utility of this size. CPS in Energy in San Antonio, as you already mentioned, Representative Raymond, is the most comparable MOU to Austin Energy, and in line with best practices, City of San Antonio and CPS Energy, they have a separate expert board with qualified expertise in the utility industry. I don't need to tell y'all how complicated the electric utility industry is. And I can say that with confidence as a former member of the Austin City Council. I don't think that my lack of extensive background in the utility industry was a major factor in my election. But yet we trust them to run a massive utility. So they can and do lose money on electric generation, but because they're a vertically integrated monopoly owning the generation, the transmission, and the retail service, they can raise customers' rates to hide the losses. They have a continued history of poor investment decisions, and customers are paying the price. Lastly, there is a significant problem with taxation without representation. There are 9 other municipalities that Austin Energy serves. It is not just the residents of the city of Austin, as you can tell by the mayor of Bee Cave's letter, as well as the Lakeway mayor who will be testifying shortly. So, and I do want to just say for those who are listening but don't have a copy of the letter, a highlight is Mayor King says, I have received a multitude of resident feedback expressing concern that they have no representation or choice for their energy provider. Our area-wide residents are demanding the same, representation or choice. So in order to address these issues, this bill creates an expert board which would include requirements for relevant experience and representation from other municipalities served by the utility. The current bill creates a 5-person board, including an appointment from the city of Austin, as well as the cities with the 4 highest number of AE customers. That currently would include the city of Bee Cave, city of Westlake Hills, the city of Lakeway, and the city of Pflugerville. And just for reference, the City of Westlake Hills is 100% served by Austin Energy. City of Bee Cave is 95% served by Austin Energy, and City of Lakeway is 40% served by Austin Energy. So sometimes there are narratives out there that, like, you know, if you're not in the city of Austin, you don't get an opinion on this. But there are a lot of other people who are paying the high price of Austin Energy's poor investment decisions. I have asked the city of Austin for feedback regarding the makeup of this board. We based it somewhat on the makeup of the CPS board. I am open to their feedback. To this point, they have declined to offer any feedback. I do anticipate, I don't know that what I've submitted will be the final model. I think we probably need to bump up the number of years of history in the utility industry. Right now it says 5 relevant years of experience. I think it's probably closer to 10 or 15 is probably more appropriate. And I'm also open to, you know, I'm just, again, encourage their communication and feedback to make Austin Energy more in line with best practices, to make them more capable of making smart investment decisions, and to give people who are served by this utility true representation in the decisions that are made. Thank you.
Questions, Member Representative Raymond.
Thank you, Chairman. So we started talking a little bit about this on the floor. The makeup, you want a 5-person, is that what it is? I'm trying to see.
Yes, CPS has a 5-person board, so that's at least my understanding is that CPS has a 5-person board, and so that's kind of what we based it on. And I have looked up their their kind of internal requirements of what they look for, since that's the most comparable entity. That's what I went with. I understand the concern that, hey, Austin Energy, people in Austin still have the highest number of customers in AE, which is why I reached out to the city for feedback.
Do you know what the percentage is? Like, what percentage of all the people they serve are from Austin?
What percentage of it's
the 90s?
It's very high. Yes.
Yeah. So that's something that I'm guessing you're going to work on. You know.
I would love your help in encouraging the city or the utility to give me some feedback. I have asked repeatedly for it, and it is hard for me, as you have seen on the previous bill. I am more than willing to work with them when they come with reasonable suggestions. In this case, they declined to have suggestions, so I moved forward with what I thought was appropriate, which is having each of the 4 largest cities appoint a utility expert. And to be honest, I don't know that a utility expert that lives in Lakeway, that would be appointed by the mayor of Lakeway, is that different from a utility expert that would be appointed by the city of Austin.
It may not be the same thing, but we ran into something 2 years ago called ERCOT and the members of ERCOT not living in Texas.
Sure.
You know, stuff like that. So I guess we're kind of sensitive to that, or I am. I mean, I'm looking at it, I don't know what you're trying to do, but if 90-some% are from one of the 5 cities or however many cities, you know, they ought to have more than 1 or 2. You know what I'm saying? And maybe make it more than 5, I don't know. I mean, I'll give you an idea if you want, but I certainly encourage, you know, the man of steel over here, he's going to encourage them to work with you also.
That would be.
That's coming. That's coming.
That would be wonderful. Because the main issue, as you understand, that I'm trying to address is they currently don't even have a way, like if you want to protest, if you live in Lakeway, you want to protest the rate, you want to protest your, if you live in Austin and you want to protest your services or your rates, the only entity that you can protest to is the Austin City Council. And guess what? They're the board of directors that set the rates and the service in the first place. So right now there is no independent accountability for what goes on. You know, there's another bill floating around that would allow AE customers to protest rates and services to the PUC. So I will be supporting that bill as well. But the idea here is, number one, accountable expert board. Number two, make sure there's no conflict of interest. Again, we just heard on the previous bill, there's a little bit of a conflict of interest when you're serving the city and the utility, which are not the same. In fact, like if you look at the makeup of a co-op, they elect their members of their board. There's a prohibition between, you cannot, if you're going to be an elected board member, you cannot serve on the city council of one of the municipalities it serves, because they are. I mean, the greater the transfer from Austin Energy, it's puts them at a disadvantage. They're losing money, the city's gaining money. So where is the oversight? Where is the accountability? And the last but not least, we do have quite a few customers. I know that you're saying the vast majority are in Austin, but the reality is you have mayors here who have not gotten the service, that have not gotten the responses, and you have customers who are being taxed without representation. They have even if they go and protest rates or services to the Austin City Council doesn't care. Those people can't vote for them. Those people don't have a say in what goes on in the city of Austin, but yet they are in a monopoly. They do not have a choice of their energy provider. So there's a representation and accountability issue that legitimately needs to be solved here, and I am absolutely willing to work in a collaborative manner with the city and with the utility to come up with a reasonable solution.
Thank you.
Representative Anchia.
Hey, Representative.
Hey.
This board structure seems a little bit out of balance.
Sure.
You know, you're giving 4 members out of a 5-member board to 2.6% of all the people served by Austin Energy. That seems a little bit out of whack, does it not?
Where did that number, where did the 2.6 come from?
If you take the 4 cities and you add them, you know, the population's up. It's my understanding it's under 3% of all the people served by Austin Energy.
And was that data provided to you by the city or the utility?
I think the utility.
Okay.
Yeah.
So I would be very grateful for them to have that direct conversation with me.
And I know you want to work with the city, but did you seek a resolution from the city council?
I did.
Okay.
I did. I can show you the email. We had a meeting. I asked specifically for feedback. Their response was, we're not willing to give.
So they just declined. So they said, we don't support it. Okay.
So I don't know. I said, I understand you're going to oppose it either way. That's different from the last bill where we had an agreement. This one, they said they're going to oppose either way. And I said, I just want to make it better. Tell me, we modeled it off of San Antonio kind of, but
Look,
tell me how this works.
I get opposition from groups. You know, I've been in the minority for almost 20 years. So I understand, you know, opposition. And sometimes your bills just don't move because of that opposition, right? That's just how this place works. It's hard to pass a bill. So let me ask this question. In your proposal, you point out that, you know, there's a monopoly and there is no way to appeal. But in fact, people in these cities get special treatment, do they not? They're able to appeal directly to the PUC currently. Is that not the case? I believe it is.
Oh, okay. Not to my knowledge.
Okay. Well.
Okay. Sounds like there may be other people testifying who might know.
Yeah. Well, let's ask maybe folks, if we have resource witnesses from the PUC, that might be working.
Sure.
Good. Thank you, Representative.
Representative Turner.
I'm good, Mr.
Okay. Thank you, and we'll let you close.
Thank you.
Would you like PUC resource? We'd like you to sign up, yeah. Wait just a second. Take him outside or something. No. No, it's fine. Can we go to the next witness? Since I called. We'll go to the next one, and then when he registers, okay. Jesus Garza. We're going to get him registered, then we're going to bring you up. So Jesus, we've got you registered for City of Austin against HB 4208. Is that correct?
Yes, sir.
All right, Jesus, go right ahead.
Chairman Hunter, committee members, I'm Jesus Garza. I'm the interim city manager for the City of Austin, and I'm here to testify against House Bill 4208 on behalf of the City of Austin. House Bill 4208 is a bracketed bill for the City of Austin. It requires the city to transfer control of Austin Energy to an independent five-member board appointed by the mayors of Austin, Bee Caves, Lakeway, Westlake, and I heard just a second ago, Pflugerville. Before this committee considers a bill that would make changes to the governing of Austin Energy, I would want to give some background about how the governing body for Austin Energy operates today. Austin Energy is governed similarly to the majority of municipally owned utilities in Texas by its city council. In fact, 63 of the 72 municipally owned utilities are governed by their city councils. The Austin City Council meets monthly in a meeting solely to receive updates and information related to Austin Energy. In addition to this governing body, we have the Austin Energy Utility Oversight Committee, which meets 6 to 8 times a year to provide oversight and policy recommendations to the utility. Then we have a civilian-led Electric Utility Commission that meets monthly and is responsible for reviewing policies related to rate structure, customer services, strategic planning, and more. And most importantly, the public has the opportunity to provide comments during every city council meeting, every Austin Energy Utility Oversight Committee meeting, and every Electric Utility Commission meeting. These opportunities exist for outside ratepayers as well. Customers that live outside the city limits can participate in our rate review process, and they do. Outside ratepayers are also formally represented by the homeowners.
Thank you. Jesus, what I'm going to ask you to do is to prepare a memo to this committee on how you operate and make sure the author of the bill gets a copy.
Sure.
And then I'll give that to the whole committee.
Yes, sir. I will be happy to do that. The only thing I'd say just is that.
No.
96.
We know we follow 2 minutes. We don't give filibusters.
Okay. All right. Very good.
Jesus, remember, where'd you come from?
Corpus Christi.
There you go. No, you're not supposed to run off just because does anybody have a question for you? All right. Thank you, Jesus.
Thank you.
It's good to see you.
Good to see you.
So now who? Okay, let's go to the next. Tom Kilgore. Tom, we got you registered City of Lakeway and Self for HB 4208. Is that correct?
That is correct.
Go right ahead.
And I'm representing the city. That's our official position.
Well,
and so
No. Okay. So let's make sure we're clear on your registration. So you're here on behalf of City of Lake.
That's what I registered, yes, the City of Lake.
And Self.
And Self, yes, sir.
Okay. And so you're for HB 4208.
That is correct, yes.
Exactly. Go right ahead.
And just as a reminder, I'm also a 20-year United States Army veteran and a retired officer and a 20-year energy executive. So we heard earlier, just a few minutes ago, the comment was east side, west side. We all care about where the power goes. And my concern is that we don't care about outside the Austin city limits, despite anything that has been said so far. They have to have board oversight. The reason is there is a standard we call best utility practices. And throughout the ice storm, Austin Energy failed to follow best utility practices. That practice requires that you re-energize and take care of critical infrastructure items before you start the restoration of residential areas. The City of Lakeway grid is very simple. It's two main transmission lines, one down a state highway, RM 620, and one down a city road. Those two transmission lines energize the 7 critical facilities in the City of Lakeway. And they are an elder care facility, our hospital, and then a second elder care facility. And then when you go into the city, it's our police department, 2 elder care facilities, and then our fire department and water department, all of which those lines have to be energized. They were not. What happened instead is resources were diverted to take care of energy elsewhere. We were not given the ability to talk to Austin Energy. They actually stopped talking to us in the Emergency Operations Center, and we discovered that city council members at Austin had a private line to the utility where they could request outage repairs ahead of the critical infrastructure. That private line directly allowed the board to take care of their friends. Thank you, sir.
Thank you. Any questions, members? Representative Turner.
Thank you, Mr. Chairman. Mayor, thank you. You're doing a fantastic job advocating for your community.
Thank you.
You've described the challenges your community faced very well, and I think we have a good grasp of what you experienced. But in terms of the specifics of this bill, however, that we have before us, as discussed, it looks like there would be a board of no more than 5 members, but maybe not necessarily 5. But each city would get to appoint 1 member. Is that your understanding of the bill?
That is my understanding of the bill as currently written, yes.
Okay. So let's say, just for math purposes, there were only 4 members, because it says it used to be up to 5, but it doesn't have to be 5. So there's only 4. So Austin would have 1, your city would have 1, and then 2 other cities would each have 1. Is that your understanding of the bill?
That's my understanding of the bill as currently written.
Right, okay. So as discussed, right now, in terms of ratepayers, though, about 3% are in your city and the other 2 smaller cities, and 7% are in the city of Austin. I mean, do you think that is honestly a fair way to construct this board to where
I would be perfectly yes. Oh, sorry.
The city with 7% of the ratepayers would have 20%, maybe up to 40% of the board seats. Is that a fair way to construct this?
I think that is probably imbalanced, sir, to your point. And I did not speak to the composition of the board as to the fact that there must be a board with outside oversight over the company.
Okay.
And
and I appreciate that. That's
just
why
to
I asked.
clarify, I was specific in my remarks, sir.
So you want to see some additional or new level of oversight, but not necessarily this oversight regimen that's prescribed in this bill currently.
I don't think it's the mayor's responsibility to tell a representative how to do their job.
No, I understand. I'm asking your opinion.
No, if the board structure were to change, as long as there's still outside oversight, I would still be in favor, and the city would still be in favor of this.
And I'll tell you, my mayors feel very comfortable telling me how to do my job. So, and I listen to them. I appreciate their feedback. So, thank you for being.
Well, thank you, sir.
Thank you very much, Mayor.
Thank you very much.
Okay, Mike Hope, Public Utility Commission of Texas, is registered neutral on HB 4208. Is that correct?
Yes, sir. Mike Hoke with the Public Utility Commission of Texas. And Representative Inchy, to answer your question.
Well, let him ask the question.
If you don't mind, if I can just restate it. So can you talk about the impact that PURA and specifically 31.101 has on ratepayers in a municipally owned utility who live outside of city limits, what the external oversight is on any rate changes?
Right. So after a rate change by municipality, the customers of that utility who reside outside the city limits of that utility, they can appeal that rate decision to the Public Utility Commission. The threshold is it's 10,000 signatures or 5% of the outside the city limits customers, whichever is lesser. If they meet that threshold, then the That appeal is heard at the Public Utility Commission. The Public Utility Commission can adjust the rates only for those outside the city limits customers.
So, but there is this special treatment for persons outside of the city limits that if you lived in Austin, you would not have the ability to collect signatures and go get an appeal to the PUC.
That's correct.
Okay. And I'm interested because I think the 2.6% figure that I said earlier was Bee Caves, Lakeway, and, I'm missing one. It didn't include Pflugerville. But just to be clear, so there are about 15,000 persons in Bee Caves, Lakeway, and Westlake. Thank you. I was missing one. And so they'd have to get 10,000 signatures for those 15,000 people in order to trigger this?
Yeah, and it's for the customers, all the customers outside the city limits. So,
and I don't know what the Pflugerville number is, and you don't either, but maybe we'll ask someone from Austin Energy. But you would need 10,000 signatures in order to trigger the appeal?
Yes, sir.
Okay, thank you.
Any other questions of the resource? Thank you, sir.
Thank you, committee.
Cyrus Reed. Cyrus, we have you registered on behalf of Lone Star Chapter Sierra Club against HB 4208. Is that correct?
That is correct.
Go right ahead.
Yes, Cyrus Reed, Lone Star Chapter of the Sierra Club against HB 4208. And my information, members, it's actually about 14% of the homes are outside the city of Austin. What Representative Troxclair is proposing, though, would take, instead of it being 15% who maybe don't have as good representation as they would want, suddenly they're having 60 or 80%. And that seems very, very unbalanced. And I will say, as a resident of Austin, all Austin City Council members are public. Any member of the public can go, right? Whether they are inside the city of Austin or outside. There is a special meeting every month of an oversight committee, and there is a citizen-appointed electric utility commission. So I think it's not correct to say there isn't access to Austin Energy and other committees that help manage Austin Energy. Sierra Club actually participated in we opposed some of the rate increases that Austin Energy had come up with in the latest, and there was a process where anyone served by Austin Energy could enter into that rate case in a hearing-like process, very similar to the PUCs. And there were participants from outside the city representing by a group that participated in that rate making. So I think, devil's always in the details, but this is a lot more complex than maybe has been presented. And we are opposed to the bill as filed.
Questions, members? Thank you, sir.
Thank you.
John Gordon. John, we've got you registered for self for HB 4208. Is that correct?
That is correct.
Go right ahead.
John Gordon, registered professional engineer, electrical. The bill is okay. The proportion is wrong between the cities and everything. Austin has probably 85%, maybe even a little bit less than that, of the total electric load of the electric utility system. The reason I know that is I'm the one in 1984 that was designated by all citizens outside of Austin in a PUC case. We didn't have to get 10,000 signatures. And that ended up in a $100 million rollback of the city of Austin's rates, 1984. So in the state of Texas, I was responsible for the largest rollback of electric rates in the state of Texas history. All right. On the 5 commission people, there needs to be something said that you've got to probably need to have at least 2 to 3 of those 5 individuals as engineers who have been responsible for the electric utility system, because that's the issue. Who is managing the electric utility system? You got the one issue of people that got a complaint, and that should be taken care of. The other is the system being managed properly? And I believe that's what this bill goes to, is to try to say, to get the system managed properly. Thank
Any
you.
questions, members? Thank you, sir.
No? Okay, thank you.
Elton Richards. Elton, we have you registered for Austin Energy against HB 4208, is that correct?
No, Chair. My name was put on this by mistake. I have no opinion on this bill.
So are we able to correct your affirmation that Elton Richards, Austin Energy, neutral on HB 4208?
Yes, Chair.
And we're giving the clerk permission to make that correction.
Yes, Chair.
Thank you so much.
Thanks, Chair.
Todd, is it Kiluk, K-I-L-U-K? Todd, we have you registered for AFSCME Local 1624 Austin, Travis County against HB 4208. Is that correct?
That is correct.
Go right ahead.
All right. My name is Todd Killick, and I'm testifying on behalf of AFSCME Local 1624 against this bill. I have worked with and represented Austin Energy frontline employees and executive staff for almost 15 years now. Our union also represents thousands of City of Austin and Travis County employees that work at, live in, and serve the City of Austin every day. Among other vital services, our members fix streets, ensure drinking water is clean, and keep important services open during extreme weather and public health disasters. Our members are proud of the work that they do at Austin Energy to provide affordable and reliable power to residents, even in the face of statewide grid challenges and more frequent weather events. The Austin Energy Oversight Committee, made up directly of elected city council members, meets often, and the civilian-led Utility Commission meets monthly. Taxpayers have the ability to make their voices heard at any of these meetings, and they often do. I attend these meetings. There are private citizens that come to them. There are businesses that come to them and talk to the council members directly with ideas, concerns, proposals. We do not need to create an additional layer of bureaucracy that will directly impact the ability of Austin Energy to plan and move forward quickly with utility projects. Vegetation management, burying above ground lines, grid upgrades, transportation projects, and many more will all be affected, slowed down, and become more costly if this bill is passed as is. As many people have said, somewhere around 96% of the utility customers are in the City of Austin, 4% outside. That gives ultimately making this structure less responsive to the most customers. We know that Austin Energy faces challenges. Thank you for your time.
We'll note that you're against HB 4208.
Thank you, sir.
Thank you very much. Appreciate it. Don Zimmerman. Don, we have you registered on behalf of Travis County Payers Union and Self for HB 4208. Is that correct?
That's correct.
Go right ahead.
Mr. Chair. Thank you. Thank you very much. First thing I'd like to do is let you know I affirm everything that former council member Ellen Troxclair has said. I was elected in 2014 to the Austin City Council at the same time that Ellen Troxclair was representing District 8. When I ran for office, I promised the voters that I would investigate Austin Energy's East Texas biomass wood chip burning plant. The reason this is important to this conversation is this was an outrageous boondoggle that ended up costing taxpayers $8 billion. Mayor Lee Leffingwell in 2008, along with the council, asked for this contract for the wood chip burning plant. It was an over $1 billion, but they were denied access to the contract that they were asked to vote for. So I made it a campaign issue. And when I got on council, I told Austin Energy that I needed that contract, and they said no. To make a long story short, I promised litigation and a public scene, and finally, I got a copy of it. We hired an electrical engineer with about 40 years of experience in utility power production. He analyzed the contract and said it was the worst contract from the ratepayer's point of view that he had ever seen in his career. And in his professional opinion, no competent executive who cared about the ratepayers would have recommended that contract for passage. But the Austin Council passed it unanimously without having a chance to even read it. I categorically deny all these claims from Austin Energy bureaucrats that they have a transparent process that the citizens and ratepayers get to contribute to. It's nonsense. Not even the elected officials really know what's going on. So I urge passage of this bill, and thank you for your time.
Thank you, sir. Any questions? Thank you very much. Bradley Hodges. Bradley Hodges. Bradley Hodges. Well, note he registered for self for HB 4208, but did not testify. Craig Nazor. Craig Nazor, N-A-Z-O-R, Craig Nazor. We'll note Craig registered Lone Star Chapter Sierra Club and self against HB 4208, but did not testify. Sean Hall Laquana. Sean, again, I'm going to show you registered for KRIAH BSHALOM and self for HB 4208. Is that correct?
Yes.
Go right ahead.
All right. Thank you. I'm testifying based on the version of the bill without any amendments or substitutes. So, conscious of the rectitude of our intentions, worshiping Almighty, the glory of the true and living God. Chair Hunter, Representative Troxclair, and the House State Affairs Committee, or what's here, I stand for HB 4208, the perfect law of Christ Jesus for the general welfare. Sam Houston, Colonel Travis, Stephen F. Austin, and James Bowie stood, and Texas received liberty, as do I. Thanking y'all for replenishing rightful accounts in our resolved community. So today I'm adding my good faith to what you all are doing. I do have a voice. I love God and his creation. He makes the tough easy. General welfare includes people, and vegetation includes trees, not just grasses. Yes, you're hearing me correctly. That is what I was told by the city of Austin. This is not climate change, but this is good faith. I'm here to stand because I know Representative Troxclair is going to get to the right conclusion with the help of all of you all and the other cities. I'm a resident of this city. I'm a dweller of this city. I'm an inhabitant of this city. And I have great faith in the one true God who is here and can help you. If you'll listen to him, and we all listen and hear and see what he will say, because he's the light, and not look for fault or blame, because that's how he works. Thank you for listening.
Thank you very much. Any questions? Thank you so much. That's the last of our registration members. Is there anybody else wishes to speak on for or against this bill? If not, Chair recognizes Representative Troxclair to close on our bill.
Thank you, committee, for your time and attention. I do think that it is clear that we do need some kind of expert board for oversight. This is, again, best practices across the country. You want people who truly understand the energy market. I hear your feedback on the current contemplated makeup of that board, and I will work with stakeholders to come up with a formation of the board that more adequately represents the distribution of the customers. and hopefully circle back with you with an acceptable committee sub soon.
Thank you, Representative. The chair moves to leave HB 4208 pending at this time. Is there any objection? Hearing none, HB 4208 is left pending. Chair lays out HB 4213 and recognizes Representative Troxclair to explain her bill.
Sorry, I dropped this on my way up. Okay, so 4213, last but not least, it prevents an MOU from subsidizing their wholesale retail rates to pay for unassociated costs of their generation assets. This gets into the weeds a little bit, but I'm going to try my best to keep it high level and do that with an example. So in 2012, Austin Energy entered into a long-term contract with the Southern Company's biomass plant in Nacogdoches to purchase power from this plant to the tune of $2.3 billion over 20 years, with the final year of the contract alone expected to cost Austin Energy $90 million. You heard previous testimony from former Councilmember Zimmerman on this contract and our difficulty in getting a copy of it. Fast forward a couple years and it became apparent that this biomass plant was incapable of economically generating electricity on a regular basis and was therefore only running a few days a year. A few days a year, spending $2.3 billion over 20 years for a couple of days of electricity a year. However, because AE had entered into a fixed cost contract, the city was still on the hook for billions of dollars. At that point, it became cheaper to actually purchase the Nacogdoches power plant for $460 million and just let it sit idle for most of the year to continue to pay for the contract. So now the city owns the plant, and due to the market design that requires the electricity to be sold onto ERCOT and not be consumed by Austin Energy customers, Austin Energy large commercial and industrial retail customers are paying $59 million a year in capacity payments to Austin Energy for a plant generating electricity that they cannot use. This would never be tolerated in the competitive market. It is a cross-subsidization that is allowing them to hide significant losses on the generation side. And again, customers are paying the price. So I'll leave it at that and let you listen to testimony and reserve my right to close.
We will let you have your right to close. Thank you. We'll go to
Mr. Chairman.
Oh, I'm sorry, I couldn't see you.
That's okay.
Representative Turner has a question for you.
Just one question is so these bills are doing different things, but this bill, am I correct, it just would apply to Austin or to Austin Energy?
That is the intention, yes.
Okay. All right. Thank you.
Thank you.
Thank you, Representative. And we'll give you the right to close, Representative. Cyrus Reed. Cyrus, we have you registered for Lone Star Chapter Sierra Club against HB 4213. Is that correct?
Yeah,
Go right ahead.
That's correct. And I'll say for the record that the Sierra Club as an organization did not support the biomass plant. We didn't think it was in the best interest of the city. But again, this bill creates a law for one municipality. And the fact is in ERCOT, all owners of generation bid in to the market and sell to the market. And then a utility like Austin Energy also buys from the market. That's the way the market works. And so I don't think I agree with Representative Troxclair's statements about the cross-subsidization issue. I think actually, whether or not it was a good investment in that plant, the plant is now owned by Austin Energy, and they run it economically when it makes sense to run it. And so I think this is, again, a little bit of an overstepping into a particular utility's business model. But at the end of the day, they're operating in the nodal market, and it works the way it works. And sorry, I'm a little tired.
No, thank you. Any questions, members? Thank you.
Thanks.
Thank you, Cyrus. Mark Dombrowski. Mark, we have you registered on behalf of Austin Energy against 4213, HB 4230. Is that correct?
That's correct,
Go
Chairman.
right ahead.
Good evening, Chairman Hunter and members. My name is Mark Dombrowski, and I'm the Deputy General Manager, Chief Financial Officer for Austin Energy. I'm here to respectfully oppose House Bill 4213. Austin Energy owns transmission and distribution infrastructure and maintains a diverse generation portfolio that includes nuclear, renewables, natural gas, biomass, and coal. Our power plants act as a physical hedge against high prices for our customers in the ERCOT market and support grid stability by providing real-time generation and ancillary services. In the last year, our generation assets saved our customers hundreds of millions of dollars in the ERCOT market. During Winter Storm Uri, this generation performed well, benefiting our customers and the ERCOT market. As a result, Austin Energy's more than 500,000 customers have very affordable and stable rates. The handout I provided illustrates how both our commercial and residential rates are below statewide averages. House Bill 4213 would upend our business model by prohibiting us from recovering fixed generation costs through customer rates in the same manner as every other municipal utility. This would force us to divest or shut down almost 1,900 megawatts of generation. It would impair our ability to comply with joint ownership agreements with Lower Colorado River Authority, NRG Energy, and CPS Energy for our coal and nuclear units. This process would inevitably harm our AA bond rating. Divestment would destabilize our customers' rates and potentially add millions of dollars in stranded costs to their electric bills. In turn, this would increase costs to our customers and hurt the overall reliability of the grid. This bill undermines the work this committee is doing to ensure existing generation is retained and new generation is built. This bill will create regulatory uncertainty and cause instability in the ERCOT market. For these reasons, we respectfully ask that you oppose HB 4213. Thank you, and I'm available to answer any questions.
Thank you very much. Questions, members? Thank you, sir. John Gordon. John, we got you registered for self for HB 4213. Is that correct?
Yes.
Go right ahead.
Thank you, John Gordon, registered professional electrical engineer. I support this bill. The reason that we Royal Massey helped me out back in 1984 was because it was cross-subsidization. And when we went to the PUC, we approved it. And the PUC had to roll the rates back. And this in some ways tries to prevent cross-subsidization in the city of Austin. I find it's rich that in 1976, I was one of the chief spokesmen to get Austin into the South Texas nuclear project. And for the last 20 years after that, they tried to get out, and now they're saying they're happy they're in it. So Austin does not have a real consistent pattern of behavior. They've been trying to get out of the Fayette power plant too. So this probably forces them to have a more consistent pattern in their rates, and that's why I support this particular bill.
Thank you, John. Any questions? Thank you, sir. Todd Killick, K-I-L-U-K. Todd, again, we have you registered for the AFSCME Local 1624 Austin, Travis County against HB 4213. Is that correct?
That's correct.
Go right ahead.
Thank you. My name is Todd Killick. I'm testifying on behalf of AFSCME Local 1624 against this bill. We oppose the bill because the large-scale negative impact that this could have on Austin Energy ratepayers, city employees, and the Texas grid overall. Prohibiting the city from owning, operating power generation could destabilize rates for taxpayers, ultimately leading to higher bills, less reliable service. We also heard that this bill would undermine Austin Energy's bond rating and negatively impact the overall budget available to provide the services, including vegetation mitigation that taxpayers depend on. Austin Energy employees are doing everything they can. They've worked through pandemics, floods, snowstorms to keep our lights on and the city running. We should be looking for ways to ensure they have the staffing levels, tools, funding that they need to do their jobs so jobs so many people are relying on. This bill would do the opposite and would be detrimental to hundreds of Austin Energy employees and Central Texas families that depend on these jobs of running and supporting Austin Energy power production. This bill could also remove much-needed generation from the Texas grid, something we have seen again and again and we cannot afford. Texans who rely on Austin Energy deserve stable prices, reliable service, something that we can all be working on together. This bill would make it harder for us to provide that, and we urge you to vote no.
Todd, thank you very much. Any questions, members? Thank you, sir.
Thank you.
Bradley Hodges. Bradley Hodges. Bradley Hodges. Will note that Bradley registered for self for HB 4213 but did not testify. Thomas Kilgore. Tom, we have you for the City of Lakeway and self for HB 4213. Is that correct?
That is correct.
Go right ahead.
Thankfully, Chairman Hunter, this is the last bill I'll be talking about. This contract was egregious in the industry. In my 20 years in the private energy business and in the corporate world, we all wanted to buy this contract and this plant because it was so mispriced. The fact that the city of Austin tried to atone for the bad contract by buying the facility and then passing the costs on to its ratepayers was viewed by those of us in the energy industry as a staggering mistake. And we never thought that that was the right case. I'm opposed I'm supporting the bill because this effective rate that we can't appeal, the way the cross subsidization works is my residents, the residents of Bee Cave, Village of the Hills, Westlake, we are paying our residential customers for a management decision that was only supposed to be working for the benefit of the large commercial users of electricity. This is the differences. As the gentleman before me testified, we have no issue with the linemen, the workers, and the people of Austin Energy. We all greeted them warmly during the ice storm. We took care of them, they took care of us. Our opposition to this bill is a management decision to cross-subsidize where my residents have to pay for their mistake at management. And I would ask you to support the bill to undo that classic mistake and that burden on my citizens. Thank you, and you've all been really great today. Thank you very much.
Thank you, Mayor. Any questions? Thank you, sir. Andrew McFarland. Andrew, we have you registered for Texas.net for HB 4213. Is that correct?
Correct.
Go right ahead.
Thank you, Mr. Chairman and members. My name is Andy McFarland, and I'm here supporting HB 4213 on behalf of TexasNet. After the market in ERCOT was deregulated, not a single kilowatt that Austin Energy generates is consumed by Austin Energy retail customers. All of the electricity produced by Austin Energy-owned production plants is sold at wholesale and consumed by retail customers of other retail distribution utilities. And therefore, Austin Energy buys all of the electricity its retail customers consume through the ERCOT market from unaffiliated generation companies. In the competitive market, this structure could and does generally work well for both wholesale and retail sectors. Retail service in Austin, however, is not competitive. Austin Energy retains its monopoly on retail service and sets its own retail rates. Austin Energy is not managed like a normal business operating in competitive markets. Austin uses its integrated electricity utility as a slush fund and social engineering experiment for the city. Austin keeps retail residential rates artificially low, imposes artificially high retail rates on businesses to make up the difference. Austin Energy has consistently been unable to recover the entire cost of production for its generation plants through its wholesale prices, and therefore is required its monopoly retail users to make up the massive losses it is suffering through mismanagement of its wholesale purchasing and generation operations. I'm not sure about the most recent numbers, but as recently as 2016-2017, Austin Energy's wholesale generation losses alone were $210 million. It's not just reasonable that for any Texan that lacks competitive choice to pay retail rates that make up for poor management decisions being made by politicians. Thank you, Mr.
Thank you,
Chairman.
Andrew, and we've got you down for HB 4213.
If I could just add that my favorite place on earth is the South Jetty at Port Aransas. Thank you.
You need to be testifying on the next bill. Craig Nazor. Craig Nazor. Craig Nazor. We'll note that Craig registered for Lone Star Chapter Sierra Club and self against HB 4213, but didn't testify. Members, that's the last of our registrations. Is there anybody else who would speak on for or against this bill? If not, Chair recognizes Representative Troxclair to close.
Aren't you so glad that you didn't hear the other 3 bills that I filed on this topic? No? Y'all aren't entertained? Okay. We're pretty desperate for relief. The bottom line of this bill is if wholesale companies lose money, they go out of business. That's what happens in the real world. If you lose money, you go out of business. They don't have retail customers to backstop the losses. But what is happening in Austin is that monopoly retail ratepayers are on the hook for the bad decisions that they have no benefit from. This bill does not, just clarifying, this bill does not prohibit Austin Energy from owning generation. Does not. All it does is prohibit them from using ratepayers for bad decisions. I will also note that this does impact Texas taxpayers because the Capitol complex is served by Austin Energy. So everybody is subsidizing this as well. So, and I guess the bottom line is, you know what? If we had an independent expert board, these poor decisions probably would never have been made in the first place. So I appreciate your time and hopefully your favorable consideration of these bills.
Thank you, Representative. The chair moves to lead HB 4213 pending at this time. Is there any objection? Hearing none, HB 4213 is left pending, and we'll be all getting back together for our update on Friday.
That's right. Thank you.
All right, members, I am going to be passing the gavel to Vice Chair Hernandez.
The chair lays out Senate Bill 2012 by Senator Schwartner and recognizes Chairman Hunter to explain his bill. The chair offers a committee substitute to Senate Bill 2012.
Thank you, Madam Chair and members. What I'm going to do is outline a proposal, and I'm going to outline this proposal, and most of the committee should have received the information. And I do want to tell our listeners and our attendees that there had been a draft, and then we got a Texas Ledge Council draft that had a little bit different type wording. The sunset date in the draft is what we're following. And just so you don't, since I know nobody's nervous about this topic, I plan to make sure that that language is followed. Sometimes when you do drafts and you go through our system, you get some different wording, but concepts, as we've talked, is what we're following. Let me go through some things, and then I'm going to ask those participating to just make a suggestion on how we proceed, Madam Chair, with everybody. First of all, the committee substitute is known as the Performance Credit Mechanism Guardrail Bill. It's very similar to HB 4831 that we heard earlier this session with some changes. Earlier this session, we heard testimony from the Public Utility Commission regarding a recently adopted reliability service known as the Performance Credit Mechanism, fondly called PCM. And the purpose of SB 2012 is intended to build on the attributes of the Public Utility Commission's proposed reliability service while adding safeguards to address some of the questions raised by stakeholders in response to several key aspects of the proposal, including the potential costs and impact on the energy-only market. The substitute stipulates that both ERCOT and the Independent Market Monitor must conduct independent cost assessments to verify the true cost of the PCM, including the impact of the program on the ancillary services market. It requires any rules adopted to implement the PCM to include strong performance penalties and market protections. In order to protect the competitive retail market and control consumer costs, and let me just say this to everybody here. If you haven't been listening for 2 years, Richard Raymond will tell you, he and I have mentioned consumer almost in every hearing. And so we have the bill adds a cost cap of $500 million. It also limits performance credits to be awarded to only those megawatts offered into the optional forward market on a seasonal basis, as well as requires generators to be able to perform in real time in order to be compensated. And we will get modified the clarifying language on the sunset so that you absolutely see the same language. Now, we only have 41 of my favorite folks out there. So I'm going to ask you, not to be facetious, but we want to engage the discussion. My members, I want them to exactly understand this bill. And so I know that as we start, we're going to have some questions. And I want my members to know, and I want you to engage. But after a little bit of time, repetition sinks in. And I think it would be more helpful that after we've got the engagement going, that it is helpful to come up and say your organization, who you are, and I'm for it, or I'm against it, or I'm neutral. But once we get the engagement, we probably don't need to hear a bunch of repetition on those 2 minutes. So I'm going to encourage we start off with a robust discussion. And let me just be real open to everybody here on the committee. Everybody has been very helpful. I want you to know business and industry, generators, utilities, TDUs, renewables, conservation. I have had everybody come in to work with us. And they have been knocking on your doors. And that isn't I'm going to just tell you, members, it's not me, it's you. This is a committee of 13. And I think the message that we can send from tonight is we never have a final plan, but we got a plan that we can make better. And I think everybody's been engaged on this one. And I also think it's time we be constructive so that we show that Texas is here to do business for everybody. And so I do know there's 2 issues as we go, and I want you to be aware. One is the cap, and I have a lot of the folks questioning, but they want to work with us on it. And they support the concept guardrails, but they got a concern on the cap. I think that's legitimate to discuss. And then some have a concern on the sunset. Do you go a sunset? Do you do a reporting? I think that's something this committee needs to look at. So I want you all to know I'm very well aware. I think I've met with most of you, but I want to lay it out. And I know there's always jitters, especially when we get language that's typed differently. And but I want you to know the goal, and you're hearing me tell you that. But I do think there's a balance between PCM approach, the business industry approach. You got to be a team in the end. And you've got a renewable approach and our conservation consumers. And so I think this is the best option to get this in before everybody. So I wanted to kind of let you know, I kind of call it the PCM guardrail with the sunset and a nice little cap on top. And so what I would like us to do is, Madam Chair, is start bringing some of the folks up, and I want our committee to engage. And, we're not stopping today. I mean, this is a growing process. But what I really want this to be is, our House proposal. And we take this approach, kind of involves everybody. And then we've got a kind of good mix from all the groups inside the Capitol. So, Madam Chair, I'll close. I think it's more constructive for our members to hear from some of the folks here so they can give their ideas. But make sure they follow the 2-minute rule, please.
Members, any questions of Chairman Hunter? If there are no questions, we'll proceed with testimony. Chair calls David Black. We show you registered as David Black, representing Shell, and you are for the bill?
Yes.
You may proceed.
Good evening, Chairman, members. My name is David Black, and I'm the CEO of Shell Energy, and I'm testifying in favor of the committee's substitute for SB 2012. Shell appreciates the committee's revisions to date. Shell participates in all sectors of the energy market, including as a generator for both gas and renewables, as a retail provider, and as an industrial consumer. We're the largest wholesale energy seller in Texas for over a decade, and because of our footprint, we are on all sides of this discussion, and our aim is for safe, reliable, and fair energy markets. We know that what benefits us today may harm us in the future through unintended consequences. Because of this longer-term view, we ask that you don't favor any one market segment because the market works best when risk and rewards are allocated appropriately. The market is already sending the correct signals to encourage investment. Shell has participated in or built over 1,500 megawatts of gas generation in the last few years alone without PCM. We have done this at our risk, on our balance sheet, and not that of the consumers. You may have concerns about long-term dispatchable capacity and reliability. The independent market monitor who Texans pay to provide expert input states that we do not have a capacity problem today. We have an operational problem. These are not my words, these are theirs, and we should listen. If we move forward with PCM without guardrails, we will silence the price signals. PCM will shift money from the energy market into the PCM market. That in turn will dampen energy prices and crowd out investment and innovation. If this committee is going to support PCM or something similar, Shell supports firm guardrails to ensure that it causes as little damage as possible. The most important guardrail being the $500 million total cost limit that you've already included. This is an essential protection for Texas consumers. Because
Thank you. Members, any questions? Representative Raymond?
So, I apologize, were you listed as a for or against?
For.
We are for.
And is there anything in the bill that you would change? Feel free, I mean, it's okay to say it.
No, I think that
The cap, nothing?
we want to make sure the cap stays in.
See, I
We
gotta ask,
must,
is there something you would change?
no, we're saying we want to keep the cap.
Oh, you want the cap?
Yes.
Okay.
Yes, just to be very clear. We believe that the consumers are going to pay for this one way or another. It's going to
believe
be
that
passed
too.
through to the load-serving entities, and load-serving entities will pass it on to consumers. I think we can all agree that's what would happen. And so we believe that a cap is prudent because the PCM is new. It's never been done before, and it could have unintended consequences.
And so are you comfortable with the sunset on it as well, or?
I believe we are. I don't think we have any strong opposition that.
You said that the IMM said that we don't have a capacity problem. You agree with that, you said, right?
I do.
And when do you have any feelings on when we might?
I don't. I mean,
If we didn't do anything, we didn't pass anything, we just sort of,
I think it's dependent upon a lot of different factors. Load growth, a lot of that is migration from folks coming here, and then there's the supply. I mean, there's a large queue, I think everyone would agree, in generation, both in renewables and dispatchable via gas. And it's hard to know what is going to get built. I believe on average, 25 to 30% of what's in the queue gets built nationally in ISOs. And so it's very difficult to predict what the future is. And that's why, because again, Shell's a little different, because we have a diverse footprint, and what we may help one side of our business may impact negatively a different side. And so our aim is to be targeted in the changes that we make. And the PCM is a bit ambiguous, and hopefully through today we'll be able to line some of that stuff out. But our view is that the capacity is not a problem today. It is an operational problem. We have a problem when the wind doesn't blow and solar doesn't shine, those types of things. And how do we solve that problem?
All right, well, thank you.
Thank you.
Any other questions? Representative Anchia.
Yes, Madam Chair. I'd ask of you and anybody else, if you're testifying in favor of the PCM guardrail bill as is, if you could also give us your opinion on whether you are for or against the PCM generally. So, because what I don't want to happen is people come up and say, well, I'm for the PCM guardrail bill because it has all these poison pills in it that will kill the PCM, and therefore I'm for it. I'd like to know people's position on the PCM as well.
Sure. Well, we are for the bill as it's presented today, specifically with the cap. I think PCM, what I would say is the concern that we have around PCM is that it's just never been done. That's a huge concern. And when we look across what's happened in the other ISOs, I think many of you may understand that some of the other ISOs that have been put in administrative constructs are now walking back from that because they get litigated, because there is a lot of ambiguity. And so I think the PCM is a tool. I don't know that it would be the best tool. But being that this is the rule in front of us, we support it as it is with the guardrails, because I think it limits the potential of unintended consequences.
Would you be happy if the PCM moved forward?
As it's presented? Yes.
Not the guardrail bill, the PCM?
No.
Without the guardrails?
No.
Okay, thanks.
Sure.
Any other questions? Thank you.
Thank you.
Chair calls Sam Siegel. As Sam Siegel, representing Vistra, and you are for the bill, is that correct?
That's correct. Chairman Hunter, Vice Chair Hernandez, members, thank you for allowing this opportunity for Vistra to testify in support of Senate Bill 2012 as submitted, with some important caveats. My name is Sam Siegel, and I'm Vice President of Wholesale Strategy at Vistra Corp. Vistra is a strong supporter of free markets and the ERCOT competitive market. Texas is facing a dispatchable capacity problem and is at risk of having insufficient dispatchable generation. A well-formulated performance credit mechanism, or PCM, is the competitive market solution that addresses this problem by compensating dispatchable generation for the reliability it provides when it provides it. The PCM framework will benefit from further stakeholder development, and appropriate legislative guardrails can guide that effort. The current guardrails in SB 2012, while well-intentioned, could be improved to make the PCM more effective. With these improvements, Vistra would likely build new generation under a PCM mechanism as reflected in SB 2012. At a minimum, for new generation to be investment worthy under the PCM, the following updates to the legislation would be needed. Revision to the cost cap language to something that retains economic incentives for dispatchable generation while balancing cost concerns such as the cap on performance credit price instead of cap on total PC costs or net cost. Removal of the sunset date. A sunset date adds uncertainty for investors who are making decisions based on a 20 to 30-year investment horizon, not a market that will end automatically 8 years from now. And removal of discriminatory language that singles out generation and retail affiliates, so-called Gen Tailors. Market manipulation concerns are not limited to particular companies in the market, and these concerns can be mitigated through robust reporting and a centralized clearing function. I'm happy to answer any questions from the committee.
Any questions? Representative Turner.
Thank you, Madam Chair. Can you walk through again the cap on costs and your suggestion there? Because that went pretty fast. I want to make sure I understand it.
Sure. So what we're suggesting is a price cap, not a cap on the total cost. That's pretty consistent with what is done in ERCOT today. There's a price cap for energy. There's a price cap for ancillary services. I think from our perspective, what we would like to see is a program that balances the energy and ancillary revenues that occur in the market, and that's netted against the cost of building new capacity. And that will be a dynamic market that grows as Texas grows, and also signals the need for new dispatchable generation organically, in a kind of self-correcting way. And we think that a $500 million cap, in particular in a state that's already growing, is going to be insufficient and likely will not incentivize new generation.
Okay. So do you address that concern by removing that language altogether in the bill, or changing the dollar amount of that cap, or changing the nature of the cap?
So we would change the nature of the cap. We would, our proposal is a 2 times net cone.
2 times?
Net cone as a limit, an upper, so the cost of new entry. Again, this is netted against the energy and ancillary revenues in the market. So as revenues go up in that segment, the PC values would go down dynamically. And, we think that is one way to do it. We think there's probably other ways to do it, but it's ideally kind of tied to the energy market, and allows the dynamic pricing of performance credits such that when there's a need, the signal is there for dispatchable investment.
Okay, thank you.
Any other questions? Speaker Guerin.
And thank you for being here tonight. So if you're suggesting that get rid of the $500 million cap, what if we raise the $500 million cap? Would there be a number that would be better?
Well, and thank you for the question, Representative. I think it would certainly be better if it was higher. We don't see that as sufficient revenue to incentivize new generation.
What if we came up with a low interest fund that this, a low interest bank that the state were to subsidize the interest rates for you? Would that be beneficial?
So we think low interest loans will help incentivize new generation. The issue that we want to address is when we only tackle the cost side of new build, then we end up pushing out existing generation. So we don't want to build a new gas plant and then have older gas plants immediately retire. We're kind of in the same place, and all we've done is sort of replace like for like. Our view is that a better cap is something that works dynamically as opposed to a fixed number, because then, as the state grows, as the needs change, as different plants come in, it adjusts dynamically. I think a larger cap would be better than 500 million, but from our perspective, that's still a more temporary solution.
Perspective, a cap is not the best thing.
We do think a price cap is a good thing. We do think guardrails are a good thing. We think that fundamentally, to get investors in Texas to support the ERCOT market, you want effective guardrails, you want confidence in the market, and you want to have an understanding of your potential upside and downside. So we're not opposed to a cap. We just think the cap should be on the price of the PCs as opposed to a total value of the credits as a kind of on an aggregated basis.
Thank you.
Sure.
Any other questions? Thank you.
Thank you.
Chair calls Rudy Garza. We show you registered as Rudy Garza, representing CPS Energy, and you are neutral on the bill. Is that correct?
Good evening, Madam Chair and members of the committee. Well, we are for the committee substitute. We're on the Senate bill.
Registered as neutral. You have to be registered on the bill, and you may speak about the committee substitute.
Very good. Then I'm on the bill.
All right, if you also confirm Rudy Garza, representing CPS Energy, and you're on the bill.
Yes, ma'am. Okay, so Rudy Garza, I am President and CEO of CPS Energy. We're the largest municipally owned electric and gas utility in the country, fourth largest generator in the state of Texas. So we're about 2/3 dispatchable, about 1/3 renewables, about 7,500 megawatts total. We believe that the PCM framework can work. Ms. Chair and Madam Vice Chair. So, I think the concepts that Chairman Hunter's laid out are certainly moving in the right direction. We're of the opinion that we do have some capacity challenges in a growing state. San Antonio is one of the largest, communities, growing communities in the country, quite frankly. And, if there's an issue, then you have to be for something. And I think the work the PUC done is to create the framework was, I think, well-intended. I think the legislature rightfully should, create whatever, guidance that, would make this, the PCM, a palpable solution. We do believe that we do need more dispatchable generation, but we also believe that, that you need to fix, incentivize dispatchable generation in the right way, but that should not necessarily include any kind of, technology choices on, penalizing renewables. So we do believe the cost allocation, methodology that's been presented probably does need a little bit of work. But we believe that energy efficiency demand response, which we're leaders in the industry on, certainly has a role to play in the solutioning here. And, the study, what that means is we got to go through a rulemaking process and understand exactly what we're doing and that it's going to get us the results that we need. We serve 1.2 million customers. So how costs are allocated to customers is important to us.
Thank you. Representative Raymond.
Thank you, Madam Chair. So you would be for a cap, is that right?
I'm not sure that I'm in a position to say whether I like it or not. I think.
No, yeah, you are. You can say yes.
Okay.
No, I don't know.
I probably would not include a cap. I think, what we know about caps and from our experience with Storm Uri is caps aren't always a great thing. And so you got to make sure that if you do include some kind of prescriptive language in the bill that, it might need to move up or down depending upon, what level of reliability you're trying to solve for. So, I don't know that 500 million or whatever the number is the right number. I know that maybe it's the right number. In some instances, maybe it's not in others. And I'd like to talk about that some more to try to get my head around it. But I don't know that I'd put a cap. I might leave that to the PUC to figure out. But if you're going to include a cap, I think it might need to be somewhat flexible.
And the sunset, would you put a sunset?
Yeah, I really don't have, an opinion on sunset. You're going to do a lot of work to sunset it in 10 years is what I do know, but you sunset the commission, anyway. So you might just, make that a provision of the PUC sunset bill.
Yeah, but I think it's a little different. I mean, I get that. We sunset every agency.
Right.
Every single agency.
Yes, sir.
But we're not asking for investors, right?
Yes,
so there's that consideration.
Well, we'd like to know what
we're not asking for investors on commissions, agencies.
Right, sir. Yes, sir.
You know what I mean?
Understood. Yeah, I mean, again, I don't have a visceral reaction to the sunset provision.
So if the chairman were asking questions, he would ask, where are you from?
Corpus Christi, Texas.
Any other questions? Thank you.
Thank you.
His dad.
Chair calls Tom Oney. We have you registered as Tom Oney, representing the Lower Colorado River Authority, and you are for the bill.
Yes, ma'am. Good evening, Madam Chair, Chairman Hunter, and members of the committee. For the record, my name is Tom Oney. I'm Executive Vice President for External Affairs at LCRA. We're a river authority that owns or has rights to about 3,500 megawatts of electric generation in ERCOT. I'm here to testify in favor of the House Committee substitute for SB 2012, specifically discussing the guardrails. As you're aware, we believe the PCM the PUC has adopted is a workable solution to both retain existing and incentivize new dispatchable generation. However, we support imposing reasonable guardrails on the PCM. We believe will enhance the program's effectiveness and also protect consumers from high cost. We believe most of the guardrails in this substitute are reasonable. However, we have concerns with two of them, and I think you've heard this already. The cost cap. We are concerned that setting an upper limit on the cost of the overall program may undermine its effectiveness and create regulatory uncertainty. We believe there are other ways to provide cost protections to consumers. You've heard about one of them. Creating a cap on the value of a performance credit, similar to the price caps we have in the wholesale market today. This should be a more effective tool during high-risk years where there might be a significant number of scarcity intervals. Without creating regulatory uncertainty, the PCM itself might just go away. Second, the proposed sunset date. As this committee is aware, power generation facilities are a long-term capital investment. We would not expect developers to invest their capital in new dispatchable generation in ERCOT, knowing the program could go away before they're able to recoup their investment. Rather than impose an end date on the PCM, we support requiring the PUC and ERCOT to assess how the program is performing and provide frequent reports to the legislature as a clear and consistent check on the program. With these revisions to the guardrails, we believe the PUC will be fully equipped to implement a PCM program that meets ERCOT's long-term reliability needs while also ensuring appropriate protections for electric consumers. I'll be happy to answer any questions you may have.
Any questions? Thank you.
Thank you.
I want to ask
Oh,
one.
I'm sorry.
You know, thank you, Madam Chair. And I don't know if it's.
Yes, Representative.
I'm going to ask something. I don't know if it'll sound silly, but I'm
Never.
not trying to be. Certainly there are times where I'm trying to be silly, but not right now. So there was a 30-year sunset on it. Because I keep hearing, you hear about, oh, they want to know they can get their money 25 years or 30 years or whatever. So, I don't know, I'm just throwing that out. What if we put a 30-year sunset on it? Does that matter, or is it just like irrelevant at that point, or does it still affect investors, or?
I think the PCM should be a dynamic program such that if we get 30 years from now and generation is built and demand is tapering off in Texas, or we've met a place where we don't need more generation, the price of the PCM should be close to zero. So I think any kind of sunset date kind of presumes that it's not a market. The PCM mechanism is a marketplace where ultimately the needs ought to be met by generation, and they will dictate the value. And I think that a previous witness said that will be reflected in the energy price and AS price. Those should play off of each other. So I think it presumes something different than a market, and that's what we have here.
So it's just hard, I guess what you're saying from your vantage point, it's just hard to imagine a program like this with a sunset, or any sunset, I guess, no matter, if we did something else and we put a sunset on it, it still clouds things up too much, you think, right?
I think so. I think it could be similar to putting a sunset on the energy-only market, right? Companies have come here to invest in this marketplace and saying within 25 years we're going to stop it. That would it would be an odd way to approach a business to come invest in Texas.
Yeah. Thank you.
Representative Anchia.
No, I think Representative Raymond got at my question. Well, Tom, go green wave.
Go green wave.
Go green wave.
Second marriage too.
What would be a good alternative to a sunset date?
I think
how should we approach that? If we say, okay, no sunset date, we want market predictability, but we do want to maintain, tight oversight over this, even outside of the committee process. What should we be demanding as policymakers?
I think that this committee is very good at asking for accountability and demanding it. I think setting up even requiring a statute that they provide a robust report to you on status of the PCM, even biannually, quarterly. I don't know what the right frequency is, but a report and maybe a hearing to follow. I think there are ways that y'all have processes that will provide for accountability, and you will know what's going on and can provide input to that process. So I think it's probably a reporting followed by a hearing to hear that out. And like I said, that could be biennially, during the even numbered years, or you could do it multiple times during a year. But I think that this chairman and this committee know how to get accountability from the PUC and ERCOT.
Any other questions? All right. Thank you. Chair calls Nathan Murphy. We have you registered as Nathan Murphy, representing Valero Companies, and you are for the bill?
Yes, ma'am.
You may proceed.
Good evening, Chairman, Vice Chair, and members of the committee. I'm Nathan Murphy, Senior Counsel for the Valero family of companies. I'm testifying on Valero's behalf in support of the committee substitute. Valero's headquartered in San Antonio, Texas, with a strategic role in the state producing liquid fuels that power our economy. We operate 7 refineries in Texas. 5 of those refineries are in ERCOT. And as a large consumer in Texas and other electricity markets, we care a lot about price and reliability. Our refineries run around the clock and need consistent and reasonably priced power no matter what time of day it is or what the weather is outside. Costs in ERCOT have been rising rapidly, and we remain very concerned about the outlook for reliability and price variability. Valero supports meaningful market design changes that will incentivize reliable dispatchable generation at least cost to Texas consumers. However, consumers really need this bill to pass because we need guardrails to protect against excessive cost increases, and we need assurance that new programs deliver the promise of reliability. We very much appreciate and want to underline the importance of the price cap. We appreciate that. We think the $500 million cap is appropriate, and that will prevent the program from becoming an expensive new mandate. We also believe that market redesign programs aimed at variability and uncertainty should be paid for by the generation and loads that cause the variability and uncertainty. Causation is important in ERCOT. Those that aren't creating the problem shouldn't have to pay for it. We thank you for the opportunity to speak, and with that, I'll answer any questions.
Any questions? Thank you.
Thank you.
Chair calls Bill Barnes. We have you registered as Bill Barnes, representing NRG Energy, and you are for the bill, correct?
Yes, ma'am. Thank you, Madam Chair. Chair Hunter, members, Bill Barnes, in support of the committee substitutes for Senate Bill 2012 for NRG. We support reasonable guardrails on the design of the PCM. Reasonable guardrails should reinforce the best practices for its design, not render the program ineffective. The objective of the PCM is to provide resource adequacy by backing up the energy and the ancillary services market with additional financial incentives only when needed to support long-term investments in dispatchable generation. Long-term investments benefit from a stable market structure that the PCM provides. However, an annual cost cap and a termination date for the PCM undermine that certainty. Therefore, we have some suggestions to improve the committee substitute. We understand the need and agree with the need to protect consumers from high costs and recommend a price cap for the PCM rather than a cost cap. Price caps are how we manage costs in the current electricity market. For instance, energy costs and ancillary service costs are both capped by price, specifically the $5,000 per megawatt hour cap in the energy and the ancillary service market. This is important because a price cap allows the market to continue to function while containing costs. A cost cap creates an abrupt end to the market, even if the fundamentals suggest a shortage of dispatchable capacity exists. We also recommend a review process to ensure the PCM is achieving its intended objectives rather than a termination or sunset date for the program in 2031. We want to instill confidence with investors that their projects will be supported here in ERCOT, not pull the rug out after a few years. New dispatchable resources typically have a 30-year time horizon. Assuming ERCOT implements the PCM in 2026 or later, that's less than 5 years of operation. Happy to take your questions.
Representative Raymond.
Thank you, Madam Chair. So I want to make sure I heard you right. You support the cap, you like the cap rather, but you don't like the sunset.
We support a price cap, rather than a cost cap.
Right, price is
a cost cap. Okay. Just thinking about how a cost cap would work in our existing ancillary service market, which fluctuates between $300 and $1.2 billion. If you were to put a $500 cost cap on the ancillary service market, it would have stopped in about August of last year of 2022. And then what do you do?
Okay.
A price cap allows the market to continue to function while containing those costs.
And you don't want to, and you would prefer not to have a sunset?
We would prefer to have a sunset review the program, an assessment done by ERCOT and the IMM at the commission's behest to report back to the legislature on how its performance how it's performed compared to its
Oh,
objectives.
again, I want to make sure I'm hearing you right. So you're getting more creative. You want a sunset review, not a
Assessment or review process is what we recommend.
So you don't want a sunset.
A hard date that says the program ends at this X time unless the legislature keeps it going, sends a signal to investors that, well, maybe it won't be here. You got a 30-year asset.
I want to make sure, just for my notes.
Yep, that's our
You want a
view.
review.
Yes, sir.
And then we'll see what happens after that.
And if it's performing as intended and everyone's happy with it, we retain it. If it's got major problems, then we'll look on ways to refine it or see if there's another approach we should be taking.
Yeah. It's kind of it's almost the same thing, but I get you.
I think having a date that signals an end to the program while we're implementing it shows some lack of confidence for those that are looking to put.
Yeah, I know, but I mean, like we do with the agencies, right? So we have to do a sunset review, and we renew it almost all the time. In your case, like do a sunset review, and if you don't like it, you end it. You don't have to renew it, you just end it, right?
Similar to
we can do, what you're saying is do a review, and the review implies it'll keep going unless you take the proactive step as a legislature ending it.
That would be a better approach, I agree.
I hear you, okay.
Yep.
Representative Turner.
Thank you, Madam Chair. Bill, sorry I missed part of your testimony to step out for a minute, and so forgive me if you already covered this in detail, but I caught you saying that you would think a price cap is more workable than a cost cap, and cost cap is what we see in this committee substitute right now. So can you just explain why you think that's the better approach, and what your concerns are with the cost cap as exists in the committee sub right now?
Yep, a price cap allows the market to continue to function, where a cost cap would bring an abrupt end to the function of that market for that particular period. In the existing energy and ancillary service market, we have a price cap. We've always had a price cap. That price cap is set so that it still produces the intended incentives that we want out of the market, right? High enough so that any supply generation that can turn on can recover their costs, and also high enough so that loads have the incentive to curtail. On the PCM, it would be something similar. We would want a price cap that still allows the program to achieve its intended objectives of encouraging new investment, but at the same time containing costs to make sure that the cost isn't going astronomically high. That's the whole purpose of the price cap. And we think that's a much better approach. If you set a hard cost cap of $500 million, investors and those that are putting money at risk are going to have to try to guess as to whether that cost cap gets hit in a future period and the market stops. A price cap, at least you know if we are short of capacity, if we're short of our reliability standard, the market will continue to function, but the prices will be capped at a certain amount so that it will still have the certainty that's needed to deploy capital.
If we have a cost cap, will the PCM work in your view?
I think if you have a high enough cost cap, it possibly could. I don't think 500 million is high enough. You would render the program ineffective, in our opinion. It would be very difficult, especially paired with the termination date in 2031. You're probably only getting 5 years, and then you're capping the total cost of the program at 500 million, which, similar to other witnesses, the value of the PCM is going to be dependent on the revenues in the energy and the ancillary service market. So there may be times, say when we get another 20, 30,000 megawatts of solar, where energy prices are very low and we have retirements of generation and we need to retain existing, and the PCM should be higher than 500 million to make sure we keep what we have and that we're attracting new investment. So that cap would undermine the PCM's function.
Okay, thanks. Thank you.
Any other questions?
Yes, ma'am.
Speaker Garrett.
What would your proposed cost cap equate to in terms of a dollar cap in 2016?
So our
2026.
Yep. A prior witness suggested a multiple of cone, cost of new entry. It's a very technical term, apologize, but we would recommend something similar to that, where the price of the PC is capped at a multiple of the value you need to invest in a new dispatchable generation resource. Just like today, our energy price cap is set at an amount that is reflective of the high cost of not having enough electricity. The price for the PC should be high enough so that it is sufficient to cover the cost of construction of a new dispatchable generation plant. That's the whole point, on an annual basis, annualized. So if you have a price cap that's too low, let's say that the price cap is set where that an investor in a new dispatchable plant can only cover their costs. Most investors aren't going to invest in anything where you're only getting cost recovery. You're not getting any type of rate of return. So
What would that be in total dollars?
It depends on the design of the net cone concept, which uses energy and ancillary service revenues to deduct from the price of the PCs itself. But typically, I think this was in the E3 report, the cost of a new dispatchable combustion turbine is around $85,000 per megawatt year. So you would have some multiple of that.
Thank you, sir.
Yep.
Representative Raymond.
So I was looking at my cell phone, and I just thought as I looked at it, for generators, how much new generation would be assured under an increase in the cap you're proposing?
Can you repeat that again?
Hold on, let me read it. For generators, how much new generation, it's a good question. How much new generation is assured, I would say, would be assured under an increase in the cap you're proposing?
First of all, be assured, I would say nothing. Nothing is assured.
Nothing is assured.
Under the PCM.
No, under yours. Under your idea, you're proposing a price cap, right? Instead of a cost cap.
I'm proposing a price cap.
Right, so
that would assure that the price.
If we had a price cap in there instead of a cost cap, how much new generation do you think that would assure us?
If the price cap is set at per the design of the E3 report at a multiple of cone, you're going to get the same amount of new build that was estimated in that report. It would be able to continue to function.
I don't remember. Do you remember how much
as
it
a
was?
program? I think it was like 5,000 or 6,000 megawatts in new gas generation.
Thank you.
Any other questions? Thank you.
Thanks.
Chair calls Edward Stones. We show you registered as Edward Stones, representing Dow, and you're for the bill?
I am. My name is Edward Stones. I'm the Vice President of Energy and Climate for Dow. I'm one of 4 industry appointees by Governor Abbott to the Texas Energy Reliability Council, and I'm testifying in support of SB 2012. Thank you, Chairman Hunter, for the work on this, and also members of the committee. Dow overall has several sites, both in ERCOT and non-ERCOT, and we do have our largest global site here in Freeport, Texas, within ERCOT. Just to begin with, for us, PCM is a capacity market and anything other than name, and we're opposed to the PCM, and we believe guardrails are essential, including a firm cost cap and a sunset provision. We have experience operating in capacity markets around the world, and capacity markets add cost, but they usually don't add capacity. You're paying for what you already have. Right now, we're paying roughly $30 a megawatt hour for wholesale power in Texas. We pay about 15% more to ensure reliability here. In Louisiana, wholesale power is about the same price, but we pay 50 to 70% of that to get reliability. Louisiana's a capacity market, Texas is not, ERCOT at least. Even in capacity markets, generation doesn't always perform. PGM during Elliott had problems. SPP and MISO during Uri had problems, including very high fraction of units that offered into the capacity market and didn't deliver. To be very clear, the cost in power and steam is a major factor in our decisions about where to invest in new facilities. And we've announced, that we have a joint development agreement with X-Energy to explore building an advanced nuclear reactor on the U.S. Gulf Coast. But that doesn't require a PCM capacity market. A PCM muddles the water for our investment decisions since we don't know what it will cost, and that uncertainty won't be resolved anytime soon.
Just to clarify, we have you registered for the bill, correct?
I'm for the alternate, yes.
Any questions, members?
Madam Chair.
Speaker Gearin?
Thank you. Mr. Stone, first, thank you for wearing the purple for TCU. I appreciate that very much. You mentioned that Dow operates in the ERCOT and non-ERCOT ISOs.
Yes.
Can you elaborate on why we should implement the guardrails on this bill?
Yes, so the guardrails are very important in ensuring two things. One, that there's an answer to your question about how much this costs. The prior witness was unable to tell you how much this was going to cost consumers, and that's because nobody can tell you that.
I'm not sure if unable's the right, but go ahead.
Well, it seemed unable to me. I didn't know what the number was, did you? And I think the other thing is this is a new concept, and it's an approach to regulate a market, but we don't know whether it's going to work. A reasonable consumer asks for a review and a sunset if it doesn't work, and that's what we're asking for.
Thank you, sir.
Representative Turner?
Thank you, Madam Chair. Just to be clear, I think you started your testimony saying we don't support the PCM.
That's correct.
We do support the guardrails.
Right.
So in your opinion, if this version of guardrails is implemented, will there be a PCM?
There will be a PCM. We would prefer not to have guardrails and not to have a PCM. But if we're going to have a PCM, then we need guardrails.
Any other questions?
Yeah, no.
Representative Raymond?
So, you don't want PCM, you don't want guardrail, you don't want PCM, period, right?
Right.
So, if we didn't do anything, you started saying that you're talking to, I forget what company or what investors or something?
I'm with Dow.
I
No,
know
we're
you're
talking
with Dow.
X-Energy for.
No, but you're with Dow, I know that, but you're, what energy?
Yeah, so it's called, company's called X-Energy. We just announced that we're looking at building a nuclear plant on the U.S. Gulf Coast, and going with the Advanced Reactor Development Program. A nuclear plant on the U.S. Gulf Coast.
What, right, but where on the U.S. Gulf Coast?
We haven't announced where we're doing it beyond that.
Okay. So, I want to ask then, I guess, your view. If we don't pass anything, if nothing happens, we don't pass anything and the governor tells ERCOT, PUC, stand down, what do you think happens?
I think, so we do believe, and I worked as part of Turk, and I like several other members who were in that spoke, we do believe that more dispatchable power is required in ERCOT, and that there are better ways to make that happen than the PCM.
Okay, go ahead.
So, we are supportive of ancillary market reform, and there's an alternate bill that I don't think I want to talk about for different reasons.
We don't say bill, but you say there are other.
Yeah, so I think, being we want to be incenting what matters, right? So what matters is dispatchable power, which is provided and available when you need it. And ancillary services are how you do that, not a PCM market.
So again, you think that if we don't do anything and the governor tells the agencies to stand down, just sort of, hey, let's follow Dow?
I think what we would say is that, there are better ways to do it than PCM, including, like I said, paying for ancillary services that provide dispatchable generation when you need it. And that excess revenue, or that new revenue, will allow investments to be made, like the one that we're contemplating. And you heard from my colleague at Shell, who's also been investing in
And
those.
so when you say paying, you mean who's paying?
Well, it's the ancillary services become a market as well and a source of revenue that are part of that are paid for eventually by the consumers of the state as well.
Okay.
One more, Madam.
Speaker Garen.
You mentioned a nuclear facility. You're not going to say where it is, and I understand that, but how long will it take before that nuclear facility will be generating electricity?
So we've said that we would anticipate startup by about 2030.
That's permitting everything.
Yep.
Thank you, sir.
Any other questions?
Madam Chair.
Chairman Metcalf?
Yeah, how much money do y'all make on the ancillary market?
I don't think we make a lot of money on the ancillary market today, but I don't know that fact. I mean, I think for us, what we're trying to focus on is providing reliable power and steam to our derivatives principally. And then we have some sales into the market above that whenever we have excess power that we produce. It's not our source of revenue isn't power generation. Our source of revenue is products. And so what's incredibly important to us is competitive power and steam to support our larger investments in plastic and chemical production, which is our principal source of business.
Thank you.
Any other questions? Thank you.
Thank you.
Chair calls Julia Harvey. We have you registered as Julia Harvey, representing the Texas Electric Cooperatives, and you are for the bill.
Yes, thank you, Madam Chair. Members, I'm Julia Harvey on behalf of Texas Electric Cooperatives. That's the statewide association representing the 75 co-ops operating throughout Texas, testifying in support of the committee substitute to Senate Bill 2012. Overall, we believe these are reasonable guardrails to ensure that the PCM or any other similar program fulfills its stated objectives. We've been on the record as skeptical of the PCM, and we still are. And to be candid, we don't have a lot of detail about the PCM or how it will work or how the market will clear or some of those fundamentals, but it can probably be effective with further stakeholder engagement and additional analysis. And so we support the revised independent market monitor and ERCOT evaluation of the costs and benefits and the implementation of real-time co-optimization alongside the PCM. Other than that, I'm just going to focus on the cost cap. So regarding that cap, the PCM cost will ultimately be determined or kind of hinge on the chosen reliability standard. The costs of the program are a function of the reliability standard. That's the amount of additional installed capacity that the PUC or the legislature determines we need in ERCOT. And we're okay with a cost cap. We are sensitive to costs as co-ops, but it's worth pointing out that if you impose a cost cap based on a fixed number, the PUC would lose some ability to determine what might be the optimal reliability standard, which is really the major policy question we're dealing with. And they would lose that ability because of a cap or a constraint in legislation. So the $500 million, I think that's probably related to the $470 million estimated cost in one study. That's a long run estimated cost outcome according to one model. So a different approach, might be a cap, and there are caps in this market. We have what's called the peaker net margin. It's an accumulation of revenue. It's considered a cost cap. Once you reach it, you change the high offer cap in the market. All right, I'll close there. Thank you.
Representative Manchia?
Yes.
Julia, I was hanging on your every word here at the end, and not to extend your testimony. I just want to say I agree with you. I hate putting rigid numbers in bills because we never get back to fix them, and they tie everybody's hands, right? Yes. So I'm right there with you on that policy. I'm also sensitive to the fact that 2 times net cone. There'll be other people I want to explain that's just a made up number, right? As far as I'm concerned, like I want to understand what the hell that means. You were about to say another alternative is, and I want to hear your alternative.
Sure. Thank you, Representative Anchia. So a different approach, rather than trying to put in, a fixed arbitrary cap in the legislation, another provision of the bill requires the IMM to do an analysis to sort of recommend an optimal reliability standard to the PUC. So you could have them do that, and then as a result of that analysis, the cost kind of falls out of that, and so you could cap the program kind of around the cost associated with that optimal reliability standard that's recommended by the IMM to the PUC.
Okay, so study happens, and would this be a rolling, analysis? Because the market's dynamic, the very reason you don't want to put a hard number in statute, in my view. How often would they make these recommendations to the PUC, and what might be the best practice there?
Sure, and we kind of do a similar study in ERCOT today, but it's biannual. You want to update it as kind of the cost environment changes. It's sort of based around and assumptions around the cost of new entry and the value of continuous service to consumers. So you want to update that over time to reflect kind of broader trends.
Okay, thank you.
You're welcome.
Any other questions? No. Representative Dean.
Julia, thank you for your testimony. And let's go back to this 2 times cones and the $500 million cap. In listening to Speaker Garen's questions and questions to several people so far, he's gotten sort of a nebulous answer, if you will. It turned into a gas and went away. Is that sound about right, Speaker? I think the reality is that I think everybody was all happy with 500 million to we have this bill coming. Now all of a sudden we don't really like it. Do you have any opinion about what that number really is?
Thank you, Representative Dean. I am not familiar with the 2 times cone recommendation right now. I think the 500 million is probably not what we would recommend. You want, again.
What would y'all recommend? Let's talk openly here.
Sure. Yeah.
We're not going to hold you to.
Yeah. At a minimum, you would want some flexibility around that cap so that you don't discontinue. I would say do not put a fixed number. Hinge it to the IMM evaluation and recommendation around the optimal reserve margin that's laid out currently.
But obviously let's keep trying, Speaker. But for us as policymakers and for us to go in front of our colleagues and whatnot and say, well, look, we're going to have a cap, but we really can't tell you what that's going to be. So just give us, because we're going to ask everybody else too, right? But give us some kind of guideline or boundary. It could be this, but it wouldn't be more than something. It's just, we understand it's a wild something guess, but in your opinion, what would that be?
Right.
And we're not going to hold your feet to the fire on this. We're just trying to get some clarity on this.
Yes, thank you for the question. It's really hard to come up with a number, and that's not satisfying. Yeah.
And your number was?
Annual cost per year is what you're looking for?
I'm talking about this 2-time cone net.
Okay. 2-time.
Would it surprise you if I heard today it was $12 billion?
Yes, to implement the PCM, depending on the design.
Would that surprise you?
Depending on the design, it could cost that much, yes.
Okay. At least you didn't give us a number, but okay, thank you.
Representative Raymond.
I was just going to ask if we have the IMM here. I don't see her, but do we know?
We have ERCOT,
As a resource?
but no IMM.
She's not here?
And do we have PUC?
Do you want to call?
Because, I mean, listening to Julia, I understand you're not wanting to give a number because you're suggesting that the IMM look at it and, kind of tell us it's a moving target. And so that's why you weren't giving a number, right?
Right, that's right, because the cost would be an output of the reliability standard. That's a recommendation of the IMM.
Yeah.
And so that's kind of the key factor that we would need to know.
I hear you.
Yep.
All right. And if she was here, I'd ask her to comment on that, but.
Any other questions? All right, thank you.
Thank you.
Chair calls Warren Lasher. Warren Lasher, we have you registered representing the Texas Oil and Gas Association, and you're for the bill?
That is correct. Thank you, Mr. Chairman, committee members. My name is Warren Lasher, here today for the Texas Oil and Gas Association to speak for the committee substitute language for Senate Bill 2012. Texas Oil and Gas Association is a statewide trade association representing every facet of the oil and gas industry. Texoga members are some of the largest consumers in the state, and we hope you will hear our concerns. Texoga supports the committee substitute to Senate Bill 2012 because of the essential consumer protections that it provides. We thank the House leadership for their work in this committee substitute to protect consumers from further increases in electricity costs. To be clear, Texoga members do not support implementation of the performance credit mechanism. It is an untried, risky proposal that without guardrails would likely be very expensive and have little impact on reliability. Of the important guardrails included in the committee substitute, as you've heard from others, I want to emphasize the most important would be the cost cap. The PCM proposal requires a cost cap to protect consumers. The details of the PCM have not been defined. All we have at this time is 12 general principles developed by the Commission. In particular, there are no limits currently on what the program will cost. Without strong guardrails around the PCM implementation, in particular a hard cost cap, Texas consumers will essentially be handing a blank check to the Commission and to power generators. To further drive this point home, the Commission asked ERCOT to develop a, quote, bridging solution to jumpstart additional funds for generators as early as June of this year. In response, just yesterday, the ERCOT board approved a recommendation to arbitrarily increase generator funding by $500 million per year over the objection of every consumer representative on the ERCOT Technical Advisory Committee. I will end by saying that Texoga still supports the Dispatchable Reliability Reserve Service to fix what is needed in the current ERCOT market. Again, thank you for these important guardrails, especially the hard cost cap, and I will be happy to take any questions that you have.
Chairman Metcalf.
Slash, thank you for being here tonight. Why do you think 500 is the right number for the cost cap?
I believe $500 million was developed from the E3 report, which said that the program would cost $500 million.
Okay. Do any of your members make revenue off the energy market today?
Some of our members, a limited number of our members, are able to participate in the market because of their large usage. It's a very small subset of our membership. Most of our members are power consumers off of the grid.
That may change if this.
Our business is the production of oil and gas.
I understand what your business is.
And well, we like to sell it too, yes. Yeah, you're absolutely correct.
No,
That's the best kind of market.
Yeah, thank you.
Thank you for the correction.
Thank you.
Any other questions? Representative Turner?
Thank you, Madam Chair. So, and I think you were very clear at the beginning of your testimony. I mean, Texoga's always opposed the PCM since this was unveiled.
That's correct.
By the Commission, isn't that right?
Yes.
Okay. So you support the bill, and my question is similar to what I asked the previous witness. I mean, you support this bill. Do you believe there will be a PCM if this bill is passed as is?
I think we would hold out hope that there will not be a PCM, even if this bill is passed.
Do you think this bill would make it less likely that there would be a PCM?
I think this bill will ensure that consumers are protected in the event that a PCM is implemented.
Okay. And so let's say there's not a PCM, whether the bill passes or not. Let's say that there's not a PCM. What is Texoga's suggestion as to what we should do to ensure we have sufficient generation and we have reliability in our grid?
Yes. Understood. Texoga and other associations have put forward a proposal combining the Dispatchable Reliability Reserve Service, which is a new ancillary service, which will provide direct funding for the types of generation that we need currently in the market, in addition to tax credits and a low-income loan program, and then tax credits for new dispatchable, reliable generation.
Low-income loan program?
That's correct. That was part of a proposal that was put out by the.
Yeah, can you refresh my memory on the low-income loan program?
I believe the issue is in terms of generators being able to acquire sufficient low-interest loans for their generation equipment.
Low-interest loan?
Yeah, what did I say?
Oh, you said low, I thought I heard low-income loan.
Low-interest loans, yeah, my apologies.
Okay.
It's late.
Low-interest loan, okay.
Yeah.
Okay,
Low-interest loans.
okay. And do we think interest rates are the problem?
We think it may be the reluctance of certain banks to finance.
To finance these particular projects?
Correct. Thermal generation, reliable gas generation projects.
Okay, all right, thank you.
Representative Dean.
Yes, sir. So, we've asked other people, the 2X and net cone.
Correct.
Your opinion?
Well, I think it's a little bit high.
So 2 times net cone.
Yeah, 2 times
So
net
what
cone.
what is that number that you're saying would be too high?
Well, so if we had some numbers that were just thrown around, the cost to fully support the investment of a new gas peaker is approximately $100,000 per megawatt per year.
About 1.1 billion for a thermal.
To completely build one, yeah.
That's right.
But I'm talking about per year. So if I built a unit and someone paid me $100,000 per megawatt per year, I would be reaping back my full capital investment on that project. So if you're trying to fund 60,000 megawatts, $100,000 per megawatt, 2 times cone, that works out to $12 billion.
Okay, so that's where the 12 billion comes from.
I would think that's where the $12 billion comes from.
My information in discussions say that that's the minimum. If we're to look to this program for new bills, it could be as high as 18 billion. Your opinion on those?
$18 billion per year. That's, I think you're going to find it becomes difficult for consumers, whether they're large or small, to start paying their
I'm
energy
not
bills.
saying I support that, sir. I'm just telling you what how this building works. And that's the information. Just wanted to see from Texoga's perspective, your thoughts on those, what those numbers are out there.
So another issue with those numbers is you're not just giving with a performance credit mechanism type program, you're not just giving that money to new generation, you're giving that money to old generation. So you've got some plants that were built before deregulation. They were mostly paid off as part of their regulated usage.
Correct.
Then there was, when we went into deregulation, there was stranded cost payments. And then they've survived in the wholesale market for 20 years. And now we're going to turn around and start paying those 50-year-old units 2 times the cost of new entry. We think that a program that is specifically focused on new generation is more likely to result in what the market needs today at a more cost-effective cost.
Okay, thank you.
Yeah, thank you.
Representative Anchia.
Just really quickly.
Please.
You mentioned a basket of 3 things that you're in favor of: DRRS, low income, low interest.
Low interest rate.
Low interest loan.
Absolutely.
How big of a fund for that?
I don't recall that number right now.
Don't worry about it.
But we can certainly get that to you.
Don't worry about it.
I apologize.
And what was the third thing in the basket?
Tax credits.
The tax credits, okay.
Correct.
Have you projected how many megawatts that would incent to come online before 2026?
I don't know that I've seen that number. We have an econometrics firm that's looking at that, but I don't believe I've seen final results from that analysis yet.
Okay, would you share that with the committee when that happens?
Absolutely.
Thank you.
Any other questions? Thank you.
You're quite welcome. Thank you.
Chair calls Daniel Booth. We have you registered as Daniel Booth, representing Tex Gen Power, and you are for the bill?
That's correct. Daniel Booth, Chief Operating Officer of Tex Gen Power. We firmly support PCM. We support SB 2012 with some tweaks that we've been talking about this evening. I think it is correct to say that those who support PCM with a $500 million cap do so because they don't like PCM and they know that cap will kill PCM. It's important to know, where did the 500 come from? I do agree with some who have said, hey, it's tied to the 460 million number that's in the E3 report. That's on page 60 of their report. That is a number that was the net cost increase of PCM. So when you talk about a cost cap on PCM, one question would be, are we talking about the cost of the credits? If you think that the total cost of PC credits is only $500 million, just some rough math, that equates to $238 per megawatt of generation. And if you think about a 500 megawatt plant, that's going to cost roughly $800 million. 500 megawatt plant, let's just say conservatively that costs $400 million to build. Putting a $500 million cap on the PCs would probably result in $3 million a year for that plant. So you're not going to invest in a new plant that costs $400 million because you're going to get $3 million from PCs. Putting a cap on PCs kills it. I would say it is critically important to talk about impacts to consumers. It's absolutely right to focus on costs for consumers, but paying for reliability is vastly cheaper than not paying for it. If we don't fix the market, everyone's going to bear the potentially enormous cost of having unreliable supply of electricity. We believe PCM can fix the market, but capping PCM costs, whatever that means, specifically at $500 million, will almost certainly prevent it from being effective.
Any questions? Thank you. Chair calls Michael Carter. We have you registered as Michael Carter, representing Just Energy, and you're for the bill?
Correct.
Proceed.
Thank you, representatives, for hearing me today. I'm the CEO and president of Just Energy. We're the largest independent retailer in the state of Texas. We have over 500,000 customers that we serve that are residential and small commercial. So we're not the big guys, we're representing the small guys. We do support the bill with the guardrails. And the reason we think the guardrails are important is because there's not enough details in the PCM as currently drafted for us to actually study and understand what those costs are going to be to residential and small commercial customers. As drafted, I do know it's more than the $460 million or $1 a megawatt hour that has been quoted as part of the PCM, because it was going to be all burdened by the residential and small commercial customers. They were going to pay more of the cost of PCMs because their load is what is variable when there is weather events. So I ask that we do look at this, we do study it. I'm more than willing to do away with the sunset. I agree. I don't think anybody's going to invest in new generation under this construct if there is a sunset. These are 30-year assets. I've been on the retail side. I've been on the generation side. I was at Vistra or at Energy Future Holdings for a long time. I've been in the market for 30 years. So I do think there are solutions. I do think there's probably needed dispatchable generation. So thank you.
Representative Anchia.
A couple questions.
Sure.
If the guardrail bill did not pass, and PCM moved forward, would you be for PCM?
Not as currently drafted, because I don't have enough information to know whether or not how it's going to be implemented.
Got it. You said that small consumers and residential consumers would be paying more than the projected $1 per megawatt hour. What do you think that is? Is it 2x, 3x?
I think it's 5 to 10x.
5 to 10x. And why would the PCM, in your view, create a cost shift from big consumers to small and residential consumers?
As drafted, where it was the 30 hours of net peak load, the peak load for a residential customer is very weather sensitive. For instance, on December 23rd, when it was really cold, the load for our residential customers was twice that of a normal December day. So if everybody else's load is staying static because they're not weather sensitive, because they're large industrials or whatever, but all my residential customer loads go up twice, then I have to, most of that cost is going to end up getting borne by the residential customers the way it was currently drafted.
Is it also the case that many of the larger consumers can avoid costs?
I think some of them can. I don't know how many of them can actually, shut down their operations in those types of events.
Or do industrial demand response or?
Yeah, there's some that can. I don't know how many of those can.
And they also have, meteorologists and traders, oftentimes they're hedged. And so the costs the cost would exponentially fall on residential and small.
Correct. And the other thing with the way the PCM is designed, it is using, to get to the $460 million, my understanding is that, energy costs are going to be cheaper because of all this renewables and everything else. And so we're going to get really cheap energy. We're going to get a bunch of 0-hour days and all these other things. That's going to drive down energy costs. Well, we hedge our energy costs forward. We don't take our energy to real time. We don't take it to day ahead. But that's exactly what E3 has modeled, as if I took all my load to real time and I can take very cheap energy, and sometimes I won't even pay $1 for the energy because there's going to be so much sun and solar and wind going on. Well, that's not how we're going to hedge. So who's going to be selling me power for zero? Nobody. I need a forward market. I'm going to be paying $20 a megawatt hour or $30 still to get somebody to actually sell me electricity, 2 years out, 3 years out, 4 years out, because I sell contracts to residential customers that are 1, 2, 3, 4 years.
And they're fixed usually?
And they're fixed price.
Okay.
So that is, in the last legislation, we made sure that for residential customers, you cannot sell anything but a fixed price contract.
Right.
And I think I have no problem with
good
that.
policy.
So that's good policy, so.
Gotcha. Okay, thank you.
Speaker Guerin.
Thank you, Madam Chair. Thank you very much for being here because we're very blessed in Texas to be represented by great generators, great TDUs, and great industrial and great manufacturing. But all of us, we represent around 200,000 consumers that you're selling electricity to. And so we have to be sensitive not only to the needs and the prices that the that the big users have, we also have to be respectful to the price that our residential consumers are paying. And so the market that you serve is very important for us, and we need to understand it very well. And I appreciate everybody that's here, but the guy that lives on my street's not here, and so we have to be thinking about him as well. And so thank you.
We appreciate it.
Any other questions? Thank you.
Thank you.
Chair calls Michelle Richmond. We have you registered as Michelle Richmond, representing Texas Competitive Power Advocates, and you are for the bill?
Yes.
Proceed.
Thank you. Thank you, Madam Chair, Chairman Hunter, and members. Michelle Richmond, representing the Texas Competitive Power Advocates. This represents the views of 11 companies that are generators in the ERCOT market generators, no cost recovery. We support the committee substitute. We have some suggestions to make it better so it actually works to incent the new investment, and that is to change the cost cap to a price cap, as you've heard before. Cost caps are the whole amount. The price cap is going to fluctuate with what's happening in the market and is a more appropriate measure, but it still maintains some checks for consumers so that you're not giving a blank check to any market participants. The sunset provision basically creates a statutory end date, and if you are investing in a 30-plus year asset with no confidence that it's going to continue, why would you make that investment? A sunset provision on such a thing really isn't necessary because the legislature comes back every 2 years. So we think that independent review is appropriate. We think that you should be looking at how it's impacting the reliability standard that gets set by the commission. Is it providing the market incentives that you expect? And are we going to have resource adequacy? Those are very realistic, rational things to look at and evaluate, and it should be dynamic. You know, markets sometimes need to change, and that's okay, to make sure that we're fitting the needs of the state.
Any questions? Representative Anchia?
All right. You don't like the 500 million. You prefer 2 times net cone.
Yes.
Okay. Explain to me first gross cone versus net cone. Explain that to me.
I mean, you're looking at the cost of new entry, what it's going to take to bring a plant online. You're going to be looking at what the annualized fixed costs of building the resource are and operating a new resource. You want to make sure that when you're making that investment, the relative profitability is going to be there. Otherwise, you end up with plants going into bankruptcy.
And
that's
what are
not
those
good.
assumptions currently?
Are you talking about for cost of new entry?
Today.
I mean, it's usually based on a dispatchable combustion turbine gas plant.
Okay.
And it's usually done by an evaluation of ERCOT and independent consultants to determine what that is based on the market at the time. So it is a dynamic amount, and it should be, which is the other reason why you are better to look at that and have the commission evaluate that, because I mean, our market has changed substantially over the last 20-something years, and we have basically kept this fairly static.
What's the difference between gross and net cone? What are you netting out?
I'd have to actually talk to people who are smarter than I about that.
And where does 2 come from? 2 times. Why not 1.25? Why not 1.5? Why not 2.6? I mean, that's what I'm trying to get at. These are just numbers.
Yeah, so for example, there's kind of a trigger that goes into place now that's called the LCAP. And when you hit a certain amount, which is actually 3 times the cost of new entry, which we've only done, I believe, once, and that was because of Winter Storm Uri, it triggers the commission reducing that cost for energy. And it's kind of a circuit breaker to protect consumers. So, you know, if you look at that's 3 times cone, it would probably be appropriate to look at something lower, but, you know, 2.
Are these questions better directed to ERCOT or to the PUC?
I would suggest you direct them to ERCOT.
Okay. Do you dispute all right, so the E3 report pointed out to 5.67 billion in new costs in the market. They said that those would be offset by new generation capacity in the amount of 5.2 billion. Roughly, that offset. Does that happen in year 1, or does that happen down the line? Do we, for example, see a lot of costs in year 1 and then see them offset by new generation when that comes online, or does it happen immediately?
I would expect that it would happen gradually. And the offset is the reduction in the energy prices and in the ancillary services prices. So you're essentially reducing the revenues in those 2 markets based on the reliability needs. And a lot of this is going to be predicated on the reliability standard that gets set by the Public Utility Commission and ERCOT, which they're still evaluating.
So it's confusing to me that yesterday, the PUC put $500 million into ancillary services? Is that right?
It was a bridging solution.
Okay. So they put more money into ancillary services. I guess I'll ask the PUC why that is and what it was designed to achieve. Do you dispute the estimates that are being circulated or discussed that 2 times net cone is going to be between 9.3 and 12 point something billion dollars of new costs?
Today was the first time I've heard that number.
Okay.
Candidly,
Does that
is
sound high to you?
extremely high. That assumes no reduction in energy or ancillary services, and that's just not realistic.
Okay. Thank you.
Representative Freeman.
Thank you, Madam Chair. Since you support the price cap and no sunset, do you also think that involving the IMM would be a way to go?
I think you need to involve, multiple independent entities, and I think, the IMM brings a kind of a making sure the market isn't being manipulated structure to it. I also think, though, that you need experts on reliability, and the IMM is not an expert on reliability because the goal here is to make sure we have a reliable grid and resource adequacy needs. So it's really a marrying of the two to make sure the market is working to achieve that reliability goal.
Thank you.
Representative Dean.
So you said that like ERCOT's working on, and I think that's where this whole thing should start. They're working on a reliability standard.
Yes, sir.
So how do we determine the 2-time net cone dollars if we don't know what the reliability standard is?
I think the best way to handle the price cap would be to direct the commission to establish one that is based on the review of the cost of new entry and the reliability standard that gets set. If you put on,
excuse me, that's what I'm asking you about. I've had everybody come to the office and I ask them, define reliability for me. Well, and we get a lot of nothing. And so you're saying ERCOT should be defining that reliability standard?
I mean, ERCOT and the PUC are in charge of ensuring that we have a reliable grid, and they're in the best position to determine that. The PUC has a project open right now to establish a reliability standard, which is what y'all have directed them to do. But at the end of the day, if you don't know what you're actually trying to achieve, that's the problem. So setting a reliability standard is the number one thing that needs to happen.
Because how do you set a number, a cap or a number, if you don't know where you're trying to get at the end of the day?
We agree.
So
I think that's also the problem with putting a hard number in statute. It becomes very inflexible, and markets have to have flexibility and be dynamic. Otherwise, markets fail.
Thank you.
Any other questions?
Thank you.
Melissa Trevino. We have you registered as Melissa Trevino, representing Occidental, and you are for the bill?
Yes. Go ahead. Good evening, Madam Chairman, committee members. My name is Melissa Trevino, and I'm the Assistant Vice President for Power at Occidental. I am testifying in favor of the House Committee Substitute for Senate Bill 2012. Occidental is an international oil and gas producer and chemical commodities producer based in Houston, Texas, and we are actively seeking to grow our investment in Texas. Electricity is one of our biggest operating costs. Each year, we spend hundreds of millions of dollars on electricity across Texas. As a large consumer, we are opposed to the PCM and prefer a more targeted approach. However, if the PCM were to move forward, we strongly support having safeguards and parameters in place. Guardrails will ensure the PCM implementation and its impact is consistent with what proponents of the program have outlined. One of the key guardrails is having a cost cap on PCM, and we support the cap of $500 million annually. The cap will allow large consumers seeking to expand their operations in Texas to better project their cost increase exposure here. In conclusion, Occidental supports a version of Senate Bill 2012 that has firm guardrails in place for the PCM. Thank you for the opportunity to testify, and I'm happy to answer any questions.
Any questions? Thank you. Michael Jewell. We have you registered as Michael Jewell, representing Enel North America, and you're for the bill?
Yes, ma'am. Thank you very much, Madam Chair and members. My name is Michael Jewell. I'm here to testify on behalf of Enel for the committee substitute to Senate Bill 2012. Like others that have spoken before, we've opposed the PCM at the Public Utility Commission. If it is going to go forward, we need very solid guardrails. Definitely support the $500 million cap. It is consistent with the net number that E3 said would be added to the market overall. We also very much appreciate the appropriate cost recovery of, excuse me, of the credits. Mr. Chairman, as you always say, the customer ends up paying in the end. And the most cost-effective, simple cost recovery is the most important. We would definitely support implementation of real-time co-optimization prior to or contemporaneous with the PCM, and then also support a more technology-neutral approach. I'd be happy to answer any questions.
Any questions? Oh, Representative Anchia.
Thanks, Michael. Just wanted to hit that last point because that's a new point that other people haven't made. A technology neutral approach. Talk about that, please.
Thank you. You know, one of the important things with regard to the competitive market is having more technology and being able to participate in the PCM and compete down the cost. Well, we've already seen very recently issues where arbitrary constraints on competitors have caused higher prices to be experienced by customers. So having the most resources being able to participate ultimately will inure to the benefit of customers.
So if we have a problem, doesn't matter what your feedstock is or what your power generation resource is, if you're participating, everybody should be treated equally if you're helping solve the problem.
Because everybody is solving the problem.
Okay, thank you.
Thank you.
Any other questions? Thank you.
Thank you.
Brian Sams. We have you registered as Brian Sams, representing Calpine Corporation, and you are for the bill?
Correct.
Go ahead.
All right, good evening, Brian Sams on behalf of Calpine. We support SB 2012 as substituted. Quickly about Calpine, we are the largest operator of dispatchable natural gas plants in Texas. We want to operate about 9,000 megawatts of dispatchable natural gas in and around Houston, the Valley, North Texas, and of course, Mr. Chairman, Corpus Christi. We support the PCM. Calpine announced construction of 425 megawatts of new dispatchable gas generation in Freestone County in response to the PCM and the Commission's continued commitment to support reliability through a competitive market. You all put your finger on our big issues, the proposed cost cap and the sunset language. We support appropriate guardrails. We support a price cap. There are ways for consumers to get cost certainty through forward hedging. And we look forward to continuing to work with you all on this bill and make it even better. What questions?
Any questions? Thank you.
Thank you.
Joe Roth. We have you registered as Joe Roth, representing Olin, and you are for the bill?
Yes, that's correct. My name is Joe Roth. I'm the Energy Business Director for Olin Corporation. I'm testing in support of the committee substitute for SB 2012. Olin is the world's largest chlor-alkali company by capacity, the largest producer of bleach and acid in North America, and the largest global supplier of epoxy resins. The products that Olin manufactures are essential to our modern way of life. Key examples include bleach to disinfect drinking water in swimming pools.
Do you have any samples on you right now for the members?
No, I don't. I just stuck my foot in my mouth like somebody in our former administration might have. So, yeah, those, bleach for disinfecting drinking water in swimming pools, epoxy resins, raise your hand if you've dropped your phone. At the end of the day, the chipsets in those things are bound by epoxy resins manufactured by Olin, make those things more robust and more resilient. We make a number of products that go into making things from pharmaceuticals to the refrigerants and air conditioning. And all these products start with the production of chlorine and caustic soda. And to produce chlorine and caustic soda, you need massive amounts of cost-competitive electricity. Our facilities in Freeport, Texas, consume the average equivalent of about the annual average equivalent of about 250,000 homes worth of electricity. Electricity is by far and away the largest cost input for our operations. Competitive costs are vital to ensure that these products continue to be manufactured here in the United States, more specifically here in Texas, and to remain competitively priced for Texans as a whole. Olin supports the Dispatchable Reliability Reserve Service, which would provide an in-market ancillary service to a product to encourage new dispatchable investment and ensure and address the operational volatility in a market-based, cost-effective manner for all electric consumers. We strongly oppose the performance credit mechanism as proposed by the PUC.
Thank you. Any questions?
What was the last thing he said?
Representative Smithy.
The last line you said, you strongly oppose or support?
We strongly oppose the PCM as proposed by the PUC. Okay. But we are in favor of the committee substitute for SB 2012.
Thank you.
All right, thank you.
Cyrus Reed. We have you registered as Cyrus Reed on behalf of Lone Star Chapter Sierra Club, and you are for the bill?
Very much for the House version of the committee substitute to SB 2012. Thank you, Chairman Hunter. We have at the PUC been opposed to the PCM, but we do think it can work with some guardrails. This bill presents some of those guardrails, and those guardrails include an upfront study. We've sent some language suggesting that if the upfront study finds that it is not in the interest, maybe there's some sort of stakeholder process to look at it before it's implemented. Might be a good idea. Secondly, we very much appreciate the co-optimization at the same time that will help consumers. Very much appreciate a cost cap of $500 million. I think we'd be open to a adder to that going forward. In other words, maybe inflation, some sort of adjustment. But we use cost caps all the time. We use them in the energy efficiency program. We say we're not going to spend more than X amount to reach these goals. So it makes sense to have a cost cap. 2 times cone seems a bit ridiculous, right? A cone is the amount of money you need to earn enough money to run that plant. So saying we're going to put 2 times that in the PCM is a very, very large number and would hurt consumers. It should be a fraction of cone because you have other ways to make money in the market. So that's a really high a really high number. And let me say, technology neutral, we would like folks to be able to earn PCM that have controllable load. So whether you're a generator, storage, or use demand response, if you can meet the performance standards, you should be able to contribute to those PCM. So that would be our other suggestion. And I'm going to rewrite my testimony more reflective of the committee sub than the previous version. So with that, I'm happy to answer any questions.
Any questions? Thank you.
Thank you.
Scott Harlan. We have you registered as Scott Harlan, representing Rockland Capital, and you are for the bill?
Yes, we're for the PCM and for the bill.
Go ahead.
So my name is Scott Harlan. I'm the managing partner of Rockland Capital. We're a Woodlands-based mid-sized company that specializes exclusively in the electric power production business. We own and operate 25 dispatchable gas-fired power plants in the U.S. and the U.K., having a total combined capacity of 3,800 megawatts. Turning to Texas, during Winter Storm Uri, we owned 2 plants, gas-fired plants that operated successfully. Since then, we have acquired another 6. 2 of those we built last year, brought them online. One of those was purchase of a mothballed peaker that we reactivated. We fixed it and reactivated it. And then we bought 3 additional gas plants, one which had been bankrupted because of Winter Storm Uri. So we now own 8 gas-fired power plants in Texas, 1,500 megawatts of capacity, mostly peaking. In addition to being one of the few ERCOT generators to build new generation since Winter Storm Uri, we have also been working on expansion opportunities at our existing sites in Northeast Houston, very close to your district, and in Wharton. I believe this gives us a unique insight into what it takes to attract private capital to build new generation. We have been looking at the prospect of these expansions, both at our Wharton project, 400 megawatts, and the Northeast Houston project, 100 megawatts. This will add another 500 megawatts to the 280 that we've already brought online over the last 15 months. So we are prepared to proceed with these projects if the PCM is passed in a way that provides reasonable certainty, and we do believe that it should have reasonable guardrails with some caveats. So given everything that's happened, I'm going to just freewheel here and say very quickly, we strongly recommend that we get away from this sunset.
Thank you. Any questions? Representative Angio?
He's senior to me, and everybody defers to the dean.
Madam Chair Thompson?
I'm interested in the caveats that you were about to enumerate.
Yeah, so the caveats are, number one, that I think we should not have a sunset on the bill. That really squelches investment. It makes it impossible. So right now, the sunset is designed for 2031 for the PCM to terminate. And so if we're making an investment, let's say, we're making a decision a year from now to move forward, we're going to put 5-year hedges on, and those hedges are going to reflect the possibility and, in fact, the statutory requirement that the PCM terminates in 2031. The market is not going to reflect positively on that. So it creates all kinds of uncertainty. We would prefer to have the legislature review it on maybe a biannual basis and then affirmatively vote to get rid of it if it isn't working. But if it is working, that the status quo would be that the PCM stays in place as it is.
What is the frequency of review?
I think biannually would be fine, but that's, open to discussion. The second thing is the cost cap. There's been a lot of discussion about the cost cap. We're strongly opposed to a fixed cost cap. I think we need something that's more of a price-based cost cap. I think tying it to net cone is the right way to do it. And I can answer questions about that if you'd like. I have thoughts about why cone is the right thing.
Please do.
Okay. First of all, cone is the cost of new entry is the cost of building a new reference power plant. When we talk about gross cone, it's the total capital cost. When we talk about net cone, it's the cost less what the expected energy and ancillary service revenues are going to be. So that's the reason net cone is the real thing that we focus on, because that's what, if you have a price at 1 times net cone, then that's sending a signal that you should marginally build a new plant. If you have a price of 2 times net cone, that's sending a very strong signal to build a new plant. And so the way that we would propose, and I think that the Commission and ERCOT are proposing that this work, is that if there's a shortage and we're not meeting that reliability standard that we were talking about, then the price would be up at 2 times cone. If there's a surplus and we are meeting the reliability standard, and we have more than we need to meet the reliability standard, then the price would drop down below 1 times cone, right? But you cap it at 2 times. That's designed to send a very strong build signal only when there's a shortage and we're not meeting the reliability standard. So that's what everyone's talking about. The reason you don't want to have just a hard cap is because it's not sensitive to what the circumstances are, right? If you have a price-based cap that's sensitive to how you're doing relative to this reliability standard, it's flexible, it sends the right signal at the right time, and it sends a signal to stop building when you don't need anything more.
Thank you so much.
Sure.
Representative Raymond? Representative Anchia?
There's some great bleach in the back. If anybody needs some to numb the pain. So, all right. It sounds to me like you are not advocating for 2 times net cone, but rather a dynamic model that could fluctuate between 1 and 2 times net cone, and that would give the PUC the flexibility to move within that band depending on what market conditions look like. Because you said, I'm for 2 times net cone, that would send a really strong signal, but you also said, hey, depending on how we're doing, we might fluctuate between that one times net cone and 2 times. Did I hear that right?
A little bit. I'm gonna correct part of it, though. So I think the cap should be tied to some multiple of cone. Listen, it is true that, 2 times is a little bit arbitrary. Do you want to send a really strong signal when there's a shortage? Make it 3 times cone, right? If you want to send just a tiny signal when there's a shortage, 1 1/4 times cone, right? But I'm saying the cap should be at, we'll say 2 times, right? But it wouldn't be something where the PUC goes in and makes a judgment that we're doing well or we're not doing well, therefore we should change, what the price is. There should be, a curve where when you're short on the reliability standard, you're automatically a 2 times cone. But, you can measure whether you're meeting your reliability standard or not. And so if you're, meeting your reliability standard, that curve would dictate without PUC intervention, the market would dictate this, right?
It would just be cost signals, price signals, I should say?
The price signal would change because you've met the reliability standard or because you have an excess supply that more than meets the reliability standard. So then the price changes basically to reflect to a number less than 1 times cone, and that sends a signal that we're not going to build anymore, right? So, I'm not going to build a new power plant if I'm not going to recover the cost of building it.
And is the response to critics that have said, hey, cost of new entry, we've met that 3 out of the last 4 years, yet there's not enough incentive to build, what would the response be to that?
You're saying in the new system, like under a PCM system, or just today in the past?
I have heard people testify that we've hit cone 3 out of the last 4 years.
The problem with the system right now is it's an energy-only system, and you're relying on a lot of volatility. We're one of the few people that's built power plants under the old system, right? I'm telling you, the economics were marginal. The only reason we did it is because we used equipment. We didn't pay the full cost of new entry. So
you bought stuff on a deep discount, I take it, out of BK?
Well, no, we bought turbines that were overseas. We refurbished them and then put them in. So we didn't pay GE's price for new equipment. We used. We're kind of the scrappy players here, right? We're not the biggest players, and we don't always use new equipment. So that's the way we were able to build when the price was at cone, is we built for less than cone, right? So, but you can't rely on that forever, right? We found opportunities to do that. Where was I? I didn't totally answer your question.
No, I think you did. That. I'll say back to you what I think I heard.
Yeah.
2 times net cone is arbitrary.
But it should be the cap.
But it could be a cap.
Right.
Mm-hmm. That between net cone and 2 times net cone, there would be, the market would respond to that, and price signals would be sent out of the market that would incentivize, somewhere in that band, in that range, would incentivize new construction.
Right, and if you're very close to meeting your reliability standard, the construct should drive the price closer to cone. And if you're way short of that reliability standard, then the construct should drive that price towards 2 times cone.
Okay, and why shouldn't the cap, again, people have testified they're worried about impact on consumers. Why shouldn't the cap be lower than, why shouldn't it be 1.5? or 1.75?
It could be 1.5, and in fact, I think in the E3 report, when they did it, I think they used an assumption of 1.5. So it could be that. That's not going to send quite as strong of a signal, you know, so if there is a shortage and you want people to build quickly, having a price at 2 is going to cause more people to build more quickly. It could also lead to an overbuild. And then you're going to have, you know, prices at a very low level for the next year. So it is, you know, that's something that I frankly think would be good in the domain of the PUC and ERCOT to think through, you know, the details of that. But yes, there should be a cap. You've got to protect consumers with a cap. So we are supportive of not having an unfettered, like, you know, there needs to be a cap.
Yeah, no, I get that. And then the last thing I think that everybody's worried about is, hey, you know, if it's at 2, is this too rich? You know, I'll use a J. Dean term. Are you getting a little lagniappe, you know?
Lagniappe.
A little lagniappe when you're not, you know, you're getting a fat benefit when you really don't, you know, you might build at a lower number, but you're getting a little something extra.
In that year, yeah. I mean, at that time, but, you know, to the extent then, you know, over the course of the next 3 years, the market gets overbuilt, then you're going to be getting less at that time. So that's a risk that we're willing to take, you know, based upon the market construct out there. I think that risk is better placed on us as the builders and the generators than it is on the ratepayers.
Thanks for your testimony.
Representative Raymond?
Thank you, Madam Chair. How long have you been working in Texas?
Since 1995.
Okay, so a long time.
Yep.
I'm curious, if we had not had Winter Storm Uri, in your opinion, would we be, do you think we'd be here talking about all this?
Probably not, but at some point, it may have been 2 years from now, right? I mean, the energy-only market wasn't stimulating the new build, and I think that the main problem was there wasn't a reliability standard. So when you start to drop below the you know, the reserve margin that the grid operator comfortably wants to have, there wasn't a good enough signal to build, and the energy-only market, there's a lot of volatility. It's very difficult to justify building using the full cost of new entry.
So we might have been here.
I think you might have been here. I think ultimately we were going to be here, right? I mean, we're here now because Winter Storm Uri happened, but something like that was going to happen ultimately, I think.
Do you have an opinion on what would happen if we passed legislation and funded the state building some gas plants?
I can tell you that Rockland won't build any more with our private capital. I mean, it's like, I don't want to be in a situation where I'm competing against subsidized generation. It's, you know, it's like, so with my existing plants, you're saying I don't get subsidies, but the new people do get subsidies, and I'm expected to compete against that. It destroys the market. It really destroys the integrity of the market that we rely on to make new investments. So while I'm saying that we will build 500 megawatts of new generation, I've got it teed up at 2 different projects. If we have a sensible PCM that comes in place, you know, with the proper, you know, guardrails, I definitely wouldn't build it if I knew that 10 gigawatts of competitors is going to be subsidized.
And so you think that there's no scenario you can envision where it doesn't have that kind of impact?
You can just, you know, I know this is a bad word here, but, you know, you just look at California. That's exactly what California did when they had their energy crisis. I was working for El Paso Corporation at the time, and I was managing some of our power assets.
So what's your opinion about why those who are advocating for that as a part of a solution, as a, you know, a safety net or whatever they want to call it, why do you think where are they coming from? If they don't,
I honestly
they don't say, if they say, well, no, we don't want to go California and we don't think we will. Why do you think they're saying that, or they're convinced that that's the way?
To me, it's the most anti-market, kind of fiscal conservatism that you could possibly, I don't understand. I can't answer it. I can't get into their head.
Well,
it would, I mean, you know, well, who are you talking about? I mean, I think that if you...
Who am I talking about?
Yeah. Okay.
What do you mean?
That's who you're talking about. No, I think if you're wanting to have, well, I don't know. I don't know the answer to it. Honestly, I can't get into.
Well, it's just because the people who are advocating it, I mean, they certainly believe, or I think don't believe, that they're going to affect the free market and, you know.
I think it would, first of all, I think it's impossible that it wouldn't affect the market pricing. And secondly, I mean, I wish you had asked every generator up here, would they invest if that was in place? Because I think everyone, I mean, Calpine's announced they're building new generation. I'm telling you, we're going to build new generation. I don't think any of us will build that new generation if the state is subsidizing competitors.
But I guess we can't get guarantees from you or anyone else, or you've about guaranteed just in your remarks, right? But you haven't legally yet.
Yeah, no, I want to be.
So we can't, I guess we can't get the audience out there to come and say, we guarantee we're going to do this.
It's difficult to guarantee, but I can tell you if the price of PCs is 2 times cone, I have every incentive to invest. I will find a way to make it work. Right? I have every incentive to invest. If the price is half of cone, then I have no incentive to invest. And so if you want to come up with a construct that sets it at 2 times when there's a shortage and you're going to have reliability problems, we will solve that problem. And you want to send a signal to the market not to build when there's a surplus. And so you have to believe that the market is going to drive us to do the right things.
Do you know enough to have an opinion how many plants or how much will go offline over the next 5 or 7 years, I guess?
I don't have, numbers that I would.
You must think about it if you're going to invest in building new, right?
I think most of the older gas and I think most of the older gas and oil plants that are what we call steamers, that aren't combustion turbines, they have very high fixed operating costs. And I think coal plants have extremely high fixed operating costs. So I think as we go forward over the next decade, you're going to see almost all of those shut down. And the reason they're going to shut down is because the price of energy, I would expect to go down because we're seeing lots of renewables come onto the grid. They have zero marginal cost of production. That's going to drive energy prices down. That's going to make it even more difficult to build dispatchable generation unless you have a revenue source like the PCM that's making up that difference between the cost of new build and what you can get out of the energy and ancillary service market. So, I think that as the value of the energy commodity goes down, the higher fixed operating cost plants, they should shut down.
And so can you, I think somebody, I won't say who told me, but someone suggested to me, and probably to other members, could you have both PCM and the state build some plants? Does that work? Or again, it just goes back to what you said.
I think it's a proverbial camel's nose under the tent. As soon as you start letting subsidized generation come in, the subsidies beget more subsidies. And in order to get anything built, you're going to have to subsidize it. And so, I mean, if you go down, that's exactly where California is right now, right? They started offering 20-year contracts only to people that would build new generation. All the private capital dried up, because unless you had a subsidy, you weren't going to build anything. And today, the only way anything gets built is if you have a long-term contract that's backed by utility or the state. And so that's what will happen, I think.
Thank you.
Representative Dean.
Thank you. Just a couple questions. And I understand you said that, as far as a sunset, that probably should really consider that. And is that because, depending on how, you build your plant, pay for your plant, that you've got it, to use a term that Sanchia used, you've got it amortized over some period of time. So if we set a date of the 2031, by the time you go through all of the preliminary things that you got to do to build a plant and then start the plant up, you might be in a 2030 by that time. Is that Is that kind of what's driving your thought on?
I mean, I'd like to think that I can build a plant faster than that, but I mean, let's say it takes a year to get everything done through the PUC, and it takes me another year and a half to build a plant, something like that. So we're looking out 2.5 years. In order to build it, if I'm going to raise debt capital, I probably want to put hedges in place, at least for the next 5 years. And the market is going to reflect the fact that this program is sunsetting at sometime during that period where I'm trying to put a hedge in place, right? And we have to then make an investment decision relying on the legislature to say, hey, the system is working great, we're going to renew the system. And it's just a difficult, it creates a risk that I think is unnecessary. Now, in our business, we wear regulatory risk all the time. Our industry is very heavily regulated. So I'm not saying that.
Let me say, you answered my question.
Okay,
So
okay, good.
Let's move off of that. The cost cap tied to cone, we're going to ask you the same thing. What is that number?
How many dollars is it? Like, I think it's
not 500 million is not the 2 times cone, obviously.
Yeah, I don't know what the answer is. I do think that the 12 billion number that's been thrown out there, I think people got to that by looking at gross cone and not net cone. So, remember I said gross is the total capital cost needed to build a new plant. So I think that number is not the right number, but I couldn't do the math on my head. I'm not that good.
Okay. Well, you can probably get back to us on that once
I can
you
do
sit
that.
down over there.
Okay.
All right. I just wanted to mention, you mentioned subsidized generation, that if you had subsidized generation, you wouldn't go build these plants and spend your money, right? I mean, if they're getting subsidized.
Right.
But we already have that going on.
Subsidized generation in.
I mean, some of our renewables and whatnot.
Oh, yeah, the renewables get tax credits and.
Yeah, but I just want to make the point that we already know that's happening. I'm not knocking them for doing that, but we have that
But
happening.
at least the state isn't like subsidizing it, right?
Okay.
But I agree. And frankly, the socialized transmission acts as a little bit of a subsidy too for those that are.
I'm not saying I agree with doing it. I'm just saying it's kind of hard to say that we wouldn't do something because of subsidy. We already got that going on.
Fair enough.
The other thing is, one of the things that's interesting to me is that the cone perspective would help us replace some of the older generators. We know for a fact, I have them in East Texas, so some of them were old coal-fired, now they're gas. Look, they're 50 years old. I mean, they're running on Band-Aids in some cases. So do you think that, I mean, as an investor, y'all, that the cone would help us to move in the right direction as far as replacing that older generation with the new metal, the new iron that we actually need? Would that incentivize that happening as part of this 2 times cone?
I think it would if it's structured properly, yeah, because again, the signal to shut down the old generation is going to be a function of what kind of energy revenues can they get, what kinds of PC revenues can they get, and what are their fixed costs. In theory, if we structure this PC mechanism the right way, older plants that aren't as reliable, that can't start as quickly, that take longer to ramp up, they're not going to get the same level of performance credits that a very new plant that can start up in 10 minutes and can perform very well. So they're not going to get the benefit of as much of the PC revenue. Their energy revenue is going to go down, and their fixed costs continue to go up because they're old, and maintaining them becomes more and more difficult. So I think naturally they will shut down.
Just as a market driver.
It's driven by the market, right?
Okay. Thank you.
Sure.
Any other questions? All right, thank you.
Thank you.
Chairman Hunter.
Members, and I'm going to ask everybody out there, we have 22 people left. And so where I said at the opening, if you don't have anything new, I still think you need to come up, tell us who you are, whether you're for, against, or on. But I also think for time's sake, if you just want to adopt what people said, let the committee know. Something new, let us know.
Sean McLaughlin. We have you registered as Sean McLaughlin.
Yes.
Representing Texas Instruments Incorporated, and you're for the bill?
Yes, ma'am.
Go ahead.
All right, thank you, Chair, committee members. Sean McLaughlin, Texas Instruments Director of Global Energy, based in Dallas, testifying in support of the committee substitute to Senate Bill 2012. TI is a globally based, Texas-based headquartered semiconductor company with multiple manufacturing operations, thousands of employees in Texas. We've been in Texas for 90 years. We continue to invest heavily in the state. Last year, we broke ground on the first 2 of 4 300-millimeter state-of-the-art fabs in Sherman, Texas. It's a $30 billion investment. It's going to create 3,000 direct TI jobs. Electricity is the lifeblood of our factories. Semiconductor manufacturing requires a lot of it. It requires us to be reliable, and we need competitive rates in support of that. We have great concerns about the PUC performance credit mechanism. Consumers, all consumers, should not have to disproportionately bear the risk of a costly and unproven plan. If the PUC and ERCOT seek to implement the PCM, strong guardrails must be in place to ensure reliability and cost efficiency for all consumers. Thank Chairman Hunter for offering this more robust version. We appreciate the emphasis on strong performance penalties, requirement of balancing reliability against cost, and the cap at $500 million. Core principle must be that the performance credit is based on actual performance during the tightest market conditions. We urge you to pass the committee sub to Senate Bill 2012. Thank you for your time. Look forward to working with you and continuing discussions on Texas energy market.
Thank you. Any questions?
Yes.
Representative Dean?
Yes, thank you, sir, so much for being here. Very familiar with Texas Instruments. And as the chairman said, we understand there's probably not anybody out here that doesn't use a whole lot of electricity and got a whole lot of concerns with this. But in essence of time and where it's getting tonight, do you have anything new to add to some of what we've been talking about as far as some ideas on what we're trying to do here?
I would just say that there's some language about seasonality of performance ahead of time to procure ahead. We should ensure that doesn't go out. Seasons to me can be 1 year, 2 year, 5 year, 10 year. We need to keep it tight and close.
Good.
And I think the other thing would be that when it comes to review and all of these sunsetting and all this time, I would actually say the review should be soon. I mean, it's a 3-year, takes admittedly 3 to 5 years to implement.
Have you offered some of this maybe to the author as far as some suggestions?
No, we're continuing to work. We're continuing to discuss these items, and willing to discuss those continue.
That's what we're looking for, some solutions. So thank you for being here.
All right.
Thank you.
All right, thank you.
Casey Kelly? We have you registered as Casey Kelly, representing Constellation Energy Generation, and you are against the bill.
I'm for the bill.
Okay, you're registered against.
Shows up on -4.
Do we have your permission to change?
You have my permission to change it,
your position
yes.
For the bill?
Yes.
I thought nobody who was against could testify. What's going on?
So we have your permission to change your
Yes, ma'am, you
position
have my
for the bill? Okay, go ahead.
Thank you. Madam Chairman, Mr. Chairman Hunter, members of the committee, my name is Casey Kelly, and I'm Director of State Government Affairs for Constellation Energy Generation. I'm here on behalf of Constellation to testify in favor of committee substitute Senate Bill 2012, pending several changes. I will spare you the details of my testimony. We have the same concerns on cost cap. We have the same concerns on the sunset date, but we do believe a guardrail bill is appropriate. We think that the guardrail bill will send a certainty to the market that we need, but we want to remind folks that guardrails should not be roadblocks or barriers to getting the right investment signal to reach the reliability standard that this state needs. So with that, I will conclude my testimony. Happy to answer any questions you might have.
Any questions? All right, thank you.
Thank you.
Mike Nasi? Mike, we have a registered representing South Texas Electric Cooperative, and you are testifying on the bill?
Yes, thank you. Chairman, Vice Chair, members. I'm here on behalf of STEC as counsel. Cliff Lange, who you've heard a lot from, who is both the chair of the Technical Advisory Committee and the co-op rep on Turk, was in D.C. with our delegation. He sends his regrets, couldn't be here, but I've been constantly talking to him about new ideas, because I'm going to focus on our chairman's direction, who represents constituents that are our consumers and owners. STEC is a G&T. You've heard that from Lange. That means we own both generation and transmission. So what's new that we have to offer is that consumer protection is not just about what the cost or price of the program is. It's also when consumers are owners of generation, like cooperative power, how are they compensated for their investment? They're building an uncompensated hedge for the entire market unless the market signal is ripe. So in the discussion at PUC and in these negotiations, we are kind of coming at from both directions. With that in mind, we'll direct a couple of things that are new. We are intrigued by the idea of a price cap instead of a cost cap. We did not support the PCM at PUC not because we disagree that ERCOT and PUC have the problem wrong. We do have a dispatchable capacity problem in Texas. We just wanted guardrails. So we respect very much the chairman is focused on those guardrails and have done a lot to think about how to come up with something new. To cut to the chase, a cost cap is bad for all the reasons you've heard. And let me explain something new. And it's also related to the fact that fixing a cost doesn't account for the fact that natural gas prices change. They're quite volatile globally, right? It doesn't account for inflation. It doesn't account for the fact that we don't have a reliability standard yet, and we might be in or out of compliance with that.
Thank you.
So that's why it's a
Any questions, members? All right, thank you.
Thanks.
Eric Schubert. We have you registered as Eric Schubert, and you are testifying, representing Lyondell Vassell, and you are for the bill?
That's correct. My name is Eric Schubert. I'm a Regulatory Affairs Advisor for Lyondell Vassell, and I'm here to testify in support of the committee substitute for SB 2012. I also have a doctorate in economics, and I was co-lead on rulemaking projects on key market design issues at the PUC at the time of deregulation, and I've worked in the power industry for 20 years. I want to thank this committee for your leadership in addressing changes to ERCOT market design. Reliable and competitively priced electricity is critical to our business success and to maintain safe operations in Texas. LyondellBasell is a leader in the global chemical industry. We have more than 6,000 employees working proudly across a dozen manufacturing sites within the ERCOT footprint and have invested more than $4.5 billion in new capital projects in ERCOT over the past decade. LyondellBasell facilities are significantly impacted by ERCOT market design, as the company has sites with highly complex and interrelated operations across the state where grid reliability and stability are imperative for maintaining safe and reliable operations. Electricity costs are a top 3 production costs for our company, and predictable market-based costs are essential. We are concerned that electricity costs within ERCOT will increase significantly if the proposed performance credit mechanism is enacted without any guarantee of improved reliability or new generation. We strongly oppose the PCM plan and support an alternative solution. The PCM is essentially a tool that allows the PUC to require customers to pay additional amounts to existing generators. And this is an extraordinary amount of discretion to give to a state agency. And estimates of the cost have ranged from hundreds of millions of dollars to billions of dollars, if you've heard today. We do not view PCM as either market-based or appropriate. Our company supports the Dispatchable Reliability Reserve Service, DRS, which provide an in-market ancillary service product to encourage new dispatchable investment and address operational volatility at the same time. That said, if the PCM is to move forward, we thank you for your hard work in crafting meaningful consumer protections in this bill.
Thank you. Any questions? All right, thank you. Catherine Webking. We have you registered as Catherine Webking, representing Team Texas Energy Association for Marketers, and you are for the bill?
Yes, that's correct, Madam Chair. Chairman and Vice Chair members, thank you very much for the willingness to listen to all of these detailed discussions of this very intense subject. And we appreciate the intense hard work that's gone into this on behalf of the committee and everyone related. I represent an association of retail electric providers, not any individual member, but retail electric providers, primarily from the perspective of serving residential and small commercial customers. We believe that it is essential that whatever reliability mechanisms are adopted ultimately, they need to match and be consistent with our retail electric market, which today provides fixed price contract opportunities to customers that they very much enjoy. And our issue is trying to make sure that that is preserved. We very much support the guardrails that are in the committee substitute that's been presented. I do feel like I could clarify a couple of questions that have come up today to try to not be redundant of other things that have been said. With regard to the overall cost in the billions, and there's been question of this, is that some mythical number or some gross number? It is not a mythical number. It is taken from the E3 report. Under the PCM as E3 designed it, there would be, the commission would determine point A and point B on this price curve. Point A under the E3 report is essentially 30 hours at about 72 megawatts. And that multiplied by net cone, which is, it's a net cone number in the E3 report, at 1.5 would get you to $9.3 billion. At 2 times cone would get you to the 12.4. If you go higher than that, it continues to go up. That is of grave concern. And as we've indicated, there's not an immediate offset of any projected energy price offset. And that offset would be in real-time energy, not necessarily the hedge.
Thank you. Any questions? All right. Thank you.
Thank you.
Jason Ryan? We have you registered as Jason Ryan, representing CenterPoint Energy, and you are for the bill?
That's right.
Go ahead.
Good evening, chairs and committee members. I'm Jason Ryan, Executive Vice President, CenterPoint Energy, testifying on behalf of CenterPoint Energy in favor of the bill as substituted. I will skip my general prepared remarks and cut right to the chase with a couple of comments specifically on the committee sub. So as I think the framework is salvageable, listening to everyone. There's obviously devils in the details. We support, though, a long-term, comprehensive market reform to make sure that we don't have the generation shortages that we have experienced and that ERCOT estimates that we will continue to experience going forward. So let me talk about the 2 items of the day, the expiration date. So while I'm not putting any of my capital at risk to build generation in this market, I do invest about $2 billion of capital in this state every year down in Houston. And if I had an expiration date on the regulatory mechanism for me to recover those dollars would cost me more. So I actually think that the expiration date in the sub works counter to the concerns about the cost of the mechanism. So if I were you, I would just kill the expiration date and focus on the cap. So I would say cap it, but don't kill it in terms of designing the framework. As it relates to the cap, the reality is that no money is going to flow through this mechanism before you all gavel out of the next legislative session, realistically. So given that, I think you could tell the commission to come up with a cap. You'll have better data points than what you're going to have trying to design a cap through this process. And then you'll be able to give a thumbs up, thumb down on the cap next session before any money flows. And then the mechanism can be designed, the cap can be decided later. Thank you.
Any questions? All right. Thank you.
Thank you.
Mark Bell? We have you registered as Mark Bell, representing the Association of Electric Companies of Texas, and you are for the bill.
That is correct.
Go ahead.
Thank you, Chairman and members of the committee. For the record, my name is Mark Bell on behalf of the Association of Electric Companies of Texas. We have three main concerns with the committee substitute, first of which is the cost cap and sunset date. As articulated in the committee sub, we fundamentally believe that it's incompatible with the ultimate goal of the PCM, which is to improve reliability and to incentivize investment. And then finally, we support keeping the bill technology neutral so the PCM can evolve with technology as it moves forward. Thank you, and I'm happy to answer any questions.
Any questions? All right. Thank you. Christopher Doro? Christopher, we have you representing BASF Corporation, and you're for the bill?
Yes, ma'am. Good evening, Chairman Hunter and members of the committee. My name is Chris Doro. I'm the Regional Category Manager of Power and Utilities for BASF Corporation. I'm here to testify in support of the committee substitute for Senate Bill 2012. I'd like to stress one of the things that haven't come up yet is in light of our sustainability goals to reduce waste and cut carbon emissions, we have invested heavily in renewable energy resources via PPAs and VPPAs while continuing to utilize our cogeneration units as appropriate. This PCM mechanism will disrupt that and cause contract uncertainty and changes of law clauses within those agreements. We have previously expressed our significant concerns with the performance credit mechanism approach adopted by the PUCT, and as the significant change in market design would cause havoc to our power pricing, our existing power purchase contracts, and would in no way ensure more reliability or resource adequacy in ERCOT. If the the substitute bill doesn't pass, BASF could experience cost increases of somewhere between $15 and $75 million annually, depending on how the PCM were implemented. We have previously supported the PUC adopting the dispatchable reliability service and would prefer to see that in place. We are greatly appreciative of that the substitute removes discriminatory cost allocation provisions, and these provisions would provide BASF with the business certainty it needs in the electrical market to continue investing in Texas and ensure our existing operations do not become endangered. We particularly support the $500 million cost cap.
Thank you. Any questions? All right. Thank you.
Thank you.
Katie Coleman. We have you registered as Katie Coleman, representing the Texas Association of Manufacturers, and you're for the bill?
Yes, I am for the committee substitute. Thank you, Chairman and members. I think you all know where I stand on the PCM. We've got a lot of members who traveled a long way because this is an important issue to the manufacturing community, so we appreciate your attention to this. I want to frame the cost cap issue a little bit differently. We don't know what we're buying with this construct, and I think that is what you all should be focused on. We were told, this was billed to the legislature and to the media as you can get 5,000 megawatts of new generation for just a 2% cost increase on consumers' bills, and that was based on the $500 million number. Well, as you've heard, it's a lot more complicated than that. There's a lot of moving parts. There's a lot of parameters that aren't defined and aren't understood. If I am in your shoes, I would be thinking, how do I get the ball back in my court so I have control over this thing and I'm not in the same position next year having to pass a bill to stop something that I don't like? You've heard a lot of testimony today. Take out the 500 million cap, take out the sunset, and if you don't like what the PUC does, you can pass a bill to stop them next session. I would turn that on its head. I would put strict parameters on this, and if you feel comfortable with the ultimate design from the PUC, then you can release those
restrictions and allow them to move forward with the proposal. But we are very concerned about the cost. We are very concerned about this turning into a blank check. We did have other suggestions for guardrails that were not implemented. One of them, which might be an alternative to the cap or the sunset date, was to establish a committee, a standing committee, where you all would receive reports on the progress and the proposed design. And we had proposed that that committee would have to affirmatively vote to allow the PUC to move forward with the final design. Our concern is if we all leave here, everybody stops paying attention to this, and then it's a very harmful design for consumers that.
Thank you.
We'll be back here next
Any
session.
questions? All right, thank you. Caitlin Smith? We have you registered as Caitlin Smith, representing Jupiter Power LLC, and you're for the bill?
Yep.
Go ahead.
Hi, Chairman Hunter, Vice Chair Hernandez, and members of the committee. Well, I'm 6 months pregnant and I've been here all night, so I'm very excited to be talking. Jupiter, I am here for SB 2012. Jupiter Power is a battery energy storage developer, owner, and operator. We have a large fleet operating already in ERCOT. We appreciate the leadership of Chairman Hunter in bringing forward the committee substitute, appreciate the guardrails put in place to ensure appropriate evaluation and development of the PCM. I do want to talk about something new, the role of batteries. They are dispatchable, and no one has spoken about that tonight. The parameters of the PCM established under the committee substitute provide that dispatchable resources are eligible to participate in PCM. However, the bill provides that participation in the program is limited to dispatchable resources with the specific attributes necessary to meet the operational needs. We're concerned about that specific attributes language. We think it opens the door to exclusionary requirements. We believe that language should reflect that participation is based on performance, because it's a performance credit mechanism. We have recently seen in non-spin, for example, the adoption of additional duration requirements. What those do is exclude or limit resources that have the ability to perform before they even get that chance to perform. And what that does is exclude suppliers or limit suppliers, and it increases cost to consumers. We respectfully request that the language be made clearer and ensuring that resources meet operational needs is better achieved by performance-based mechanisms rather than through restrictive requirements.
Members, any questions? Representative Anchia.
How you holding up?
A little out of breath. It's really hard to do this.
Caitlin, thanks. Thanks for your
Garza
testimony.
told me it was hard to speak.
And
Pregnant,
listen,
so.
and so I won't tax you on that, but I'm glad battery people are here and testifying. You know, it is, I think, an important voice that has not been articulated tonight. And I think what you were talking about is the language that is in section B sub 2 that talks about specific attributes. And that language could open the door for, as you said, duration requirements that could freeze out batteries, right?
Yes.
And so right now, 97% of events where we're tight can be solved in 4 hours or less, and 95% in 2 hours or less, which batteries play an important role in, or could play an important role in.
That's correct.
And so if you set this arbitrary number outside of that 95 or 97% occurrence, and you say, oh no, they have to be 8 hours, they have to be 10 hours, then suddenly batteries are out of the money on this thing. And again, it is my opinion that that Texas should be the battery, capital of the world. I mean, I think we should dominate that market, both in R&D and also commercialization and implementation. So I think what you're saying is, hey, let's tighten up this language so that we can't set these specific attributes in an arbitrary way. Let's have them be correlated to the needs of the market. Fair?
Yes.
Okay.
And it's not just so batteries are in the money, it's a consumer cost issue as well.
Yep.
We've seen this in non-spend recently. Costs of that have risen because we've increased procurement of it through conservative operations at the same time, limiting suppliers with arbitrary duration requirements.
Gotcha. And you'd say that all resources who can come to the rescue should be compensated, right?
I think if it is a performance credit mechanism and not a capacity market, you should be awarded for performance.
For showing up.
Yes.
Yep. Okay, thanks.
Any other questions? Thank you.
Thank you.
Mike Alvarado? We have you registered as Mike Alvarado, representing Wattbridge, and you're for the bill?
Yes, ma'am.
Go ahead.
Chairman Hunter, Madam Vice Chair, committee members, appreciate the opportunity to provide testimony again. I don't have a lot of original thought here, so I'm not going to go through a bunch of stuff that's already been gone through. I will say, though, I think we as an organization, I'm Mike Alvarado, president of Wattbridge, do have an original position relative to this whole discussion as investors of $2 billion in this state over the last 36 months in precisely the kind of technology that the market needs. 2,400 megawatts, $2 billion, 6 facilities in the last 36 months. So we feel like we have a very unique perspective relative to what it takes to bring investment into this market, capital into this market. You've heard the views about cost cap. We are a supporter of a price cap. We believe in a cap, just not a cost cap. We think a horizon stated as it's currently stated will absolutely discourage any investment. With that, I'm happy to answer any questions.
Any questions?
No questions.
No questions. Thank you.
Thank you.
Jeff Smith? We have you registered as Jeff Smith, representing Samsung Austin Semiconductor, and you're for the bill?
Correct.
Go ahead.
Jeff Smith, Samsung Austin Semiconductor, Vice President of Infrastructure. We're against PCM. We are for the substitute that's been discussed here tonight. We have the same position, I think, that you've heard from many of the customers who purchase electricity to produce products that are built here in Texas. So I'm not going to repeat that. What I will say is that we've already committed $17 billion investment in Taylor, Texas that we're building right now, with the possibility of another $180 million or $1 billion in the next few years for the site that we've purchased up there. But electricity is a key driver to our feasibility studies for those expansions. Under the current constructs that we've been talking about, we can't predict what our cost is going to be. So therefore, I can't recommend building in Texas if we can't figure this out. That's, I think, some of the positions, that's where we are, and that's what we struggle with. To that end, even for the new plant that we have committed to, we are struggling to get contracts on the 500 megawatts of power that we need. So many of the folks in this room that we've talked to for those contracts, we're not able to come up with a proper, just your normal, I want to buy power. Can you give me a contract that I can sign? And I think the PCM has put so much question marks, I think, in the market that we're not even able to buy power at the moment. And so, yes, we have a lot of work to do. We're very willing to sit down and work with you on those. I think you've heard a lot of different substitutes, even to the guardrail bill that you've talked about. But that's our position. Yeah.
Thank you. Any questions? All right. Thank you.
Appreciate it.
2.2 220 megawatts.
Shannon McGriff?
You don't know about it.
We have you registered as Shannon McGriff, representing TEPA, and you are testifying on the bill?
Correct.
Go ahead.
Thank you. For the record, my name is Shannon McGriff, and I am the Executive Director of the Energy Professionals Association, also known as TEPA, and I am also a registered energy broker. I'm here today representing TEPA and testifying on Senate Bill 2012. Currently, TEPA has more than 175 member organizations, which represent 12,000 energy professionals. Our members represent approximately 82% of brokered power transactions in the United States. Our aggregator, broker, and consultant members work in the best interest of the end user in every competitive market, focusing on procurement, demand response programs, risk management, energy technologies, and ESG implementation, and more. In addition, our membership base includes retail energy providers as well as service providers. TEPA members are concerned about the PCM as a proposed reliability standard, and that said, we recognize the improvements that would be made to the PCM through the guardrails contained in Chairman Hunter's proposed committee substitute, and we thank you for that. Competition is a fundamental element of customer choice, and so TEPA particularly appreciates the $500 million cap provision given our concerns about the potential for the PCM to disrupt price signals in the market and lead to further consolidation and reductions in the number of retail electricity providers offering service to customers in ERCOT. In closing, TEPA recognizes that there is not a single solution that is likely to fully address the current and future capacity or reliability needs for the Texas grid, and we believe Texas consumers would benefit from a more conservative approach to incentivizing new generation, one that does not shift the risk of investment from generators to consumers in the manner proposed in the PCM. Thank you again.
Any questions? Thank you.
Thanks.
Ann Rappold. We have registered as Ann Rappold, representing Freeport LNG, and you are for the bill?
Correct. Yes. Thank you, Madam Chair. I will keep this short. I will not try not to repeat. My name is Ann Bierger-Rappold. I'm Vice President of Government Affairs, Risk and Compliance for Freeport LNG, and I'm testifying in support of SB 2012. We are a privately held liquefied natural gas company headquartered in Houston with facilities near Freeport in Brazoria County. We're the only large-scale all-electric drive LNG facility in the world, and we are also the largest single retail electric power consumer in the state. So if the PCM, by our calculations, is implemented, our power costs will increase approximately 24%. And we anticipate those costs to be incremental and not supplemental. As is summarized here by the other consumers, we support DRS, tax incentives, low-interest loans. We do not like the PCM, but if it is passed through, we need to have these guardrails in place. We do support a cost cap, the $500 million that's in the substitute, and we also support the sunset. So with that, thank you for your consideration.
Any questions? Thank you.
Thank you.
David Roylance. We have you registered as David Roylance, representing Prism Energy Solutions, and you're testifying on the bill?
Correct.
Go ahead.
Just for clarity and expediency of time, so against PCM, for the alternative, thank you for proposing that. We represent large consumers, mostly commercial, healthcare, religious organizations, and we've got a lot of uncertainty that's been introduced. It's a very regressive effort with PCM. The market's working. A new fact that hasn't come out today, if you look at the 10-year forward value for just the generation component of energy price, starting in 2024 all the way through 2033, compared to the same time last year, that has increased 20%. That's $2.5 billion a year, additional costs that consumers are paying for that period, 2024 through 2033, if they're buying power now versus had they bought it last year. $2.5 billion a year, $25 billion over the 10-year period. The market's working. It's trying to allocate resources or value so the generation gets built. The other point I would make is a megawatt saved is the same as a megawatt generated. If we move forward with anything, we need to be thoughtful about ancillary services that also incent load that can reduce to reduce. Because ultimately, if we're trying to balance a grid, we can incentivize generation or we can incentivize load reduction where it's possible. Thank you for your time.
Any questions? Thank you.
Thank you.
John Pitts. We have you registered as John Pitts, representing Texas Energy Buyers Alliance, and you are for the bill?
Yes, ma'am. Hello, Mr. Chairman and members. My name is John Pitts on behalf of the Texas Energy Buyers Alliance, testifying for the committee substitute. TEBA represents almost 400 companies, including some of the state's largest employers and electricity users, including companies who have spoken here tonight. Our members employ hundreds of thousands of Texans in retail, consumer brands, manufacturing, and support innovative energy projects across the state. In short, we appreciate this substitute, the requirement for both ERCOT and IMM to conduct extensive studies with particular attention to the PCM's impact to consumers. We appreciate the cost cap and the sunset date. Also, we want to ensure that the bill stays technology neutral and that any available resource, especially dispatchable resources, including anything with a battery, is able to participate. While it is not in this bill, we urge you to resist ongoing efforts to assign costs to any particular generator under the concept of firming or similar. Our members are investing billions in this state right now because of the non-discriminatory manner in which you treat generation technologies. And a major shift like firming or cost allocation like that would not punish those technologies as much as they will dramatically increase costs to consumers and cool that industrial investment in the state. Thank you.
Any questions? Thank you. Thomas Brocado. All right, Thomas, we have registered as Thomas Brocado, representing TCAP Steering Committee of Cities Served by Encore, and you are for the bill?
That's correct. Good evening, Chairman, committee members. Thomas Brocado on behalf of the Steering Committee of Cities Served by Encore and the Texas Coalition of Cities for Affordable Power. Together, these consist of over 200 cities across the state, including Dallas, Fort Worth, Midland, Odessa, Waco, Tyler, Corpus Christi, and many others. Our position aligns most closely with the comments that have been made previously tonight by Dow, Texoga, Olin, Michael Jewell, Sierra Club, and TAM. We believe that the committee substitute strikes the right balance between ensuring a reliable electric grid while limiting the financial impact on consumers. We're against capacity markets such as PCM. We believe that those are a transfer of wealth and risk from consumers to generators. We support a cost cap as contained in the committee substitute. We believe it provides consumers with certainty and a clear target for generators. Experience has demonstrated to us that even a price cap can become extremely expensive very quickly. With respect to a sunset, we understand the arguments that state that having a hard sunset would potentially undermine the incentives of the program, but we do believe that it is critical that there be a review process to ensure that we're going in the right direction. Fundamentally, the public wants assurances that sufficient and reliable electricity is going to be available. And this is particularly true given the increased cost the public is expected to pay. So one additional thing that we would suggest that has not been brought up is a means of making sure that generators are held accountable. And as such, we would support the adoption of penalty provisions in the event that generators fail to use the funds for new generation upgrades or maintenance. At a minimum, we'd like to see that the bill include reporting provisions that provide transparency into how the payments are being utilized. This should not just be a wealth transfer from the public to generators with no assurance.
Thank you.
Thank you.
Any questions? All right. Thank you. Brent Bennett. We have you registered as Brent Bennett, representing the Texas Public Policy Foundation, and you are testifying on the bill?
Yes, neutral on the bill. Thank you. Thank you, Chair and members. Brent Bennett from Texas Public Policy Foundation. I want to bring up one point which was only briefly mentioned about cost allocation and how the cost allocation that was in the bill as it came over from the Senate was taken out. That language is mirroring what is still in Senate Bill 7. And now the only mention of cost allocation in this bill is in paragraph C11, which says that it'll all be allocated to load. And our concern is that if this bill and Senate Bill 7 were to pass as is, then it would create a confusion as to what would apply to which programs the PUC is adopting. It's our opinion that, first of all, the cost allocation language in Senate Bill 7 does not create a firming incentive or requirement on its own. It has to be applied to a reliability service or ancillary service that the PUC is creating. And then as that cost is applied, then it creates an incentive for generators and load to reduce their variability. So we see it as the variability in the system is what we're trying to correct for. So cost allocation gives an incentive to reduce that variability, and it's naturally a consumer protection mechanism. We see it as a guardrail in and of itself, because it will help reduce the variability of the system. If the variability isn't allowed to grow unchecked, then the reliability service is also going to grow unchecked. And that's our concern, is that the reliability service becomes too large because there's too much variability in the system and they're not correcting each other. So that's why we really support that cost allocation element. And the simple answer would be, if we want to save that discussion for Senate Bill 7, would be to strike that paragraph from this bill, keep this firmly centered around the other guardrail discussions, and then have that discussion within the context of Senate Bill 7. On the cost cap, we agree with the statements that it should be flexible, a little more flexible, applied over a period of, say, 5 years or so, and potentially indexed to natural gas prices, et cetera. Thank you.
Thank you. Jean Ryle. We have you registered as Jean Ryle, representing Advanced Power Alliance, and you are for the bill?
That's correct, for the committee substitute. Thank you, Madam Vice Chair, Mr. Chairman, members. My name is Jean Ryle, and I'm testifying today on behalf of the Advanced Power Alliance in support of the committee substitute for Senate Bill 2012. We support the PCM guardrails as described by Chairman Hunter, the cap and the sunset, also a robust evaluation of the PCM, cost allocation to load, and ERCOT implementing real-time co-optimization prior to the implementation of PCM. We do believe the committee substitute could be further improved by allowing all resources to participate, as modeled by E3, to provide the lowest cost to consumers while still increasing revenues to dispatchable generation. Most importantly, committee substitute removes the discriminatory cost allocation approved by the Senate, which would have done significant harm to Texas consumers. ERCOT's CEO testified recently that the Senate cost allocation method would be a tax on generation resources that would create an energy valley by driving resources out of the market. By moving away from the disastrous cost allocation, the House version of this bill ensures that Texas consumers can continue reaping the benefits, such as reduced wholesale electricity cost. In 2022 alone, consumers saved nearly $12 billion due to the low cost of renewable generation, and consumers would have saved even more had it not been for transmission congestion costs of $2.8 billion. Our thanks again to Chairman Hunter for his measured approach with the committee substitute, and I'm happy to answer any questions.
Any questions? All right, thank you.
Thank you.
Michael Jewell. We have you registered as Michael Jewell, representing Octopus Energy, and you are for the bill?
Thank you, Madam Chair, Chairman. Yes, my name is Michael Jewell. I'm here on behalf of Octopus Energy, testifying for the committee substitute to Senate Bill 2012. Octopus Energy is a retail electric provider that focuses on residential customers. A few key issues wanted to touch base on that have not been talked about. We absolutely support the allocation of costs prospectively rather than retrospectively, which is a significant improvement in the bill to allow the recovery of costs. We also support the central procurement of the credits by ERCOT, which will be a key to avoiding potential market abuse. Very much support the independent analysis of the IMM and ERCOT to be sure that all of this is going to work. The sunset provision, we think, is a good idea as well, and sunset shouldn't be such a scary thing. The entire code is subject to sunset, and this market still works. So the sunset in this particular provision should not be a problem. And the concern with regard to price based on code is that would be all existing generators would get the significant amount of money regardless of whether they're investing in new generation, which is obviously a huge burden on customers. Be happy to answer any questions.
Any questions? Thank you.
Thank you.
Kenneth Flippen? Kenneth Flippen? Kenneth Flippen? We'll show him registered neutral on the bill, did not testify. Oh, and he's representing U.S. Green Building Council, Texas chapter, and self. John Gordon?
You ready for a discussion?
We have you registered as John Gordon, representing yourself, and you are against the bill. Is that correct?
I am definitely against the PCA, and unfortunately, I'm against your bill. Y'all got one task. That's to get 5,000 megawatts of peaking, seldom used capacity online as fast as possible to protect our grid. You also have a task of defining who is going to be responsible for reliability. It should be ERCOT. Either bill will get that 5,000 megawatts of peaking capacity in the next 2 years. It's going to take $1 billion a year for the next 20 years. That'll come out of the consumer's pocket, consumers. After 2 years, ERCOT can drop its all of those reserve costs, and that's $1.5 billion that goes back into the consumer's pocket. So that will give a net to the consumers of $500 million a year. We're facing the problem that's always been headed this way since they opened up and free marketed. You have the need for capacity to protect the grid at the end, dispatchable capacity, capacity that just sits there and it may not be used hardly at all in a year. You cannot feed it energy costs. It'll cause them to go bankrupt that year immediately. It's a capacity charge, and that $1 billion a year is mainly capacity charges to have those units sitting there under the authority of ERCOT to go online when we have the winter Uri, or when we have a nuclear plant drop off, or when we have other problems. And until y'all address this issue, you will not get the capacity needed to protect the grid. I open myself up to any question you might want to ask.
Any questions? All right, thank you.
Sure there's no questions?
No questions.
Are you sure? Okay.
All right, those are all the witnesses we have registered. Is there anyone else who wishes to speak on, for, or against the bill? If not, the chair recognizes Chairman Hunter to close on his bill.
Well, members and everybody here, thanks. I think we've got a lot of good ideas. It looks exactly like we started. We have a good framework, but need to look at the sunset, need to look at the cap. I like a little bit of the commentary on the batteries that have been made. Let's all take a look. The homework assignment for everybody here is get your stuff in. Here's your timeline, ASAP. So try to get as much as you can into us. Let's just say by the end of this week. And by the way, I'll be here this weekend. But I appreciate everybody. I close, and I'll be working with all 13 of you, and I appreciate you. Thank you.
Thank you, Chairman Hunter. The chair moves to withdraw the committee substitute to Senate Bill 2012 and leave the bill pending at this time. Is there any objection? Hearing none, Senate Bill 2012 is left pending.
Cody. Thank you, thank you. All right, thank you very much. Thank you, Madam Vice Chair. The chair lays out HB 1075, recognizes Chairman Harris to explain his bill.
Thank you, Mr. Chairman and members. From 2009 to 2019, foreign ownership of agricultural land doubled, according to the U.S. Department of Agriculture. The greatest share of foreign ownership is in Texas, with over 4.4 million acres held by foreign interests. In 2010, China owned a mere 13,720 acres of land in the United States. By the beginning of 2021, it had increased its ag land holdings to over 352,000 acres in our state. In Texas alone, the amount of land held by foreign investors increased by 287,000 acres in 2020. House Bill 1075 would prevent foreign nations and companies owned or controlled by a foreign nation from purchasing or leasing agricultural land in Texas. As defined in the bill, agricultural land includes property which qualifies as such in Chapter C and D of the tax code. Simply put, if a property is designated as agricultural land by a local appraisal district, then this bill would apply. House Bill 1075 is about securing the food and fiber resources of our state and having reasoned and strategic policy in place that will allow us to sustain the population growth that is forecast for Texas in the coming years. Food security is national security. Thank you, members. I reserve the right to close and will defer to witnesses to speak for the bill.
Any questions, members?
Yes, sir, Mr. Chairman.
Speaker Guerin.
Mr. Chairman, could you, I understand Russia or China or Iran, but what about some of our allies, Canada, Denmark, Sweden, or somebody? Is this just a blanket coverage?
The way the bill is written, it is blanket. You know, that's something that was debated by me when I was writing the bill. And to point at where I saw this bill, the idea for this bill was last summer. I just happened to be reading the news and saw that California, their legislature passed this bill out unanimously, and it was vetoed by Governor Newsom. And so, you know, I know there are other bills in this building as well that do specify certain countries. But if we're specifically talking about protecting our food and fiber resources, I personally don't think it matters what country it is. If we're going to have the resources we need to provide for our population for the years to come and continue to make sure that Texas provides those resources for the rest of the world, it should be us doing it and not other countries doing it with our land.
I know that there are some renewable energy producers that lease land in Texas. It's ag land for wind and solar farms, some that are partially owned by foreign governments and other investors. And are we going to cut them out of doing that?
I would be curious to know if once they acquire the land that they're leasing for renewable energy, I would think that land, the qualification would then revert to non-ag use if they're using it for.
But the way the bill's written, if it's currently ag, they can't do it.
Mm-hmm.
So if they do, that's what I'm saying. Like if my ranch in Johnson County, Texas, and I've got some proposals to put solar farms on. I don't like renewables. I'm going to use my property. If I were to do a 40-year lease on 1,000 acres, but the company is 51% owned by a Canadian company, I can't do that?
The way the bill is written, that's correct. One simple solution to that would be to take it out of ag qualification.
Well, it will immediately come out at that point, because I've looked at the leases. They would pick up, then they would be paying the taxes on it without an ag valuation. I'd still be able to use the property to graze on, especially if it's wind. So you're saying if you take it out of ag, then you can do it, but if you leave it with an ag, you cannot. Is that?
The way the bill is written, yes, sir.
Okay. Thank you. I appreciate it.
Representative Dean.
Yeah, just along the same lines, Cody. I mean, so like
you know, right now, oil and gas, big for our economy, right? And let's say a Shell, okay? So with this bill, are we saying that a Shell, because they're a UK company or whatever, cannot go and lease land that's agricultural land in order to drill wells?
That's a fair point, Representative Dean, and that's not my intent in the bill. The intent behind the bill is for agriculture production.
And that's where I was going, Chairman, because you're bracketing for for food and et cetera. And I just want to make sure, and maybe it's something we work on either wise or whatnot to bracket away from, you know, like I said, the oil and gas industry and that.
Yeah, happy to work with you on language.
And also, just like Speaker talked about with the, you know, solars and whatnot. But one other question, I was looking for your bill up here, but so a lot of these companies are stock market owned companies. So if and I'm just grabbing a name, at Exxon, if Exxon stock is owned by a majority of foreign investors and whatnot, do they now become certified or become considered a foreign company?
Yes.
So we might have to work on that. But you are interested in possibly looking at some brackets?
Absolutely.
Okay, thanks.
Representative Anchia.
Yeah, just following up, Cody, I'm I think a co-author of this bill. I really like your approach of not naming companies, right? That was really important to me. And at the same time, you know, we don't want to discourage foreign investment. You've got Royal Dutch Shell, you got British Petroleum, you've got Total, you know, and a lot of this is the foreign investment that we want in Texas. The other point I really wanted to spend some time on and is the interplay between ag and power production. They may not be mutually exclusive, right? You have situations where you've got wind, but you're still going to have ag activity, right? You're going to have grazing, you're going to maybe run cattle, you're going to have other animals out there, and even solar, right? You can have grazing under solar and stuff like that. I've seen that, and we're at the very nascent point of solar. So my question is, if you're open to working on that, I'd love to collaborate with Jay and Charlie and
absolutely
come up with a good bill. And one last point, and Cody, I'm sorry to slow your roll there, but let's also think about state-owned enterprises, you know, versus maybe publicly traded companies. Like if you have a state-owned enterprise or a company that is owned exclusively by a government but not private shareholders, that's something we might consider.
Sure, you bet. I'd be glad to look at that with you. And I think y'all understand the intent behind the bill, and it's not, you know, I don't want to by any means discourage economic activity. Strictly looking at how can we secure our food resources into the future.
Representative Raymond.
Thank you, Chairman. Thank you, Chairman. Do you know, because I haven't read anything on this, the 350,000 or however many ag acres they purchased here in Texas, do you have any idea if they're growing anything or doing anything with it, or what they're doing with that land?
I believe the majority of it's going to be ranch land for cattle production.
Okay.
I'm not sure on row crop production how much that would be, but from what I've seen, primarily cattle. And we're specifically talking about the 300 some odd thousand acres from China. Not the
that's right. That's only,
that was specifically China.
That's only
4.4 million acres total that's foreign.
Yeah, I'm glad you made that point because you hadn't mentioned that 4 point some million. You just said 350 or whatever from China. Can I also ask something, and I apologize, I didn't know this, guys. I'll tell you. So if you have ag exemption and you have, well, okay, and you have wind turbines up there, do you lose that or do you not lose it? Can you hold on to it if you're still running cattle or whatever? I don't know. You keep it? I didn't know. Okay, thanks.
Any other, Representative Smith?
So, Cody, is this perspective only? I mean, does it require any ownership that would be contrary to the law to be divested or?
No, sir.
Okay.
No, not, at least the way I have written it, that's not my intent behind it. It's for going forward, any purchases or new leases going forward.
Well, I mean, I guess the question I have then is, okay, if a foreign entity owns land in Texas now, when they sell it, can they sell it then to another foreign entity or not?
Not by my interpretation of the bill.
One more question.
Yeah, Speaker Guerin.
Cody, one more question. So if I own land has an ag valuation today, I can take it out of the ag valuation and sell it to anybody I want to?
With the way the bill is written, yes, sir.
Okay, thank you. I just want to make sure I
Yes, sir.
understood what we were talking about.
Any other questions? Thank you. We'll let you have the right to close. First witness, Stephen Skurlock. Stephen, we've got you listed as registering for the Independent Bankers Association of Texas, and you're registered neutral on HB 1075. Is that correct?
That is correct,
Go
Mr.
right
Chairman. Thank you very much. I will do my best to be under 2 minutes. Cut a lot of this stuff out. I'd like to make about 3 quick points just on a number. This bill, primarily a number of bills, or just a lot of observations are out there. First, citizens and legal residents need to have the opportunity to buy real estate. That's an issue that we dealt with over in the Senate. That is an absolute, and I think a deal killer. In the event these transactions are financed, which obviously is not going to happen with a foreign government or a foreign corporation in most situations, our banks are relying on the sanctity of that collateral for backup. And I think that's an important point. We have some concerns that in some of these transactions, they may appear to be legitimate. There may be a follow-up determination that they are indeed not. And the unraveling of these is potentially problematic, and we'd like to make sure that that is taken care of. We have also some significant safeguards already in effect. I will not go into the details of OFAC, or the Office of Foreign Assets Control. Title companies go through some of the same things, and I'm sure Representative Spiller can add to that maybe by tomorrow morning early. And finally, we have a ton of regulation in the banking industry. So with that, I have cut out all the really fun anecdotes, and I will be happy to attempt to answer any questions that you may have.
Representative Anchia.
Steve, just
Yes,
real
sir.
quick, thanks for
Yes,
being
sir.
here.
Absolutely.
Always, you're one of the trusted hands.
Thank you, sir.
OFAC, KYC, Patriot Act, you have any number of requirements to vet your ultimate borrowers.
Absolutely.
I imagine there would be some, if a bill like this passed, there'd be some covenants that you would have in your loan agreements that would allow you to seize collateral for any misrepresentation, with respect to the origin of the company. I imagine that would be, you would change your loan documents to reflect that.
We could certainly do that, Representative Anchia, and the question is, as this goes to, again, depending upon the version, the comptroller's office, the AG's office, wherever it is, and if there is litigation and, how that all ends up, I think is potentially problematic for us. But yes, we absolutely would have that. Would it be valid, and would it override a legal proceeding of some kind? I don't know.
Okay, thank you.
But thank you.
Any other questions, members? Thank you very much.
Appreciate it.
Joe Shu, ZHU. Joe, we have you registered for Leaders Forum 4, HB 1075. Is that correct?
That is correct.
Go right ahead.
Thank you so much, Chairman, committee members. My name is Joe Zhu. I'm the National Co-Chair of Leaders Forum. We're an Asian American organization, bipartisan of C-suite executives. I'm also standing before you today as an Asian American, as an immigrant from China, as well as a proud U.S. citizen. Corley, my background from an immigrant as China, my parents have a very unique background in terms of they were blacklisted. They understand the aspects of being a secondary citizen. Most critically, my great-grandfather, who was essentially punished for hiding Jewish people in his church. So we have this understanding and feeling of prosecution. Very critically, I just bring that up because whether we intend to or not, we're all understanding of the implicit biases and associations that cause others to innocently discriminate against other people. So as the National Co-Chair of Leaders Forum, I do interact very often with a number of the high-level organizations, Asian organizations, and business leaders. What I have today, and the reason why I say that is merely just to indicate that I'm not the wholly representative of the Asian American community, but I do represent a number of influential leaders and organizations past. And because of that, I have letters from several Asian organizations. I have copies for each of the members in support for HB 1075. In large part for two aspects. One, and most critically, we want to show solidarity with Texans. You know, we want to show solidarity as an Asian American community, and most critically, that we want to tell hostile foreign nations, just as everybody else does, don't mess with Texas. But very critically, we also want to protect and balance the harms of unintended consequences that certain policies can attract by singling out certain groups and people. And that is critically our aspect. We think that this bill makes total sense. We need to protect our food supply. We need to protect what is critical to our state and to our country. Thank you very much.
Thank you very much, Joe. Any questions? Thank you, sir.
Thank you. Do I pass these copies to you?
Yes, give that to our assistant clerk right here. Trey Bates. Trey, we have you with the Texas Realtors registered neutral on HB 1075. Is that correct?
That is correct, Mr.
Go right ahead.
Trey Bates, Vice President of Texas Realtors, and we are testifying on the bill and want to let you know that we've been a part of a partnership of a coalition of many of the trade organizations that we work with naturally in a lot of real estate transactions. And this topic's kind of been something we've been engaged in through most of the session. And so collectively, we've all agreed that it's incredibly complicated to apply prohibitions on real property, purchases by individuals and private businesses. It's challenging to identify ownership of business entities and legally problematic to seek information about a person's country of origin in a real estate transaction. Also, the idea that a real estate sale might be illegal raises questions about how that crime's enforced and what happens to the title and disposition of the property if such a sale occurs. So we appreciate Chairman Harris's efforts to keep House Bill 1075 limited to agricultural property instead of any real property, as we understand there are potential risks in our community security by giving control over ag land to hostile actors. We also appreciate that the bill limits its application to governments and entities that are owned and controlled by foreign governments. However, we're worried about the impacts of full prohibition on foreign entities purchasing this land might have on Texas's ability to draw investment in both commercial and residential projects. Typically, in a timeline to develop a new project, often there's an agricultural piece of land that's first acquired, then financing and other investment considerations are solidified, and then land use is converted so that a development may occur. Many of our members are engaged in brokering these types of land transactions, and House Bill 1075 could complicate that process and have a chilling effect on our ability to bring much of the needed commercial and residential development to the state.
Thank you, Trey.
Thank you.
Any questions, members? Thanks, Trey. Just so you all know, Trey grew up down the block from me in Corpus Christi. So we're glad. Great family, and thank you for being here. Aaron Day. Aaron, we've got you registered for Texas Land Title Association neutral, and HB 1075. Is that correct?
Yes, sir.
Go right ahead.
Aaron Day with the Texas Land Title Association, testifying on the bill. And the perspective I'm sharing today from the title industry perspective is one of certainty and workability. That's where we're coming from. We understand the goals of Chairman Harris, and we don't quarrel with those. We're just simply, and I also want to underscore the fact that his staff has been great to work with. They've sent a very clear message that they are willing to take in all the feedback, and they want a workable bill at the end of the day. And so that's much appreciated. The two technical points I'll note about this bill of room for improvement is that it includes the word void. And void is a very difficult word in the title industry because it creates a great deal of uncertainty. So if a transaction is void in this instance, then, and it has changed hands, loans have been taken out on that property, it really starts to become a chain reaction, a title chain reaction, if you will. And then the other element to emphasize here is the need to close the loop in this process. You identify thou shalt not, but then what is the remedy for that? And we encourage the chairman and the committee to look at ways to do a divestiture of some sort, have some sort of police action by the state to come in and then take the property, have some form of remedy, and then, of course, stakeholders that have come into play, like lenders and other lien holders, they can be made whole as a result of that process. That includes due process. But I know the chairman's open to all of that, and that's why we're on the bill. We just wanted to clarify that for the record.
Thank you, Aaron. Any questions, members? Thank you.
Thank you.
I'm getting better. Zhanggang Cheng. Mr. Cheng, you've registered for yourself.
Yes.
And you're for HB 1075, correct?
Yes.
Go right ahead.
Okay. Thank you, Chairman. My name is Zinggan Chen from Dallas area, representing myself and as a member of Chinese community. I'm for the bill. Our community is being slaughtered from legislators on our rights in Texas, Florida, and many other states, and also in U.S. Congress. In Texas alone, we are facing a barrage of discriminatory bills in both Senate and the House. Those bills intend to strip away our property rights or take away our freedom to use apps and other aspects. The authors of those discriminatory bills should be aware those bills are in violation of U.S. federal laws or Constitution. Those bills are in direct conflict with core American values. Equality for all before the law. Everyone shall be assumed innocent until conviction, and it's illegal to discriminate anyone. Those bills are in direct violation of U.S. Fair Housing Acts for discrimination based on national origin. They are also in direct violation of U.S. Constitution and the Texas state constitution for equal rights for everyone living in Texas and the United States. HB 1075 to me is like a beacon from heaven, where it's impartial and genuinely trying to tackle some potential security issue that may be posed by some foreign government. But above all, it's a bill that's non-discriminatory and applies to all foreign nations and bill left individuals alone.
Thank you. And again, for the record, you're for HB 1075.
Yes.
Thank you very much.
Thank you.
Thank you. Any questions? Thank you very much, Zenke. John Fleming. John, we have you registered for Texas Mortgage Bankers Association, neutral, and HB 1075. Is that correct?
That's correct,
Go right
Mr.
ahead.
Chairman. John Fleming, Texas Mortgage Bankers Association. Mr. Bates and Mr. Day have indicated that some of the concerns are unintended consequences, particularly on the part of the bill that declares acquisition in violation of the bill makes that transaction void. Many times, this has been indicated, you may have a developer who will buy a large tract of land to turn into subdivisions. So imagine if that transaction happens to be void because it's a prohibited person, then you have 30, 35, 50 lots with 50 homes sold on it, financed by my members. If the first transaction void, the rest of them are potentially void. There's a fix for that, and that is simply to remove the language relating to the void and institute a divestiture proceeding. And our recommendation for the divestiture proceeding is to use things that are already existing in law. In this case, Chapter 64 of the Civil Practice and Remedies Code provides for a receivership proceeding, and that would allow for a court-administrated receivership to be established, which could then cause a divestiture of the party, the protection of persons who have claims against that owner, whether they're contractors or creditors of any kind, and we believe that's the correct approach.
Any questions, members? Thank you very much, John. All right, now, members, that's all the affirmations we have on this bill. We did have a witness cut off at 5 o'clock. Is there anyone else who believed they were to testify for, against, or on that met the deadline? Saying none, Representative Chairman Harris to close.
Thank you, Mr. Chairman and members. I think there was some great testimony, a lot of really good points brought up. One point of clarification, Mr. Speaker, on what happens to the land if you do a lease with a renewable company. So if it's wind, if it's wind, the pad site where that turbine sits, that's where the valuation is lost. The remainder of the land is not lost. On solar, since it's much more expansive, you lose use of agricultural production capabilities as it is. So, yes, sir. Second point I would like to bring up is the mechanism for the enforcement. I think you're going to hear other bills this evening that have a lot of really good ideas around how we enforce it. But I did really like the divestiture proceeding recommendation from that last witness. So more than happy to work with all of the members of this committee to craft language that would work to move forward in a common sense way. So thank you all very much for your time. I know you have a late evening, so I appreciate it very much, and I close.
Any other questions? Thank you very much. The chair moves to leave HB 1075 pending at this time. Is there any objection? Hearing none, HB 1075 is left pending. Chair lays out HB 2788 and recognizes Representative Chaton to explain his bill. Chair offers a committee substitute to HB 2788. Go right ahead.
Thank you, Chairman. Members, I'm here to lay out House Bill 2788, committee sub. This bill addresses a growing concern in our country based on strong evidence of what hostile foreign governments are doing around the world. Some governments purchase land in other countries to disrupt their critical infrastructure or commit espionage. It is a tactic used to control the actions of these countries around the world, and Texas must do all it can to protect itself from bad actors. House Bill 2788 addresses the issue by prohibiting hostile foreign governments from purchasing land in Texas and creating an investigative process to identify possible violations. The bill uses an existing process for determining which foreign governments are hostile, outlines the specific individuals that could be impacted, authorizes the identification of critical infrastructure, creates a process to prioritize investigations around critical infrastructure, and establishes penalties for violations and ensures checks and balances in the process to protect the freedoms of individuals. I'll briefly elaborate on these elements of the bill. Beginning with determining who is a hostile government and what is critical infrastructure. The governor would work with the Department of Public Safety and Homeland Security Council to create a list of hostile governments and critical infrastructure sites, as well as the allowable proximity to a critical infrastructure site. The language authorizing the governor to establish these lists is pulled from the existing statute that was created last session, SB 2116, which created the Lone Star Infrastructure Act last session, gave these powers to the governor for the purposes of prohibiting access to critical infrastructure. To create the list of critical infrastructure, the governor could reference the list of critical infrastructure sites maintained by the federal government that includes one by the Office of Director of National Intelligence Office that includes over 400 sites in Texas that are considered critical. These include military bases, electricity, water, agriculture, and anything else that, if disrupted or hacked, would have negative consequences for many Americans. When determining who is allowed to purchase and acquire land in Texas, HB 2788 is careful to strike a balance between freedom and security. This bill narrowly identifies the following individuals as not allowed to purchase land in Texas: a citizen of a hostile country that is also a government official or officer in the military forces of the country, a member of the governing body or an officer of a company that is headquartered in a designated country, directly or indirectly held and controlled by a designated government, or majority owned by officials or officers of the military forces of the country, a member of the governing body of or officer in the governing political party of the country, or related within the first consanguinity or affinity to any of those types. The bill will not impact any individual or business that receives approval by the Committee on Foreign Investment in the United States, also known as CFIUS. The vetting process done by CFIUS can provide a safe harbor that would demonstrate to Texas that the individual or business does not pose a threat to national security and can do business in Texas, regardless of their relation and national origin. The comptroller will maintain a database of real estate transactions and will refer to those near critical sites to DPS for further investigation. The comptroller will establish rules to accept forms, CFIUS safe harbor letters, and other appropriate documents to implement this bill. DPS will investigate potential security concerns. If DPS finds an individual in violation of this bill, they can refer the individual back to the comptroller who to possibly impose fines equal to greater of $250,000 or 50% of the market value of the real property that is the subject of the violation. DPS can also refer the individual to the appropriate state or federal law enforcement agency for possible criminal prosecution, as the bill creates a felony for violations. Land acquired in violation of this bill will be considered contraband. The checks and balances involved in this referral investigation process create many opportunities for an individual to cure incorrect documents, for discretion by an agency, and ultimately for due process and judicial system. The option of CFIUS exemption also creates a safe harbor for any individual or business that does not want to deal with the above process. Given the option of CFIUS to investigate individuals and businesses, I have received questions on why Texas or any other state needs additional tools to limit investment by hostile foreign governments. In a recent meeting that included the commander of the Northern Fleet, Texas DPS, the FBI, and other Texas stakeholders, our federal partners revealed that if the commander of Fort Hood was able to look out the window and at a satellite directed at a base, potentially intercepting signals or committing espionage, that they could not go and investigate. Additionally, the FBI would not have the ability to investigate, nor any other federal agency. Finally, neither would the Texas DPS or any law enforcement agency, as there is no state law against it. The act of potential espionage is currently outside the bounds of any agency ability to investigate, state or federal. That is why this bill is necessary. In Grand Forks, North Dakota, the mayor and city council found themselves in the only entity able to slow down a significant threat to national security. A food manufacturing company based in a nation hostile to the United States purchased land and began the process of attempting to develop a mill 12 miles from Grand Forks Air Force Base. U.S. senators, the Air Force, and others explicitly called the land purchase a significant threat to national security. However, North Dakota had no law in the books preventing the purchase. CFIUS said it did not have the authority to weigh into the issue, but the Air Force worked with the Grand Forks City Council a city of a population of 60,000, to deny the building permits. The company still owns the land, but they were not able to build the mill. The situation is not uncommon, and other states evaluating implementing similar laws as this in state legislatures of North Dakota and South Dakota. Federalism is a key part of our government, which means we must have state laws that fill the gaps where federal jurisdiction is limited. House Bill 2788 fills that gap while taking significant steps to protect individual freedoms and preserve the American dream. As the son of a Korean immigrant and the son-in-law of Chinese immigrants, preserving the American dream and the right of immigrants is personal to me. I am confident that this bill strikes a balance between prohibiting bad actors from purchasing land and ensuring lawful individuals can continue to live and do business in Texas. At this time, I'm happy to answer any questions. Otherwise, I reserve the right to close.
Any questions, members? We'll give you the right to close.
Thank you.
Aaron Day. Aaron, we have you registered on behalf of the Texas Land Title Association, neutral on HB 2788. Is that correct?
Yes, sir.
Go right ahead.
Aaron Day with the Texas Land Title Association, and similar theme of certainty and workability. And also, I want to extend the praise to the representative staff as well, because they have also expressed that they're very open to suggestions. And again, so we are on the bill. I would also like to thank the representative for filing this bill when he did the way he did, because there have been many bills in both chambers on this subject, and the representatives was the first to close that loop, as I've previously testified to the importance of what happens on the back end of this transaction and this determination. So his bill was the first bill to start to reason and think about an approach to that piece of the puzzle. And so we're very grateful for that. The one note of caution about the bill, and look forward to continuing conversations with the office, is it's a very complex bill. There's a lot of moving parts to it. And that added complexity and the added elements of that start to give us pause and concern in the context of certainty. The clearer we make the rules, the better, and the clearer we define the authorities, the better. So I look forward to continued conversations about that.
Any questions? Thank you.
Thank you.
So our next witness, and I'm going to have to spell, Xiaoyu Wu. Now, Mr. Wu, we have you registered for yourself against HB 2788. Is that correct?
Yes.
Go right ahead.
Good evening, Chairman and member of the House Committee on State Affairs. My name is Dr. Xiaoyu Wu. I urge the committee to vote against House Bill 2788. This bill grants the governor sweeping power to prevent immigrants from any arbitrary country from owning a house in Texas. Despite this bill's intention, I see minimal, if not zero, regulations to the governor's power, which could violate the spirit of U.S. Constitution and push Texas toward a dangerous slope toward dictatorship. Texas has always been a beacon of hope for immigrants seeking opportunity in this great state. However, this bill, as a side effect, will punish immigrants because of the country they come from, and has caused great concerns and uncertainty for many immigrants, including myself and many of my friends. It is important to remember that immigrants contribute significantly to the economy, and they enrich our community with a diverse background and skills. If this bill becomes law, it will send a message that Texas is unwelcoming to immigrants, and it could harm our state's reputation as a welcoming place for all. As a result, many immigrants may choose to leave Texas for other states or countries that welcome and appreciate their contributions. I strongly urge the committee to reject the bill and ensure Texas remain a land of friendship, opportunity, and inclusivity. Thank you for your time.
Thank you very much, Mr. Wu. Any questions? Thank you very much, sir.
Thank you.
Chang, and then it's XUE.
That's my wife. The school has been dismissed earlier. So.
I'll note. So Chang, XUE, registered for herself
yes.
Against HB 2788. And we'll note in the record that she did not testify, but registered again.
Do you think I can read her testimony?
No. You can give it to our assistant clerk. Bradley Hodges. Bradley Hodges. Bradley Hodges will show Bradley registered for himself for HB 2788, but did not testify. Mingwan Wei. We have you registered for yourself.
Yes, sir.
Against HB 2788, is that correct?
Yes, sir.
Go right ahead.
Dear Chairman and committee members, I am Mingwan Wei, and I stand here to oppose the HB 2788, which is unconstitutional, discriminatory, and impractical. As like other discriminatory bills such as SB 147, HB 2788 single out an individual from a certain country and prohibit him to buy a property. This is unconstitutional and discriminatory. Furthermore, HB 2788 will grant the governor and then the state the power to determine whether a person can buy a house or land based on the observed rules that are stated in the bill. For example, if someone live in Texas and buy a house, but somehow the state realized that his father is a member of CCP, and then the state, according to the bill, will seek penalties against this person, including taking away his house and 250,000 fine. This is against a basic human right. This person cannot be assumed guilty just because his father's membership to CCP. Such assumed guilty situation is going to make the state of Texas a Nazi government. More importantly, HB 2788 has a $6 million fiscal note, which will waste taxpayers' money on the impossible task to check every single property purchase in Texas. If I were you, I would rather be spending the $6 million on state IT security system. Recently, I received a letter from Texas Department of Public Safety, and my driver license information was leaked. A replaced driver license was sent to someone in another state. After almost 4 months, DPS sent me a letter to notify me. I don't know how much money I lost from my bank account, and I don't know what my driver license has been signed up for yet. This is the security I think you should focus on to protect the Texas personal information from leaking.
Thank you, and we will note that you're against HB 2788, correct?
Yes, sir.
Thank you so much.
All right, thank you.
John Fleming. John, we have you registered for the Texas Mortgage Banker Association, neutral on HB 2788.
Yes,
Is that correct?
Yes, Mr. Hunter,
right
that's
ahead.
correct. Thank you, Mr. Chairman. John Fleming, Texas Mortgage Bankers Association. This bill has a lot of intriguing aspects to it. We haven't seen the committee substitute. It's still in process. We've seen some of the comments. However, I would say that anytime you expand it beyond entities to individuals, then we must be sensitive to potential possibilities of discriminatory impact under the Fair Housing Act, under the Equal Credit Opportunity Act. And so I think that's something that has to be very carefully thought about. And as we go through these bills, don't forget we are in a community property state. So you could have a U.S. citizen who marries a prohibited person, and that might impair their ability to acquire Texas real estate in their individual name because we are a community state, and by that, the spouse automatically has property rights in that. Again, we're back to the enforcement mechanism. We think the safer route is to go and use the receivership proceeding under Chapter 64, and there are other options available, but we believe that's something that should be looked at as an enforcement mechanism. Happy to take questions.
Any questions, members? Thank you very much. C.E. Way. Now, we have you registered for yourself against HB 2788. Is that correct?
Correct.
Go right ahead.
Okay, I hope I could say good morning, but good evening, Chairman and members. I'm Ce. I live in Austin, Texas, and I'm here to oppose the HB 2778. Recently, there have been so many bills that want to modify the Section 5005. Let me repeat and emphasize it. An alien has the same real and personal property rights as a United States citizen. So, what 2778 does, it gives the governor the power to decide that people or companies from which countries that will be limited to purchase a real property. It's totally unconstitutional and violates democracy because the governor's his own mindset cannot represent the people in the community like you and me. So it's totally possible that a great British citizen or Italian citizen hit and run Greg's car, and then he feels really angry and starts to ban those people from buying a property. So if this bill really cares about the national security, what it should do is ban all of the governments from buying the property. So no HB 2778. Thank you.
Thank you very much. Any questions? Thank you, sir. Stephen Skurlock. Steve, we have you registered for Independent Bankers Association of Texas, neutral on HB 2788. Is that correct?
That is absolutely correct.
Go right ahead.
Very briefly, just my comments from the last bill stand. I do want to thank all of those that have attempted to address this issue. It is a very complicated moving part. Push here, it gets pulled here, and vice versa. So thank you to those who have been there. Thank you guys for staying up so late, and I appreciate it. Thank you, and happy to answer any questions if I'm able.
Thank you. Any questions? Thank you very much. June XU. June Zhu. June XU. We'll note that June registered for herself against HB 2788, but did not testify. Julia Parenteau. Julia, we got you for the Texas Realtors. Neutral on HB 2788, is that correct?
That is correct.
Go right ahead.
Chairman, thank you. We almost made good morning again. Thank you, members, for hearing our testimony on this and the other bills related to this issue. We want to, of course, echo our thanks to Representative Jatan for his approach to this issue that has been such an important discussion throughout this whole session. We appreciate his creativeness and his thoughtfulness in how he drafted this legislation. We understand and share the concerns about our national security, particularly around our food supply. But as you've heard, real estate transactions are complex, much more so than a Dreamhouse TV might like us all to believe. And so the implementation of this type of legislation is where we have focused our concern. We, again, are grateful for the committee substitute for House Bill 2788's narrow focus on particular countries, on particular individuals, and for those entities that are controlled or owned by those governments. And as another colleague mentioned, for its thoughtfulness around the end of the transaction. We do maintain our concerns about the bill's complexity and its application to all property, not just agricultural, and its potential discriminatory outcomes. One other additional piece I want to mention with the substitute that gave us pause as we read the substitute language was the creation of a registry with the comptroller that would require any buyer of real property to send a registration to the comptroller with their identity and any other information they may deem necessary. That's a new idea, one we never thought we might consider here in Texas, and we want to spend some time talking through that element as well. So again, with that, I want to thank Representative Jatan, his great staff for their open door and for continuing to talk to us about this important matter. And Mr. Chairman, that is it, unless anyone has any questions.
Questions? Thank you so much.
Thanks.
Petrus Young, Y-E-U-N-G. Petrus, Y-E-U-N-G. Petrus Young, Y-E-U-N-G. Will note registered for self against HB 2788, but did not testify. Chun Yu Lin. Chun Yu Lin. C-H-U-N-Y-U-L-I-N. Will show registered for self against HB 2788, but did not testify. Lin Wan. Lin, L-I-N, Y-U-A-N. Lynn, we have you registered for Texas Capital News and Self against HB 2788. Is that correct?
Correct.
Go right ahead.
Dear Chairman and committee members, my name is Ling Yuan. I lived in Austin for 30 years. I'm here against HB 2788 because this bill criminalizes innocent individuals. Just because someone has a relative who serve in the government, a certain country, or a party member, what does not really mean that relative work for that government against the U.S. and create a national security. Or this person should be, deserve to be banned or criminalized for buying property. Tom Zhu, who's responsible for Tesla U.S. assembly plant and the sales operations, he's from China. Just this year, my company helped 30 of his engineers rented a house in Austin. Their family might be moving here. They might be buying houses. And I'm from China. Some of their family, sister, brother, relative, might work for the government. How in the Texas we can verify if some of those people have relations with CCPs? So it's a really dangerous assumption to ban those folks because they are visa holder working in the U.S. and because they have relatives who work in the Chinese government. The bill also prohibits purchase of a real property by a foreign company headquartered in this country. Allow me to give an example. And just a couple of weeks ago, I met a gentleman. He represents a public trade company looking all over the U.S. to find a site for his company. This company provides smart devices for Tesla and Samsung.
Thank you. We will note that you have registered against HB 2788, correct?
Correct.
Thank you.
Thank you.
Chen, okay. Is that? Okay, John Coleman, C-O-W-M-A-N. John Coleman, C-O-W-M-A-N. John Coleman. Will note that he registered for himself against HB 2788, but did not testify. Alice Yee. Alice, we have you registered for the Asian American Leadership Council, Asian Texas for Justice, and self against HB 2788. Is that correct?
Correct.
Go right ahead.
Thank you for the opportunity for me to speak up. I grew up from China. I want to share a little bit of my personal experience back in China. 1951, my grandma, on my father's side, grandma was kicked out from her house. She has 7 children, built 7 houses, has 200 acres. She was kicked out from one day from landlord, become homeless because she was categorized from government as too rich. Okay, 1959, my mother was kicked out from a workforce just because she has a sister living in Taiwan. I grew up, as long as I can remember, was discriminated because of our family background. Using my experience back then and compare with what this bill means to Asian American, I feel like so much familiarity. Using government's power, government hostile method to punish ordinary citizens, punish legal residents in the United States, take away the property, fine them for $250,000. And this is really Communist Party's method. Dictatorship. If I gave a governor the right to determine which country is an animal country, this is wrong. We cannot let this happen. I feel sad to be here all day to testify for these 2 minutes. I feel like I'm living back to Cultural Revolution time in China.
Thank you. And we're going to note you're against HB 27.
Yes.
Thank you, ma'am. Chen Yang Zong. Chen Yang and then Z-H-A-N-G.
My name is Zai Guai Sang.
Is it spelled C-H-E-N-Y-A-N-G-Z-H-A-N-G, self-electrical engineer?
No, it's not.
Okay.
I'm sorry.
So let's start over again. Chen, C-H-E-N, then it's Y-A-N-G, then Z-H-A-N-G. Again, is this person present? Chen, Y-A-N-G, Z-H-A-N-G. One more time, C-H-E-N, Y-A-N-G, Z-H-A-N-G. I will note that person had registered for themselves against HB 2788, but did not testify. All right, now I have X-I-A-O-N-A-N Lee. Now we have you registered for Texas Capital News against HB 2788. Is that correct?
Yes, correct.
Go right ahead.
Good evening. My name is Xiao Nan. I'm representing Texas Capital News, Austin's longest-running Chinese language publication since 1991. I'm here to express our opposition to this bill. Firstly, granting the governor the power to designate restricted country violates the principle of the United States federal system. Texas is not a sovereign nation and does not have the constitutional authority to manage diplomatic relations with other countries. Secondly, this proposal assumes that we all have foreign government background. We cannot choose our region or where we came from. There are no legal basis for involving foreigners or immigrants in this matter, and depriving them of the rights granted by the Constitution. Lastly, clarifying property transactions as felonies abuses power and abase the presumptions of innocence, harming the whole specific community and setting a dangerous precedent for treating foreigners and immigrants in Texas. In conclusion, I urge the Texas legislation to reject this bill. Thank you for listening.
Thank you very much. Appreciate it. QUINGU. Now, we have you registered for yourself against HB 2788, is that correct?
Yes, it's correct.
Go right ahead.
Yeah, my name is Qin, Q-I-N. I think it's not Q-U-I-N. Thank you, Chairman and members. It has been a long day, and I represent myself and I oppose HB 2788. Actually, I talk about the same story to oppose SB 147. I graduated from UT Austin 4 years ago, and I started to work here in Austin. Since then, I'm now an H-1B working visa holder and work as hard as anyone else in the city and work as hard as anyone in this room. I love Texas, love opportunities and vibes Austin provides. Always anyone asks me why you don't move to California. I say I don't like California, I like Texas. I pay my tax, but after reading HB 2788, I'm questioning myself. Am I an alien has the same real and personal property rights as a United States citizen? Probably not. HB 2788 just give the governor the right to pick the countries that he thinks is evil. And thus, I need to foreclose my properties and maybe pay a fine up to $250,000. That's ridiculous. I think if passed, HB 2788 would be a reason that many high-tech employees and PhD students choose not to stay in Texas. They would definitely turn down Texas as their home and turn to other states because they are truly equal, and maybe California should be the right state to live in, And I have already heard my friend who was preparing to move to Austin for his high-tech job as a software engineer is recently considering other states, including, Seattle and California, because he does not want to be a second-class resident here. And do we really want to be investigated because we are Chinese citizens? Maybe not. And for people like me, I'm opposed this bill. Thank you.
Thank you very much. Yeah, Representative, excuse me, you have a question. We have Representative Chia would like to ask you a question.
I wanted to say, 你好, 谢谢.
你好, 谢谢.
I'm really grateful.
Thank you.
I'm grateful to you and the entire community for coming out to let your voices be heard. And your testimony raises an important point on any bill that we may adopt, and that is that you may have completely legitimate visa holders like H-1B visa holders that are not U.S. citizens, that are not permanent residents, but still should be treated equally in their ability to buy homes in the state of Texas. So I really wanted to appreciate that nuance in your testimony, because we have thousands of H-1B workers here in the United States that are contributing, in Texas, that are contributing mightily and should be able to buy real property here. So thank you.
Thank you.
Thank you so much. Z-I-L-I-N-G, Rue. We have you registered for yourself against HB 2788. Is that correct?
That's correct.
Go right ahead.
Sorry. Yeah, good evening, committee members. My name is Zillian Rue. I'm presenting myself against the bill HB 2788. I think I got this similar experience with the previous speakers. I became an Austin resident about 6 years ago. For my job, I work as an account manager in a real estate company and holding the H-1B working visa as well at this moment. So currently, we are experiencing a hard time due to the bill, since it states the destination of country is subject to prohibition on purchase of our acquisition of title to real properties. Many of our friends, coworkers, business partners, and clients, they are real estate-related persons, business owner, high-tech company employees, have been asking me about the bills that's been causing them concerns and times. They fear that the bill might prevent them from purchasing land or investing in Texas in the future. Also, if the bill passed, probably many of them could not purchase a home that bill after the time. Our clients, many of them are small group entity as well, contributed 1/3 of the funds this year to help developers build in the high-rise building in the middle of the downtown Austin, right next to the Lady Bird Lake. Now, the only thing they could do is finger cross the bill won't pass, or they are not going to purchase even one condo just because their nationality so as their family background. It also doesn't make any sense to me. So if the bill passed, not just the individual seller, the lender, builder will have all the concerns regarding the people like me, our loans and property purchase with these unacceptable reasons. Essentially, this bill is pushing us away from Texas, which goes against our desire to promote a business-friendly environment in the state. Lastly, whenever a bill is passed that discriminates against a particular group.
Thank you, and we're going to note you're against HB 2788, correct?
Yes.
Thank you very much.
Thank you.
Is that? Okay. Zhengang Cheng? You're getting to be my old friend. Come on down here.
I will appear for every discriminatory bill because, I mean, it's my duty as a member of Chinese community.
Let me just make sure before you start. We have you registered for yourself against HB 2788, correct?
Yes.
Go right ahead.
Thanks, Chairman, for being so late and listening to our testimony. My name is Zhengang Chen from the Dallas area, representing myself and as a member of Chinese community. This bill, to me, is very dangerous and against the democratic values, as it's like creating a kingdom in Texas. The governor can wield so much power to deprive a group of people from certain countries of their rights under their property. It just makes me think of Nazi Germany. This bill is discriminatory in nature and shall be rejected. For example, in China, when I look up, I saw ruling party has about 96 million members. If considering their spouse, kids, parents, it's about 600 million people could be impacted by this bill. I understand everyone is dreaded about CCP or communist. To me, anyone willing to volunteer or to serve for the good of community has a spirit as a communist. As seen in China, lots of members of those CCP are just ordinary workers, like everyone working in the government do their normal business. They are the ones that will stand up in face of danger or disaster, trying to take care of others and lead the people around them to overcome the difficulty. I'd like to share a brief personal experience. I'm from a small and rural area in China, about 300 people, but with only 50 acres of arable land. My grandfather was a member of CCP as a village leader. As a kid, I saw him devoting most of his time to help the village people. I also saw him failed to start factory. Sorry.
Thank you. And again, so we have it in the record, you're against HB 2780.
Yes.
Thank you, sir. Is it Hewley? We have you registered on behalf of Austin Chinese American Network and Self against HB 2788. Is that correct?
Yes, that's correct.
Go right ahead.
Yeah, thank you, Mr. Chairman, committee members, and good morning. My name is Hugh Lee. I'm the president of Austin Chinese American Network, a Austin-based nonprofit with more than 1,000 members. And I'm here representing myself and my organization, and we oppose HB 2788. Among the many flaws of this bill, I would like to list 3 that stand out. Number 1, this bill gives undue and unlawful authority to the governor to designate a hostile country. Under the U.S. Constitution, the power to conduct foreign affairs is vested in the federal government. This expansion of state authority, if granted and replicated across 50 states, will create chaos in U.S. foreign policies that will harm every U.S. citizen's interests, including those of the Texans. Number 2, Section 5.252, Subdivision 4D is particularly offensive. Essentially says that if my father is a CCP party member and I have been living in the U.S. as a legal resident, minding my own business, I still can't own real properties in Texas simply because I'm related to my father, quote, within the first degree by consanguinity, unquote. And what the heck is this? This is what happened during China's Cultural Revolution, where if your father is declared an enemy of the state, then you automatically have no rights of any sorts. This provision of HB 2788 harkens back to such a dark age that it's simply shocking. Number 3, further on with the above example, if I were to buy an apartment for my son, I could be committing a felony crime according to Section 5.252B with jail time, even if the transaction itself is fair and otherwise lawful. And let this sink in, ladies and gentlemen, buying an apartment for my son can be a felony crime here in Texas. This is arbitrary cruelty and a terrible abuse of government power. And how exactly is this related to national security? So Representative Jitang, I'm sure you didn't mean it, but when applied to legal aliens here in Texas, I only see wanton intention and naked discrimination. Thank you.
Thank you. And we'll have you registered against HB 2788.
Yes, thank you.
Thank you. This is Xinjun Liu. We have you registered for yourself against HB 2788, is that correct?
Yeah, correct.
Go right ahead.
Good evening, Chairman, committee members. So my name is Shenjun Liu. I'm here today to voice my opposition to Bill HB 2788. So as the Chinese students who legally relocated to Austin from Singapore 3 years ago, me and my wife has we have legitimate jobs and we have some investment in different fields. And right now, so someone told me that if I want to buy a property for investment purpose, that's a felony, that's a crime. Think about it. I don't think that's make any sense. To be honest with you, I think that's the most illogical things I've been heard in recent years. So I think this bill is just another example of racial discrimination that has pledged in the US for centuries. In my opinion, this kind of bill is just is same as the Chinese Exclusive Act in the last century, which prohibit Chinese immigrants from entering the US. So this is clear violence of civil rights and the basic human rights. So I really hope that all the committee members to against this particular bills. Thank you for your time.
Okay. We'll register you against HB 2788.
That's correct.
Thank you so much.
Thank you.
Okay, JIE-LUO. We have you registered for yourself against HB 2788. Is that correct?
Yes.
Go right ahead.
So my name is J Lo. I moved in the United States since 2008, and it's been like many years. And I'm a single father. I have a 7-year-old boy. And a few days ago, I told my boys that, okay, we're going to celebrate. Celebrate for what? celebrate your grandfather is not CCP member. And he asked me, what is CCP? And you don't need to know what is that, but the thing is, I'm living with my son in a single family right now, and my son loves like downtown high-rise condo building, and I already purchased one for him on the contract, which should be closed next year. And because we're lucky, your grandfather is not a CCP member, so that is why I can purchase this condo for you. Otherwise, if I purchase that condo for you, I'm gonna get a penalty, and I probably being put in a jail. So that is probably sounds funny, but it's really happened. And secondly, I'm gonna tell another story. I finished my master's degree in Texas, and I moved to Boston and Columbus, Ohio for many years. And I choose to move back to Texas because I love Texas. And I have many friends, clients moved to all over every corner of the state to the United States because we all love Texas. But right now, there's some client or my friend, they are planning to move out from Texas because they fear Texas is make them scary. Because you never know if that bill passed, maybe there's another new bill gonna come up and bring like a new idea to bring like to limit it, like the people's right for even erase the property or anything else in the future. Okay.
Thank you, sir. And we'll note you're against HB 2788.
Yes.
Thank you.
Okay, thank you.
CHIQUAN Sun. We got you this time.
Yes, sir.
So we have you registered for the Greater San Antonio Chinese Chamber of Commerce and Self against HB 2788. Is that correct?
That's correct.
Go right ahead.
Yes, sir. Thank you, Mr. Chairman and the committee members. Thank you for giving me the opportunity to share my opinion for the bill. At first, I'd like to share a video. It's about the similar bill, which is SB 264, Florida, because this bill already passed. They posted the bill to the Chinese TVs, internet, and social medias. Let's see what happened. It's a bill.
You're not able to show, but you can tell us what
yes,
the video says.
Okay, there's data. There is 100K plus forward to their friends, families, and groups. There is 69.7K non-up, and there is 73.2K put on the news on the top. And also there is 15.4K left their comments. Let's see what comments, what their opinions and what they say. It's their words. The first, the government, the USA government did a great job. They did what our government, which means Chinese government, wants to do but couldn't do. The second, our international students, experts, high-tech talents should come back to our country to service our country. The third, it's great. The traitors, they called us traitors. The traitors should get a punishment. Confiscate their, it's my time?
That's your time, but we're going to note that you're against 2788.
Yes.
Thank you, sir.
Thank you. Okay, thank you.
Appreciate it. Helen Shi.
Should I begin or wait till?
Okay, good. Helen, we have you registered for UCA, United Chinese Americans, and SELF against HB 2788. Is that correct?
Correct. Thank you, Chairman.
Go right ahead.
And thank you, everyone, stay this late. I'm amazed by your ability to even listen to us after a whole long day. Yes, my name is Dr. Helen Shi. I'm speaking on Asian community and also UCA, which is a national civil rights organization for Chinese community. So today we're very concerned about this bill. Since January, our community has come out strongly against and opposing SB 147 and its variation, which essentially include this bill, because they remind us of the dark history of America, and that is called the Alien Land Law and the Chinese Exclusion Act. This bill in particularly has passed full control to the governor's and comptroller's office, potentially put a civilian and intrusion into private citizens and their business. And so that can be potentially create a civil right violation and abuse to our community. You have heard what people have talked about. Just because a person may be related to someone working in the government can be put in a jail and they cannot purchase any property. And I remind you that every one of you actually is working with the government, American government, and every one of you is actually trying to help the community and doing some good work for this country. And that's the same thing happened to the Chinese government. People there have to serve the people. And if you exclude all of them and treat them as enemies of this country, that can create a big backslash to people like you. That means you may have some problem when you go to China. Your right may be having put in danger, and you might be retaliated. And this is a serious problem to national security. This bill does not really protect national security, but actually can endanger that. So thank you so much for your attention.
And again, you're against HB 2788.
Correct. Thank
Thank
you.
you so much. Okay, is it Ling Zhang? We have you registered for yourself against HB 2788. Is that correct?
Yes, that's correct.
Go right ahead.
So I don't have any immediate family members who are the Chinese Communist Party members, so this bill might not directly impact me. However, the inside fear, and it reminds me of the dark history in China. Back to 1950s to 1970s, rich people were considered as evil and persecuted. My grandpa was a rich person and was heavily persecuted. My uncle, who was the best student in our county, was not allowed to go to college. And at that time, many people had to testify against their parents to prove that they are not guilty. And so this bill in 2023 in Texas has some similarity with what happened in China back in that time. So some Chinese immigrants, may have their parent or grandparents was a party member. But so if they purchase the property here, then they will be put in jail. And I think the bill also said that it's going to be at least $250,000 or half of the property price, whichever is higher. And also to forfeit your property. So that has some similarity. It feels like my uncle. So he was denied, he was punished not because of what he did, but because of what his parent or someone's grandparent was. And so I came here more than 11 years ago. I never returned to China since then. And I love this country and love every American I met who I've been friends with. And I never see something so unfriendly. Currently, there are at least 11 bills in Senate and House that targeting at Chinese immigrants for not allow you to buy in property, to not using the social app developed by Chinese companies, to not allow Chinese students to attend Texas universities.
Thank you. And we'll note again, you're registering against HB 2788, correct?
Correct.
Thank you.
Thank you.
Is it Heilong Jin? Hailongjin. Hailongjin. Show represented DFW Chinese Alliance and Self against HB 2788, but did not testify. Is it Zhao Guo, G-U-O? We show that you've registered for yourself against HB 2788. Is that correct?
Yes.
Go right ahead.
My name is Zhao Guo. I live in House District 136, but I visited Corpus Christi and love it very much. And I oppose HB 2788. The author of the bill discussed federalism, and I want to tell a history anecdote. Like 100 years ago, California segregated Japanese American children in their school. As a result, lots of Japanese seppuku in front of U.S. embassy in Tokyo. And then during World War II, one naval aviator, when attacking Pearl Harbor years later, sent this note to his family. And finally, I can revenge for this shame brought upon by California school district. What's this bill, HB 2788, is doing the same thing. And based on the principle of federalism, I don't think the state of California can have this much power in international relationship. Thank you for your consideration. I'm open to questions.
Thank you for bringing up Corpus Christi. No, thank you very much, and we've got you down against HB 278. Yeah. Thank you. CJ Zhao, we have you registered for APAPA Texas Chapter and Self against HB 2788. Is that correct?
That's correct.
Go right ahead.
My name is CJ Zhao. I'm a Texas voter and American citizen. I've been in this country for almost 30 years, way longer than the childhood I spent in China. And I heard quite a few great, whether they are neutral or against, I heard quite a few great certain testimonies. Some of the trade association, I thought they did a very good job talking about the complexity of the bills, and the fact that it's communal property, there's all kinds of issues about the implementation. And I just filed my income tax for 2022 with lots of digits in it, let's put it that way. And I really don't appreciate spending my tax money to build this gigantic database, trying to track everybody, trying to figure out who did what, who is associated with what. It just feels like such a waste of my money as a taxpayer. But I'm here to tell you a little bit of kind of joke story, almost comic, okay? I have an uncle in China right now. He's in his 90s. He's a Communist Party member, CCP member. Guess how he became a member? When he was in his 17, 18, the Nationalist Party army passed our village. We live in a rural village, very poor, and he was starving, right? The army said, join us, you will be fed. He joined. He's illiterate. He doesn't read. He doesn't have any ideology or belief. He just wants to be fed. So he actually joined the Nationalist Party army. First battle, he got captured by the Communist Party army. Okay, doesn't matter to me. I just want to be fed. Communist Party said, okay, you got captured. We will feed you if you keep fighting with us against the Nationalist Party army. He said, fine, I'll fight for you. 2 battles later, I don't think he managed to kill anybody. He got hurt. And so basically, he was crippled permanently, actually. So he retired. But because he got hurt during the battle, they honored him and enrolled him in the Communist Party. Guess what? My cousin, his son, is in the U.S. as a legal resident. His son literally had to call him, say, can you de-enroll
You've gone past your limit as a long joke. All right.
But
the point is you're against HB 2788, correct?
Yes.
Thank you a lot. Thank you. Enzeng, E-N-G-E, thank you. Now, we have you registered for yourself against HB 2788. Is that correct?
That's correct, Chairman.
Go right ahead.
Before I start, can I ask a question to the author
you
of the bill?
cannot.
I can't?
You
Okay.
can only address us.
Okay. So
However, after the hearing, you may go talk with him. Okay. Go right ahead.
Okay, we can talk on the street 3 o'clock, no problem. Let's get that way. The author has said about hostile country and protecting infrastructure at his beginning. I read through the passage and entire this bill. I haven't found those 2 words, hostile and infrastructure. So I would like to know where on this bill these 2 are. Okay, so I'm against 2788. There's 2 main problems. The one is give the governor ultimate power, but didn't give him enough resources. He's at state level. The country-to-country relationship is on a national level, is on a federal level. But tell him to designate a country is hostile, not giving him, not consulting the federal agent, not consulting the White House, not consulting the federal agents, just consulting Department of Public Safety is irresponsible. And the second point is about how do you decide a person is closely fit with the foreign authority? My brother marries a girl whose father is a former mayor. Is he related? Am I related? If I buy a house, will my agent to be criminalized later for buying me a house? My brother's agent criminalized later for buying him a house. Those things are very vague and hard to execute. I know that the intention is good to protect, but how do you differentiate? Then you have so many vague cases, so many cases are iffies. So, and this also can be extended to American citizen.
Gotcha.
Thank you.
Thank you, and we have you down against HB 2788. Okay, PINGHE. We have you registered for yourself against HB 2788. Is that correct?
Not exactly. I'm also on behalf of my wife. She's right here.
No.
But she doesn't speak English, so may I share her time?
No.
Okay.
So, first of all, are you PINGHE?
Correct.
How do you say that?
Pinghe.
Pinghe, okay. Yeah. You're registered for yourself against 2788, correct?
Correct.
Okay. That's how you've registered, so that's how you'll need to testify. Is that an agreement?
Mm-hmm.
Go right ahead.
Good morning, Chairman and members. My name is Pinghe. I'm on behalf of myself. So we oppose this House Bill 2788. The bill would allow the executive branch to strip companies and individuals of their property rights based on their country of origin, which be prohibited by the United States Constitution and the Texas Constitution and the Federal Fair Housing Act. Okay, we can skip this. Most of our attorneys, so you know this. So let's talk about the presumption of innocence. We believe the phrase innocent until proven guilty. It's unreasonable that an individual citizen of a designated country should lose their house or have no right to buy a house just because of their nationality. Everyone should be treated equally. Secondly, HB 2788 gives the governors more authority to override the law. A government that's completely controlled by the governor is not a democracy, it's a dictatorship. It's dangerous for society. Our governor, Abbott, won the election with 54.8% of the vote in 2022. That means the other 45.2% of Texans don't think he's a good governor. So when he designates a country, how can we say that's for all Texans rather than his personal preference? We legislated to protect our state and our people, not to create a breeding ground for democracies to be destroyed to produce dictators. Therefore, governors should follow the laws and regulations to ensure their powers are used appropriately
And we have
reasonably.
we have to end you here. But we'll note that you're against HB 2788.
Yeah,
Thank you,
right.
sir. Thank you. Faye XIAO. We have you registered for yourself against HB 2788. Is that correct?
Yes.
Go right ahead.
My name is Sophie Xiao. I live in Austin. I'm come here. I just against this bill. I have a lot of reasons against this bill, but my English is not good. So I just want to come here today here is all day. I just want to face tell you I against this bill. That's all.
That was very good, right?
Sorry.
No, very good, to the point. And we thank you. And again, I'm going to make sure we say it in the record, you're against HB 2788, correct?
Yes.
Thank you so much.
Thank you.
Okay, members, that is the end of our registrations. So now everybody listen. Is there anybody else who we didn't call that was to testify for, against, or on that made the 5 o'clock deadline? You have to be on that deadline. Seeing none, we call to, well, you'll have to come up here and check.
I thought I registered. I didn't get my name heard. I don't know what happened. Get it, please.
Okay. No, come up. Come up.
Hi.
All right, Janet,
Yes.
LIU.
Yes.
So you've registered for yourself against HB 2788.
Yes. As a
Go right ahead. Go
as
right ahead.
language as stands right now. Well, before I start, have the member of the chamber read the latest
You're going to have to speak. You can't ask us questions.
Okay, anyway.
Go right ahead.
Okay. I've been talking to a lot of lawmakers over the last few weeks, and one of the concerns I really have is in this legislative session, there are a lot of bills in the name of national security and encounter Chinese espionage, presumably assume the average Chinese citizen, legal citizens are guilty, whether my sister, my niece, or my friends, and ban them from anything, land, property, everything. To me, I want to kind of share with you guys, the chamber of the members, member of the chambers. There was an article by Texas Tribune on the 11th, where U.S. Congressman Mike McCall telling the state legislator that let's focus our China countering measures over espionage, not targeting the Chinese immigrants. I don't know anybody read it, but I want to share with you. This is published by Texas Tribune on April 11th. That being said, and also talk about, I am a volunteer to my local Asian chamber. We just got on the phone with my Dallas Regional Chamber. We are, as a state, we pro-business. We want to get foreign investment coming in. So I haven't even read the revision. I was driving actually, but I know the foreign companies are listed. I mean, U.S.-China, I was, 2013 was actually a translator for President Bush for investment. This to me is not good for investment.
And you're against HB 2788.
Correct.
Thank you very much.
Thank you.
Now, is there anybody else, for, against, or on, that believe they met the 5 p.m. deadline? Seeing none, closed by Representative Jatan.
Thank you, Chairman. Thank you, members. I appreciate everyone that came out to testify. I know that there's a lot of complexities in this bill. I just want to make some real fast clarifications, and then I will close. First off, the governor already has authority to designate those hostile countries. We all voted on that, passed unanimously out of the House and Senate last session. So that already exists. This creates an investigative process. It creates a safe harbor for those few that fit into that narrow category to be able to go to CFIUS, which is free for most individuals. It's a 45-day preliminary investigation. If there's no threats made that's determined by the Security Council at federal level, then they're clear. They have safe harbor here in the state. And so I'm happy to discuss this more with any of the stakeholders. We've talked to a lot of stakeholders to put this together and try to perfect something that works for Texas. Happy to talk to the members of the community as well, and my office remains open. And with that, I'm happy to answer any questions. Otherwise, I close.
Okay, thank you, Representative Jatan. I think they heard you've reached out to them, so I'll encourage them to go by your office. The chair moves to withdraw the committee substitute to HB 2788. Leave the bill pending at this time. Is there any objection? Hearing none, HB 2788 is left pending. Now, members, we're going to the last bill, but one administrative. The chair moves to correct the minutes for the meeting held on March 29th, 2023. Upon final adjournments or on March 20, the chair moves to correct the minutes for the meeting held on March 29th. Is there objection? The chair hears none, and the motion prevails. Thank you all. Okay, now what is his? All right, our last bill, members, the chair lays out HB 4006 and recognizes Representative Spiller to explain his bill. The chair offers a committee substitute to HB 4006.
All right. Thank you, Mr. Chairman. Mr. Chairman, Vice Chair Hernandez, and also members, thank you all for being here. Thank you for being here late hour. I'll try to be brief. I need to be thorough, but I'll try to be brief. And what I won't do is I won't go back over some of the preface for this bill because some of it was included in the layouts that Chairman Harris and Representative Jatan did as far as the basis for and the purpose for this bill or a bill like it. Members, House Bill 4006 seeks to address concerns that have been raised regarding foreign ownership and foreign governments owning and leasing land in the state of Texas. One thing I will say, previously, Chairman Harris talked about the number of acres. Actually, Texas leads the nation in land that is now owned by foreign governments or foreign entities. And that number is the current number that I have is 5.3 million acres in Texas. We lead the nation. The second is Maine with 3.6 million, Colorado 1.9, but we're substantially more than anybody else. So it is a concern. It has doubled, as he said, over the last 10 years. So there's a committee substitute that's referenced that changes the applicability of the bill as it relates to specific countries that will be included. I'll talk about that in just a second. Because after filing the legislation, concerns were expressed about the countries listed and how we address that, and so we fixed that in the committee substitute. Simplifies the legislation to encompass all countries identified by the U.S. National Intelligence Community. So it's not based on the governor's determination or anything. It is based on an annual threat assessment of the U.S. intelligence community promulgated by the Office of the Director of National Intelligence. That list of countries currently is Russia, China, Iran, and North Korea, but it's referenced in here the way that it is so that could be adjusted over a period of time, and it's based on ones that have been in there for the previous 3 years. So the list is updated by the federal government annually and reflects the countries that are currently deemed and determined to pose a threat to our nation. So Additionally, the change in applicability puts professionals and our intelligence and foreign affairs experts in the position of determining which countries pose a threat to our nation's security. So House Bill 4006 would prohibit businesses headquartered in those countries, businesses that are owned directly or indirectly by those countries, and the countries themselves from owning or leasing property in Texas. The countries would all be prohibited from owning land, minerals, timber, improvements to property, and if an entity is found, one of these entities is found to be in violation of these statutes, it is the Attorney General's office that would intervene, and there is a remedy. Let me tell you, you've heard a lot about different issues about some others. Let me tell you what the bill doesn't do. First and foremost, there is no reference in here to individuals. There's no individual liability. We're not dealing with folks' residences or homes, anything like that. All of that is specifically excluded. We're only talking about foreign entities and entities that are owned by foreign governments. So there's nothing like that. There are no criminal charges in this bill. No felonies, no misdemeanors, no fines, no substantial fines. None of that is in place. And also, as I said, we're only dealing with the designated countries as those are determined. We're not dealing with all countries. We're not dealing with any foreign entity. And the reason for that is that we're focused primarily on not those that have been good partners and good enterprise partners and investors in things in Texas and our economy, but those that simply pose a threat to us. Also, unlike some, there's nothing that just says, well, the transaction is void, or there's no, here, there's the determination, there's a prescribed course of action taken by the Attorney General's office if he suspects that something is done, and prescribes a method by which we've heard already from some witnesses under Chapter 64 of the Texas Civil Practice and Remedies Code that deals with receiverships and the remedies provided through that process. So it doesn't create, I'm very attuned to title issues, owning a title company, so I'm well aware of issues. Just to say something is void is problematic. So this doesn't do that. We've got a process and procedure there that we go through. So, and let me say this also. It's very simple to say if we have a problem, well, let's just prohibit foreign countries or foreign entities from owning property in Texas. Well, it's just not that simple. And it's not that simple because you don't know. The title company doesn't know. When they close a transaction, they see a name of an entity. There's really no way for them to independently determine if that entity is foreign or if it's not. You're kind of on the honor system, because if you go and you check and you look with the Secretary of State's office, you're going to find out who the officers or directors of an entity are, or if it's an LLC, you're going to find who the managers or members are, but you're not going to know who actually is otherwise owning that interest. And then by the same token, just the example that was given before about Exxon, there's no way to look up currently in Texas to see who all the shareholders of a particular company are. So it's a very difficult issue and a complicated issue, and that's why I feel that this bill deals with that appropriately. So with that, Mr. Chairman, subject to any questions that the panel may have of me, I'd turn it over to the witnesses and respectfully reserve the right to close.
Any questions, members?
Yes.
Representative Raymond.
First, let me commend you. It sounds like you've really given this a lot of thought and tried to, address something that, notwithstanding the witnesses that we've had in the real world, there's some issues we got to deal with when it comes to security, national security. And so I feel like you're trying to do it in a responsible way, and it's still hard, right?
Right.
Can you just take a minute or two to walk through an example of how you think, let's say this passes, right? Becomes law. What happens? Where we are able to identify somebody that would sort of fall under the new law.
Well, I think, and thank you, I appreciate that, and I have worked on this for months and months and trying to come up with the best way to approach it, and hopefully we're getting there, and I'm not saying this is a perfect thing. I'm certainly open to suggestions on what we can do to improve it. But I think what would happen would be if there's a situation either based on what is happening on the ground or the use of the property or anything, that the Attorney General could be notified, and the Attorney General would make a determination of, is that something they want to look into? So when you look into the body of the bill here, it says if the Attorney General suspects this to happen, you think, okay, well, what happens there? I would suspect that typically under the Texas Rules of Civil Procedure, you do what you call a Rule 202 deposition. I mean, I'm just spitballing here, but this is what I would think, is that typically that's where you don't really file a suit and make claims against folks that are unwarranted. Those days are long past, or should be. But instead, if you suspect something happened, you can send out a deposition or depositional written questions, get some of that information, and you could find out very quickly if it's an entity that falls within the definition of this statute. So, and then if moving forward, then they take it to a court that where all or part of the property is located, and the court would make a determination of either it was done in violation or not. If not, then fine. If it was done in violation of the statute, then the court would have the authority to appoint a receiver, and the receiver would have authority to do everything from receive rents, royalties, control the property, do whatever, and ultimately even do a disposition of the property if necessary.
So what is that they lose it completely, or what happens? The original owner?
They could, yes.
They could?
Yes.
Does that mean that they might not?
I will say this.
I'm talking about somebody that we determined, the AG determined, and the court determined. So we've now got somebody from Iran, right? And so what happens at that point?
The filed version that I had of the bill actually specifically stated that the property could be sold. It may very well be sold subject to the lien if there's a valid vendor's lien. And
so you take care of that first.
What's that?
Take care of the lien first.
Right. I mean, I'm assuming that would be the case. If they have a valid lien there, then certainly they would be made a party to the proceeding because they're an interested stakeholder to the extent that they have an equity interest in the property. So, but actually in the committee sub, some of that language was left out. So in all fairness, I'm going to revisit that idea to have that specifically contained in there.
Yeah. And then, so the lien's taken care of, then you've still got an asset, and the court determines, or what did you put in there on what happens to that asset at that point?
The Attorney General's office has some time period to make some rules and develop some policies about what actually happens with those, presumably with those net sales proceeds or whatever would happen.
Okay, thank you.
You bet.
All right, thank you all. We'll go to the live witnesses and let you close. XIAOYU Wu. I'm getting the last names pretty good now. All right. You have registered for yourself against HB 4006, correct?
Yes.
Go right ahead.
Thank you. I'm not going to bore you by a similar testimony, so I'm going to tell a story about my wife. Yeah. Good evening. My name is Dr. Xiaoyu Wu. I'm here to testify against House Bill 4006. I firmly believe this bill discriminates against individuals from certain countries by limiting how they can contribute to the economy, how they can run a business, without considering their contribution to our community. My wife is a living proof that these prejudices are unfounded. She is an international nursing student. During the pandemic, she was accepted into the ACC nursing program and have dedicated herself to her patients' care for almost 2 years. Despite being from China, not once has any of her patients refused treatment or doubted her expertise. Her colleagues and she have worked tirelessly, wearing PPE and N95 masks to fight COVID-19 together. They were a team, and they saved lives for Texas. However, This bill labels individuals like us as potential threats, denying us the right to own real property or run a business. What's next? Will my wife fail a nursing background check simply because where she come from? Must she show her permanent resident card to every patient and coworker to prove that she is not a threat to the society? These implications are unfair and unjust. Therefore, I implore this committee to consider the potential harm this bill could cause. It sends a message that individuals from certain countries are not welcomed in our community, regardless of their contributions. My wife, as a nursing student, she wants to serve the community, and she wants to be judged only by her character and ability.
Thank you,
not
and
by the
we'll
country.
note you're against HB 4006.
Thank you.
Correct? Thank
Yes.
you. John Fleming. John, we have you registered for Texas Mortgage Bankers Association for HB 4006. Is that correct?
Yes,
Go right
Chairman
ahead.
Hunter, that is correct. John Fleming, Texas Mortgage Bankers Association, testifying in favor for the committee substitute for HB 4006. We want to thank Representative Spiller and his staff for working very diligently and hard for bringing the committee substitute, because we think the committee substitute addresses a lot of the issues that you've heard tonight. It focuses only on certain designated foreign countries and on the entities that are headquartered in those foreign countries that are deemed a threat or owned by the governments. It does not reach down to individuals, and it does not reach down to individuals in the United States who may originate from those other countries. And we think that's a great improvement. We believe this is the right approach. I'm not going to go over the layout because Representative Spiller did it extremely well and covered really what's in there. I would simply say, in response somewhat to Representative Raymond, that the receivership proceedings under Chapter 64 outline how this has been done. And if you want to see how it is, you look at Chapter 64. It's not new ground. We think that's one of the very good things about this. You're using existing proceedings with a distinct process on how those funds are to be distributed. If you want to revisit that further, that certainly could be done and wrapped in, but we think that's a good start. Happy to take questions.
Thank you, John. Appreciate it very much. Cheng Zhu, XUE.
That's my wife.
Okay, we'll note that we'll have to do it 3 times. Cheng Zhu, we'll note Cheng Zhu, XUE, registered herself against HB 4006, but did not testify. Aaron Day. Aaron, we've got you registered, Texas Land Title Association, neutral, HB 4006, is that correct?
Yes, sir.
Go right ahead.
Aaron Day, Texas Land Title Association, commenting on the bill, registering on the bill. And I feel a little bit like Goldilocks tonight because this is just right. Some porridge has been a little warm, some porridge has been a little cold, but this is absolutely just the right approach. First, I'd highlight the fact that it doesn't focus on individuals, so it doesn't invite a lot of the discriminatory either actions or accusations, which could really envelop some of my partners in the building trades. And then also, of course, from the title perspective, is highlighted. It has a police power process. It closes it on the back end, avoids uncertainty. And also, we particularly like the part that the AG would file something in the land records, letting everybody know that this happened, so that increases the certainty even more so. So I think it's a well-worn path, as the Texas Mortgage Bankers and John Fleming alluded to, and so I think you really have a great approach with this bill, avoiding a lot of the externalities of some of the others. With that, I'm happy to answer.
Thank you very much, Aaron. Thank you.
Okay. Thank you.
Ming-Wan Wei. We've got you registered for yourself against HB 4006. Is that correct?
Yes, sir.
Go right ahead.
So I just want to say I don't have issue with the part with the company and entity. The only concern is with the individual, because I read the bill. I believe that if LLC company owned by an individual and this person is like U.S. green card but not a citizen yet, and then this LLC is not allowed to purchase the land or property, this is unconstitutional and is discriminatory, like we mentioned earlier. So that's the only point I want to point out, that anything against individual like this way is not okay. And you may ask, well, if that easy, just get a citizenship, everything's good to go. But in fact, it will take average 8 years to get a green card and another 5 years to become a U.S. citizen. So in these 5 years, this person, even though they had a lot of money to invest, he cannot do anything. So here I urge you to vote against this bill, at least at this format. I don't think it will show the Texas image of pro-business in this way. Thank you.
Thank you very much. We'll note you're against HB 4006. Stephen Scurlock. Steve, we got you registered for Independent Bankers Association of Texas, neutral on HB 4006. Is that correct?
That's correct, Mr. Chairman. Thank you very much. Representative Spiller, thank you for your efforts on this. I think it addresses the majority of the concerns, if not all of them. Bravo, thank you. Thank you to all of you public servants. It's been a long day, and I'm glad we don't do this in PIFs very often. I yield the remainder of my time, Mr. Chairman. Thank you very much.
Thank you. Helen Shi. Helen, we have you with UCA, United Chinese Americans, and self-registered against HB 4006. Is that correct?
Correct. Thank you,
Go right
Chairman.
ahead.
As I'm representing Asian community and also a national civil rights organization called United Chinese American, or UCA. We're coming here to urge you to vote no to this bill because we have serious concern how this bill can impact and harm our community. Many immigrants come to this country, struggle to make a life here, and many leave their home country to seek protection in Texas. And this process of obtaining green card or permanent resident can be extremely long and very painful, and it's a very long struggle for many families. At the same time, they may want to contribute their skill and the talent to serve the local community and Texas economy. So some of them will start a business, and such as a music studio or small school to help neighbors and the community. However, this bill actually can paint a broad brush against them, pointing them to be the enemy of the state, or somehow they're hostile or problematic for the community or for this country or for the state. So this can be a serious discrimination against such legal residents and legal immigrants. And therefore, we really want you to seriously consider how this bill may impact our community, and such a bill can be a violation of Texas Constitution and the Constitution of the United States, and including Fair Housing Act and other federal regulations. Thank you.
Thank you very much. We'll note you're against HB 4006.
Correct. Thank you.
Say Wei. We have you registered for yourself against HB 4006. Is that correct?
Correct.
Go right ahead.
Okay, good to see you twice in 1 day. Technically, I think it is 2 days. So I'm Che. I live in Austin, Texas, and I'm here to oppose the HB 4006. So just in case we forget the very constitutional Section 5005, let me repeat it again. An alien has the same real and personal property rights as a United States citizen. So regarding the 4006, it is for sure introduces the discrimination. we probably, some of us may have a misunderstanding about the immigration system. We probably feel like, hey, we got a job and I got a green card immediately. No, it is totally wrong. For some people like me from China, it takes me about like 10 years, actually more than 10 years to get a green card. So we study really hard and work really hard and contribute to the community a lot. But prior to that, if this bill passes, we won't be able to hold any LLC that needs to buy a property to operate, no matter it's a motel or gas station or just a Chinese restaurant. So if it passes, there will be fewer and fewer Chinese people come here, and we pretty much need to say goodbye to a delicious Chinese food, no matter it's authentic Chinese food or just orange chicken. So it hurts the economy of the community so much and apparently introduces the discrimination that limits those people's rights of doing legal business and investment. So no HB 4006. Last but not least, I remember you said you feel better now, and I wish you feel much better after hearing. Thank you.
Thank you very much. Appreciate it. Trey Bates. Trey, we have you registered with the Texas Realtors Neutral and HB 4006. Is that correct?
That's correct, Chair.
Right ahead.
Thank you very much. Trey Bates, Vice President of Government Affairs for Texas Realtors, and we are on the bill. And I just want to express gratitude to Representative Spiller. This bill, just like some of my friends in the trades business have been, like this is a Goldilocks moment. This could be just right. The narrow approach to your bill, which only addresses the government and entities that are owned by the government, does not touch on the individual or the companies owned by individuals. That was our gravest concern with some of these bills, and this solves that concern that we had with this approach to national security. We really appreciate your willingness to listen and work with all of us to make sure that this is a good bill, and we look forward to working with you to continue see what we can do to help you with that. We are on the bill, but I'm willing to go back to our leadership and see if we can change our decision on that because of the great changes made to this bill. So thank you, Representative Spiller.
Thank you very much. June Zhu, XU. June XU. June Zhu. Will note that she registered for herself against HB 4006, but did not testify. Petrus Young, Y-E-U-N-G. Petrus Young, Y-E-U-N-G. Petrus, Y-E-U-N-G. Will note was registered for self against HB 4006, but did not testify. Chun Yulin. Chun, Y-U-L-I-N. Chun, Y-U-L-I-N. Will note registered for themselves against HB 4006, but did not testify. Lin Wan. We have you registered for real, international, and self against HB 4006. Is that correct?
Correct.
Go right ahead.
Thank you, Chairman and the committee members. My name is Ling Yuan. I live in Austin for 30 years. HB 4006 is intended to address national security by limiting the company who owned by Chinese government. However, if that's not executed, planned correctly or carefully, that could cause a negative impact to the businesses for execution if not planned correctly. My company represents lots of businesses from China. Give you an example, back in 2019, I represent a company called Goodix. They're a 3D imaging company. They hire 30 IT professional in Austin. If this bill was not executed correctly back in 2019, this company could decide not to come to Austin. We could lose 30 jobs here. And just 2021, my client Changsan, it's a knife company. I helped them buy 40 acres in Leander and plan to build 500,000 square foot warehouses manufacturing site. This company relocated from California. They plan to build 300 jobs, and they signed the 380 agreements. So again, back in 2021, if this company was not, the transaction wasn't planned correctly or executed correctly, we could lose the opportunity to have lost 300 jobs. Just last month, a Chinese-owned laser company, they are a Samsung supplier. My colleague transacted this property. They bought a 262-acre from Manor, built a manufacturing to hire 1,000 people. Manor Mayor Christopher Harvey stated that this is going to be an anchor for everything we're trying to do for the city out in the east. I'm very excited about the opportunity, and this will remain for us. So.
Thank you, and we'll note you're against HB 4006. Thank you. John Kelman, C-O-W-M-A-N. John Kalman, C-O-W-M-A-N. John Kalman will note registered for himself against HB 4006, but did not testify. Alice Yee. Alice, we have you registered for Asian American Leadership Council, Asian Texans for Justice, and Self against HB 4006. Is that correct?
Correct.
Go right ahead.
My name is Alice Yee. Again, I want to introduce my title. I'm president of Asian American Leadership Council and co-founder of Asian Texans for Justice. And currently, I'm also Asian Community Liaison for Congressman Doggett. I'm coming to United States 43 years. Actually, I'm coming to Texas 43
We
years.
have to, when you do that, we have to make sure you've registered correctly.
Oh, okay.
So your registration says Asian American Leadership Council, Asian Texans for Justice, and Self against HB 4006.
Yes.
Is that
Yes.
correct?
Yes.
And go right ahead.
Where I am. I'm coming to Texas 43 years. Actually, Representative Spiller's bill, honestly, is much better than 2788. But still, as an Asian American, I want you all to understand our position. If you stood in our position, you will feel like the consequences to all Asian American living in Texas. We have to prove what our status is, where our country, where we come from. So this is put our 1.9 million Asian American in the hot spot. So we feel like we're not equal with other citizens. We are third class citizen. This bring me the experience like when before coming to United States. In China, I'm always a third citizen because government categorize the people with a different level. I thought that this is a democratic country. You are never going to face not equal. You will be treated equally no matter what. But I was sad. After 43 years in Texas, I'm not proud to be Texan anymore because Texas discriminates our Asian Americans. Thank you.
Thank you very much. XIAONAN Lee. Now we have you registered for Texas Capital News against HB 4006. Is that correct?
Yes, correct.
Go right ahead.
Thank you for the opportunity. Let me, on behalf of Texas Capital News, to express our opposition. This bill is discriminatory and unconstitutional. It should treat people differently based on where they came from or what they look like. It violates the Equal Protection Clause. It should lead to racial profiling and discrimination against Asians and other groups with similar appearance. This bill would hurt Texas' economy and real estate market by creating legal uncertainty and costs. It should also hurt the many businesses and industries that rely on foreign customers, partners, and employees. This bill would also harm the cultural diversity and social harmony of Texas. It should convey that Texas is unwelcoming and hostile to foreigners and immigrants. Our community, like many others, has contributed significantly to Texas' prosperity and vibrancy. It should also undermine Texas' international reputation and leadership role in the global arena. I urge you to reject this bill and uphold the value of freedom, equality, and opportunity that make Texas great. Thank you for your time and attention.
Thank you very much. Janet Liu. Janet, we have you registered for yourself against HB 4006, is that correct?
Correct.
Go right ahead.
Yes, I do oppose this bill. Definitely, as Alice was saying, Rep. Spiller's message, text is much better than other bills. Thank you. And definitely right now, there's a big concern amount within the community with the current two-country animosity. Anything related to business and investment becomes a concern. So I don't know what's the right thing to do, but just to be sensitive. So encourage the investment flow, which will make our state great, because I believe China is still a great trading partner to our state. In terms of entity, I'm not sure I understood so if it's a government entity, fine. But if it is a foreign business, I think should be allowed, because all the enemy country entity, I'm okay, but not businesses owned by regular people. So I wasn't sure if I understood the bill right. But in general, I work for the chamber as volunteer. I talk to my Dallas Regional Chamber all the time. I wish to continue to see investment coming in.
Thank you. Very good. We'll note you're against HB 4006.
Correct.
Thank you.
Mm-hmm.
Zilling Rue. We have you registered for yourself against HB 4006. Is that correct?
That's correct.
Go right ahead.
Okay. Thank you. And I'm presenting myself against the bill HB 4006. This bill proposed to ban the entity who have majority members or headquartered from 4 specific 5 countries purchase property in Texas. The things I understand is this bill's purpose is for the state security. Although the things I don't agree or I doubt is, I don't think this bill will make many people, many residents here feel safer. Like if my friend who's a U.S. citizen that would like to purchase an investment property with me under an LLC, half and half ownership, if the bill passed, the transaction will not be able to happen because I'm a Chinese citizen. But what if someone will say, what about you have your U.S. citizen friends have the ownership was 51% of the ownership? Probably it will happen. But why this 1% ownership change make the state safer? I highly doubt. So it will discourage potential foreign investor and reduce the flow of foreign capital into Texas. So as hurt many people who are doing international real estate related business like us. Immigrants now account for 1/6 of the state total population and support the local economy in a growing number of industries. Whenever a bill is passed that discriminates against a particular group, it often leads to an increase in violence directed towards that group. So we urge our committee members will vote against the bill. Thank you for your time.
Thank you very much. Appreciate it. Zhenggang Cheng. We've got you registered for yourself against HB 4006, correct?
Yes, thanks,
Go
Chairman.
right ahead.
Yeah. Just minutes ago, I got the substitute. Thank you for removing that clause of C that will impact for person like me. I'm a Chinese citizen, but legal permanent resident in the U.S. If that clause was there, I have LLC, then, and I'm using it to hold some property, then I'll be subject to that. So thank you so much, removing that and not targeting the individuals here in the U.S. For me, I don't know whether you're aware, but people like me, Chinese coming here, take many years to get a green card and actually 5 years to eligible to apply for citizenship. For me, I came here 25 years ago. I'm still permanent resident. So I was against this because of the change. I think, although I don't like it, but because it has still have reference to China and those specific countries, I don't like, but it's a little.
So we're clear, you're still opposed to it, but you're glad to know he has some changes. Correct?
Yeah, definitely. And I really appreciate that. Now, I'm still opposing it, but opposing it is following a different background. Previously, is discriminatory against individuals. Now, I think it's because this bill is bad for Texas and for the interest of the United States. I think in the interest of Texas and the United States, we need to welcome people, talent, investment, and business from around the world. With them, it will bring jobs and opportunities for fellow citizens, and it will be good for everyone in Texas. So.
And you oppose 4006.
Yeah, I'm still opposing it because it's not doesn't bring good for Texas.
Got it. Thank you, sir.
Thank you.
Hugh Lee. We've got you registered for Austin Chinese American Network and Self against HB 4006, correct?
That's correct.
Go right ahead.
Thank you very much, Mr. Chairman, committee members. I should also mention that I used to bring my daughter to play tennis a lot in Corpus Christi. My name is Hugh Lee, and I'm the president of Austin Chinese American Network. I'm here representing both myself and my organization, and we oppose HB 4006 as it stands today. I want to commend, though, Representative Spiller for your effort to take special care in not targeting individuals. But it still has the potential to discriminate against a group of people of certain national origins who are on legal status here in Texas, because reality is it is very common to engage in real estate transactions through an LLC for liability reasons. As it reads, Section 5.251, subsection 2C of this bill seems to forbid LLCs formed by these targeted aliens to engage in real property deals in Texas. At least it needs clarification from the representative whether these LLCs formed in the U.S. and owned by legal aliens from these designated countries fall under the scope of the prohibited entities. If they are, then we see no difference between individuals and the entities they form as far as discrimination goes. And forbidding private foreign entities to do real estate deals in Texas is obviously not business friendly, and it can harm Texas economy more than it benefits national security. So that's a concern that needs to be carefully considered and balanced. Thank you for your time.
And Corpus Christi thanks you, too.
Thank you.
Appreciate you. Thank you very much. Thank you very much. And we've got you noted, currently still against HB 4000.
Yes.
Thank you.
Mr. Chairman?
Yes.
If I may, I think he was wanting me to respond to his question.
But he's not able to ask you questions.
Right.
I'd prefer you to do it at
I'll do it at
closing. if you would.
Thank you.
Thank you. Because I'm trying to get through the remaining witnesses, because they've all been sitting here a while. I want to make sure we get you in. JIE, and then it's LUO, L-U-O, JIE, then L-U-O. You've registered for yourself against HB 4006, correct?
Yes, correct.
Go right ahead.
Okay, I'm gonna tell another story. It's a true story, happened just a couple of weeks ago. So I have a friend, client, he's relocated from California, graduated from Stanford, he's a professor, and he want to relocate to Austin to open a new lab. His major is like focus on the solar panel battery, can save more power on the smaller size of the chips. The thing is, he was worried about his right to purchase a home for himself. And then finally, I helped him purchase a home, a few months ago, before the bill, SB 741. But right now, he have another concern. So he just realized because of the new bill, HB 4006, he cannot register LLC and open his new lab in Austin, and which will help Austin create about 12 to 16 new high-tech innovation jobs. So he said he was holding his plan to relocate his lab to Austin right now until that bill got being killed. So that is my story. Thank you for your time.
Thank you very much. Okay, ZHIQUAN Sun. Again, we have you registered for Greater San Antonio Chinese Chamber of Commerce and self against HB 4006, correct?
Yes, sir.
Go right ahead, sir.
Thank you. Good morning, Mr. Chairman and committee members. Thank you for your time. I represent the Greater San Antonio Chambers of Commerce, and we focus on the, commerce and economic in San Antonio area. So thank you, Representative Spiller, for your change. But I still concerned about some details. So the first, the bill can be very dangerous as it allows a governor to designate which country and the international entity to ban. And the current political environment, it will elevate state affairs into an international crisis. The governor should not have the right to do so. In addition, the bill grants Texas prosecutors and the right to prosecute real estate transactions under the law. The bill will harm the economy of Texas. This bill violated the United States Constitution, number 14th Amendment, the State of Texas Constitution, Article 1, Section 3A, and the Federal Fair Housing Act. Thus, I opposite this bill. Thank you.
Thank you very much. We appreciate it.
Yes, thank you for hearing.
Chenyang Zhang. CHENYANGZHANG. Chenyang Zhang will show registered for self against HB 4006, but did not testify. Heilong Jin, HAILONG, Jin, J-I-N. Heilong Jin showed registered for DFW Chinese Alliance and self against HB 4006, but did not testify. Zhao Guo, Zhao we show you've registered for yourself against HB 4006. Is that correct?
That's true.
Go right ahead.
My name is Zhao Guo. I live in House District 136, and I oppose HB 4006. And I enjoy the USS, like the aircraft carrier in Corpus Christi. For many aspiring small business owners, they need to purchase investment property, farmland, or industrial land for their business. The bill bans small business of the designated country from purchasing land in Texas. Main Street business is the backbone of the economy. If foreign investors, entrepreneurs, and business owners from this country who wish to apply for EB-5, E-1C, and L-1A visa can't purchase real property, they will invest elsewhere, taking the job they create with them. This would reduce the tax income for local schools. This bill betrays Texas pro-business value. And to specify L1 visa, L1 and L1 visa, E1C green card, and E5, if lots of the requirement for those visas actually ask for the control of the business in question. Second point is that also there are many high net worth and high skilled immigrants who would like to bring their business talent and job creation to Texas. One of the green strengths of the U.S. is to attract talents all over the world, such as medical and IT workers in H-1B and L-1B visas. Extraordinary individuals in O-1, E-1A, E-1C, E-1B visas, as well as F-1 students who pay out of student tuition and wish to contribute. This bill will bring a chilling effect on immigration to Texas. So I would like to ask this committee to vote nay to this discriminatory, unlawful, and unconstitutional bill. Thank you for your time. I'm open to questions.
Thank you very much. We appreciate you.
Thanks.
CJ Zhao. Again, we have you registered for APA, PA, Texas chapter, and self against HB 4006, correct?
Correct.
Go right ahead.
Yeah, my name is CJ Zhao. I forgot to introduce myself. I'm president of APAPA Austin chapter. We are a 501c3 nationwide organization with over 50 chapters all over the United States. I'm the chapter president in Texas, Central Texas. And we encourage the Asian community to vote, to participate civically. Honestly, you guys can tell we're not professionals. We don't hide. We don't know professional. We are a minority group participating in a civic engagement process for the first time, literally. Texas legislations, you guys did it. You get us in the state capitol. There are so many of us. We never had that many people showing up. That's how upset we are. But that said, I just learned from John Fleming, Mr. John Fleming from MBA, the substitute bill. Because we're non-professionals, we didn't know the substitute bill just came out. I'm mainly here against the bill because 2C sounds like the substitute bill actually dropped 2C, which means that any LLC formed by individuals of the citizens of the country actually is no longer being prohibited. So we definitely need a clarification on that at the closing, hopefully. So I'm almost ready to switch neutral, not against the bill, but I'm almost.
But right now,
no, I'm
you're
still
opposed to HB 4006, right?
Against
Correct.
the bill.
Go, keep going.
Okay, so the reason I'm against the bill is I don't like the name China being mentioned, but I also think as a legislation, we entrust you with our taxpayer money. We know you guys can do better. Come on, there's so many pressing issues facing this nation, facing this state. You're talking about freedom of speech. You're talking about education quality. You're talking about safety on the street. You're talking about economy, huge inflation. Come on, let's do something bigger. Let's do something more for the citizens, for the people of Texas. Let's encourage economic growth. Let's go push, do something bigger. Don't be doing this. Come on.
See, you did it. You hit the buzzer.
Thank you.
Thank you. And we'll note that you're against HB 4006. Is it ENGE and then XING? Yes. We have you registered for yourself against HB 4006. Is that correct?
Yes, almost correct. Yes, it's correct.
Right.
I think a lot depending on you can nod or shake your head if the 2C's out. Okay. So that I think it's a key. I think I'm here, I would.
Let me tell you, because, seriously, because of the registration, you're against it.
Yes.
And
I
so
was
if you even start saying it, we have to re-register you.
Okay.
So my suggestion is that you all stay your course as you've filed, and then you get with his office to take a look at the information. So are we still correct to say you're against HB 4006?
Correct.
Go right ahead.
Thank you. Thank you, Representative. Thank you, Chairman. I think I made enough of here. I would encourage a lot of communications when you have any change. Our Chinese community, there are leaders today in our court, the Chinese, they will communicate to a lot of us what's changed, what's been updated. I think it could save us a lot of time on a stance if they will go home a little earlier. That's all. Thank you.
Thank you very much. And I do encourage you to communicate with the representative's office, and you can get that information. And that way you'll have it to be able to review. Is it Ping He? We have you registered for yourself against HB 4006, correct?
Yes, correct.
Go right ahead.
Yeah, I'm on representing myself only, but I oppose this bill 200%. You know why? Definitely, this is a racist bill. It's a discrimination to list the above countries separately. I understand that national security is important, but this cannot strip the legal rights of individuals or companies in the name of state security. I know individuals are not included in this bill, but all entities are operated by people. It's better that individuals are not included in this bill, but less discrimination is still discrimination. This bill passes this message that all people from these 4 countries are kind of a threat and will cause more and more hate crime against them. It doesn't just affect Chinese Americans, it affects all immigrants. It makes Texas unfriendly. This bill will obviously affect the future economic development and job opportunities in Texas. If this bill passed 20 years ago, maybe some immigrants wouldn't come to Houston to study from Mexico. Maybe they went to another state to get their degrees, get their jobs. If that happened, possibly we wouldn't have our charming, outstanding vice chair Anna here in this committee. Family and house are important for Americans, so are Chinese Americans. In most biographies of our representative webpage, your value for the Texans you represent in your district. There are many immigrants in your district as well. They live and work in Texas just like you and me. They pay taxes and contribute to the development of their country like you and me, like other native Texans. They are your future voters. They deserve the human rights. So I urge all of you to vote against this
Thank you, sir.
bill.
Thank you very much.
Thank you.
Is it Fei Zhao? That's FEIXIAO. We've got you registered for yourself against HB 4006. Is that correct?
Yeah.
Go right ahead.
Yes, my name is Sophie. I live in Austin. It's short time we face to face again. I think a lot of people is tired. We want to go home. So I just clear tell you against this bill.
And we want to tell you thanks because you're right to the point. Some of these lawyers up here. But anyway, for the record, you're against HB 4006.
Yes.
Thank you so much.
Yeah, thank you a lot.
Now, members, thank you. That's the last of our registrations. Now, everybody in the audience, so you hear it, is there anybody else who did register to testify for, against, or on by the 5 o'clock? Okay, Representative Spiller, close.
I'm going to be very brief, but there are two things I want to address. Number one is I want everybody on this committee to understand, and everybody that's been here and stayed here to understand, this bill is not meant or intended in any way to be discriminatory in any way. It was filed and meant only to protect the great state of Texas that we love and the United States of America. That is the sole purpose of this bill. And I'm very sensitive to the concerns that have been raised tonight. I will continue to work with anybody, any stakeholder, anybody, any individual that wants to visit with me about making this bill better. I'm open to that because I'm very sensitive to that, and I want to get it right. And I think we can do it right, and we can do it as a model for other states that if they want to do something right, I'd like to set the tone for that. Number two is I want to make it very clear in the property code in the state of Texas, every citizen, if you're a citizen or non-citizen, you still have the right to own real and personal property in the state of Texas. You have every right as a non-citizen or someone that's working, that has a green card or working towards citizenship, and I applaud that. But you have every right to own property except as this bill provides. And this bill provides only 3 categories of things. Either you're a governmental entity of one of these designated countries, you're an organization that's headquartered in one of these countries, or directly or indirectly under their control, or you're an organization underneath that. So this issue about whether you're an LLC and you have a group of people or whatever, and you form that, and it's formed in Texas, or it could be formed in any state, there is absolutely nothing to prevent you or that entity from owning property in the state of Texas. So I want to make that very clear, and if we need to do something to clarify that, I'm happy to do it. But with that, Mr. Chairman.
And I want to make it real clear, you're closing, right? Okay. Thank you, Representative Spiller. Any questions? Thank you. Chair moves to withdraw the committee substitute HB 4006 and leave the bill pending at this time. Is there any objection? Hearing none. HB 4006 is left pending. Thank you to our witnesses and my members for their participation in today's hearing. Is there any business left to be discussed? That concludes our business. If there's no objection, Committee on State Affairs will stand adjourned, subject to the call of the chair. The chair has no objection. Committee on State Affairs is now adjourned.